American people who have not seen the Mueller report. They still don't understand what the big brouhaha is about, and they're just read some of your sound bites or some of your headlines. So this is an attempt to make sure that for that person who is curious and who really doesn't have the full time to dive through all this, to be able to listen to it and to try to understand what this is really all about. Because in the end, it's really not about polls, it's not about politics, it's really not even about this president. It's about the Constitution and the future of our country. We were invaded by the Russians through cyberspace. As Ms. Jackson-Lee pointed out, the Florida governor yesterday said 2 of his counties were hacked and they were tampered with. That's just 2. I'm sure that if we look around, we might find other states or other counties in some states. Because I know we've had some troublesome things happen even in our state of Texas. So I think it's important that people realize that this is something that we're doing to protect the people of this country, to protect our way of governing, and to protect the future of our country. Thank you.
And with that, my colleagues are going to be coming back to read in a little while, but we do have time for a couple questions.
3 questions. Congresswoman Jackson-Lee, we're talking about asking the Rules Committee and then the House to authorize an investigation. You all have an investigation going. Are you talking about an impeachment investigation specifically? That's the kind of thing that would require authorization, right?
There is, in House Rules 6 and 7, the opportunity to have a resolution of investigation, no word in front of it. And it would have to be processed through the Rules Committee, then referred to the floor, then referred to the House Judiciary Committee after that vote. What it simply does, we are investigating. Chairman Nadler has done an excellent job. The members of the Judiciary Committee are serious about their work. But as you have seen, we have an executive, we have an Article II body that is doing something that most members of Congress or the American people have never confronted, because the Founding Fathers established a coordinate, collaborative process, even when we were at odds with each other. For example, the issue with General Holder some 2 or 3, 5 years ago, General Holder did present documentation. But in this instance, the resolution of investigation gives the force of the full House and the instructions to the Judiciary Committee to do a litany of things that we believe is part of our duty of educating the public, our members of Congress, and proceeding in the way that would be in consistency with the fact that we're doing other work. We're fighting for health care, the Equality Act, Violence Against Women Act. We are working, but we cannot have an administration that seeks to undermine the order of 3 branches of government, and this would be a procedure that could work to frame our investigation.
I know that Chairman Nadler has been working this out and negotiating to get Robert Mueller up here to testify, but he's implying that there's some serious feet dragging going on. How soon would you potentially like the committee to move to subpoena him to appear?
Well, there's not a member of the committee does not hold Robert Mueller in high esteem. Those of us who knew him as director of the FBI, he is a former Marine. He was the one that wrote the letter that was uncomfortable with the way General Barr characterized it. I think Director Mueller wants to come to present the facts. That's all we ask of him. And I think as long as we can evidence that it will be the facts and whatever is worked out with the House Judiciary Committee, I'm going to maintain optimism that Director Mueller will come. We have to work on schedules. You know that Ms. McGahn is scheduled for the 21st. I've already indicated that even constitutional scholars can find no reason for him not to come. But Director Mueller supervised writing this very plain-spoken Mueller report. And if he had his hands on it, then he should be the one that we have the opportunity to question, and I would hope that he'd want to have an opportunity to speak. We're working with him and his team to ensure that that happens.
Okay, I think we have one last.
How would the resolution do any more to help your investigation than what you all are already doing? I mean, the White House is already, stonewalling subpoenas, not complying with those sort of actions. How would the resolution, comply them to actually cooperate?
When we have the full weight of the House behind it, then it does give it additional weight in the courts. But as
Rather than just committee.
rather than just the committee, yes.
Yeah,
And the other piece of this is, as Congresswoman Jackson Lee mentioned, this is an extraordinary circumstance where we have an administration asserting blanket privilege over an entire document, all of the underlying materials, when there's no legal grounds to do that. I mean, the executive privilege is piece by piece with respect to specific items. You have to be able to say what your grounds are for that piece, and we're not seeing anything like that. So it is just stonewalling.
If I might, it operates under the rules of the House, and the Congresswoman is right, both Congresswomen are right. What would happen is that you would have an actual referral and a vote, and that means an instruction by the House of Representatives. We don't want to do any of this. If we can have our hearings and have the Article 2 body respond as it should, and not pretend that a blanket executive privilege can be utilized. But we have to do our job. And certainly this is something that has to be discussed and deliberated on, and that will be the case, and it's only on the grounds of needing and having the duty of doing our job. We are working in collaboration with our next steps.
Thank you. Thank you.
Thank you all for being here and for your time.
Thank you so much.
We'll be back at 1:30.
Yeah, 1:30.
I'll be right back.
Introduction to Volume 1. This report is submitted to the Attorney General pursuant to 28 CFR Section 600.8C, which states that, at the conclusion of the special counsel's work, he shall provide the Attorney General a confidential report explaining the prosecution or declination decisions the special counsel reached. The Russian government interfered in the 2016 presidential election in sweeping and systematic fashion. Evidence of Russian government operations began to surface in mid-2016. In June, the Democratic National Committee and its cyber response team publicly announced that Russian hackers had compromised its computer network. Releases of hacked materials, hacks that public reporting soon attributed to the Russian government, began that same month. Additional releases followed in July through the organization WikiLeaks, with further releases in October and November. In late July 2016, soon after WikiLeaks' first release of stolen documents, a foreign government contacted the FBI about a May 2016 encounter with Trump campaign foreign policy advisor George Papadopoulos. Papadopoulos had suggested to a representative of that foreign government that the Trump campaign had received indications from the Russian government that it could assist the campaign through the anonymous release of information damaging to Democratic presidential candidate Hillary Clinton. That information prompted the FBI on July 31st, 2016, to open an investigation into whether individuals associated with the Trump campaign were coordinating with the Russian government in its interference activities. That fall, 2 federal agencies jointly announced that the Russian government directed recent compromises of emails from U.S. persons and institutions, including U.S. political organizations, and that these thefts and disclosures are intended to interfere with the U.S. election process. After the election, in late December 2016, the United States imposed sanctions on Russia for having interfered in the election. By early 2017, several congressional committees were examining Russia's interference in the election. Within the executive branch, these investigatory efforts ultimately led to the May 2017 appointment of Special Counsel Robert S. Mueller III. The order appointing the special counsel authorized him to investigate the Russian government's efforts to interfere in the 2016 presidential election, including any links or coordination between the Russian government and individuals associated with the Trump campaign. As set forth in detail in this report, the special counsel's investigation established that Russia interfered in the 2016 presidential election principally through 2 operations. First, a Russian entity carried out a social media campaign that favored presidential candidate Donald J. Trump and disparaged presidential candidate Hillary Clinton. Second, a Russian intelligence service conducted computer intrusion operations against entities, employees, and volunteers working on the Clinton campaign, and then released stolen documents. The investigation also identified numerous links between the Russian government and the Trump campaign. Although the investigation established that the Russian government perceived that it would benefit from a Trump presidency and worked to secure that outcome, and that the campaign expected that it would benefit electorally from information stolen and released through Russian efforts. The investigation did not establish that members of the Trump campaign conspired or coordinated with the Russian government in its election interference activities. Below, we describe the evidentiary considerations underpinning statements about the results of our investigation and the special counsel's charging decisions, and we then provide an overview of the 2 volumes of the report. The report describes actions and events that the special counsel's office found to be supported by the evidence collected in our investigation. In some instances, the report points out the absence of evidence or conflicts in the evidence about a particular fact or event. In other instances, when substantial, credible evidence enabled the office to reach a conclusion with confidence, the report states that the investigation established that certain actions or events occurred. A statement that the investigation did not establish particular facts does not mean that there was no evidence of those facts. In evaluating whether evidence about collective action of multiple individuals constituted a crime, we applied the framework of conspiracy law, not the concept of collusion. In so doing, the office recognized that the word collude was used in communications with the acting Attorney General confirming certain aspects of the investigation's scope, and that the term has frequently been invoked in public reporting about the investigation. But collusion is not a specific offense or theory of liability found in the United States Code, nor is it a term of art in federal criminal law. For those reasons, the office's focus in analyzing questions of joint criminal liability was on conspiracy as defined in federal law. In connection with that analysis, we addressed the factual question whether members of the Trump campaign coordinated, a term that appears in the appointment order, with Russian election interference activities. Like collusion, coordination does not have a settled definition in federal criminal law. We understood coordination to require an agreement, tacit or express, between the Trump campaign and the Russian government on election interference. That requires more than the two parties taking actions that were informed or responsive to the other's actions or interests. We applied the term coordination in that sense when stating in the report that the investigation did not establish that the Trump campaign coordinated with the Russian government in its election interference activities. The report on our investigation consists of 2 volumes. Volume 1 describes the factual results of the special counsel's investigation of Russia's interference in the 2016 presidential election and its interactions with the Trump campaign. Section 1 of that volume describes the scope of the investigation. Sections 2 and 3 describe the principal ways Russia interfered in the 2016 presidential election. Section 4 describes links between the Russian government and individuals associated with the Trump campaign. Section 5 sets forth the special counsel's charging decisions. Volume 2 addresses the president's actions toward the FBI's investigation into Russia's interference in the 2016 presidential election and related matters, and his actions toward the special counsel's investigation. Volume 2 separately states its framework and the considerations that guided that investigation. Executive summary to Volume 1, Russian social media campaign. The Internet Research Agency, IRA, carried out the earliest Russian interference operations identified by the investigation, a social media campaign designed to provoke and amplify political and social discord in the United States. The IRA was based in St. Petersburg, Russia, and received funding from the Russian oligarch Yevgeny Prigozhin, and companies he controlled. Prigozhin is widely reported to have ties to Russian President Vladimir Putin. There's then a redacted section. In mid-2014, the IRA sent employees to the United States on an intelligence gathering mission with instructions redacted. The IRA later used social media accounts and interest groups to sow discord in the US political system through what it termed information warfare. The campaign evolved from a generalized program designed in 2014 and 2015 to undermine the US electoral system to a targeted operation that by early 2016 favored candidate Trump and disparaged candidate Clinton. The IRA's operation also included the purchase of political advertisements on social media in the names of US persons and entities, as well as the staging of political rallies inside the United States. To organize those rallies, IRA employees posed as US grassroots entities and persons and made contact with Trump supporters and Trump campaign officials in the United States. The investigation did not identify evidence that any US persons conspired or coordinated with the IRA. Section 2 of this report details the office's investigation of the Russian social media campaign. Russian hacking operations. At the same time that the IRA operation began to focus on supporting candidate Trump in early 2016, the Russian government employed a second form of interference: cyber intrusions, hacking, and releases of hacked materials damaging to the Clinton campaign. The Russian intelligence service, known as the Main Intelligence Directorate of the General Staff of the Russian Army, the GRU, carried out these operations. In March 2016, the GRU began hacking the email accounts of Clinton campaign volunteers and employees, including campaign chairman John Podesta. In April 2016, the GRU hacked into the computer networks of the Democratic Congressional Campaign Committee, the DCCC, and the Democratic National Committee, the DNC. The GRU stole hundreds of thousands of documents from the compromised email accounts and networks. Around the time that the DNC announced in mid-June 2016 the Russian government's role in hacking its network, the GRU began disseminating stolen materials through fictitious online personas, DC Leaks and Guccifer 2.0. The GRU later released additional materials through the organization WikiLeaks. The presidential campaign of Donald J. Trump, the Trump campaign or campaign, showed interest in WikiLeaks releases of documents and welcomed their potential to damage candidate Clinton. Beginning in June 2016, redacted, senior campaign officials that WikiLeaks would release information damaging to candidate Clinton. WikiLeaks' first release came in July 2016. Around the same time, candidate Trump announced that he hoped Russia would recover emails described as missing from a private server used by Clinton when she was Secretary of State. He later said that he was speaking sarcastically. Redacted. WikiLeaks began releasing Podesta's stolen emails on October 7th, 2016, less than 1 hour after a US media outlet released video considered damaging to candidate Trump. Section 3 of this report details the office's investigation into the Russian hacking operations, as well as other efforts by Trump campaign supporters to obtain Clinton-released emails. Russian contacts with the campaign. The social media campaign and the GRU hacking operations coincided with a series of contacts between Trump campaign officials and individuals with ties to the Russian government. The office investigated whether those contacts reflected or resulted in the campaign conspiring or coordinating with Russia in its election interference activities. Although the investigation established that the Russian government perceived it would benefit from a Trump presidency and worked to secure that outcome, and the campaign expected it would benefit electorally from information stolen and released through Russian efforts, the investigation did not establish that members of the Trump campaign conspired or coordinated with the Russian government in its election interference activities. The Russian contacts consisted of business connections, offers of assistance to the campaign, invitations for candidate Trump and Putin to meet in person, invitations for campaign officials and representatives of the Russian government to meet, and policy positions seeking improved US-Russian relations. Section 4 of the report details the contacts between Russia and the Trump campaign during the campaign and transition periods, the most salient of which are summarized below in chronological order. 2015. Some of the earliest contacts were made in connection with a Trump Organization real estate project in Russia known as Trump Tower Moscow. Candidate Trump signed a letter of intent for Trump Tower Moscow by November 2015, and in January 2016, Trump Organization executive Michael Cohen emailed and spoke about the project with the Office of Russian Government Press Secretary, Dmitry Peskov. The Trump Organization pursued the project through at least June 2016, including by considering travel to Russia by Cohen and candidate Trump. Spring 2016. Campaign foreign policy advisor George Papadopoulos made early contact with Joseph Mifsud, a London-based professor who had connections to Russia and traveled to Moscow in April 2016. Immediately upon his return to London from that trip, Mifsud told Papadopoulos that the Russian government had dirt on Hillary Clinton in the form of thousands of emails. 1 week later, in the first week of May 2016, Papadopoulos suggested to a representative of a foreign government that the Trump campaign had received indications from the Russian government that it could assist the campaign through the anonymous release of information damaging to candidate Clinton. Throughout that period of time and for several months thereafter, Papadopoulos worked with Mifsud and 2 Russian nationals to arrange a meeting between the campaign and the Russian government. No meeting took place. Summer 2016. Russian outreach to the Trump campaign continued into the summer of 2016 as candidate Trump was becoming the presumptive Republican nominee for president. On June 9, 2016, for example, a Russian lawyer met with senior Trump campaign officials Donald Trump Jr., Jared Kushner, and campaign chairman Paul Manafort to deliver what the email proposing the meeting had described as official documents and information that would incriminate Hillary. The materials were offered to Trump Jr. as, quote, part of Russia and its government support for Mr. Trump, end quote. The written communication setting up the meeting showed that the campaign anticipated receiving information from Russia that could assist candidate Trump's electoral prospects, but the Russian lawyer's presentation did not provide such information. Days after the June 9 meeting, on June 14, 2016, a cybersecurity firm and the DNC announced that Russian government hackers had infiltrated the DNC and obtained access to opposition research on candidate Trump, among other documents. In July 2016, campaign foreign policy advisor Carter Page traveled in his personal capacity to Moscow and gave the keynote address at the New Economic School. Page had lived and worked in Russia between 2003 and 2007. After returning to the United States, Page became acquainted with at least 2 Russian intelligence officers, one of whom was later charged in 2015 with conspiracy to act as an unregistered agent of Russia. Page's July 2016 trip to Moscow and his advocacy for pro-Russian foreign policy drew media attention. The campaign then distanced itself from Page, and by late September 2016, removed him from the campaign. July 16 was also the month WikiLeaks first released emails stolen by the GRU from the DNC. On July 22, 2016, WikiLeaks posted thousands of internal DNC documents revealing information about the Clinton campaign. Within days, there was public reporting that U.S. intelligence agencies had high confidence that the Russian government was behind the theft of emails and documents from the DNC. And within a week of the release, a foreign government informed the FBI about its May 2016 interaction with Papadopoulos and his statement that the Russian government could assist the Trump campaign. On July 31, 2016, based on the foreign government reporting, the FBI opened an investigation into potential coordination between the Russian government and individuals associated with the Trump campaign. Separately, on August 2, 2016, Trump campaign chairman Paul Manafort met in New York City with his longtime business associate, Konstantin Kilimnik, who the FBI assesses to have ties to Russian intelligence. Kilimnik requested the meeting to deliver in person a peace plan for the Ukraine that Manafort acknowledged to the special counsel's office was a backdoor way for Russia to control part of eastern Ukraine. Both men believed the plan would require candidate Trump's assent to succeed were he elected to be president. They also discussed the status of the Trump campaign and Manafort's strategy for winning Democratic votes in Midwestern states. Months before that meeting, Manafort had caused internal polling data to be shared with Kilimnik, and the sharing continued for some period of time after their August meeting. Fall 2016. On October 7, 2016, the media released video of candidate Trump speaking in graphic terms about women years earlier, which was considered damaging to his candidacy. Less than an hour later, WikiLeaks made its second release, thousands of John Podesta's emails that had been stolen by the GRU in late March 2016. The FBI and other U.S. government institutions were at the time continuing their investigation of suspected Russian government efforts to interfere in the presidential election. That same day, October 7th, the Department of Homeland Security and the Office of the Director of National Intelligence issued a joint public statement that the Russian government directed the recent compromises of emails from U.S. persons and institutions, including from U.S. political organizations. Those thefts and the disclosures of the hacked materials through online platforms such as WikiLeaks, the statement continued, are intended to interfere with the U.S. election process. Post-2016 election. Immediately after the November 8 election, Russian government officials and prominent Russian businessmen began trying to make inroads into the new administration. The most senior levels of the Russian government encouraged these efforts. The Russian embassy made contact hours after the election to congratulate the president-elect and to arrange a call with President Putin. Several Russian businessmen picked up the effort from there. Kirill Dmitriev, the chief executive officer of Russia's Sovereign Wealth Fund, was among the Russians who tried to make contact with the incoming administration. In early December, a business associate steered Dmitriev to Eric Prince, a supporter of the Trump campaign and an associate of senior Trump advisor Steve Bannon. Dmitriev and Prince later met face-to-face in January 2017 in the Seychelles and discussed U.S.-Russia relations. During the same period, another business associate introduced Dmitriev to a friend of Jared Kushner, who had not served on the campaign or the transition team. Dmitriev and Kushner's friend collaborated on a short written reconciliation plan for the United States and Russia, which Dmitriev implied had been cleared through Putin. The friend gave that proposal to Kushner before the inauguration, and Kushner later gave copies to Bannon and incoming Secretary of State Rex Tillerson. On December 29, 2016, then President Obama imposed sanctions on Russia for having interfered in the election. Incoming National Security Advisor Michael Flynn called Russian Ambassador Sergei Kislyak and asked Russia not to escalate the situation in response to the sanctions. The following day, Putin announced that Russia would not take retaliatory measures in response to the sanctions at that time. Hours later, President-elect Trump tweeted, "Great move on delay by V. Putin." The next day, on December 31st, 2016, Kislyak called Flynn and told him the request had been received at the highest levels, and Russia had chosen not to retaliate as a result of Flynn's request. On January 6, 2017, members of the Intelligence Community briefed President-elect Trump on a joint assessment drafted and coordinated among the Central Intelligence Agency, FBI, and National Security Agency that concluded with high confidence that Russia had intervened in the election through a variety of means to assist Trump's candidacy and harm Clinton's. A declassified version of that assessment was publicly released the same day. Between mid-January 2017 and early February 2017, 3 congressional committees, the House Permanent Select Committee on Intelligence, HPSI, the Senate Select Committee on Intelligence, SSCI, and the Senate Judiciary Committee, SJC, announced they would conduct inquiries or had already been conducting inquiries into Russian interference in the election. Then FBI Director James Comey later confirmed to Congress the existence of the FBI's investigation into Russian interference that had begun before the election. On March 20, 2017, in open session testimony before HPSI, Comey stated, "I have been authorized by the Department of Justice to confirm that the FBI, as part of our counterintelligence mission, is investigating the Russian government's efforts to interfere in the 2016 presidential election, and that includes investigating the nature of any links between individuals associated with the Trump campaign and the Russian government, and whether there was any coordination between the campaign and Russia's efforts. As with any counterintelligence investigation, this will also include an assessment of whether any crimes were committed." The investigation continued under then-Director Comey for the next 7 weeks until May 9, 2017, when President Trump fired Comey as FBI director, an action which is analyzed in Volume 2 of the report. On May 17, 2017, Acting Attorney General Rod Rosenstein appointed the special counsel and authorized him to conduct the investigation that Comey had confirmed in his congressional testimony, as well as matters arising directly from the investigation and any other matters within the scope of 28 CFR Section 600.4a, which generally covers efforts to interfere with or obstruct the investigation. President Trump reacted negatively to the special counsel's appointment. He told advisors that it was the end of his presidency, sought to have Attorney General Jefferson Jeff Sessions unrecused from the Russia investigation, and to have the special counsel removed, and engaged in efforts to curtail the special counsel's investigation and prevent the disclosure of evidence to it, including through public and private contacts with potential witnesses. Those and related actions are described and analyzed in Volume 2 of the report. the special counsel's charging decisions. In reaching the charging decisions described in Volume 1 of the report, the office determined whether the conduct it found amounted to a violation of federal criminal law chargeable under the principles of federal prosecution. See Justice Manual Section 9-27 et sec. 2018. The standard set forth in the Justice Manual is whether the conduct constitutes a crime. If so, whether admissible evidence would probably be sufficient to obtain and sustain a conviction, and whether prosecution would serve a substantial federal interest that could not adequately be served by prosecution elsewhere or through non-criminal alternatives. See Justice Manual Section 9-27.220. Section 5 of the report provides detailed explanation of the office's charging decisions, which contain three main components. First, the office determined that Russia's two principal interference operations in the 2016 US presidential election, the social media campaign and the hacking and dumping operations, violated US criminal law. Many of the individuals and entities involved in the social media campaign have been charged with participating in a conspiracy to defraud the United States by undermining through deceptive acts the work of federal agencies charged with regulating foreign influence in US elections, as well as related counts of identity theft. See United States versus Internet Research Agency et al., number 18-CR-32 DDC. Separately, Russian intelligence officers who carried out the hacking into Democratic Party computers and the personal email accounts of individuals affiliated with the Clinton campaign conspired to violate, among other federal laws, the Federal Computer Intrusion Statute, and they have been so charged. See United States versus Netishko et al., number 18-CR-215 DDC. Then there's a redacted portion. Second, while the investigation identified numerous links between individuals with ties to the Russian government and individuals associated with the Trump campaign, the evidence was not sufficient to support criminal charges. Among other things, the evidence was not sufficient to charge any campaign official as an unregistered agent of the Russian government or other Russian principal. And our evidence about the June 9, 2016 meeting and the WikiLeaks releases of hacked materials was not sufficient to charge a criminal campaign finance violation. Further, the evidence was not sufficient to charge that any member of the Trump campaign conspired with representatives of the Russian government to interfere in the 2016 election. Third, the investigation established that several individuals affiliated with the Trump campaign lied to the office and to Congress about their interactions with Russia-affiliated individuals in related matters. Those lies materially impacted the investigation of Russian election interference. The office charged some of those lies as violations of the federal false statement statute. Former National Security Advisor Michael Flynn pleaded guilty to lying about his interactions with Russian Ambassador Kislyak during the transition period. George Papadopoulos, a foreign policy advisor during the campaign period, pleaded guilty to lying to investigators about, inter alia, the nature and timing of his interactions with Joseph Mifsud, the professor who told Papadopoulos that the Russians had dirt on candidate Clinton in the form of thousands of emails. Former Trump Organization attorney Michael Cohen pleaded guilty to making false statements to Congress about the Trump-Moscow project. Then there's a redacted portion. And in February 2019, the U.S. District Court for the District of Columbia found that Manafort lied to the office and the grand jury concerning his interactions and communications with Konstantin Kilimnik about the Trump campaign polling data and a peace plan for Ukraine. The office investigated several other events that have been publicly reported to involve potential Russia-related contacts. For example, the investigation established that interactions between Russian Ambassador Kislyak and Trump campaign officials, both at the candidate's April 2016 foreign policy speech in Washington, D.C., and during the week of the Republican National Convention, were brief, public, and non-substantive. And the investigation did not establish that one campaign official's efforts to dilute a portion of the Republican Party platform on providing assistance to Ukraine were undertaken at the behest of candidate Trump or Russia. The investigation also did not establish that a meeting between Kislyak and Sessions in September 2016 at Sessions' Senate office included any more than a passing mention of the presidential campaign. The investigation did not always yield admissible information or testimony, or a complete picture of the activities undertaken by the subjects of the investigation. Some individuals invoked their Fifth Amendment right against compelled self-incrimination and were not, in the office's judgment, appropriate candidates for grants of immunity. The office limited its pursuit of other witnesses' information, such as information known to attorneys or individuals claiming to be members of the media, in light of internal Department of Justice policies, CEG Justice Manual Sections 9-13400, 13.410. Some of the information obtained via court process, moreover, was presumptively covered by legal privilege and was screened from investigators by a filter or taint team. Even when individuals testified or agreed to be interviewed, they sometimes provided information that was false or incomplete, leading to some of the false statement charges described above. And the office faced practical limits on its ability to access relevant evidence as well. Numerous witnesses and subjects lived abroad, and documents were held outside the United States. Further, the office learned that some of the individuals we interviewed or whose conduct we investigated, including some associated with the Trump campaign, deleted relevant communications or communicated during the relevant time period using applications that feature encryption or that do not provide for long-term retention of data or communications records. In such cases, the office was not able to corroborate witness statements through comparison to contemporaneous communications or fully question witnesses about statements that appeared inconsistent with other known facts. Accordingly, while this report embodies factual and legal determinations that the office believes to be accurate and complete to the greatest extent possible, given these identified gaps, the office cannot rule out the possibility that the unavailable information would shed additional light on or cast in a new light the events described in the report. Section 1, the Special Counsel's investigation. On May 17, 2017, Deputy Attorney General Rod J. Rosenstein, then serving as Acting Attorney General for the Russia investigation following the recusal of former Attorney General Jeff Sessions on March 2, 2016, appointed the Special Counsel to investigate Russian interference with the 2016 presidential election and related matters. Office of the Deputy Attorney General, Order Number 3915-2017, appointment of Special Counsel to investigate Russian interference with the 2016 presidential election and related matters, May 17, 2017, hereinafter called the Appointment Order. Relying on the authority vested in the Acting Attorney General, including 28 U.S.C. Sections 509, 510, and 515, the Acting Attorney General ordered the appointment of a Special Counsel in order to discharge the Acting Attorney General's responsibility to provide supervision and management of the Department of Justice and to ensure a full and thorough investigation of the Russian government's efforts to interfere in the 2016 presidential election. Appointment Order Introduction. The Special Counsel, the order stated, is authorized to conduct the investigation confirmed by then FBI Director James B. Comey in testimony before the House Permanent Select Committee on Intelligence on May 20th, 2017, including, number 1, any links or coordination between the Russian government and individuals associated with the campaign of President Donald Trump, and number 2, any matters that arose or may arise directly from the investigation, and number 3, any other matters within the scope of 28 CFR Section 600.4a, Appointment Order, Paragraph B. Section 600.4 affords the Special Counsel the authority to investigate and prosecute federal crimes committed in the course of and with the intent to interfere with the Special Counsel's investigation, such as perjury, obstruction of justice, destruction of evidence, and intimidation of witnesses, 28 CFR Section 600.4a. The authority to investigate any matters that arose directly from the investigation, Appointment Order, Paragraph B2, covers similar crimes that may have occurred during the course of the FBI's confirmed investigation before the Special Counsel's appointment. If the Special Counsel believes it is necessary and appropriate, the order further provided, the Special Counsel is authorized to prosecute federal crimes arising from the investigation of these matters. Id, Paragraph C, Finally, the Acting Attorney General made applicable Sections 600.4 through 600.10 of Title 28 of the Code of Federal Regulations, id at paragraph D. The Acting Attorney General further clarified the scope of the Special Counsel's investigatory authority in 2 subsequent memoranda. A memorandum dated August 2, 2017, explained that the appointment order had been worded categorically in order to permit its public release without confirming specific investigations involving specific individuals. It then confirmed that the Special Counsel had been authorized since his appointment to investigate allegations that 3 Trump campaign officials, Carter Page, Paul Manafort, and George Papadopoulos, committed a crime or crimes by colluding with Russian government officials with respect to the Russian government's efforts to interfere with the 2016 presidential election. The memorandum also confirmed the Special Counsel's authority to investigate certain other matters, including 2 additional sets of allegations involving Manafort, crimes arising from payments he received from the Ukrainian government, and crimes arising from his receipt of loans from a bank whose CEO was then seeking a position in the Trump administration. Allegations that Papadopoulos committed a crime or crimes by acting as an unregistered agent of the Israeli government, and 4 sets of allegations involving Michael Flynn, the former National Security Advisor to President Trump. On October 20th, 2017, the Acting Attorney General confirmed in a memorandum the Special Counsel's investigative authority as to several individuals and entities. First, as part of a full and thorough investigation of the Russian government's efforts to interfere in the 2016 presidential election, the Special Counsel was authorized to investigate the pertinent activities of Michael Cohen, Richard Gates, redacted, Roger Stone, and redacted. Confirmation of that authorization to investigate such individuals, the memorandum stressed, does not suggest that the Special Counsel has made a determination that any of them has committed a crime. Second, with respect to Michael Cohen, the memorandum recognized the Special Counsel's authority to investigate leads related to Cohen's establishment and use of Essential Consultants LLC to, inter alia, receive funds from Russian-backed entities. Third, the memorandum memorialized the Special Counsel's authority to investigate individuals and entities who are possibly engaged in jointly undertaken activity with existing subjects of the investigation, including Paul Manafort. Finally, the memorandum described an FBI investigation opened before the Special Counsel's appointment into allegations that then Attorney General Jeff Sessions made false statements to the United States Senate and confirmed the Special Counsel's authority to investigate that matter. The Special Counsel structured the investigation in view of his power and authority to exercise all investigative and prosecutorial functions of any United States attorney, 28 CFR 600.6. Like a U.S. Attorney's Office, the Special Counsel's Office considered a range of classified and unclassified information available to the FBI in the course of the office's Russia investigation, and the office structured that work around evidence for possible use in prosecutions of federal crimes, assuming that one or more crimes were identified that warranted prosecution. There was substantial evidence immediately available to the Special Counsel at the inception of the investigation in May 2017, because the FBI had, by that time, already investigated Russian election interference for nearly 10 months. The Special Counsel's Office exercised its judgment regarding what to investigate and did not, for instance, investigate every public report of a contact between the Trump campaign and Russia-affiliated individuals and entities.
Thank you very much. The office has concluded its investigation into links and coordination between the Russian government and individuals associated with the Trump campaign. Certain proceedings associated with the office's work remain ongoing. After consultation with the Office of the Deputy Attorney General, the office has transferred responsibility for those remaining issues to other components of the Department of Justice and FBI. Appendix D lists those transfers. 2 district courts confirmed the breadth of the Special Counsel's authority to investigate Russia election interference and links and/or coordination with the Trump campaign. See United States versus Manafort, United States versus Manafort. In the course of conducting that investigation, the office periodically identified evidence of potential criminal activity that was outside the scope of the special counsel's authority established by the acting Attorney General. After consultation with the Office of the Deputy Attorney General, the office referred that evidence to appropriate law enforcement authorities, principally other components of the Department of Justice, and to the FBI. Appendix D summarizes those referrals. To carry out the investigation and prosecution of the matters assigned to him, the special counsel assembled a team that at its high point included 19 attorneys, 5 of whom joined the office from private practice and 14 on detail or assigned from other Department of Justice components. These attorneys were assisted by a filter team of department lawyers and FBI personnel who screened materials obtained via court process for privileged information before turning those materials over to investigators. A support staff of 3 paralegals on detail from the department's antitrust division, and an administrative staff of 9 responsible for budget, finance, purchasing, human resources, records, facilities, security, information technology, and administrative support. The special counsel attorneys and the support staff were co-located with and worked alongside approximately 40 FBI agents, intelligence analysts, forensic accountants, a paralegal, and professional staff assigned by the FBI to assist the special counsel's investigation. Those assigned FBI employees remained under FBI supervision at all times. The matters on which they assisted were supervised by the special counsel. During its investigation, the office issued more than 2,800 subpoenas under the auspices of a grand jury sitting in the District of Columbia, executed nearly 500 search and seizure warrants, obtained more than 230 orders for communications records under 18 U.S.C. 2703D, obtained almost 50 orders authorizing use of pen registers, made 13 requests to foreign governments pursuant to mutual legal assistance treaties, and interviewed approximately 500 witnesses, including almost 80 before a grand jury. From its inception, the office recognized that its investigation could identify foreign intelligence and counterintelligence information relevant to the FBI's broader national security mission. FBI personnel who assisted the office established procedures to identify and convey such information to the FBI. The FBI's counterintelligence division met with the office regularly for that purpose for most of the office's tenure. For more than the past year, the FBI also embedded personnel at the office who did not work on the special counsel's investigation, but whose purpose was to review the results of the investigation and to send in writing summaries of foreign intelligence and counterintelligence information to FBI HQ and FBI field offices. These communications and other correspondence between the office and the FBI contain information derived from the investigation, not all of which is contained in this volume. This volume is a summary. It contains, in the office's judgment, that information necessary to account for the special counsel's prosecution and declination decisions, and to describe the investigation's main factual results. The first form of Russian election influence came principally from the Internet Research Agency, LLC-IRA, a Russian organization funded by Yevgeny Viktorovich Prigozhin and companies he controlled, including Concord Management and Consulting, LLC, and Concord Catering, collectively Concord. The IRA conducted social media operations targeted at large U.S. audiences with the goal of sowing discord in the U.S. political system. These operations constituted active measures, a term that typically refers to operations conducted by Russian security services aimed at influencing the course of international affairs. The IRA and its employees began operations targeting the United States as early as 2014. Using fictitious U.S. personas, IRA employees operated social media accounts and group pages designed to attract U.S. audiences. These groups and accounts, which address divisive U.S. political and social issues, falsely claimed to be controlled by U.S. activists. Over time, these social media accounts became a means to reach large U.S. audiences. IRA employees traveled to the United States in mid-2014 on an intelligence gathering mission to obtain information and photographs for use in their social media posts. IRA employees posted derogatory information about a number of candidates in the 2016 U.S. presidential election. By early to mid-2016, IRA operations included supporting the Trump campaign and disparaging candidate Hillary Clinton. The IRA made various expenditures to carry out these activities, including buying political advertisements on social media in the names of U.S. persons and entities. Some IRA employees posing as U.S. persons and without revealing their Russian association communicated electronically with individuals associated with the Trump campaign and with other political activists to seek to coordinate political activities, including the staging of political rallies. The investigation did not identify evidence that any U.S. persons knowingly or intentionally coordinated with the IRA's interference operation. By the end of the 2016 U.S. election, the IRA had the ability to reach millions of U.S. persons through their social media accounts. Multiple IRA-controlled Facebook groups and Instagram accounts had hundreds of thousands of U.S. participants. IRA-controlled Twitter accounts separately had tens of thousands of followers, including multiple U.S. political figures who retweeted IRA-created content. In November 2017, a Facebook representative testified that Facebook had identified 470 IRA-controlled Facebook accounts that collectively made 80,000 posts between January 2015 and August 2017. Facebook estimated the IRA reached as many as 126 million persons through its Facebook accounts. In January 2018, Twitter announced that it had identified 3,814 IRA-controlled Twitter accounts and notified approximately 1.4 million people Twitter believed may have been in contact with the IRA-controlled account. A, structure of the Internet Research Agency. Redacted. The organization quickly grew. Redacted. The growth of the organization also led to more detailed organizational structure. Redacted. Redacted. Two individuals headed the IRA's management, its General Director, Mikhail Bistrov, and its Executive Director, Mikhail Burchik. Redacted. As early as the spring of 2014, the IRA began to hide its funding and activities. Redacted. The IRA's U.S. operations are part of a larger set of interlocking operations known as Project Lachta. Redacted. B, funding and oversight from Concord and Prigozhin. Until at least February 2018, Yevgeny Viktorovich Prigozhin and two Concord companies funded the IRA. Prigozhin is a wealthy Russian businessman who served as the head of Concord. Redacted. Prigozhin was sanctioned by the U.S. Treasury Department in December 2016. Redacted. Numerous media sources have reported on Prigozhin's ties to Putin, and the two have appeared together in public photographs. Redacted. 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 Redacted, 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 redacted. IRA employees were aware that Prigozhin was involved in the IRA's U.S. operations. Redacted. In May 2016, IRA employees claiming to be U.S. social activists and administrators of Facebook groups recruited U.S. persons to hold signs, including one in the front of the White House that read, Happy 55th birthday, dear boss, as an homage to Prigozhin, whose 55th birthday was on June 1st, 2016. Redacted, redacted. C, the IRA targets U.S. elections. 1, the IRA ramps up U.S. operations as early as 2014. The IRA's U.S. operations sought to influence public opinion through online media and forums. By the spring of 2014, the IRA began to consolidate U.S. operations within a single general department known internally as the Translator Department. Redacted. IRA subdivided the Translator Department into different responsibilities, ranging from operations on different social media platforms to analytics, to graphics and IT. Redacted, redacted. Redacted, 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 redacted. IRA employees also traveled to the United States on intelligence gathering missions. In June 2014, 4 IRA employees applied to the U.S. Department of State to enter the United States, while lying about the purpose of their trip and claiming to be 4 friends who had met at a party. Ultimately, 2 IRA employees, Anna Bogacheva and Alexandra Krylova, received visas and entered the United States on June 4, 2014. Prior to traveling, Krylova and Bogacheva compiled itineraries and instructions for the trip. Redacted. Redacted. 2, U.S. operations through IRA-controlled social media accounts. Dozens of IRA employees were responsible for operating accounts and personas on different U.S. social media platforms. The IRA referred to employees assigned to operate their social media accounts as, quote, specialists. Starting as early as 2014, the IRA's U.S. operations included social media specialists focusing on Facebook, YouTube, and Twitter. The IRA later added specialists who operated on Tumblr and Instagram accounts. Initially, the IRA created social media accounts that pretended to be the personal accounts of U.S. persons. By early 2015, the IRA began to create larger social media groups or public social media pages that claimed falsely to be affiliated with U.S. political and grassroots organizations. In certain cases, the IRA created accounts that mimicked real U.S. organizations. For example, one IRA-controlled Twitter account at 10 GOP purported to be connected to the Tennessee Republican Party. More commonly, the IRA created accounts in the names of fictitious U.S. organizations and grassroots groups and used these accounts to pose as anti-immigration groups, Tea Party activists, Black Lives Matter protesters, and other U.S. social and political activists. The IRA closely monitored the activity of its social media accounts. Redacted, redacted, redacted. By February 2016, internal IRA documents referred to support for the Trump campaign in opposition to candidate Clinton. For example, redacted, directions to IRA operators, redacted. Main idea, use any opportunity to criticize Hillary Clinton and the rest except Sanders and Trump. We support them. Redacted. The focus on the U.S. presidential campaign continued throughout 2016. In redacted 2016, internal redacted, reviewing the IRA-controlled Facebook group Secured Borders, the author criticized the lower number of posts dedicated to criticizing Hillary Clinton and reminded the Facebook specialists it is imperative to intensify criticism in criticizing Hillary Clinton. IRA employees also acknowledged that their work focused on influencing the U.S. presidential election. Redacted. 3, U.S. operations through Facebook. Many IRA operations use Facebook accounts created and operated by its specialists. Redacted, 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 redacted. IRA Facebook groups active during the 2016 campaign covered a range of political issues and included purported conservative groups with names such as Being Patriotic, Stop All Immigrants, Secured Borders, and Tea Party News, purported black social justice groups, Black America, Black Matters, Blacktivist, and Don't Shoot Us, LGBTQ groups, LGBT United, and religious groups, United Muslims of America. Throughout 2016, IRA accounts published an increasing number of materials supporting the Trump campaign and opposing the Clinton campaign. For example, on May 31st, 2016, the operational account Matt Skyber began to privately message dozens of pro-Trump Facebook groups asking them to help plan a pro-Trump rally near Trump Tower. To reach larger U.S. audiences, the IRA purchased advertisements from Facebook that promised the IRA groups that promoted the IRA groups on the news feeds of U.S. audience members. According to Facebook, the IRA purchased over 3,500 advertisements, and the expenditures totaled approximately $100,000. During the U.S. presidential campaign, many IRA purchased advertisements explicitly supported or opposed the presidential candidate or promoted U.S. rallies organized by the IRA, discussed below. As early as March 2016, the IRA purchased advertisements that overtly opposed the Clinton campaign. For example, on March 18, 2016, the IRA purchased an advertisement depicting candidate Clinton and a caption that read in part, quote, "If one day God lets this liar into the White House as the president, that day would be a real national tragedy," close quote. Similarly, on April 6, 2016, the IRA purchased advertisements for its account Black Matters, calling for a flash mob of U.S. persons to, quote, to take a photo with Hillary Clinton or prison 2016 or no Hillary 2016. IRA purchased advertisements featuring Clinton were, with very few exceptions, negative. IRA purchased advertisements referencing candidate Trump largely supported his campaign. The first known IRA advertisement explicitly endorsing the Trump campaign was purchased on April 19, 2016. The IRA bought an advertisement for its Instagram account, quote, Tea Party News, close quote, asking U.S. persons to help them, quote, make a patriotic team of young Trump supporters by uploading photos with the hashtag Kids for Trump. In subsequent months, the IRA purchased dozens of advertisements supporting the Trump campaign, predominantly through the Facebook groups Being Patriotic, Stop All Invaders, and Secured Borders. Collectively, the IRA's social media accounts reach tens of millions of U.S. persons. Individual IRA social media accounts attracted hundreds of thousands of followers. For example, at the time they were deactivated by Facebook in mid-2017, the IRA's United Muslims of America Facebook group had over 300,000 followers. The Don't Shoot Us Facebook group had over 250,000 followers. The Being Patriotic Facebook group had over 200,000 followers, and the Secured Borders Facebook group had over 130,000 followers. According to Facebook, in total, the IRA-controlled accounts made over 80,000 posts before their deactivation in August 2017. And these posts reached at least 29 million U.S. persons and may have reached an estimated 126 million people. 4, U.S. operations through Twitter. A number of IRA employees assigned to the translator department served as Twitter specialists. Redacted. The IRA's Twitter operations involved two strategies. First, IRA specialists operated certain Twitter accounts to create individual U.S. personas. Redacted. Separately, the IRA operated a network of automated Twitter accounts, commonly referred to as a bot network, that enabled the IRA to amplify existing content on Twitter. A, individualized accounts. Redacted. The IRA operated individualized Twitter accounts similar to the operation of its Facebook accounts by continuously posting original content to the accounts while also communicating with U.S. Twitter users directly through public tweeting or Twitter's private messaging. The IRA used many of these accounts to attempt to influence U.S. audiences on the election. Individualized accounts used to influence the U.S. presidential election included hashtag 10GOP, described above, hashtag Jen Abrams, claiming to be a Virginian Trump supporter with 70,000 followers, hashtag Pamela Moore 13, claiming to be a Texan Trump supporter with 70,000 followers, and hashtag America First, an anti-immigration persona with 24,000 followers. In May 2016, the IRA created the Twitter accounts hashtag March for Trump, which promoted IRA-organized rallies in support of the Trump campaign baseball team. Where was it? Using these accounts and others, the IRA provoked reactions from users in the media. Multiple IRA-posted tweets gained popularity. U.S. media outlets also quoted tweets from IRA-controlled accounts and attributed them to the reactions of real U.S. persons. Similarly, numerous high-profile U.S. persons, including former Ambassador Michael McFaul, Roger Stone, Sean Hannity, and Michael Flynn Jr., retweeted or responded to tweets posted to these IRA-controlled accounts. Multiple individuals affiliated with the Trump campaign also promoted IRA tweets, discussed below. B, IRA botnet activities. Redacted, redacted, redacted. In January 2018, Twitter publicly identified 3,814 Twitter accounts associated with the IRA. According to Twitter, in the 10 weeks before the 2016 U.S. presidential election, these accounts posted approximately 175,993 tweets. Quote, approximately 8.4% of which were election-related, close quote. Twitter also announced that it had notified approximately 1.4 million people who Twitter believed may have been in contact with an IRA-controlled account. 5, U.S. operations involving political rallies. The IRA organized and promoted political rallies inside the United States while posing as U.S. grassroots activists. First, the IRA used one of its pre-existing social media personas, Facebook groups and Twitter accounts, for example, to announce and promote the event. The IRA then sent a large number of direct messages to followers of its social media account, asking them to attend the event. From those who responded with interest in attending, the IRA then sought a U.S. person to serve as the event's coordinator. In most cases, the IRA account operator would tell the U.S. person that they personally could not attend the event due to some pre-existing conflict, or because they were somewhere else in the United States. The IRA then further promoted the event by contacting U.S. media about the event and directing them to speak with the coordinator. And after the event, the IRA posted videos and photographs of the event to the IRA's social media accounts.
The office identified dozens of U.S. rallies organized by the IRA. The earliest evidence of a rally was a, quote, Confederate rally, unquote, in November of 2015. The IRA continued to organize rallies even after the 2016 U.S. presidential election. The attendance at rallies varied. Some rallies appeared to have drawn few, if any, participants, while others drew hundreds. The reach and success of these rallies was closely monitored. And then there's a section deleted, harm to ongoing matter. And then the next page is also entitled harm to ongoing matter. Then at the top of page 31, from June 2016 until the end of the presidential campaign, almost all of the U.S. rallies organized by the IRA focused on the U.S. election, often promoting the Trump campaign and opposing the Clinton campaign. Pro-Trump rallies included 3 in New York, a series of pro-Trump rallies in Florida in August 2016, and a series of pro-Trump rallies in October 2016 in Pennsylvania. The Florida rallies drew the attention of the Trump campaign, which posted about the Miami rally on candidate Trump's Facebook account, as discussed below. Many of the same IRA employees who oversaw the IRA's social media accounts also conducted the day-to-day recruiting for political rallies inside the United States. And the next section is deleted, harm to ongoing matter. 6, targeting and recruitment of U.S. persons. As early as 2014, the IRA instructed its employees to target U.S. persons who could be used to advance its operational goals. Initially, recruitment focused on U.S. persons who could amplify the content posted by the IRA. And the next 2 parts are deleted, indicating harm to ongoing matter. IRA employees frequently used, and then this section deleted, investigative technique, and then it continues with Twitter, Facebook, and Instagram to contact and recruit U.S. persons who followed the group. The IRA recruited U.S. persons from across the political spectrum. For example, the IRA targeted the family of, and then there are a couple of words deleted, indicating personal privacy, and a number of black social justice activists, while posing as a grassroots group called, quote, Black Matters US. In February 2017, the persona, quote, Black Fist, unquote, purporting to want to teach African Americans to protect themselves when contacted by law enforcement, hired a self-defense instructor in New York to offer classes sponsored by Black Fist. The IRA also recruited moderators of, the IRA also recruited moderators of conservative social media groups to promote IRA-generated content, as well as recruited individuals to perform political acts, such as walking around New York City dressed up as Santa Claus with a Trump mask. Then the next 3 sections are harm to ongoing matter, and it picks up. As the IRA's online audience became larger, the IRA tracked U.S. persons with whom they communicated and had successfully tasked with tasks ranging from organizing rallies on, to taking pictures with certain political messages. And then it continues with harm to ongoing matter.
Picking up at the top of page 33, there's a large redacted section. And number 7, interactions and contacts with the Trump campaign. The investigation identified 2 different forms of connections between the IRA and members of the Trump campaign. The investigation identified no similar connections between the IRA and the Clinton campaign. First, on multiple occasions, members and surrogates of the Trump campaign promoted, typically by linking, retweeting, or similar methods of reposting, pro-Trump or anti-Clinton content published by the IRA through IRA-controlled social media accounts. Additionally, in a few instances, IRA employees represented themselves as U.S. persons to communicate with members of the Trump campaign in an effort to seek assistance and coordination on IRA-organized political rallies inside the United States. Section A, Trump campaign promotion of IRA political materials. Among the U.S. leaders of public opinion targeted by the IRA were various members and surrogates of the Trump campaign. In total, Trump campaign affiliates promoted dozens of tweets, posts, and other political content created by the IRA. Posts from the IRA-controlled Twitter account @10GOP were cited or retweeted by multiple Trump campaign officials and surrogates, including Donald J. Trump Jr., Eric Trump, Kellyanne Conway, Brad Parscale, and Michael T. Flynn. These posts included allegations of voter fraud, as well as allegations that Secretary Clinton had mishandled classified information. A November 7, 2016 post from the IRA-controlled Twitter account @PamelaMoore13 was retweeted by Donald J. Trump Jr. On September 19, 2017, President Trump's personal account @RealDonaldTrump responded to a tweet from the IRA-controlled account @10GOP, the backup account of uppercase @10GOP, which had already been deactivated by Twitter. The tweet read, "We love you, Mr. President." IRA employees monitored the reaction of the Trump campaign and later Trump administration officials to their tweets. For example, on August 23, 2016, the IRA-controlled persona Matt Skyber Facebook account sent a message to a U.S. Tea Party activist writing that Mr. Trump posted about our event in Miami. This is great. The IRA employee included a screenshot of candidate Trump's Facebook account, which included a post about the August 20, 2016 political rallies organized by the IRA. Then there's a redacted section. Section B, contact with Trump campaign officials in connection with rallies. Starting in June 2016, the IRA contacted different U.S. persons affiliated with the Trump campaign in an effort to coordinate pro-Trump IRA-organized rallies inside the United States. In all cases, the IRA contacted the campaign while claiming to be U.S. political activists working on behalf of a conservative grassroots organization. The IRA's contacts included requests for signs and other materials to use at rallies, as well as requests to promote the rallies and help coordinate logistics. While certain campaign volunteers agreed to provide the requested support, for example, agreeing to set aside a number of signs, the investigation has not identified evidence that any Trump campaign official understood the requests were coming from foreign nationals. In sum, the investigation established that Russia interfered in the 2016 presidential election through the active measures social media campaign carried out by the IRA an organization funded by Prigozhin and companies that he controlled. As explained further in Volume 1, Section 5A, the office concluded, and a grand jury has alleged, that Prigozhin, his companies, and IRA employees violated U.S. law through these operations, principally by undermining through deceptive acts the work of federal agencies charged with regulating foreign influence in U.S. elections. Section 3, Russian hacking and dumping operations. Beginning in March 2016, units of the Russian Federation's main intelligence directorate of the General Staff, the GRU, hacked the computers and email accounts of organizations, employees, and volunteers supporting the Clinton campaign, including the email account of campaign chairman John Podesta. Starting in April 2016, the GRU hacked into the computer networks of the Democratic Congressional Committee and the Democratic National Committee. The GRU targeted hundreds of email accounts used by Clinton campaign employees, advisors, and volunteers. In total, the GRU stole hundreds of thousands of documents from the compromised email accounts and networks. The GRU later released stolen Clinton campaign and DNC documents through online personas DC Leaks and Guccifer 2.0, and later through the organization WikiLeaks. The release of the documents was designed and timed to interfere with the 2016 U.S. presidential campaign and to undermine the Clinton campaign. The Trump campaign showed interest in the WikiLeaks releases, and in the summer and fall of 2016, there's a redacted portion. WikiLeaks' first Clinton-related release, redacted, the Trump campaign stayed in contact, redacted, about WikiLeaks activities. The investigation was unable to resolve, redacted, WikiLeaks' release of the stolen Podesta emails on October 7, 2016. The same day a video from years earlier was published of Trump using graphic language about women. Section A, GRU hacking directed at the Clinton campaign. Number 1, GRU units target the Clinton campaign. 2 military units of the GRU carried out the computer intrusions into the Clinton campaign, DNC, and DCCC, military units 26165 and 74455. Military Unit 26165 is a GRU cyber unit dedicated to targeting military, political, governmental, and non-governmental organizations outside of Russia, including in the United States. The unit was subdivided into departments with different specialties. One department, for example, developed specialized malicious software or malware, while another department conducted large-scale spear phishing campaigns. There's a redaction. A Bitcoin mining operation to secure used to purchase computer infrastructure and used in hacking operations. Military Unit 74455 is a related GRU unit with multiple departments that engaged in cyber operations. Unit 74455 assisted in the release of documents stolen by Unit 26165, the promotion of those releases, and the publication of anti-Clinton content on social media accounts operated by the GRU. Officers from Unit 74455 separately hacked computers belonging to state boards of elections, secretaries of state, and U.S. companies that supplied software and other technology related to the administration of U.S. elections. Beginning in mid-March 2016, Unit 26165 had primary responsibility for hacking the DCCC and DNC, as well as email accounts of individuals affiliated with the Clinton campaign. Unit 26165 used something redacted to learn about something redacted, different Democratic websites, including Democrats.org, HillaryClinton.com, DNC.org, and DCCC.org. Further redaction. Began before the GRU had obtained any credentials or gained access to these networks, indicating that the later DCCC and DNC intrusions were not crimes of opportunity, but rather the result of targeting. GRU officers also sent hundreds of spear phishing emails to the work and personal email accounts of Clinton campaign employees and volunteers. Between May 10, 2016 and March 15, 2016, Unit 26165 appears to have sent approximately 90 spear phishing emails to email accounts at HillaryClinton.com. Starting on March 15, 2016, the GRU began targeting Google email accounts used by Clinton campaign employees, along with a smaller number of DNC.org email accounts. The GRU's spear phishing operation enabled it to gain access to numerous email accounts of Clinton campaign employees and volunteers, including campaign chairman John Podesta, junior volunteers assigned to the Clinton campaign's advance team, informal Clinton campaign advisors, and a DNC employee. GRU officers stole tens of thousands of emails from spear phishing victims, including various Clinton campaign-related communications. Number 2, intrusions into the DCCC and DNC networks. A, initial access. By no later than April 12, 2016, the GRU had gained access to the DCCC computer network using the credentials stolen from a DCCC employee who had been successfully spear phished the week before. Over the ensuing weeks, the GRU traversed the network, identifying different computers connected to the DCCC network. By stealing network access credentials along the way, including those of IT administrators with unrestricted access to the system, the GRU compromised approximately 29 different computers on the DCCC network. Approximately 6 days after the first hacking into the DCCC network, on April 18, 2016, GRU officers gained access to the DNC network via a virtual private network connection between the DCCC and DNC networks. Between April 18, 2016 and June 8, 2016, Unit 26165 compromised more than 30 computers on the DNC network, including the DNC mail server and shared file server. Section B, implantation of malware on DCCC and DNC networks. Unit 26165 implanted on the DCCC and DNC networks 2 types of customized malware, known as X-Agent and X-Tunnel. Mimikatz, a credential harvesting tool, and RAR.exe, RAR.exe, a tool used in these intrusions to compile and compress materials for exfiltration. X-Agent was a multifunction hacking tool that allowed Unit 26165 to log keystrokes, take screenshots, and gather other data about the infected computers, such as file directories and operating systems. X-Tunnel was a hacking tool that created an encrypted connection between the victim, DCCC DNC computers, and the GRU-controlled computers outside the DCCC and DNC networks that was capable of large-scale data transfers. GRU officers then used X-Tunnel to exfiltrate stolen data from the victim computers. To operate X-Agent and X-Tunnel on the DCCC and DNC networks, Unit 26165 officers set up a group of computers outside those networks to communicate with the implanted malware. The first set of GRU-controlled computers, known by the GRU as middle servers, sent and received messages to and from malware on the DNC DCCC networks. The middle servers, in turn, relayed messages to a second set of GRU-controlled computers, labeled internally by the GRU as an AMS panel. The AMS panel, redaction, served as a nerve center through which GRU officers monitored and directed the malware's operations on the DNC DCCC networks. The AMS panel used to control X-Agent during the DCCC and DNC intrusions was housed on a leased computer located near, redaction, Arizona. Then there's further redactions. The Arizona-based AMS panel also stored thousands of files containing key logging sessions captured through X-Agent. These sessions were captured as GRU officers monitored DCCC and DNC employees' work on infected computers regularly between April 2016 and June 2016. Data captured in these key logging sessions included passwords, internal communications between employees, banking information, and sensitive personal information. Section C, theft of documents from DNC and DCCC networks. Officers from Unit 26165 stole thousands of documents from the DCCC and DNC networks, including significant amounts of data pertaining to the 2016 U.S. federal elections. Stolen documents included internal strategy documents, fundraising data, opposition research, and emails from the work inboxes of DNC employees. The GRU began stealing DCCC data shortly after it gained access to the network. On April 14, 2016, approximately 3 days after the initial intrusion, GRU officers downloaded RAR.exe onto the DCCC's document server. On the following day, the GRU searched one compromised DCCC computer for files containing search items that included Hillary, DNC, Cruz, and Trump. On April 25, 2016, the GRU collected and compressed PDF and Microsoft documents from folders on the DCCC's shared file server that pertain to the 2016 election. The GRE appears to have compressed and exfiltrated over 70 gigabytes of data from this file server. The GRU also stole documents from the DNC network shortly after gaining access. On April 22, 2016, the GRU copied files from the DNC network to GRU-controlled computers. Stolen documents included the DNC's opposition research into candidate Trump. Between approximately May 25, 2016 and June 1, 2016, GRU officers accessed the DNC's mail server from a GRU-controlled computer leased inside the United States. During these connections, Unit 26165 officers appear to have stolen thousands of emails and attachments, which were later released by WikiLeaks in July 2016. Section B, dissemination of the hacked materials. The GRU's operations extended beyond stealing materials and included releasing documents stolen from the Clinton campaign and its supporters. The GRU carried out the anonymous release through two fictitious online personas that it created, DC Leaks and Guccifer 2.0, and later through the organization WikiLeaks. Number one, DC Leaks. The GRU began planning the releases at least as early as April 19, 2016, when Unit 26165 registered the domain dcleaks.com through a service that anonymized the registrant. Unit 26165 paid for the registration using a pool of Bitcoin that it had mined. The dcleaks.com landing page pointed to different tranches of stolen documents arranged by victim or subject matter. Other dcleaks.com pages contained indices of the stolen materials that were being released, bearing the sender, recipient, and date of the email. To control access and timing of releases, pages were sometimes password protected for a period of time and later made unrestricted to the public. Starting in June 2016, the GRU posted stolen documents onto the website dcleaks.com, including documents stolen from a number of individuals associated with the Clinton campaign. These documents appear to have originated from personal email accounts, in particular Google and Microsoft accounts, rather than the DNC and DCCC computer networks. DC Leaks victims included an advisor to the Clinton campaign, a former DNC employee, and Clinton campaign employee, and 4 other campaign volunteers. The GRU released through dcleaks.com thousands of documents, including personal, identifying, and financial information, internal correspondence related to the Clinton campaign and prior political jobs, and fundraising files and information. GRU officers operated a Facebook page under the DC Leaks moniker, which they primarily used to promote releases of materials. The Facebook page was administered through a small number of pre-existing GRU-controlled Facebook accounts. GRU officers also used the DC Leaks Facebook account, the Twitter account @DCLeaks, and the email account dcleaksproject@gmail.com to communicate privately with reporters and other U.S. persons. GRU officers using the DC Leaks persona gave certain reporters early access to our archives of leaked files by sending them links and passwords to pages on the DC Leaks website that had not yet become public. For example, on June 14, 2016, GRU officers operating under the DC Leaks persona sent a link and password for a non-public DC Leaks web page to a U.S. reporter via the Facebook account. Similarly, on September 14, 2016, GRU officers sent reporters Twitter direct messages from @DCLeaks with a password to another non-public part of the dcleaks.com website. The dcleaks.com website remained operational and public until March 2017. Number 2, Guccifer 2.0. On June 14, 2016, the DNC and its cyber response team announced the breach of the DNC network and the suspected theft of DNC documents. In the statements, the cyber response team alleged that the Russian state-sponsored actors, which they referred to as Fancy Bear, were responsible for the breach. Apparently, in response to that announcement on June 15, 2016, GRU officers using the persona Guccifer 2.0 created a WordPress blog. In the hours leading up to the launch of the WordPress blog, GRU officers logged into a Moscow-based server used and managed by Unit 74455, and searched for a number of specific words and phrases in English, including some hundred sheets, Illuminati, and worldwide known. Approximately 2 hours after the last of those searches, Guccifer 2.0 published its first post, attributing the DNC server hack to a lone Romanian hacker and using several of the unique English words and phrases that the GRU officers had searched for that day. That same day, June 15, 2016, the GRU also used the Guccifer 2.0 WordPress blog to begin releasing to the public documents stolen from the DNC and DCCC computer networks. The Guccifer 2.0 persona ultimately released thousands of documents stolen from the DNC and DCCC in a series of blog posts between June 15, 2016 and October 18, 2016. Released documents included opposition research performed by the DNC, including a memorandum analyzing potential criticisms of candidate Trump, internal policy documents such as recommendations on how to address politically sensitive issues, analyses of specific congressional races, and fundraising documents. Releases were organized around thematic issues such as specific states, e.g. Florida and Pennsylvania, that were perceived as competitive in the 2016 U.S. presidential election. Beginning in late June 2016, the GRU also used the Guccifer 2.0 persona to release documents directly to reporters and other interested individuals. Specifically, on June 27, 2016, Guccifer 2.0 sent an email to the news outlet The Smoking Gun, offering to provide exclusive access to some leaked emails linked to Hillary Clinton's staff. The GRU later sent the reporter a password and link to a locked portion of the DCleaks.com website that contained an archive of emails stolen by Unit 26165 from a Clinton campaign volunteer in March 2016. That the Guccifer 2.0 persona provided reporters access to a restricted portion of the DC Leaks website tends to indicate that both personas were operated by the same or a closely related group of people. The GRU continued its release efforts through Guccifer 2.0 into August 2016. For example, on August 15, 2016, the Guccifer 2.0 persona sent a candidate for the U.S. Congress documents related to the candidate's opponent. On August 22, 2016, the Guccifer 2.0 persona transferred approximately 2.5 gigabytes of Florida-related data stolen from the DCCC to a U.S. blogger covering Florida politics. On October 22, 2016, the Guccifer 2.0 persona sent a U.S. reporter document stolen from the DCCC pertaining to the Black Lives Matter movement. The GRU was also in contact through the Guccifer 2.0 persona with Redacted, a former Trump campaign member. Further redactions. In early August 2016, Redacted Twitter's suspension of the Guccifer 2.0 Twitter account. After it was reinstated, GRU officers posing as Guccifer 2.0 wrote, Redacted, via private message, "Thank you for writing back. Do you find anything interesting in the docs I posted?" On August 17, 2016, the GRU added, "Please tell me if I can help you anyhow. It would be a great pleasure to me." On September 9, 2016, the GRU, again posting as Guccifer 2.0, referred to a stolen DCCC document posted online and asked Redacted, "What do you think of the info on the turnout model for the Democrats' entire presidential campaign?" Redacted responded, "Pretty standard." The investigation did not identify evidence of other communications between Redacted and Guccifer 2.0. Number 3, the use of WikiLeaks. In order to expand its interference in the 2016 U.S. presidential election, the GRU units transferred many of the documents they stole from the DNC and the chairman of the Clinton campaign to WikiLeaks. GRU officers used both the DC Leaks and Guccifer 2.0 personas to communicate with WikiLeaks through Twitter private messaging and through encrypted channels, including, possibly, through WikiLeaks' private communication system. Section A. WikiLeaks expressed opposition toward the Clinton campaign. WikiLeaks, and particularly its founder, Julian Assange, privately expressed opposition to candidate Clinton well before the first release of stolen documents. In November 2015, Assange wrote to other members and associates of WikiLeaks that, "We believe it would be much better for GOP to win. Dems plus media plus liberals would then form a bloc to rein in their worst qualities. With Hillary in charge, GOP will be pushing for her worst qualities. Dems plus media plus neoliberals will be mute. She's a bright, well-connected, sadistic sociopath. In March 2016, WikiLeaks released a searchable archive of approximately 30,000 Clinton emails that had been obtained through Freedom of Information Act litigation. While designing the archive, one WikiLeaks member explained the reason for building the archive to another associate. "We want this repository to become the place to search for background on Hillary's plotting at the State Department during 2009 to 2013. Firstly, because it's useful and will annoy Hillary, but second, because we want to be seen to be a resource or player in the US election, because it may encourage people to send us even more important links." Section B, WikiLeaks' first contact with Guccifer 2.0 and DC Leaks. Shortly after the GRU's first release of stolen documents through dcleaks.com in June 2016, GRU officers also used the DC Leaks persona to contact WikiLeaks about possible coordination in the future release of stolen emails. On June 14, 2016, @DC Leaks sent a direct message to WikiLeaks noting, "You announced your organization was preparing to publish more Hillary's emails. We're ready to support you. We have some sensitive information too, in particular, her financial documents. Let's do it together. What do you think about publishing our info at the same moment? Thank you." And then there's some redaction. Around the same time, WikiLeaks initiated communications with the GRU persona Guccifer 2.0 shortly after it was used to release documents stolen from the DNC. On June 22, 2016, 7 days after Guccifer 2.0's first release of stolen DNC documents, WikiLeaks used Twitter's direct message function to contact the Guccifer 2.0 Twitter account and suggest that Guccifer 2.0 send any new material stolen from the DNC here for us to review, and it will have a much higher impact than what you're doing. On July 6, 2016, WikiLeaks again contacted Guccifer 2.0 through Twitter's private messaging function, writing, "If you have anything Hillary-related, we want it in the next 2 days, preferable, because the DNC is approaching and she will solidify Bernie supporters behind her after." The Guccifer 2.0 persona responded, "Okay, I see." WikiLeaks also explained, "We think Trump has only a 25% chance of winning against Hillary, so conflict between Bernie and Hillary is interesting." Section C, the GRU's transfer of stolen materials to WikiLeaks. Both the GRU and WikiLeaks sought to hide their communications, which has limited the office's ability to collect all of the communications between them. Thus, although it is clear that the stolen DNC and Podesta documents were transferred from the GRU to WikiLeaks, and then there's a redacted portion. The office was able to identify when the GRU, operating through its personas Guccifer 2.0 and DC Leaks, transferred some of the stolen documents to WikiLeaks through online archives set up by the GRU. Assange had access to the internet from the Ecuadorian embassy in London, England. And then there's the redacted portion. On July 14, 2016, GRU officers used a Guccifer 2.0 email account to send WikiLeaks an email bearing the subject "Big Archive" and the message "A New Attempt." The email contained an encrypted attachment with the name WCDNC Link 1 TXT GPG. Using the Guccifer 2.0 account, GRU officers sent WikiLeaks an encrypted file and instructions on how to open it. On July 18, 2016, WikiLeaks confirmed in a direct message to the Guccifer 2.0 account that it had the 1 gigabyte or so archive and would make a release of stolen documents this week. On July 22, 2016, WikiLeaks released over 20,000 emails and other documents stolen from the DNC computer networks. The Democratic National Convention began 3 days later. Similar communications occurred between WikiLeaks and the GRU-operated persona DC Leaks. On September 15, 2016, DC Leaks wrote to @WikiLeaks, "Hi there, I'm from DC Leaks. How could we discuss some submission-related issues? I'm trying to reach out to you via your secured chat, but getting no response. I've got something that might interest you. You won't be disappointed, I promise." The WikiLeaks account responded, "Hi there," without further elaboration. The DC Leaks account did not respond immediately. The same day, the Twitter account @Guccifer2 sent @DC Leaks a direct message, which is the first known contact between the personas. During subsequent communications, the Guccifer 2.0 persona informed DC Leaks that WikiLeaks was trying to contact DC Leaks and arrange for a way to speak through encrypted emails. An analysis of the metadata collected from the WikiLeaks site revealed that the stolen Podesta emails show a creation date of September 19, 2016. Based on information about Assange's computer and its possible operating system, this date may be when the GRU staged the stolen Podesta emails for transfer to WikiLeaks, as the GRU had previously done in July 2016 for the DNC emails. The WikiLeaks site also released PDFs and other documents taken from Podesta that were attachments to emails in his account. These documents had a creation date of October 2, 2016, which appears to be the date the attachments were separately staged by WikiLeaks on its site. Beginning on September 20th, 2016, WikiLeaks and DC Leaks resumed communications in a brief exchange. On September 22, 2016, a DC Leaks email account, dcleaksproject@gmail.com, sent an email to a WikiLeaks account with the subject submission and the message, "Hi from DC Leaks." The email contained a PGP encrypted message with the file name Wikimail text GPG. Then there's a redaction. The email, however, bears a number of similarities to the July 14, 2016 email in which GRU officers used the Guccifer 2.0 persona to give WikiLeaks access to the archive of DNC files. On September 22, 2016, the same day of DC Leaks' email to WikiLeaks, the Twitter account @DCLeaks sent a single message to @WikiLeaks with the string of characters, and then there's a redaction. The office cannot rule out that stolen documents were transferred to WikiLeaks through intermediaries who visited during the summer of 2016. For example, public reporting identified Andrew Müller-Bericht as a WikiLeaks associate who may have assisted with the transfer of those stolen documents to WikiLeaks. And then there's further redaction. On October 7, 2016, WikiLeaks released the first email stolen from the Podesta email account. In total, WikiLeaks released 33 tranches of stolen emails between October 7, 2016 and November 7, 2016. The releases included private speeches given by Clinton, internal communications between Podesta and other high-ranking members of the Clinton campaign, and correspondence related to the Clinton Foundation. In total, WikiLeaks released over 50,000 documents stolen from Podesta's personal email account. The last in-time email released from Podesta's account was dated March 21, 2016, 2 days after Podesta received a spear-phishing email sent by the GRU. Section D, WikiLeaks statements dissembling about the source of stolen materials. As reports attributing the DNC and DCCC hacks to the Russian government emerged, WikiLeaks and Assange made several public statements apparently designed to obscure the source of the materials that WikiLeaks was releasing. The file transfer evidence described above and other information uncovered during the investigation discredit WikiLeaks' claims about the source of the material it posted. Beginning in the summer of 2016, Assange and WikiLeaks made a number of statements about Seth Rich, a former DNC staff member who was killed in July 2016. The statements about Rich implied falsely that he had been the source of the stolen DNC emails. On August 9, 2016, the @WikiLeaks Twitter account posted, "Announce, WikiLeaks has decided to issue a $20,000 reward for information leading to the conviction for the murder of DNC staffer Seth Rich." Likewise, on October 25, 2016, Assange was asked in an interview, "Why are you so interested in Seth Rich's killer?" and responded, "We're very interested in anything that might be a threat to alleged WikiLeaks sources." The interviewer responded to Assange's statement by commenting, "I know you don't want to reveal your source, but it certainly sounds like you're suggesting a man who leaked information to WikiLeaks was then murdered." Assange replied, "If there's someone who's potentially connected to our publication and that person has been murdered in suspicious circumstances, it doesn't necessarily mean that the two are connected, but it is a very serious matter. That type of allegation is very serious, as it's taken very seriously by us." After the U.S. intelligence community publicly announced its assessment that Russia was behind the hacking operation, Assange continued to deny that the Clinton materials released by WikiLeaks had come from Russian hacking. According to media reports, Assange told a U.S. congressman that the DNC hack was an inside job and purported to have physical proof that Russians did not give the materials to Assange. Section C, additional GRU cyber operations. While releasing the stolen emails and documents through DC Leaks, Guccifer 2.0, and WikiLeaks, GRU officers continued to target and hack victims' linked to the Democratic campaign and eventually to target entities responsible for election administration in several states. Number 1, summer and fall 2016 operations targeting Democratic-linked victims. On July 27, 2016, Unit 26165 targeted email accounts connected to candidate Clinton's personal office, redaction. Earlier that day, candidate Trump made public statements that included the following: Russia, if you're listening, I hope you're able to find the 30,000 emails that are missing. I think you will probably be rewarded mightily by our press. The 30,000 emails were apparently a reference to emails described in media accounts as having been stored on a personal server that candidate Clinton had used while serving as Secretary of State. Within approximately 5 hours of Trump's statement, GRU officers targeted for the first time Clinton's personal office. After candidate Trump's remarks, Unit 26165 created and sent malicious links targeting 15 email accounts at the domain redacted, including an email account belonging to Clinton aide, redacted. The investigation did not find evidence of earlier GRU attempts to compromise accounts hosted on this domain. It is unclear how the GRU was able to identify these email accounts, which were not public. Unit 26165 officers also hacked into a DNC account hosted on a cloud computing service, redacted. On September 20th, 2016, the GRU began to generate copies of the DNC data using a redacted function designed to allow users to produce backups of databases referred to redacted as snapshots. The GRU then stole those snapshots by moving them to redacted account that they controlled. From there, the copies were moved to GRU-controlled computers. The GRU stole approximately 300 gigabytes of data from the DNC cloud-based account.
Campaign, GRU officers also targeted individuals and entities involved in the administration of elections. Victims governments, as well target these victims through the elections in November 2016, while the investigation identified evidence that the GRU targeted these individuals and entities. The office did not investigate further. The office did not, for instance, obtain or examine servers or other relevant items belonging to these victims. The office understands that the FBI, the U.S. Department of Homeland Security, and the states have separately investigated the activity. By at least the summer of 2016, GRU officers sought access to state and local networks by exploiting known software vulnerabilities on websites of state and local entities. GRU officers, for example, targeted state and local databases of registered voters using a technique known as SOL injection, by which malicious code was sent to the state or local website in order to run commands such as exfiltrating the database contents. In one instance, in approximately June of 2016, the GRU compromised the computer network of the Illinois State Board of Elections by exploiting a vulnerability in the SBOE's website. The GRU then gained access to a database containing information on millions of registered Illinois voters and extracted data related to thousands of U.S. voters before the malicious activity was identified. GRU officers' investigative technique: scan state and local websites for vulnerabilities. For example, over a 2-day period in July 2016, GRU redacted investigative technique for vulnerabilities on websites of more than 24 states. Investigative techniques. It proceeds during the footnotes of investigative technique, investigative technique, investigative technique. Similar redacted for vulnerabilities continued through the election. Unit 74455 also sent spear-splishing emails to public officials involved in election administration and personnel at companies involved in voting technology. In August 2016, GRU officers targeted employees of Redacted, a voting technology company that develops software used by numerous U.S. counties to manage voter rolls, and installed malware on the company network. Similarly, in November 2016, the GRU sent spear-phishing emails to over 120 email accounts used by Florida county officials responsible for administering the 2016 U.S. elections. The spear-phishing emails contain an attached Word document coded with malicious software, commonly known or referred to as a Trojan, that permitted the GRU to access the infected computer. The FBI was separately responsible for this investigation. We understand the FBI believes that this operation enabled the GRU to gain access to the network of at least one Florida county government. The office did not independently verify that belief and, as explained above, did not undertake the investigative steps that would have been necessary to do so. D, Trump campaign and the dissemination of hacked materials. The Trump campaign showed interest in WikiLeaks releases of hacked materials throughout the summer and fall of 2016. Redacted, harm to ongoing matter. Redacted, HOM, harm to ongoing matter. Background, one and then A, background, and then redacted, harm to ongoing matter. Continuous redacted investigative matter. B, contacts with the campaign about WikiLeaks. Redacted, harm to ongoing matters. On June 12, 2016, Assange claimed in a televised interview to have emails related to Hillary Clinton, which are pending publication, but provided no additional context. In debriefing with the office, former Deputy Campaign Chairman Rick Gates said that redacted, harm to ongoing matters. Gates recalled candidate Trump being generally frustrated that the Clinton emails had not been found. Paul Manafort, who would later become campaign chairman, redacted, harm to ongoing matter. Redacted. Michael Cohen, former executive vice president of the Trump Organization and special counsel to Donald J. Trump, told the office that he recalled an incident in which he was in candidate Trump's office in the Trump Tower. Redacted, harm to ongoing matter. Cohen further told the office that after WikiLeaks' subsequent release of stolen DNC emails in July 2016, candidate Trump said to Cohen something to the effect of, redacted, harm to ongoing matter. Harm to ongoing matter, redacted. According to Gates, Manafort expressed excitement about the relief. Redacted, harm to ongoing matters. Manafort, for his part, told the office that shortly after WikiLeaks' July 22nd release, Manafort also spoke with candidate Trump. Redacted, harm to ongoing matter. Manafort also, redacted, harm to ongoing matter, wanted to keep apprised of any continuously redacted harm to ongoing matter throughout the footnotes, developments with WikiLeaks, and separately told Gates to keep in touch, redacted, harm to ongoing matters about future WikiLeaks releases. According to Gates, by the late summer of 2016, the Trump campaign was planning a press strategy, a communications campaign, and messaging based on the possible release of Clinton emails to WikiLeaks, redacted, harm to ongoing matters. While Trump and Gates were driving to LaGuardia Airport, redacted, harm to ongoing matters. Shortly after the call, candidate Trump told Gates that more releases of damaging information would be coming. Redacted, harm to ongoing matter. Redacted, harm to ongoing matter. Redacted, harm to ongoing matter. Corsi is an author who holds a doctorate in political science. In 2016, Corsi also worked for the media outlet World Net Daily. Redacted, harm to ongoing matter. Continue to redact throughout the footnotes. Harm to ongoing matter. Corsi told the office during the interviews that he must have previously discussed Assange with Malik. Previously was redacted, now it's redacted again, harm to ongoing matter. Grand jury, harm, redacted. According to Malik, Corsi asked him to put Corsi in touch with Assange, whom Corsi wishes to interview. Malik recalled that Corsi also suggested that individuals in the orbit of UK politician Nigel Farage might be able to contact Assange and ask him if Malik knew them. Malik told Corsi that he would think about the request, but made no actual attempt to connect Corsi with Assange. Redacted, harm to ongoing matters, redacted in footnotes. Malik stated to investigators that beginning in or about August 2016, he and Corsi had multiple FaceTime discussions about WikiLeaks, redacted, harm to ongoing matter, had made a connection to Assange, and that the hacked emails of John Podesta would be released prior to Election Day and would be helpful to the Trump campaign. In one conversation around August or September of 2016, Corsi told Malik that the release of the Podesta emails was coming, after which we were going to be in the driver's seat. Redacted, harm to ongoing matter, 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 redacted, 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 harm to ongoing matter, redacted, harm to ongoing matter, redacted, 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 harm to ongoing matter. On October 7th, 2016, 4 days after the Assange press conference, redacted, harm to ongoing matter, the Washington Post published an Access Hollywood video that captured comments by candidate Trump some years earlier that were expected to adversely affect the campaign. Less than an hour after the video's publication, WikiLeaks released the first set of emails stolen by the GRU from the account of Clinton campaign chairman John Podesta. Redacted, harm to ongoing matter. Redacted, harm to ongoing matter. Corsi said that because he had no direct means of communicating with WikiLeaks, he told members of the news site WND, who were participating on a conference call with him that day, to reach Assange immediately. Corsi claimed that the pressure was enormous. Redacted, ongoing matter. Redacted, harm to ongoing matter. And recalled telling the conference call the Access Hollywood tape was coming. Corsi said that he was convinced that his efforts had caused WikiLeaks to release the emails when they did. In a later November 2018 interview, Corsi said that he thought that he had told people on a WND conference call about the forthcoming tape and had sent out a tweet asking whether anyone would contact Assange, but then said that maybe he had done nothing. The office investigated Corsi's allegations about the events of October 7, 2016, but found little corroboration for his allegation about that day. Redacted, harm to ongoing matter. Redacted, harm to ongoing matter. However, the phone records themselves do not indicate that the conversation was with any of the reporters who broke the Access Hollywood story, and the office has not otherwise been able to identify the substance of the conversation. Redacted, harm to ongoing matter. However, the office has not identified any conference call participant or anyone who spoke to Corsi that day who says that they received non-public information about the tape from Corsi or acknowledge having contacted a member of WikiLeaks on October 7, 2016, after a conversation with Corsi. Donald Trump Jr. interaction with WikiLeaks. Donald Trump Jr. had direct electronic communication with WikiLeaks during the campaign period. On September 20, 2016, an individual named Jason Fishbein sent WikiLeaks the password of an unlaunched website found on Trump's unprecedented and dangerous ties. Donald Trump had direct electronic communications, and in dealing with that, we move to the ties that Donald Trump Jr. had with Russia. PutinTrump.org, WikiLeaks publicly tweeted, "Let's bomb Iraq. Progress for America PAC to launch PutinTrump.org at 9:30 a.m. Oops, PW is PutinTrump, PutinTrump.org. Several hours later, WikiLeaks sent a Twitter direct message to Donald Trump Jr. A PAC-run anti-Trump site, PutinTrump.org, is about to launch. The PAC is a recycled pro-Iraq war PAC. We have guessed the password. It is Putin Trump. See about for those for who is behind it, and comments. Any comments? Several hours later, Trump Jr. emailed a variety of senior campaign staff. Guys, I got a weird Twitter DM from WikiLeaks. See below. I tried the password and it works. And the About section they reference contains the next PIC in terms of who is behind them, and it is a DM. Do you know the people mentioned, what the conspiracy they are looking for could be? These are just screenshots, but it's a fully built out page claiming to be a PAC. Let me know your thoughts and if we want to look into it. Trump Jr. attached a screenshot of the About page for the unlaunched site PutinTrump.org. The next day, after the website had launched publicly, Trump Jr. sent a direct message to WikiLeaks, off the record. I don't know who that is, but I'll ask around. Thanks. On October 3rd, 2016, WikiLeaks sent another direct message to Trump Jr. asking you guys to help disseminate a link alleging candidate Clinton had advocated using a drone to target Julian Assange. Trump Jr. responded that he already had done so and asked, what's behind this Wednesday leak I keep reading about? WikiLeaks did not respond. On October 12, 2016, WikiLeaks wrote again that it was great to see you and your dad talking about our publications. Strongly suggest your dad tweets this link if he mentions us. WLSEARCH.TK. WikiLeaks wrote that the link would help Trump in digging through leaked emails and stated, we just released Podesta's emails, part 4. 2 days later, Trump Jr. publicly tweeted the WLSearch.TK link. Some more redacted. Other potential campaign interests in Russian hacked materials. Throughout 2016, the Trump campaign expressed interest in Hillary Clinton's private email server and whether approximately 30,000 emails from that server had in fact been permanently destroyed as reported by the media. Several individuals associated with the campaign were contacted in 2016 about various efforts to obtain the missing Clinton emails and other stolen material in support of the Trump campaign. Some of these contacts were met with skepticism and nothing came of them. Others were pursued to some degree. The investigation did not find evidence that the Trump campaign recovered any such Clinton emails or that these contacts were part of a coordinated effort between Russia and the Trump campaign. Henry Osnowski, aka Henry Greenberg, In the spring of 2016, Trump campaign advisor Michael Caputo learned through a Florida-based Russian business partner that another Florida-based Russian, Henry Oskowski, who also went by Henry Greenberg, claimed to have information pertaining to Hillary Clinton. Caputo notified Roger Stone and brokered communication between Stone and Oskowski. Oskowski and Stone were set up for a May 2016 in-person meeting. Oskowski was accompanied to the meeting by Alexei Rasin, a Ukrainian associate involved in Florida real estate. At the meeting, Rasin offered to sell Stone derogatory information on Clinton that Rasin claimed to have obtained while working for Clinton. Rasin claimed to possess financial statements demonstrating Clinton's involvement in money laundering with Rasin's companies. According to Oskowski, Stone asked if the amounts in question totaled millions of dollars, but was told it was closer to hundreds of thousands. Stone refused the offer, stating that Trump would not pay for opposition research. Oskowski claimed to the office that Rasin's motivation was financial. According to Oskowski, Rasin had tried unsuccessfully to shop the Clinton information around to other interested parties, and Oskowski would receive a cut if the information was sold. Rasin noted in public source documents as the director and/or registered agent for a number of Florida companies, none of which appears to be connected to Clinton. The office found no other evidence that Rasin worked for Clinton or any Clinton-related entities. In their statements to investigators, Oskowski and Caputo had contradictory recollections about the meeting. Oskowski claimed that Caputo accompanied Stone to the meeting and provided an introduction, whereas Caputo did not tell us that he had attended and claimed that he was never told what information Oskowski offered. Caputo also stated that he was unaware Oskowski sought to be paid for the information until Stone informed him after the fact. The office did not locate Rasin in the United States, although the office confirmed Rasin had been issued a Florida driver's license. The office otherwise was unable to determine the content and origin of the information he purported to offer to Stone. Finally, the investigation did not identify evidence of a connection between the outreach or the meeting and Russian interference efforts. Campaign efforts to obtain deleted Clinton emails. After candidate Trump stated on July 27, 2016, that he hoped Russia would find the 30,000 emails that are missing, Trump asked individuals affiliated with his campaign to find the deleted Clinton emails. Michael Flynn, who would later serve as a national security advisor in the Trump administration, recalled that Trump made this request repeatedly, and Flynn subsequently contacted multiple people in an effort to obtain the emails. Barbara Ledeen and Peter Smith were among the people contacted by Flynn. Ledeen, a longtime Senate staffer who had previously sought the Clinton emails, provided updates to Flynn about her efforts throughout the summer of 2016. Smith, an investment advisor who was active in Republican politics, also attempted to locate and obtain the deleted Clinton emails. Ledeen began her efforts to obtain the Clinton emails before Flynn's request as early as December 2015. On December 3rd, 2015, she emailed Smith a proposal to obtain the emails, stating, "Here is a proposal I briefly mentioned to you. The person I described to you would be happy to talk with you either in person or over the phone. The person can get the emails, which I view as 1, classified, and 2, were purloined by our enemies. That would demonstrate what needs to be demonstrated." Attached to the email was a 25-page proposal stating that the Clinton email was in all likelihood breached long ago, and that the Chinese, Russian, and Iranian intelligence services could reassemble the server's email content. The proposal called for a three-phase approach. The first two phases consisted of open source analysis. The third phase consisted of checking with certain intelligence resources that have, or sources that have access through liaison work with various foreign services to determine if any of those services had gotten to the server. The proposal noted, even if a single email was removed and the provenance of that email was a foreign service, it would be catastrophic to the Clinton campaign. Smith forwarded the email to two colleagues and wrote, "We can discuss to whom it should be referred." On December 16, 2015, Smith informed Ledeen that he declined to participate in her initiative. According to one of Smith's business associates, Smith believed Ledeen's initiative was not viable at that time.
Just a week after Trump's July 2016 request to find the Clinton emails, however, Smith tried to locate and obtain the emails himself. He created a company, raised tens of thousands of dollars, and recruited security experts and business associates. Smith made claims to others involved in the effort and those from whom he sought funding that he was in contact with hackers with ties and affiliations to Russia who had access to the emails, and that his efforts were coordinated with the Trump campaign. On August 28, 2016, Smith sent an email from an encrypted account with the subject, quote, Secretary Clinton's unsecured private email server, end quote, to an undisclosed list of recipients, including campaign co-chairman Sam Clovis. The email stated that Smith was, quote, just finishing 2 days of sensitive meetings here in D.C. with involved groups to poke and probe on the above. It is clear that the Clintons' home-based, unprotected server was hacked with ease by both state-related players and private mercenaries. Parties with varying interests are circling to release ahead of the election, end quote. On September 2nd, 2016, Smith directed a business associate to establish KLS LLC in furtherance of his search for the deleted Clinton emails. One of the purposes of the KLS research was to manage the funds Smith raised to support of his initiative. KLS research received over $30,000 during the presidential campaign, although Smith represented that he raised even more money. Smith recruited multiple people for his initiative, including security experts, to search for and authenticate the emails. In early September 2016, as part of his recruitment and fundraising effort, Smith circulated a document stating that his initiative was in coordination with the Trump campaign, quote, to the extent permitted as an independent expenditure organization, end quote. The document listed multiple individuals affiliated with the Trump campaign, including Flinch, Clovis, Brannon, and Kellyanne Conway. The investigation established that Smith communicated with at least Flynn and Clovis after his search for the deleted Clinton emails, but the office did not identify evidence that any of the listed individuals initiated or directed Smith's efforts. In September 2016, Smith and Ledeen got back in touch with each other about their respective efforts. Ledeen wrote to Smith, quote, wondering if you had some more detailed reports or memos other than data you could have shared, because we have come a long way in our efforts since we last visited. We would need as much technical discussion as possible so that we can marry it against the new data we have found and then could share it back to you, your eyes only, end quote. Ledeen claimed to have obtained a trove of emails from what she described as the dark web that purported to be the deleted Clinton emails. Ledeen wanted to authenticate the emails and solicited contributions to find that effort. Eric Prince provided funding to hire a web advisor, a tech advisor, to ascertain the authenticity of the emails. According to Prince, the tech advisor determined the emails were not authentic. A backup of Smith's computer contained 2 files that had been downloaded from WikiLeaks and that were originally attached to emails received by John Podesta. The files on Smith's computer had creation dates of October 2, 2016, which was prior to the date of their release by WikiLeaks. Forensic examination, however, established that the creation date did not reflect when the files were downloaded to Smith's computer. It appears the creation date was when WikiLeaks staged the documents for release, as discussed in Volume 1, Section 3B, 3c, SOPRA. The investigation did not otherwise identify evidence that Smith obtained the files before their release by WikiLeaks. Smith continued to send emails to an undisclosed recipient list about Clinton's deleted emails and until shortly before the election. For example, on October 28, 2016, Smith wrote that there was a tug-of-war going on within WikiLeaks over its planned releases in the next few days, and that WikiLeaks, quote, has maintained it will save its best revelations for last under the theory this allows little time for response prior to the U.S. election, November 8. An attachment to the email claimed that WikiLeaks would release all, quote, 33,000 deleted emails by November 1st. No emails obtained from Clinton's server were subsequently released. Smith drafted multiple emails stating or intimidating that he was in contact with Russian hackers. For example, in one such email, Smith claimed that on August 2016, KLS Research had organized meetings with parties who had access to the deleted Clinton emails, including parties with ties and affiliations to Russia. The investigation did not identify evidence that any such meetings occurred. Associates and security experts who worked with Smith on the initiative did not believe that Smith was in contact with Russian hackers and were aware of no such connections. The investigation did not establish that Smith was in contact with Russian hackers or that Smith, leading, or any other individuals in touch with the Trump campaign ultimately obtained the deleted emails. In sum, the investigation established that the GRU hacked into email accounts of persons affiliated with the Clinton campaign, as well as the computers of the DNC and the DCCC. The GRU then exfiltrated data related to the 26th election from these accounts and computers and disseminated that data through fictitious online persons, DC Leaks and Lucifer 2.0, and later through WikiLeaks. The investigation also established that the Trump campaign displayed interest in the WikiLeaks releases and that redacted, as explained in Volume 1, Section VB, the evidence was sufficient to support computer intrusion and other charges against GRU officers for their role in the election-related hacking. Redacted. Number 4, Russian government links to and contacts with the Trump campaign. The office identified multiple contacts, leaks in the words of the appointment order, between Trump campaign officials and individuals with ties to Russian government. The office investigated whether those contacts constituted a third avenue of attempted Russian interference with or influence on the 2016 presidential election. In particular, the investigation examined whether these contacts involved or resulted in coordination or conspiracy with the Trump campaign in Russia, including with respect to Russia providing assistance to the campaign in exchange for any sort of favorable treatment in the future. Based on the available information, the investigation did not establish such coordination. This section describes the principal links between the Trump campaign and individuals with ties to Russian government, including some contacts with campaign officials or associates that have been publicly reported to involve Russian contacts. Each subsection begins with an overview of the Russian contact at issue and then describes in detail the relevant facts, which are generally presented in chronological order, beginning with the early months of the campaign and extending through the post-election transition period. A, campaign period September 2015 through November 8, 2016. Russian government-connected individuals and media entities began showing interest in Trump's campaign in the months after he announced his candidacy in June 2015. Because Trump's status as a public figure at the time was attributable in large part to his prior business and entertainment dealings, this office investigated whether a business contact with Russian-linked individuals and entities during the campaign period, the Trump Tower Moscow Project, see Volume 1, Section 5A1, led to or involved coordination of election assistance. Outreach from individuals with ties to Russia continued in the spring and summer of 2016 when Trump was moving toward and eventually becoming the Republican nominee for president. As set forth below, the office also evaluated a series of links this period outreach to two of Trump's then recently named foreign policy advisors, including a representation that Russia had, quote, dirt on Clinton in the form of thousands of emails, dealings with a DC-based think tank that specializes in Russia and has connections with governments, parentheses, Volume 1, Section 4A4, a meeting at a Trump Tower between the campaign and a Russian lawyer promising dirt on candidate Clinton that was, quote, part of Russia and its government support for Trump, end quote. See Volume 1, Section 4A5. Events at the Republican National Convention, parentheses, Volume 1, Section 4A6. Post-convention contacts between Trump campaign officials and Russian ambassador to the United States, parentheses, Volume 1, Section 4A7. And contacts through campaign chairman Paul Manafort, who had previously worked for a Russian oligarch and a pro-Russian political party in Ukraine, parentheses, Volume 1, Section 4AB. The Trump Tower Moscow Project. The Trump Organization had pursued and completed projects outside the United States as part of its real estate portfolio. Some projects involved the acquisition and ownership, parentheses, through subsidiary corporate structures of property. In other cases, the Trump Organization has executed licensing deals with real estate developers and management companies, often local to the country where the project was located. Between at least 2013 and 2016, the Trump Organization explored a similar licensing deal in Russia involving the construction of a Trump-branded property in Moscow. The project, commonly referred to as the Trump Tower Moscow or Trump Moscow Project, anticipated a combination of commercial, hotel, and residential properties all within the same building. Between 2013 and June 2016, several employees of the Trump Organization, including then president of the organization, Donald J. Trump, pursued a Moscow deal with several Russian counterparties. From the fall of 2015 until the middle of 2016, Michael Cohen spearheaded the Trump Organization's pursuit of a Trump Tower Moscow project, including by reporting on the project status to candidate Trump and other executives in the Trump Organization. A Trump Tower Moscow venture with the Crocus Group, 2013 to 2014. The Trump Organization and the Crocus Group, a Russian real estate conglomerate owned and controlled by Aris Agalarov, began discussing a Russian-based real estate project shortly after the conclusion of the 2013 Miss Universe pageant in Moscow. Donald J. Trump Jr. served as the primary negotiator on behalf of the Trump Organization. Emin Agalarov, son of Aris Agalarov, and Ikli Ike Kevin Lassie represented the Crocus Group during negotiations with the occasional assistance of Robert Goldstone. In December 2013, Gavelatzi and Trump Jr. negotiated and signed preliminary terms of an agreement for the Trump Tower Moscow project. On December 23, 2013, after discussions with Donald J. Trump, the Trump Organization agreed to accept an arrangement whereby the organization received a flat 3.5 commission on all sales with no licensing fees or incentives. The parties negotiated a letter of intent during January and February of 2014. From 2014 through November 2014, the Trump Organization and Crocus Group discussed development plans for the Moscow project. Sometime before January 24, 2014, the Crocus Group sent the Trump Organization a proposal for a 800-unit, 194-meter building to be constructed at an Agalarov-owned site in Moscow called Crocus City, which had also been the site of the Miss Universe pageant. In February 2014, Ivanka Trump met with Emin Agalarov and toured the Crocus City site during a visit to Moscow. From 2014 through 2014, the groups discussed design standards and other architectural elements. For example, in July 2014, members of the Trump Organization and Crocus Group counterparty questions about the quote, demographics of these prospective buyers in the Crocus area, the development of neighboring parcels in Crocus City, and concepts for redesigning portions of the building. In August 2014, the Trump Organization requested specifications for a competing Marriott-branded tower being built in Crocus City. Beginning in September 2014, the Trump organizations stopped responding in a timely fashion to correspondence and proposals from the Crocus Group. Communications between the two groups continued through November 2014 with decreasing frequency. What appears to be the last communication is dated November 24, 2014. The project appears not to have developed past the planning stage and no construction occurred. B, communications with IC Expert Investment Company in Georgie, looks like Brishniskish, sorry about that. In the late summer of 2015, the Trump Organization received a new inquiry about pursuing a Trump Tower project to Moscow. In approximately 2015, Felix Sater, a New York-based real estate advisor, contacted Michael Cohen, then Executive Vice President of the Trump Organization and Special Counsel to Donald J. Trump. Sater had previously worked with the Trump Organization and advised it on a number of domestic and international projects. Sater had explored the possibility of a Trump Tower project in Moscow while working with the Trump Organization, and therefore knew of the organization's general interest in completing a deal there. Sater had also served as an informal agent of the Trump Organization in Moscow, previously and accompanied Ivanka Trump and Donald Trump Jr. to Moscow in the mid-2000s. Sater contacted Cohen on behalf of IC Expert Investment, a Russian real estate development corporation controlled by Andrei Vladimirovich Rosov. Sater had known Rosov since approximately 2007, and in 2014 had served as an agent on behalf of Rosov during Rosov's purchase of a building in New York City. Sater later contacted Rosov and proposed that IC Expert pursue a Trump Tower Moscow project in which LC Expert would license the name and brand the Trump Organization, but construct the building on its own. Sater worked on the deal with Rosov and another employee of IC Expert. Cohen was the only Trump Organization representative to negotiate directly with LC Expert or its agents. In approximately September 2015, Cohen obtained approval to negotiate with IC Expert from candidate Trump, who was then president of the Trump Organization. Cohen provided updates directly to Trump about the project to 2015 and into 2016, assuring him the project was continuing. Cohen also discussed the Trump Moscow project with Ivanka Trump as to design elements, parentheses, such as possible architects to use for the project, and Donald J. Trump Jr., parentheses, about his experience in Moscow and possible involvement in the project during the fall of 2015. Also during the fall of 2015, Cohen communicated about the Trump-Moscow proposal with Giorgio Rosdisi, a business executive who previously had involved in a development deal with a Trump organization in Bethune, Georgia. Cohen stated that he spoke to Rosdisi in part because Rosdisi had purchased business ventures in Moscow, including a licensing deal with the Agalarov-owned Crocus Group. On September 22, 2015, Cohen forwarded a preliminary design study for the Trump-Moscow project to Rosdisi asking, quote, "I look forward to your reply about this spectacular project in Moscow." Rosdisi forwarded Cohen's email to an associate and wrote, quote, "If we could organize the meeting in New York at the highest level of the Russian government, and Mr. Trump in this project would definitely receive the worldwide attention," end quote. On September 24, Rosdisi sent Cohen an attachment that he described as a proposed, quote, "letter to the mayor of Moscow from Trump Organization," end quote, explaining that, quote, "we need to send this letter to the mayor of Moscow, second guy in Russia. He is aware of the potential project and will pledge his support," end quote. In a second email to Cohen, sent the same day, Rosdisi provided in the translation of the letter, which described the Trump Tower project as a, quote, "symbol of stronger economic, business, and cultural relationships between New York and Moscow, and therefore United States and the Russian Federation," end quote. On September 27, 2015, Rosdisi sent another email to Cohen proposing that the Trump Organization partner on the Trump-Moscow project with Global Development Group, LLC, which he described as being controlled by Michel Pushkin, a Russian architect, and Simon Nizharisi. Cohen told the office that he ultimately declined the proposal and instead continued to work with LC Expert, the companies represented by Felix Slater. C, letter of intent and context to Russian government, parentheses, dating October 2015 through 2016. 1, Trump signs a letter on intent on behalf of the Trump Organization. Between approximately October 13, 2015 and November 15, the Trump Organization, through its subsidiary Trump Acquisitions, LLC, and LC Expert, completed a letter of intent for a Trump-Moscow project. The letter of intent signed by the Trump Organization and Rosov on behalf of IC Expert was, quote, intended to facilitate further discussions, end quote, in order to, quote, attempt to enter into a mutually acceptable agreement, end quote, related to the Trump-branded project in Moscow. The letter of intent contemplated a development with residential, hotel, commercial, and office components and called for, quote, approximately 250 first-class luxury residential condominiums, end quote, as well as, quote, one first-class luxury hotel consisting of approximately 15 floors and containing not fewer than 150 hotel rooms, end quote. For the residential and commercial portions of the project, the Trump Organization would receive 1% and 5% of all condominium sales, plus 3% of all rental and other revenues. For the project's hotel portion, the Trump Organization would receive a base fee of 3% of gross operating revenues for the first 5 years and 4% thereafter, plus a separate incentive fee of 20% of operating profit. Under the letter of intent, the Trump Organization also would receive a $4 million upfront fee prior to groundbreaking. Under these terms, the Trump Organization stood to earn substantial sums over the lifetime of the project without assuming significant liabilities or financing commitments. On November 3, 2015, The day after the Trump organization transmitted the letter of intent, Sater emailed Cohen suggesting that the Trump-Moscow project could be used to increase candidate Trump's chances of being elected, writing, and this is a quote, "Buddy, our boy can become president of USA and we can engineer it. I will get all the Putin's team to buy in on this. I will manage this process. Michael, Putin gets on stage with Donald for ribbon cutting for Trump Tower, and Donald owns the Republican nomination and possibly beats Hillary, and our boy is in. We will manage this process better than anyone. You and I will get Donald and Vladimir on stage together very shortly. That's the game changer." Later that day, Sater followed up, quote, "Donald doesn't stare down. He negotiates and understands the economic issues, and Putin only want to deal with a pragmatic leader and a successful businessman and a good candidate for someone who knows how to negotiate. Quote, business, politics, whatever it all is, the same for someone who knows how to deal. I think I can get Putin to say that at the Trump-Moscow Tower, if he says it, we own this election. America's most difficult adversary agreeing that Donald is a good guy to negotiate. We can own this election. Michael, my next steps are very sensitive with Putin's very, very close people. We can pull this off. Michael, let's go. 2 boys from Brooklyn getting a USA president elected. This is good, really good. According to Cohen, he did not consider the political import of the Trump-Moscow project to the 2016 U.S. presidential election at the time. Cohen also did not recall candidate Trump or anyone affiliated with the Trump campaign discussing implications of the Trump-Moscow project with him. However, Cohen recalled conversations with Trump in which the candidate suggested that his campaign would be a significant infomercial for Trump-branded properties. 2, post letter of intent contacts with individuals in Russia. Given the size of the Trump-Moscow project, Sater and Cohen believed the project required approval, whether express or implied, from the Russian national government, including from the presidential administration of Russia. Sater stated that he therefore began to contact the presidential administration through another Russian business contact. In early negotiations with the Trump organization, Sater had alluded to the need for government approval in his attempts to set up meetings with Russian officials. On October 12, 2015, for example, Sater wrote to Cohen that, quote, all we need is Putin on board and we are golden, end quote, and that a meeting with Putin and a top deputy is tentatively set for the 14th of October, redacted. This meeting was coordinated by associates in Russia and that he had no direct interaction with the Russian government. Approximately a month later, after the letter of intent had been signed, Lana Uskova emailed Ivanka Trump on behalf of Urchova's then husband, Dmitry Klokov, to offer Klokov's assistance to the Trump campaign. Klokov was at the time director of external communications for PJSC, Federal Grid Company of United Energy System, a large Russian electricity transmission company, and had been previously employed as an aide and press secretary to Russia's energy minister. Ivanka Trump forwarded the email to Cohen. He told the office that after receiving this inquiry, he had conducted an internet search for Klokov's name and concluded incorrectly that Klokov was a former Olympic weightlifter. Between November 18 and 19, 2015, Klokov and Cohen had at least one telephone call and exchanged several emails. Describing himself in emails to Cohen as a, quote, trusted person, end quote, who could offer the campaign political energy and, quote, synergy on a government level, end quote, Klokov recommended that Cohen travel to Russia to speak with him and an unidentified intermediary. Klokov said that those conversations could facilitate a later meeting in Russia between the candidate and an individual Klokov described as, quote, our person of interest, end quote. In an email to the office, Arkhovat later identified, quote, the person of interest as Russian President Vladimir Putin. In the telephone call and follow-up emails with Klokov, Cohen discussed his desire to use a near-term trip to Russia to do site surveys and talk over the Trump-Moscow project with local developers. Cohen registered his willingness also to meet with Klokov and the unidentified intermediary, but was emphatic that all meetings in Russia involving him or candidate Trump, including a possible meeting between candidate Trump and Putin, would next be, quote, in conjunction with a development in an official visit, end quote, with the Trump organization receiving a formal invitation to visit. Parentheses, Klokov had written previously that the visit by candidate Trump in Russia has to be informal. Klokov has also previously recommended to Cohen that he separate their negotiations over a possible meeting between Trump and the person of interest from any existing business track. Re-emphasizing that his outreach was not done on behalf of any business, Klokov added in second email to Cohen that if publicized well, such a meeting could have phenomenal impact in the business dimension, and that the person of interest's most important support could have significant ramifications for the level of projects and their capacity. Klokov concluded by telling Cohen that there was no bigger warranty in any project than the consent of the person of interest. Cohen rejected the proposal, saying that currently our letter of intent developer is in talks with VP's chief of staff and arranging a formal invite for the two to meet. This email appears to be their final exchange, and the investigation did not identify evidence that Cohen brought Klokov's initial offer of assistance to the campaign's attention, or that anyone associated with the Trump organization or the campaign dealt with Klokov at a later date. Cohen explained that he did not pursue the proposed meeting because he was already working on the Moscow project with Sater, who Cohen understood to have his own correct connections to the Russian government.
By late December 2015, however, Cohen was complaining that Sater had not been able to use those connections to set up the promised meeting with Russian government officials. Cohen told Sater that he was, quote, setting up the meeting myself, end quote. On January 11, 2016, Cohen emailed the office of Dmitry Peskov, the Russian government's press secretary, indicating that he desired contact with Sergei Ivanov, Putin's chief of staff. Cohen erroneously used the email address PR_PESKOVA@PRPRESS.gov.ru instead of PR_PESKOVA@PRPRESS.gov.ru. So the email apparently did not go through. On January 14, 2016, Cohen emailed a different address, info@prpress.gov.ru with the following message. Dear Mr. Peskov, over the past few months, I have been working with a company based in Russia regarding the development of a Trump Tower Moscow project in Moscow City. Without getting into lengthy specifics, the communication between our two sides has stalled. As this project is too important, I am hereby requesting your assistance. I respectfully request someone, preferably you, contact me so that I might discuss the specifics as well as arranging meetings with the appropriate individuals. I thank you in advance for your assistance and look forward to hearing from you soon. 2 days later, Cohen sent an email to PR_PESKOVA@PRPRESS.gov.ru, repeating his request to speak with Sergei Ivanov. Cohen testified to Congress and initially told the office that he did not recall receiving a response to his email inquiry and that he decided to terminate any further work on the Trump-Moscow project as of January 2016. Cohen later admitted that these statements were false. In fact, Cohen had received and recalled receiving a response to his inquiry, and he continued to work on and update candidate Trump on the project through as late as June 2016. On January 20th, 2016, Cohen received an email from Elena Polyakova, Peskov's personal assistant. Writing from her personal email account, Polyakova stated that she had been trying to reach Cohen and asked that he call her on the personal number that she provided. Shortly after receiving Polyakova's email, Cohen called and spoke to her for 20 minutes. Cohen described to Polyakova his position at the Trump Organization and outlined the proposed Trump-Moscow project, including information about the Russian counterparty with which the Trump Organization had partnered. Cohen requested assistance in moving the project forward, both in securing land to build the project and with financing. According to Cohen, Polyakova asked detailed questions and took notes, stating that she would need to follow up with others in Russia. Cohen could not recall any direct follow-up from Polyakova or from any other representative of the Russian government, nor did the office identify any evidence of direct follow-up. However, the day after Cohen's call with Polyakova, Sater texted Cohen asking him to call me when you have a few minutes to chat. It's about Putin. They called today. Sater then sent a draft invitation for Cohen to visit Moscow to discuss the Trump-Moscow project, along with a note to, quote, tell me if the letter is good as amended by me or make whatever changes you want and send it back to me, end quote. After a further round of edits on January 25th, 2016, Sater sent Cohen an invitation signed by Andrei Ryabinsky of the company MHJ to travel to Moscow for a working visit about the prospects of development and the construction business in Russia, the various land plots available suited for construction of this enormous tower, and the opportunity to coordinate a follow-up visit to Moscow by Mr. Donald Trump. According to Cohen, he elected not to travel at the time because of concerns about the lack of concrete proposals about land plots that could be considered as an option for the project. D, discussions about Russia travel by Michael Cohen or candidate Trump, December 2015 through June 2016. Sater's overtures to Cohen to travel to Russia. The late January communication was neither the first nor the last time that Cohen contemplated visiting Russia in pursuit of the Trump-Moscow project. Beginning in late 2015, Sater repeatedly tried to arrange for Cohen and candidate Trump as representatives of the Trump Organization to travel to Russia to meet with Russian government officials and possible financing partners. In December 2015, Sater sent Cohen a number of emails about logistics for traveling to Russia for meetings. On December 19, 2015, Sater wrote, please call me. I have Evgeny Devoskin on the other line. He needs a copy of your and Donald's passports. They need a scan of every page of the passports. Invitations and visas will be issued this week by VTB Bank to discuss financing for Trump Tower Moscow. Politically, neither Putin's office nor Ministry of Foreign Affairs cannot issue invite, so they are inviting commercially/business. VTB is Russia's second biggest bank, and VTB Bank CEO Andrei Kostin will be at the meetings with Putin so that it is a business meeting, not political. We will be invited to Russia, to Russian consulate this week to receive invite and have visa issued. In response, Cohen texted Sater an image of his own passport. Cohen told the office that at one point he requested a copy of candidate Trump's passport for Rona Graf, Trump's executive assistant at the Trump Organization, and that Graf later brought Trump's passport to Cohen's office. The investigation did not, however, establish that the passport was forwarded to Sater. Into the spring of 2016, Sater and Cohen continued to discuss a trip to Moscow in connection with the Trump-Moscow project. On April 20th, 2016, Sater wrote Cohen, I quote, "The people wanted to know when you were coming," end quote. On May 4th, 2016, Sater followed up. "I had a chat with Moscow. Assuming the trip does happen, the question is before or after the convention. I said I believe, but don't know for sure, that it's probably after the convention. Obviously, the pre-meeting trip, you only, can happen anytime you want, but the two big guys were the question. I said I would confirm and revert. Let me know about if I was right by saying I believe after Cleveland, and also when you want to speak to them and possibly fly over." Cohen responded, quote, "My trip before Cleveland, Trump once he becomes the nominee after the convention," end quote. The day after this exchange, Sater tied Cohen's travel to Russia to the St. Petersburg International Economic Forum, an annual event attended by prominent Russian politicians and businessmen. Sater told the office that he was informed by a business associate that Peskov wanted to invite Cohen to the forum. On May 5th, 2016, Sater wrote to Cohen, "Peskov would like to invite you as his guest to the St. Petersburg Forum, which is Russia's Davos. It's June 16th through 19th. He wants to meet there with you and possibly introduce you to either Putin or Medvedev, as they are not sure if I or both will be there. This is perfect. The entire business class of Russia will be there as well. He said anything you want to discuss, including dates and subjects, are on the table to discuss." The following day, Sater asked Cohen to confirm those dates would work for him to travel. Cohen wrote back, quote, "Works for me," end quote. On June 9th, 2016, Sater sent Cohen a notice that he, Sater, was completing the badges for the forum, adding, quote, "Putin is there on the 17th, very strong chance you will meet him as well," end quote. On June 13th, 2016, Sater forwarded Cohen an invitation to the forum signed by the director of the Rose Congress Foundation, the Russian entity organizing the forum. Sater also sent Cohen a Russian visa application and asked him to send 2 passport photos. According to Cohen, the invitation gave no indication that Peskov had been involved in inviting him. Cohen was concerned that Russian officials were not actually involved or were not interested in meeting with him, as Sater had alleged, and so he decided not to go to the forum. On June 14, 2016, Cohen met Sater in the lobby of the Trump Tower in New York and informed him that he would not be traveling at the time. Candidate Trump's opportunities to travel to Russia. The investigation identified evidence that during the period the Trump-Moscow project was under consideration, the possibility of candidate Trump visiting Russia arose in 2 contexts. First, in interviews with the office, Cohen stated that he discussed the subject of traveling to Russia with Trump twice, once in late 2015 and again in spring 2016. According to Cohen, Trump indicated a willingness to travel if it would assist the project significantly. On one occasion, Trump told Cohen to speak with then-campaign manager Corey Lewandowski to coordinate the candidate's schedule. Cohen recalled that he spoke with Lewandowski, who suggested that they speak again when Cohen had actual dates to evaluate. Cohen indicated, however, that he knew that travel prior to the Republican National Convention would be impossible given the candidate's pre-existing commitments to the campaign. Second, like Cohen, Trump received and turned down an invitation to the St. Petersburg International Economic Forum. In late December 2015, Mira Duma, a contact of Ivanka Trump's from the fashion industry, first passed along invitations for Ivanka Trump and candidate Trump from Sergei Prihodko, a deputy prime minister of the Russian Federation. On January 14, 2016, Rona Graf sent an email to Duma stating that Trump was, quote, honored to be asked to participate in the highly prestigious, end quote, forum event, but that he would, quote, have to decline, end quote, the invitation given to his, quote, very grueling and full travel schedule, end quote, as a presidential candidate. Graf asked Duma whether she recommended that Graf, quote, send a formal note to the deputy prime minister, end quote, declining the invitation. Duma replied that a formal note would be, quote, great, end quote. It does not appear that Graf prepared the note immediately. According to written answers from President Trump, Graf received an email from Deputy Prime Minister Prikhotko on March 17, 2016, again inviting Trump to participate in the 2016 forum in St. Petersburg. 2 weeks later, on March 31, 2016, Graf prepared for Trump's signature a two-paragraph letter declining the invitation. The letter stated that Trump's, quote, schedule has been extremely demanding, end quote, because of the presidential campaign, and that he, quote, already had several commitments in the United States, end quote, for the time of the forum, but that he otherwise, quote, would have gladly given every consideration to attending such an important event, end quote. Graf forwarded the letter to another executive assistant at the Trump Organization with instructions to print the document on letterhead for Trump to sign. At approximately the same time that the letter was being prepared, Robert Forsman, a New York-based investment banker, began reaching out to Graf to secure an in-person meeting with candidate Trump. According to Forsman, he had been asked by Anton Kobiakov, a Russian presidential aide involved with the Roscongress Foundation, to see if Trump could speak at the forum. Forsman first emailed Graf on March 31, 2016, following a phone introduction brokered through Trump business associate Mark Burnett, who produced the television show The Apprentice. In his email, Forsman referenced his long-standing personal and professional expertise in Russia and Ukraine, his work setting up early private channel between Vladimir Putin and former U.S. President George W. Bush, and an approach he had received from senior Kremlin officials about the candidate. Forsman asked Graf for a meeting with the candidate, Corey Lewandowski, or another relevant person to discuss this and other concrete things Forsman felt uncomfortable discussing over unsecure email. On April 4th, 2016, Graf forwarded Forsman's meeting request to Jessica Macchia, another executive assistant to Trump. With no response forthcoming, Forsman twice sent reminders to Graf, first on April 26th and then on April 30th, 2016. Graf sent an apology to Forsman and forwarded his April 26th email, as well as his initial March 2016 email to Lewandowski. On May 2nd, 2016, Graf forwarded Forsman's April 30 email, which suggested an alternative meeting with Donald Trump Jr. or Eric Trump so that Forsman could convey to them information that, quote, should be conveyed to the candidate personally or to someone the candidate absolutely trusts, end quote, to policy advisor Stephen Miller. No communications or other evidence obtained by the office indicate the Trump campaign learned that Forsman was reaching out to invite the candidate to the forum, or that the campaign otherwise followed up with Forsman until after the election, when he interacted with the transition team as he pursued a possible position in the incoming administration. When interviewed by the office, Forsman denied that the specific approach from senior Kremlin officials noted in his March 31st, 2016 email was anything other than Kobyakov's invitation to Roscongress. According to Forsman, the concrete things he referred to in the same email were a combination of the invitation itself, Forsman's personal perspective on the invitation, and Russia policy in general, and details of Ukraine's plan supported by a U.S. think tank, East-West Institute. Forsman told the office that Kobyakov had extended similar invitations through him to another Republican presidential candidate and one other politician. Forsman also said that Kobyakov had asked Forsman to invite Trump to speak after the other presidential candidate withdrew from the race, and the other politician's participation did not work out. Finally, Forsman claimed that to have no plans to establish a back channel involving Trump, stating the reference to his involvement in the Bush-Putin back channel was meant to burnish his credentials to the campaign. Forsman commented that he had not recognized any of the experts announced as Trump's foreign policy team in March 2016 and wanted to secure an in-person meeting with the candidate to share his professional background, and policy views, including that Trump should decline Kobyukov's invitation to speak at the forum. George Papadopoulos. George Papadopoulos was a foreign policy advisor to the Trump campaign from March 2016 to October 2016. In late April 2016, Papadopoulos was told by London-based professor Joseph Mifsud, immediately after Mifsud's return from a trip to Moscow, that the Russian government had obtained, quote, dirt, end quote, on candidate Clinton in the form of thousands of emails. 1 week later, on May 6, 2016, Papadopoulos suggested to a representative of a foreign government that the Trump campaign had received indications from the Russian government that it could assist the campaign through the anonymous release of information that would be damaging to candidate Clinton. Papadopoulos shared information about Russian, quote, dirt, end quote, with people outside of the campaign, and the office investigated whether he also provided to a campaign official. Papadopoulos and the campaign officials with whom he interacted told the office they did not recall Papadopoulos passed them the information. Throughout the relevant period of time and for several months thereafter, Papadopoulos worked with Mifsud and 2 Russian nationals to arrange meetings between the campaign and the Russian government. That meeting never came to pass. Origins of campaign work. In March 2016, Papadopoulos became a foreign policy advisor to the Trump campaign. As early as the summer of 2015, he had sought a role as a policy advisor to the campaign, but in a September 30, 2015 email, he was told that the campaign was not hiring policy advisors. In late 2015, Papadopoulos obtained a paid position on the campaign of Republican presidential candidate Ben Carson. Although Carson remained in the presidential race until early March 2016, Papadopoulos had stopped actively working for his campaign by early February 2016. At the time, Papadopoulos reached out to a contact at the London Center of International Law Practice, LCILP, which billed itself as a, quote, unique institution comprising high-level professional international law practitioners dedicated to the advancement of global legal knowledge and the practice of international law, end quote. Papadopoulos said that he had finished his role with the Carson campaign and asked if LCILP was hiring. In early February, Papadopoulos agreed to join LCILP and arrived in London to begin work. As he was taking his position at LCILP, Papadopoulos contacted Trump campaign manager Corey Lewandowski via LinkedIn and email campaign official Michael Glassner about his interest in joining the Trump campaign. On March 2nd, 2016, Papadopoulos sent Glassner another message reiterating his interest. Glassner passed along word of Papadopoulos' interest to another campaign official, Joy Lutz, who notified Papadopoulos by email that she had been told by Glassner to introduce Papadopoulos to Sam Clovis, the Trump campaign's national co-chair and policy advisor. At the time, Papadopoulos' March 2 email, the media was criticizing the Trump campaign for lack of experienced foreign policy or national security advisors within its ranks. To address that issue, the senior campaign officials asked Clovis to put a foreign policy team together on short notice. After receiving Papadopoulos' name from Lutz, Clovis performed a Google search on Papadopoulos, learned that he had worked at the Hudson Institute, and believed that he had credibility on energy issues. On March 3, 2016, Clovis arranged to speak with Papadopoulos by phone to discuss Papadopoulos' joining the campaign as a foreign policy advisor. And on March 6, 2016, the two spoke. Papadopoulos recalled that Russia was mentioned as a topic, and he understood from the conversation that Russia would be an important aspect of the campaign's foreign policy. At the end of the conversation, Clovis offered Papadopoulos a role as a foreign policy advisor to the campaign, and Papadopoulos accepted the offer. Approximately, initial Russia-related context. Approximately a week after signing on as foreign policy advisor, Papadopoulos traveled to Rome, Italy, as part of his duties with LCILP. The purpose of the trip was to meet officials affiliated with Link Campus University, a for-profit institution headed by a former Italian government official. And during the visit, Papadopoulos was introduced to Joseph Mifsud. Mifsud is a Maltese national who worked as a professor at the London Academy of Diplomacy in London, England. Although Mifsud worked out of London and was affiliated with LCILP, The encounter in Rome was the first time that Papadopoulos had met him. Mifsud maintained various Russian contacts while living in London, as described further below. Among his contacts was, there's a redaction, a one-time employee of the IRA, the entity that carried out the Russian social media campaign, see Volume 1, Section 2, Supra. In January and February 2016, Mifsud discussed possibly meeting in Russia. The investigation did not identify evidence of them meeting. Later in the spring of 2016, there's a redaction, was also in contact with another redaction that was linked to an employee of Russian Ministry of Defense. And that account had overlapping contacts with a group of Russian military-controlled Facebook accounts that included accounts used to promote the DC leaks releases in the course of the GRU's hack and release operations, see Volume 1, Section 3, B1 Supra. According to Papadopoulos, Mifsud at first seemed uninterested in Papadopoulos when they met in Rome. After Papadopoulos informed Mifsud about his role in the Trump campaign, however, Mifsud appeared to take greater interest in Papadopoulos. The two discussed Mifsud's European and Russian contacts and had a general discussion about Russia. Mifsud also offered to introduce Papadopoulos to European leaders and others with contacts to the Russian government. Papadopoulos told the office that Mifsud's claim of substantial connections with the Russian government officials interested in Papadopoulos, who thought that such connections could increase his importance as a policy advisor to the Trump campaign. On March 17th, Papadopoulos returned to London. 4 days later, candidate Trump publicly named him as a member of the Foreign Policy and National Security Advisory Team chaired by Senator Jeff Sessions, describing Papadopoulos as, and I quote, an oil and energy consultant, and I quote again, excellent guy. On March 24th, 2016, Papadopoulos met with Mifsud in London. Mifsud was accompanied by a Russian female named Olga Polonskaya. Mifsud introduced Polonskaya as a former student of his who had connections to Vladimir Putin. Papadopoulos understood at the time that Polonskaya may have been Putin's niece, but later learned that this was not true. During the meeting, Polonskaya offered to help Papadopoulos establish contacts in Russia and stated that the Russian ambassador in London was a friend of hers. Based on this interaction, Papadopoulos expected Mifsud and Polonskaya to introduce him to the Russian ambassador in London, but that did not occur. Following his meeting with Mifsud, Papadopoulos sent an email to members of the Trump campaign's foreign policy advisory team. The subject line of the message was, and I quote, meeting with Russian leadership, including Putin, end quote. The message stated in pertinent part, I just finished a very productive lunch with a good friend of mine, Joseph Mifsud, the director of the London Academy of Diplomacy, who introduced me to both Putin's niece and the Russian ambassador in London, who also acts as the deputy foreign minister. The topic of the lunch was to arrange a meeting between us and the Russian leadership to discuss U.S.-Russia ties under President Trump. They are keen to host us in a, quote, neutral, end quote, city or directly in Moscow. They said the leadership, including Putin, is ready to meet with us and Mr. Trump should there be interest. Waiting for everyone's thoughts on moving forward with this very important issue. Papadopoulos' message came at a time when Clovis perceived a shift in the campaign's approach toward Russia, from one of engaging with Russia through the NATO framework and taking a strong stance on Russian aggression in Ukraine. And then there's a redaction. Clovis' response to Papadopoulos, however, did not reflect that shift. Replying to Papadopoulos and other members of the Foreign Policy Advisory Team copied on the initial email, Clovis wrote, this is the most informative. Let me work it through the campaign. No commitments until we see how this plays out. My thought is that we probably should not go forward with any meetings with the Russians until we have had occasion to sit with our NATO allies, especially France, Germany, and Great Britain. We need to reassure our allies that we are not going to advance anything with Russia until we have everyone on the same page. More thoughts later today. Great work. March 31, Foreign Policy Team Meeting. The campaign held a meeting of the Foreign Policy Advisory Team with Senator Sessions and candidate Trump approximately 1 week later on March 31, 2016 in Washington, D.C. The meeting, which was intended to generate press coverage for the campaign, took place at the Trump International Hotel. Papadopoulos flew to Washington for the event. At the meeting, Senator Sessions sat at one end of the Oval table, while Trump sat at the other. As reflected in the photograph below, which was posted to Trump's Instagram account, Papadopoulos sat between the two seats to Sessions' left. During the meeting, each of the newly announced foreign policy advisors introduced themselves and briefly described their areas of experience and expertise. Papadopoulos spoke about his previous work in the energy sector and then brought up a potential meeting with Russian officials. Specifically, Papadopoulos told the group that he had learned through his contacts in London that Putin wanted to meet with the candidate, with candidate Trump, and that these connections could help arrange that meeting. Trump and Sessions both reacted to Papadopoulos' statement. Papadopoulos and campaign advisor J.D. Gordon told investigators in an interview that he had a, quote, crystal clear, quote, recollection of the meeting, have stated that Trump was interested in and receptive to the idea of meeting with Putin. Papadopoulos understood Sessions to be similarly supportive of his efforts to arrange a meeting. Gordon and two other attendees, however, recalled that Sessions generally opposed the proposal, though they differ in their accounts of the concerns he voiced or the strength of the opposition that he expressed. George Papadopoulos learns that Russia has dirt in the form of Clinton emails. Whatever Sessions' precise words at the March 31 meeting, Papadopoulos did not understand Sessions or anyone else in the Trump campaign to have directed that he refrain from making further efforts to arrange a meeting between the campaign and the Russian government. To the contrary, Papadopoulos told the office that he understood the campaign to be supportive of his efforts to arrange such a meeting. Accordingly, when he returned to London, Papadopoulos resumed those efforts. Throughout April 2016, Papadopoulos continued to correspond with, meet with, and seek Russia contacts through Mifsud and at times Polonskaya. For example, within a week of her initial March 24 meeting with him, Polonskaya attempted to send Papadopoulos a text message, which email exchanges showed to have been drafted or edited by Mifsud, addressing Papadopoulos', quote, wish to engage with the Russian Federation, end quote. When Papadopoulos learned from Mifsud that Polonskaya tried to message him, he sent her an email seeking another meeting. Polonskaya responded the next day that she was, quote, back in St. Petersburg, but would be very pleased to support Papadopoulos' initiatives between our two countries, end quote, and, quote, to meet him again, end quote. Papadopoulos stated in reply that he thought, quote, a good step would be to introduce him to, quote, the Russian ambassador in London, and that he would like to talk to the ambassador or anyone else you recommend about a potential foreign policy trip to Russia. Mifsud, who had been copied on the email exchanges, replied on the morning of April 11th, 2016. He wrote, and I quote, this is already been agreed. I am flying to Moscow on the 18th for a Valde meeting, plus other meetings at the Duma. We will talk tomorrow, end quote. The two bodies referenced by Mifsud are part of or associated with the Russian government. The Duma is a Russian legislative assembly, while Valde refers to the Valde Discussion Club, a Moscow-based group that is, quote, close to Russia's foreign policy establishment, end quote. Papadopoulos thanked Mifsud and said that he would see him tomorrow. For her part, Polonskaya responded that she had, quote, already alerted my personal links to our conversation and your request, end quote, and, quote, we are all very excited the possibility of a good relationship with Mr. Trump, end quote, and that, quote, the Russian Federation would love to welcome him once his candidature would be officially announced. Papadopoulos's and Mifsud's mentions of seeing each other tomorrow referenced a meeting that the two had scheduled for the next morning, April 12, 2016, at the Andaz Hotel in London. Papadopoulos acknowledged the meeting during interviews with the office, and records from Papadopoulos's UK cell phone and his internet search history all indicate that the meeting took place. Following the meeting, Mifsud traveled as planned to Moscow. On April 18, 2016, while in Russia, Mifsud introduced Papadopoulos over email to Ivan Timofeev, a member of the Russian International Affairs Council, RIAC. Mifsud had described Timofeev as having connections with the Russian Ministry of Foreign Affairs, MFA, the executive entity in Russia responsible for Russia's foreign relations. Over the next several weeks, Papadopoulos and Timofeev had multiple conversations over Skype and email about setting, quote, the groundwork, end quote, for a potential meeting between the campaign and Russian government officials. Papadopoulos told the office that on one Skype call, he believed that his connection with Timofeev was being monitored or supervised by an unknown third party because Timofeev spoke in an official manner and Papadopoulos heard odd noises on the line. Timofeev also told Papadopoulos in an April 25, 2016 email that he had just spoken to Igor Ivanov, the president of RIAC and former foreign minister of Russia, and conveyed Ivanov's advice about how best to arrange a Moscow visit. After a stop in Rome, Mifsud returned to England on April 25, 2016. The next day, Papadopoulos met Mifsud for breakfast at the Andaz Hotel, same location as their last meeting. During that meeting, Mifsud told Papadopoulos that he had met with high-level Russian government officials during his recent trip to Moscow. Mifsud also said on that trip, he learned that the Russians had obtained, quote, dirt, end quote, on candidate Hillary Clinton. As Papadopoulos later stated to the FBI, Mifsud said that the, quote, dirt, end quote, was in the form of, quote, emails of Clinton, end quote, and that they have, quote, they have thousands of emails, end quote. On May 6, 2016, 10 days after the meeting with Mifsud, Papadopoulos suggested to a representative of a foreign government that the Trump campaign had received indications from the Russian government that it could assist the campaign through the anonymous release of information that would be damaging to Hillary Clinton. Russia-related communications with the campaign. While he was discussing with his foreign contacts a potential meeting of campaign officials with Russian government officials, Papadopoulos kept campaign officials apprised of his efforts. On April 25, 2016, the day before Mifsud told Papadopoulos about the emails, Papadopoulos wrote to a senior policy advisor, Stephen Miller, that, quote, the Russian government has an open invitation by Putin for Mr. Trump to meet him when he is ready, end quote. And that, quote, the advantage of being in London is that these governments tend to speak a bit more openly in neutral cities, end quote. On April 27, 2016, after his meeting with Mifsud, Papadopoulos wrote a second message to Miller stating that, quote, some interesting messages were coming in from Moscow about a trip when the time is right, end quote. The same day, Papadopoulos sent a similar email to campaign manager Corey Lewandowski, telling Lewandowski that Papadopoulos had, quote, been receiving a lot of calls over the last month about Putin wanting to host Trump and the team when the time is right, end quote. Papadopoulos' Russia-related communications with campaign officials continued throughout the spring and summer of 2016. On May 4, 2016, he forwarded to Lewandowski an email from Timofeev raising the possibility of a meeting in Moscow, asking Lewandowski whether that was, quote, something we want to move forward with, end quote. The next day, Papadopoulos forwarded the same Timofeev email to Sam Clovis, adding to the top of the email, quote, Russia update, end quote. He included the same email in a May 21, 2016 message to senior campaign officials, the senior campaign official Paul Manafort, under the subject line, quote, request from Russia to meet with Mr. Trump, end quote, stating that, quote, Russia has been eager to meet Mr. Trump for quite some time and have been reaching out to me to discuss. Manafort forwarded the message to another campaign official without including Papadopoulos and stated, quote, let's discuss. We need someone to communicate that Trump is not doing these trips. It should be someone low-level in the campaigns so as not to send any signal," end quote. On June 1, 2016, Papadopoulos replied to an earlier email chain with Lewandowski about a Russia visit, asking if Lewandowski, quote, "wanted to have a call about this topic," end quote, and whether, quote, "we were following up with it." After Lewandowski told Papadopoulos to, quote, "connect with Clovis," because he was, quote, "running point," Papadopoulos emailed Clovis that, quote, "the Russian MFA," end quote, was asking him, quote, if Mr. Trump was interested in visiting Russia at some point, end quote. Papadopoulos wrote in an email that he, quote, "wanted to pass the info along to you for you to decide what's best to do with it and what message I should send or ignore."
After several email and Skype exchanges with Timofeyev, Papadopoulos sent one more email to Lewandowski on June 19, 2016, Lewandowski's last day as a campaign manager. The email stated that the Russian Ministry of Foreign Affairs had contacted him and asked if Mr. Trump could not travel to Russia, a campaign representative such as Papadopoulos could attend the meeting. Papadopoulos told Lewandowski that he was, open quote, "willing to make the trip off the record if it's in the interest of Mr. Trump in the campaign to meet specific people," close quote. Following Lewandowski's departure from the campaign, Papadopoulos communicated with Clovis and Walid Phrases, another member of the Foreign Policy Advisory Team, about off-the-record meetings between the campaign and Russian government officials or with Papadopoulos' other Russian connections, Misfud and Timofeyev. Papadopoulos also interacted directly with Clovis and Faris in connection with the summit of the Transatlantic Parliamentary Group on Counterterrorism, or TAG, a group for which Faris was co-secretary general. On July 16, 2016, Papadopoulos attended the TAG summit in Washington, D.C., where he sat next to Clovis, as reflected in the paragraphs below, period. Although Clovis claimed to have no recollection of attending the TAG summit, Papadopoulos remembered discussing Russia in the foreign policy trip with Clovis and Faris during the event. Papadopoulos' recollection is consistent with email sent before and after the TAG summit. The pre-summit messages included a July 11, 2016 email in which Faris suggested a meeting Papadopoulos the day after the summit to chat, and a July 12th message in the same chain in which Faris advised Papadopoulos that other summit attendees, open quote, "are very nervous about Russia, so beware," close quotes. 10 days after the summit, Papadopoulos sent an email to Misfud listing Faris and Clovis as other participants in a potential meeting at the London Academy of Diplomacy. Finally, Papadopoulos' recollection is also consistent with handwritten notes from the journal that he kept at the time. Those notes, which are reprinted in part below, appear to refer to potential September 16 meetings in London with representatives of the Office of Putin, and suggest that Faris, Clovis, and Papadopoulos would attend without the official backing of the campaign. Later communications indicated that Clovis determined that he could not travel. On August 15, 2016, Papadopoulos emailed Clovis that he had received requests from multiple foreign governments, even Russia, for closed-door workshop consultations abroad, and asked whether there was still interest from Clovis, Faris, and Papadopoulos to go on that trip. Clovis copied Faris on his response, which said that he could not travel before the election, but that he would encourage Papadopoulos and Waleed to make the trips if it is feasible. Papadopoulos was dismissed from the Trump campaign in early October 2016 after an interview he gave to the Russian news agency Interfax generated adverse publicity. Papadopoulos admitted telling at least one individual outside of the campaign, specifically the then Greek foreign minister, about Russia's obtaining Clinton-related emails. In addition, a different foreign government informed the FBI that 10 days after meeting with Ms. Food in April 2016, Papadopoulos suggested that the Trump campaign had received indications from the Russian government that it would assist the campaign through anonymously released of information that would be damaging to Hillary Clinton. This conversation occurred after the GRU spearished Clinton campaign chairman John Podesta and sold his emails. The GRU hacked into the DCCC and DNC. Such disclosures raised questions about whether Papadopoulos informed any Trump campaign officials about the email. When interviewed, Papadopoulos and the campaign officials who interacted with him told the office that they could not recall Papadopoulos sharing the information that Russia had obtained dirt on candidate Clinton in the form of emails, or that Russia could assist the campaign through the anonymous release of information about Clinton. Papadopoulos stated that he could not clearly recall having told anyone on the campaign, and wavered about whether he accurately remembered an incident in which Clovis had been upset after hearing Papadopoulos tell Clovis that Papadopoulos thought they have her emails. The campaign officials who interacted or corresponded with Papadopoulos had similarly stated with varying degrees of certainty that he did not tell them. Senior policy advisor Stephen Miller, for example, did not remember hearing anything from Papadopoulos or Clovis about Russia having emails of or dirt on candidate Clinton. Clovis stated that he did not recall anyone, including Papadopoulos, having given them non-public information that a foreign government might be in possession of material damaging to Hillary Clinton. Redaction, grand jury, redaction, grand jury. Redaction, grand jury. No documentary evidence and nothing in the email accounts or other communication facilities reviewed by the office show that Papadopoulos shared his information with the campaign. Additional George Papadopoulos contact. The office investigated another Russian-related contact with Papadopoulos. The office was not fully able to explore the contact because the individual at issue, Sergei Milan, remained out of the country since the inception of our investigation and declined to meet with members of the office despite our repeated efforts to obtain an interview. Papadopoulos first connected with Milan via LinkedIn on July 15, 2016. Shortly after Papadopoulos had attended the TAG summit with Clovis, Milan, an American citizen who is a native of Belarus, introduced himself as president of the New York-based Russian-American Chamber of Commerce and claimed that he thought that the position he had insider knowledge and direct access to the top hierarchy in Russian politics. Papadopoulos asked Timofey whether he had heard of Milan. Although Timofey said no, Papadopoulos then met Milan in New York City. The meeting took place on July 30th and August 1st, 2016. Afterwards, Milan invited Papadopoulos to attend and potentially speak at 2 international energy conferences, including one that was to be held in Moscow in September 2016. Papadopoulos ultimately did not attend either conference. On July 31st, 2016, following his first in-person meeting with Milan, Papadopoulos emailed Trump campaign official Bo Deniskic to say that he had been contacted by some leaders of Russian-American voters here in the U.S. about their interest in voting for Mr. Trump, and to ask whether he should put you in touch with other groups, Russian Chamber of Commerce. Denisic thanked Papadopoulos for taking the initiative, but asked him to hold off with the outreach of Russian Americans because too many articles had already portrayed the campaign, then campaign chairman Paul Manafort, and candidate Trump as being pro-Russian. On August 23, 2016, Milan sent a Facebook message to Papadopoulos promising that he would share with you a disruptive technology that might be instrumental in your political work for the campaign. Papadopoulos claimed to have no recollection of this matter. On November 9, 2016, shortly after the election, Papadopoulos arranged to meet Milan in Chicago to discuss business opportunities, including potential work with Russian billionaires who are not under sanctions. The meeting took place on November 14, 2016, at the Trump Hotel and Tower in Chicago. According to Papadopoulos, the two men discussed partnering on business deals, but Papadopoulos perceived that Milan's attitude towards him changed when Papadopoulos stated that he was only pursuing private sector opportunities and was not interested in a job in the administration. The two remained in contact, however, and had extended online discussions about possible business opportunities in Russia. The two also arranged to meet at a Washington, D.C. bar when both attended Trump's inauguration in late January 2017. Carter Page. Carter Page worked for the Trump campaign from January 2016 to September 2016. He was formally and publicly announced as a foreign policy advisor by the candidate in March 2016. Page had lived and worked in Russia and had been approached by Russian intelligence officers several years before he volunteered for the Trump campaign. During his time with the campaign, Page advocated pro-Russian foreign policy positions and traveled to Moscow on his personal capacity. Russian intelligence officials had formed relationships with Page in 2008 and 2013, and Russian officials may have focused on Page in 2016 because of his affiliation with the campaign. However, the investigation did not establish that Page coordinated with the Russian government in its efforts to interfere with the 2016 presidential campaign. Background. Before he began working for the campaign in January 2016, Page had substantial prior experience studying Russian policy issues and living and working in Moscow. From 2004 to 2007, Page was deputy branch manager of Merrill Lynch's Moscow office. There he worked on transactions involving Russian energy company Gazprom and came to know Gazprom's deputy chief financial officer, Sergei Yatsenko. In 2008, Page founded Global Energy Capital LLC, GEC, an investment management advisory firm focused on the energy sector in emerging markets. redaction, grand jury. The company otherwise had no source of income, and Page was forced to draw down his life savings to support himself and pursue his business venture. Page asked Yasenko to work with him at GEC as a senior advisor on a contingency basis. Grand jury redaction. In 2008, Page met Alexander Bulatov, a Russian government official who worked at the Russian consulate in New York. Page later learned that Bulatov was a Russian intelligence officer. Grand jury redaction. In 2013, Viktor Podonovyi, another Russian intelligence officer working covertly in the United States under diplomatic cover, formed a relationship with Page. Podivny met Page at an energy symposium in New York City and began to exchange emails with him. Podonovny and Page also met in person on multiple occasions, during which Page offered his outlook on the future of the energy industry and provided documents to Podovny about the energy business. In a recorded conversation on April 8, 2013, Podonovny told another intelligence officer that Page was interested in business opportunities in Russia. In Podovny's words, Page got hooked on Gazprom in thinking that if they have a project, he could rise up. Maybe he can. It's obvious that he wants to earn a lot of money. Podovny said that he had led Page on by feeding him empty promises that Podovny would use his Russian business connections to help Page. Podovny told the other intelligence officer that his method of recruiting foreign sources was to promise them favors and then discard them once he obtained relevant information from them. In 2015, Podovny and two other Russian intelligence officers were charged with conspiracy to act as an unregistered agent of a foreign government. The criminal complaint detailed Podovny's interaction with and conversations about Page, who was identified only as Male 1. Based on the criminal complaint's description of the interaction, Page was aware that he was the individual described as Male 1. Page later spoke with Russian government officials at the United Nations General Assembly and identified himself so that the official could understand that he was Male 1 from Podovny's complaint. Page told the official that he didn't do anything. Grand jury redaction. In interviews with the FBI before the office opening, Page acknowledged that he understood that the individual he had associated with were members of the Russian intelligence services, but he stated that he had only provided immaterial, non-public information to them and that he did not view this relationship as a back channel. Page told investigating agents that the more immaterial, non-public information I give them, the better for this country. In January 2016, Page began volunteering on an informal, unpaid basis for the Trump campaign after Ed Cox, a state Republican Party official, introduced Page to the Trump campaign officials. Page told the office that his goal in working on the campaign was to help candidate Trump improve relations with Russia. To that end, Page emailed campaign officials offering his thoughts on U.S.-Russia relations, prepared talking points and briefing memos on Russia, and proposed that candidate Trump meet with President Vladimir Putin in Moscow. In communications with the campaign officials, Page also repeatedly touted his high-level contacts in Russia and his ability to forge connections between candidate Trump and senior Russian government officials. For example, on January 30th, 2016, Page sent an email to senior campaign officials stating that he had spent the past week in Europe and had been in discussions with some individuals with close ties to the Kremlin who recognized that Trump could have a game-changing effect in bringing the end to the new Cold War. The email stated that through his discussions with these high-level contacts, Page believed that a direct meeting in Moscow between Mr. Trump and Putin could be arranged. Page closed the email by criticizing U.S. actions on Russia. Grand jury redaction. On March 21st, 2016, candidate Putin formally and publicly identified Page as a member of his foreign policy team to advise on Russia in the energy sector. Over the next several months, Page continued providing policy-related work product to the campaign officials. For example, in April 2016, Page provided feedback on an outline for a foreign policy speech that the candidate gave at the Mayflower Hotel. See Volume 1, Section 4, Infra A4. In May 2016, Page prepared an outline of an energy policy speech for the campaign and then traveled to Bismarck, North Dakota, to watch the candidate deliver the speech. Chief Policy Advisor Sam Clovis expressed appreciation for Page's work and praised his work on the other campaign officials. Page's affiliation with the Trump's campaign took on a higher profile and drew the attention of Russian officials after the candidate named him a foreign policy advisor. As a result, in late April 2016, Page was invited to give a speech at the July 2016 commencement ceremony at the New Economic School in Moscow, or NES. The NES commencement ceremony generally featured high-profile speakers. For example, President Barack Obama delivered a commencement address at the school in 2009. NES officials told the office that the interest in inviting Page to speak at NES was based entirely on his status as a Trump campaign advisor who served as the candidate's Russia experts. Andrzej Krikovic, an associate of Page's and an assistant professor at the Higher School of Economics in Russia, recommended that NES Rector Shlomo Weber invite Page to give the commencement address based on his connections to the Trump campaign. Denis Klimetov, an employee of NES, said that when Russians learned of Page's involvement in the Trump campaign in March 2016, the excitement was palpable. Weber recalled that in summer of 2016, there was substantial interest in the Trump campaign in Moscow, and he felt that bringing a member of the campaign to the school would be beneficial. Page was eager to accept the invitation to speak at NES, and he sought approval from the Trump campaign officials to make the trip. On May 16, 2016, while their request was still under consideration, Page emailed Clovis J.D., Gordon, and Walid Fares and suggested that candidate Trump take his place to speak at the commencement ceremony in Moscow. On June 19, 2016, Page followed up again to request approval to speak at the NES event and to reiterate that NES would love to have Mr. Trump speak at this annual celebration in Page's place. Campaign manager Corey Lewandowski responded the same day saying, "If you want to do this, it would be outside your role with the JDT for president's campaign. I'm certain Mr. Trump will not be able to attend." In early 2016, Page traveled to Russia for the NES events. On July 5th, 2016, Denis Klimetov, copying his brother Dmitry Klimetov, emailed Maria Sarakhanova, the director of the Russian Ministry of Foreign Affairs Information and Press Department, about Page's visit and his connection to the Trump campaign. Denis Klimetov said in the email that he wanted to draw the Russian government's attention to Page's visit in Moscow. His message to Zakharova continued. Page is Trump's advisor on foreign policy. He is a known businessman. He used to work in Russia. If you have any questions, I will be happy to help you contact him. Dmitry Klimetov then contacted Russian press secretary Dmitry Peskov about Page's visit to see if Peskov wanted to introduce Page to any other Russian government officials. The following day, Peskov responded to what appears to have been the same Denis Klimetov-Zakharova email thread. Peskov wrote, "I have read about Page. Specialists say that he is far from being the main one, so better not initiate a meeting in the Kremlin."
On July 7, 2016, Page delivered the first of his 2 speeches in Moscow at NES. In the speech, Page criticized the U.S. government's foreign policy toward Russia, stating that Washington and other Western capitals have impeded potential progress through their often hypocritical focus on ideas such as democratization, inequality, corruption, and regime change. On July 8, 2016, Page delivered a speech during the NES commencement. After Page delivered his commencement address, Russian Deputy Prime Minister and NES board member Arkady Dvorkovich spoke at the ceremony and stated that the sanctions the United States had imposed on Russia had hurt the NES. Page and Dvorkovich shook hands at the commencement ceremony, and Weber recalled that Dvorkovich made statements to Page about working together in the future. Page said that during his time in Moscow, he met with friends and associates he knew from when he lived in Russia, including Andrei Baranov, a former Gazprom employee who had become the head of investor relations at Rosneft, a Russian energy company. Page stated that he and Baranov talked about immaterial, non-public information. Page believed he and Baranov discussed Rosneft President Igor Sechin, and he thought Baranov might have mentioned the possibility of a sale of a stake in Rosneft in passing. Page recalled mentioning his involvement in the Trump campaign with Baranov, although he did not remember details of the conversation. Page also met with individuals from Tatneft, a Russian energy company, to discuss possible business deals, including having Page work as a consultant. On July 8, 2016, while he was in Moscow, Page emailed several campaign officials and stated he would send a readout soon regarding some incredible insights and outreach I've received from a few Russian legislators and senior members of the presidential administration here. On July 9, 2016, Page emailed Clovis, writing in pertinent part, Russian Deputy Prime Minister and NES board member Arkady Dvorkovich also spoke before the event. In a private conversation, Dvorkovich expressed strong support for Mr. Trump and a desire to work together toward devising better solutions in response to the vast range of current international problems. Based on feedback from a diverse array of other sources close to the presidential administration, it was readily apparent that this sentiment is widely held at all levels of government. Despite these representations to the campaign, redaction, the office was unable to obtain additional evidence or testimony about who Page may have met or communicated with in Moscow. Thus, Page's activities in Russia, as described in his emails with the campaign, were not fully explained. In July 2016, after returning from Russia, Page traveled to the Republican National Convention in Cleveland. While there, Page met Russian Ambassador to the United States, Sergei Kislyak. That interaction is described in Volume 1, Section 4A6A Infra. Page later emailed campaign officials with feedback he said he received from ambassadors he had met at the convention, and he wrote that Ambassador Kislyak was very worried about candidate Clinton's worldviews. Following the convention, Page's trip to Moscow and his advocacy for pro-Russia foreign policy drew the media's attention and began to generate substantial press coverage. The campaign responded by distancing itself from Page, describing him as an informal foreign policy advisor who did not speak for Mr. Trump or the campaign. On September 23, 2016, Yahoo News reported that U.S. intelligence officials were investigating whether Page had opened private communication with senior Russian officials to discuss U.S. sanctions policy under a possible Trump administration. A campaign spokesman told Yahoo News that Page had no role in the campaign and that the campaign was not aware of any of his activities, past or present. On September 24, 2016, Page was formally removed from the campaign. Although Page had been removed from the campaign, after the election, he sought a position in the Trump administration. On November 14, 2016, he submitted an application to the transition team that inflated his credentials and experiences, stating that in his capacity as a Trump campaign foreign policy advisor, he had met with top world leaders and effectively responded to diplomatic outreach efforts from senior government officials in Asia, Europe, the Middle East, Africa, and the Americas. Page received no response from the transition team. When Page took a personal trip to Moscow in December 2016, he met again with at least one Russian government official. That interaction and a discussion of the December trip are set forth in Volume 1. Members of the Trump campaign interacted on several occasions with the Center for National Interest, principally through its president and chief executive officer, Dmitry Simes. CNI is a think tank with expertise in and connections to the Russian government. Simes was born in the former Soviet Union and immigrated to the United States in the 1970s. In April 2016, candidate Trump delivered his first speech on foreign policy and national security at an event hosted by the National Interest, a publication affiliated with CNI. Then Senator Jeff Sessions and Russian Ambassador Kislyak both attended the event, and as a result, it gained some attention in relation to Sessions' confirmation hearings to become Attorney General. Sessions had various other contacts with CNI during the campaign period on foreign policy matters, including Russia. Jared Kushner also interacted with Simes about Russian issues during the campaign. The investigation did not identify evidence that the campaign passed or received any message to or from the Russian government through CNI or Simes. CNI is a Washington-based nonprofit organization that grew out of a center founded by former President Richard Nixon. CNI describes itself as a voice for strategic realism in U.S. foreign policy and publishes a bi-monthly foreign policy magazine, The National Interest. CNI is overseen by a board of directors and an advisory council that is largely honorary and whose members at the relevant time included Sessions, who served as an advisor to candidate Trump on national security and foreign policy issues. Dmitry Simes is president and CEO of CNI, and the publisher and the CEO of the National Interest. Simes was born in the former Soviet Union, emigrated to the United States in the early 1970s, and joined CNI's predecessor after working at the Carnegie Endowment for International Peace. Simes personally had many contacts with current and former Russian government officials, as does CNI collectively. As CNI stated when seeking a grant from the Carnegie Corporation in 2015, CNI has unparalleled access to Russian officials and politicians among Washington think tanks, in part because CNI has arranged for U.S. delegations to visit Russia and for Russian delegations to visit the United States as part of a so-called Track 2 diplomatic efforts. On March 14, 2016, CNI board member Richard Plepler organized a luncheon for CNI and its honorary chairman, Henry Kissinger, at the Time Warner Building in New York. The idea behind the event was to generate interest in CNI's work and recruit new board members for CNI. Along with Simmons, attended at the event included Jared Kushner, son-in-law of candidate Trump. Kushner told the office that the event came at a time when the Trump campaign was having trouble securing support from experienced foreign policy professionals, and that as a result, he decided to seek Simmons' assistance during the March 14 event. Simmons and Kushner spoke again on a March 24, 2016 telephone call, 3 days after Trump had publicly named the team of foreign policy advisors that he had been put together on short notice.
On March 31, 2016, Symes and Kushner had an in-person, one-on-one meeting in Kushner's New York office. During that meeting, Symes told Kushner that the best way to handle foreign policy issues is for the Trump campaign would be to organize an advisory group of experts to meet with candidate Trump and develop a foreign policy approach that was consistent with Trump's voice. Symes believed that Kushner was receptive to that suggestion. Symes had also had contact with other individuals associated with the Trump campaign regarding the campaign's foreign policy positions. For example, on June 17, 2016, Symes sent J.D. Gordon an email with a, quote, memo to Senator Sessions that we discussed at our meeting, at our recent meeting, end quote, and asked Gordon to both read it and share it with Sessions. The memorandum proposed building a, quote, small and carefully selected group of experts, end quote, to assist Sessions with the campaign, operating under the assumption that, quote, Hillary Clinton is very vulnerable on national security and foreign policy issues, end quote. The memorandum outlined key issues for the campaign, including a, quote, new beginning with Russia, end quote. Section B, national interest hosts a foreign policy speech at the Mayflower Hotel. During both their March 24th phone call and their March 31 in-person meeting, Symes and Kushner discussed the possibility of CNI hosting a foreign policy speech by candidate Trump. Following those conversations, Symes agreed that he and others associated with CNI would provide behind-the-scenes input on the substance of the foreign policy speech, and that CNI officials would coordinate the logistics of the speech with Sessions and his staff, including Sessions' Chief of Staff, Rick Dearborn. In mid-April 2016, Kushner put Symes in contact with Senior Policy Advisor Stephen Miller and forwarded to Symes an outline of the foreign policy speech that Miller had prepared. Symes sent back to the campaign bullet points with ideas for the speech that he had drafted with CNI Executive Director Paul Saunders and board member Richard Burt. Symes received subsequent draft outlines from Miller, and he and Saunders spoke to Miller by phone about substantive changes to the speech. It is not clear, however, whether CNI officials received an actual draft of the speech for comment. While Saunders recalled having received an actual draft, Symes did not, and the emails that CNI produced to this office do not contain such a draft. After board members expressed concern to Symes that CNI's hosting the speech could be perceived as an endorsement of a particular candidate, CNI decided to have its publication, The National Interest, serve as the host, and to have the event at the National Press Club. Kushner later requested that the event be moved to the Mayflower Hotel, which was another venue that Symes had mentioned during initial discussions with the campaign, in order to address concerns about security and capacity. On March 25, 2016, Saunders booked event rooms at the Mayflower to host both the speech and a VIP reception that was to be held beforehand. Saunders understood that the reception, at which invitees would have the chance to meet candidate Trump, would be a small event. Saunders decided who would attend by looking at the list of CNI's invitees to the speech itself, and then choosing a subset for the reception. CNI's invitees to the reception included Sessions and Kislyak. The week before the speech, Symes had informed Kislyak that he would be invited to the speech and that he would have the opportunity to meet Trump. When the pre-speech reception began on April 27th, a receiving line was quickly organized so that attendees could meet Trump. Sessions first stood next to Trump to introduce him to the members of Congress who were in attendance. After these members had been introduced, Symes stood next to Trump and introduced him to the CNI invitees in attendance, including Kislyak. Symes perceived the introduction to be positive and friendly, but thought it clear that Kislyak and Trump had just met for the very first time. Kislyak also met Kushner during the pre-speech reception. The two shook hands and chatted for a minute or two, during which Kushner recalled Kislyak saying, "We like what your candidate is saying." We quote, "We like what your candidate is saying. It's refreshing," end quote. Several public reports state that in addition to speaking to Kushner at the pre-speech reception, Kislyak also met or conversed with Sessions at that time. Sessions stated to investigators, however, that he did not remember any such conversation, nor did anyone else affiliated with CNI or the national interest specifically recall a conversation or meeting between Sessions and Kislyak at the pre-speech reception. It appears that if a conversation occurred at the pre-speech reception, it was a brief one conducted in public view, similar to the exchange between Kushner and Kislyak. The office found no evidence that Kislyak conversed with either Trump or Sessions after the speech, or would have had the opportunity to do so. Symes, for example, did not recall seeing Kislyak at the post-speech luncheon, and the only witness who accounted for Sessions' whereabouts stated that Sessions may have spoken to the press after the event, but then departed for Capitol Hill. Saunders recalled, based in part on a food-related request he received from a campaign staffer, that Trump left the hotel a few minutes after the speech to go to the airport. Section C, Jeff Sessions' post-speech interactions with CNI. In the wake of Sessions' confirmation hearings as Attorney General, questions arose about whether Sessions' campaign period interactions with CNI, apart from the Mayflower speech, included any additional meetings with Ambassador Kislyak or involved Russian-related matters. With respect to Kislyak contacts, on May 23, 2016, Sessions attended CNI's Distinguished Service Award dinner at the Four Seasons Hotel in Washington, D.C. Sessions attended a pre-dinner reception and was seated at one of two head tables for the event. A seating chart prepared by Saunders indicates that Sessions was scheduled to be seated next to Kislyak, who appears to have responded to the invitation by indicating he would attend the event. Sessions, however, did not remember seeing, speaking with, or sitting next to Kislyak at the dinner. Although CNI board member Charles Boyd said he may have seen Kislyak at the dinner, Symes, Saunders, and Jacob Heilbrunn, editor of the National Interest, all had no recollection of seeing Kislyak at the May 23rd event. Kislyak also does not appear in any of the photos from the event that the office obtained. In the summer of 2016, CNI organized at least two dinners in Washington, D.C. for Sessions to meet with experienced foreign policy professionals. The dinners included CNI-affiliated officials such as Richard Burt and Zalmay Khalilzad, a former U.S. ambassador to Afghanistan and Iraq, and the person who had introduced Trump before the April 27, 2016 foreign policy speech. Khalilzad also met with Sessions one-on-one separately from the dinners. At the dinners and in the meetings, the participants addressed U.S. relations with Russia, including how U.S. relations with NATO and European countries affected U.S. policy toward Russia. But the discussions were not exclusively focused on Russia. Khalilzad, for example, recalled discussing, quote, nation building, unquote, and violent extremism with Sessions. In addition, Sessions asked Saunders of CNI to draft 2 memoranda not specific to Russia, one on Hillary Clinton's foreign policy shortcomings and another on Egypt.
Between the April 2016 speech at the Mayflower Hotel and the presidential election, Jared Kushner had periodic contacts with Samis. These contacts consisted both in-person meetings and phone conversations, which concerned how to address issues related to Russia in the campaign and how to move forward with the advisory group of foreign policy experts that Samis had proposed. Samis recalled that he, not Kushner, initiated all conversations about Russia, and that Kushner never asked him to set up back-channel conversations with the Russians. According to Samis, after the Mayflower speech in late April, he raised the issue of Russian contacts with Kushner, advised that it was bad optics for the campaign to develop hidden Russian contacts, and told Kushner both that the campaign should not highlight Russia as an issue and should handle any contacts with Russians with care. Kushner generally provided a similar account of his interactions with Samis. Among the Kushner-Samis meetings was one held on August 17, 2016, at Samis' request, in Kushner's New York office. The meeting was to address foreign policy advice that CNI was providing and how to respond to the Clinton campaign's Russian-related attacks on candidate Trump. In advance of the meeting, Samis sent Kushner a Russian policy memo laying out what Mr. Trump may want to say about Russia. In a covered email transmitting that memo and a phone call to set up the meeting, Samis mentioned a well-documented story of highly questionable connections between Bill Clinton and the Russian government, parts of which, according to Samis, had even been discussed with the CIA and the FBI in the late 1990s and shared with the independent counsel at the end of the Clinton presidency. Kushner forwarded the email to senior Trump campaign officials Stephen Miller, Paul Manafort, and Rick Gates, with the note, "Suggestion only." Manafort subsequently forwarded the email to his assistant and scheduled a meeting with Samis. Manafort was on the verge of leaving the campaign by the time of the scheduled meeting with Samis, and Samis ended up meeting only with Kushner. During the August 17th meeting, Samis provided Kushner the Clinton-related information that he had promised. Samis told Kushner, this is didactous, Samis claimed that he had received his information from former CIA and Reagan White House official Fritz Erdmars, who claimed to have learned it from U.S. intelligence sources, not from the Russians. Samis perceived that Kushner did not find the information to be of interest or use to the campaign because it was, in Samis' world, old news. When interviewed by the office, Kushner stated that he believed that there was little chance of something new being revealed about the Clintons, given their long career as public figures, and that he never received from Samis information that could be operationalized for the Trump campaign. Despite Kushner's redaction, Samis believed that he provided the same information at a small group meeting of foreign policy experts that CNI organized for Sessions. On June 9th, 2016, senior representatives of the Trump campaign met in Trump Tower with a Russian attorney expecting to receive derogatory information about Hillary Clinton from the Russian government. The meeting was proposed to Donald Trump Jr. in an email from Robert Goldstone at the request of his then contact, Amin Agalarov, the son of a Russian real estate developer. Goldstone relayed to Trump Jr. that the Crown Prosecutor of Russia offered to provide the Trump campaign with some official documents and information that would incriminate Hillary and her dealings with Russia as part of Russia and its government support for Mr. Trump. Trump Jr. immediately responded, "If it's what you say, I love it," and arranged the meeting through a series of emails and telephone calls. Trump Jr. invited campaign chairman Manafort and senior advisor Jared Kushner to attend the meeting, and both attended. Members of the campaign discussed the meeting before it occurred, and Michael Cohen recalled that Trump Jr. may have told the candidate Trump about an upcoming meeting to receive adverse information about Clinton, without linking the meeting to Russia. According to written answers submitted by President Trump, he had no recollection of the meeting, of learning of the meeting at that time, and the office found no documented evidence showing that he was made aware of the meeting or its Russian connection before it occurred. The Russian attorney who spoke at the meeting, Natalia Veselinkaya, had previously worked for the Russian government and maintained a relationship with that government throughout this period of time. She claimed the funds derived from illegal activities in Russia were provided to Hillary Clinton and other Democrats. Trump Jr. requested evidence to support those claims, but she did not provide such information. She and her associates then turned to a critique of the origins of the Magnitsky Act, a 2012 statute that imposed financial and travel sanctions on Russian officials and that resulted in retaliatory ban on adoptions of Russian children. Trump Jr. suggested that the issue could be revisited when and if the candidate Trump was elected. After the election, she made additional efforts to follow up on the meeting, but the Trump transition team did not engage. Aras Agalarov is a Russian real estate developer with ties to Putin and other members of the Russian government, including Russia's Prosecutor General Yuri Cheka. Aras Agalarov is the president of the Crocus Group, a Russian enterprise that holds substantial Russian government construction contracts, and that, as discussed above in Volume 1, Section 4, worked with Trump in connection with the 2013 Miss Universe pageant in Moscow and a potential Trump-Moscow real estate project. The relationship continued over time as the parties pursued the Trump-Moscow project in 2013 to 2014 and exchanged gifts and letters in 2016. For example, in April of 2016, Trump responded to a letter from Aras Agalarov with a handwritten note. Aras Agalarov expressed interest in the Trump's campaign and passed on congratulations for winning the primary, and according to one email drafted by Goldstone, an offer of his support and that of many of his important Russian friends and colleagues, especially with reference to US-Russian relations. On June 3rd, 2016, Amin Agalarov called Goldstone, Amin's then publicist. Goldstone is a music and events promoter who represented Amin from approximately the late 2012 until the late 2016. While representing Amin Agalarov, Goldstone facilitated the ongoing contact between the Trumps and the Agalarovs, including an invitation that Trump sent to Putin to attend the 2013 Miss Universe pageant in Moscow. There is a set of redactions. Goldstone understood a Russian political connection, and Amin Agalarov indicated that the attorney was a prosecutor. Goldstone recalled that the information might interest Trumps involved in Hillary Clinton. We've got some redactions here. The redaction mentioned by Amin Al-Groaf was Natalie. Yes. Yeah. Okay. Why don't you start here?
Thank you, Representative Srilela. We're going to continue reading their special counsel's report. The redacted mentioned by Emin Agalov was Natalia Veselnitskaya. From approximately 1998 until 2001, Veselnitskaya worked as a prosecutor for the Central Administrative District of the Russian Prosecutor's Office, and she continued to perform government-related work and maintain ties to the Russian government following her departure. She lobbied and testified about the Magnitsky Act, which imposed financial sanctions and travel restrictions on Russian officials, and which was named for a Russian tax specialist who exposed a fraud and later died in a Russian prison. Putin called the statute a purely political, unfriendly act, and Russia responded by barring a list of current and former U.S. officials from entering Russia and by halting the adoption of Russian children by U.S. citizens. Veselnitskaya performed legal work for Denis Katsev, the son of Russian businessman Peter Katsev, and for his company, President Holdings Ltd., which was a defendant in a civil forfeiture action alleging the laundering of proceeds from the fraud exposed by Magnitsky. She also appears to have been involved in an April 2016 approach to a U.S. congressional delegation in Moscow offering confidential information from the Prosecutor General of Russia about interactions between certain political forces in our two countries. Shortly after his June 3rd call with Emin Agalarov, Goldstone emailed Trump Jr. The email stated, "Good morning. Emin just called and asked me to contact you with something very interesting. The Crown Prosecutor of Russia met with his father, Aris, this morning, and in their meeting offered to provide the Trump campaign with some official documents and information that would incriminate Hillary and her dealings with Russia and would be very useful to your father. This is obviously very high level and sensitive information, but as part of Russia and its government's support for Mr. Trump, helped along by Aris and Emin." Whoa, I just have to read that again. This is obviously very high level and sensitive information, but as part of Russia and its government's support for Mr. Trump, helped along by Aris and Emin. What do you think is the best way to handle this information, and would you be able to speak to Emin about it directly? I can also send this info to your father via Rhoda, but it is ultra sensitive, so wanted to send to you first. Best, Rob Goldstone. Within minutes of this email, Trump Jr. responded, emailing back, "Thanks, Rob, I appreciate that. I am on the road at the moment, but perhaps I could just speak to Emin first. Seems we have some time, and if it's what you say, I love it, especially later in the summer." I just have to read that again. Trump Jr. says, "Seems we have some time, and if it's what you say, I love it, especially later in the summer. Could we do a call first thing next week when I am back?" Goldstone conveyed Trump Jr.'s interest to Emin Agalov, emailing that Trump Jr. wants to speak personally on their issue. On June 6, 2016, Emin Agalarov asked Goldstone if there was any news, and Goldstone explained that Trump Jr. was likely still traveling for the final elections where Trump will be crowned the official nominee. On the same day, Goldstone again emailed Trump Jr. and asked when Trump Jr. was free to talk with Emin about this Hillary info. Trump Jr. asked if they could speak now, and Goldstone arranged a call between Trump Jr. and Emin Agalarov. On June 6 and June 7, Trump Jr. and Emin Agalarov had multiple brief calls. Also on June 6, 2016, Aris Aglarov called Ike Kaveladaz and asked him to attend a meeting in New York with the Trump Organization. Kaveladaz is a Georgia-born, naturalized U.S. citizen who worked in the United States for the Crocus Group and reported to Aris Aglarov. Kaveladaz told the office that in a second phone call on June 6, 2016, Aris Aglarov asked Kaveladaz if he knew anything about the Magnitsky Act, and Aris sent him a short synopsis for the meeting and Vesselnitskaya's business card. According to Kaveladaz, Aris Aglarov said the purpose of the meeting was to discuss the Magnitsky Act, and he asked Kaveladaz to translate. On June 7th, Goldstone emailed Trump Jr. and said that Eman asked that I schedule a meeting with you and the Russian government attorney who is flying over from Moscow. Trump Jr. replied that Manafort, identified as the campaign boss, Jared Kushner, and Trump Jr. would likely attend. Goldstone was surprised to learn that Trump Jr., Manafort, and Kushner would attend. Kaveladaz redacted. Puzzled by the list of attendees and that he checked with one of Eman Aglarov's assistants, Roman Benyaminov, who said that the purpose of the meeting was for Vesselnitskaya to convey negative information on Hillary Clinton. Benyaminov, however, said he did not recall having known or said that. Early on June 18, 2016, Kushner emailed his assistant asking her to discuss a 3 p.m. meeting the following day with Trump Jr. Later that day, Trump Jr. forwarded the entirety of his email correspondence regarding the meeting with Goldstone to Manafort and Kushner under the subject line, Forward, Russia, Clinton, Private and Confidential, adding a note that the meeting got moved to 4 p.m. tomorrow at my offices. Kushner then sent his assistant a second email informing her that the meeting with Don Jr. is 4 p.m. now. Manafort responded, see you then, P. Rick Gates, who was the deputy campaign chairman, stated during interviews with the office that in the days before June 9, 2016, Trump Jr. announced at a regular morning meeting of senior campaign staff and Trump family members that he had a lead on negative information about the Clinton Foundation. Gates believed that Trump Jr. said the information was coming from a group in Kyrgyzstan and that he was introduced to the group by a friend. Gates recalled that the meeting was attended by Trump Jr., Eric Trump, Paul Manafort, Hope Hicks, and joining late, Ivanka Trump and Jared Kushner. According to Gates, Manafort warned the group that a meeting likely would not yield vital information and they should be careful. Hicks denied any knowledge of the June meeting before 2017, and Kushner did not recall if the planned June 9th meeting came up at all earlier that week. Michael Cohen recalled being in Donald J. Trump's office on June 6th or 7th when Trump Jr. told his father that a meeting to obtain adverse information about Clinton was going forward. Cohen did not recall Trump Jr. stating the meeting was connected to Russia. From the tenor of the conversation, Cohen believed that Trump Jr. had previously discussed the meeting with his father, although Cohen was not involved in any such conversation. In an interview with the Senate Judiciary Committee, however, Trump Jr. stated that he did not inform his father about the emails or the upcoming meeting. Similarly, neither Manafort nor Kushner recalled anyone informing candidate Trump of the meeting, including Trump Jr. President Trump has stated to this office in written answers to questions that he has no recollection of learning at the time that his son, Manafort Kushner, was considering participating in a meeting in June 2016 concerning potentially negative information about Hillary Clinton. Vesselnitskaya was in New York on June 9, 2016 for appellate proceedings in a Preservan civil forfeiture litigation. That day, Vesselnitskaya called Rinat Akhmetshin, a Soviet-born U.S. lobbyist, redacted, and when she learned that he was in New York, invited him to lunch. Akhmetshin told the office that he had worked on issues relating to the Magnitsky Act and had worked on a Prevezan litigation. Kaveladaz and Anatoly Semekonov, a Russian-born translator who had assisted Vesselnitskaya with Magnitsky-related lobbying in the Preservan case, also attended the lunch. Redacted. Vesselnitskaya said she was meeting, all redacted, and asked Akhmetshin what she should tell him. According to several participants in the lunch, Vesselnitskaya showed Akhmetshin a document alleging financial misconduct by Bill Browder and the Ziff brothers, Americans with business in Russia, and those individuals subsequently making political donations to the DNC, redacted. The group then went to Trump Tower for the meeting. Trump Jr., Manafort, and Kushner participated on the Trump side, while Kavaladaz, Samakornov, Ametchin, and Goldstone attended with Veselnitskaya. The office spoke to every participant except Veselnitskaya and Trump Jr., the latter of whom declined to be voluntarily interviewed by their office. Redacted. The meeting lasted approximately 20 minutes. More redactions. Goldstone recalled that Trump Jr. invited Veselnitskaya to begin, but did not say anything about the subject of the meeting. Participants agreed that Veselnitskaya stated that the Ziff brothers had broken Russian laws and had donated their profits to the DNC of the Clinton campaign. She asserted that the Ziff brothers had engaged in tax evasion and money laundering in both the United States and Russia. More redactions. According to Ametchin, Trump Jr. asked follow-up questions about how the alleged payments could be tied specifically to the Clinton campaign, but Veselnitskaya indicated that she could not trace the money once it entered the United States. Kavaladaz similarly recalled that Trump Jr. asked what they have on Clinton, and Kushner became aggravated and asked, "What are we doing here?" Ametchin then spoke about U.S. sanctions imposed under the Magnitsky Act and Russia's response prohibiting U.S. adoption of Russian children. Several participants recalled that Trump Jr. commented that Trump is a private citizen and there was nothing they could do at that time. Trump Jr. also said they could revisit the issue if and when they were in government. Notes that Manafort took on his phone reflect the general flow of the conversation, although not all of its details. At some point in the meeting, Kushner sent an iMessage to Manafort stating, "Waste of time," followed immediately by 2 separate emails to assistants at Kushner companies with requests that they call him to give him an excuse to leave. Samakornov recalled that Kushner departed the meeting before it concluded. Veselnitskaya recalled the same when interviewed by the press in July 2017. Veselnitskaya's press interviews and written statements to Congress differ materially from other accounts. In the July 2017 press interview, Veselnitskaya claimed that she had no connection to the Russian government and had not referred to any derogatory information concerning the Clinton campaign when she met with Trump campaign officials. Veselnitskaya's November 2017 written submission to the Senate Judiciary Committee stated the purpose of the June 9th meeting was not to connect with the Trump campaign, but rather to have a private meeting with Donald Trump Jr., a friend of my good acquaintance's son, on the matter of assisting me or my colleagues in informing the Congress members as to the criminal nature of manipulation and interference with the legislative activities of the U.S. Congress. In other words, Veselnitskaya claimed her focus was on Congress and not the campaign. No witness, however, recalled any reference to Congress during the meeting. Veselnitskaya also maintained that she attended the meeting as a lawyer of Denise Katsev, the previously mentioned owner of Prevezon Holdings, but she did not introduce herself in this capacity. In a July 2017 television interview, Trump Jr. stated that while he had no way to gauge the reliability, credibility, or accuracy of what Goldstone had stated was the purpose of the meeting, if someone has information on our opponent, maybe this is something. I should hear them out. Trump Jr. further stated in September 2017 congressional testimony that he thought he should listen to what Rob and his colleagues had to say. Depending on what, if any, information was provided, Trump Jr. said he could then consult with counsel to make an informed decision as to whether to give it any further consideration. After the June 9th meeting concluded, Goldstone apologized to Trump Jr. According to Goldstone, he told Trump Jr., redacted, and told Eamon Agalarov in a phone call that the meeting was about adoption, more redactions. Aras Agalarov asked Kavaladaz to report in after the meeting, but before Kavaladaz could call, Aras Agalarov called him. With Veselnitskaya next to him, Kavaladaz reported that the meeting had gone well, but he later told Aras Agalarov that the meeting about the Magnitsky Act had been a waste of time because it was not with lawyers and they were preaching to the wrong crowd. Veselnitskaya and Aras Agalarov made at least 2 unsuccessful attempts after the election to meet with Trump representatives to convey similar information about Browder and the Magnitsky Act. On November 23, 2016, Kavaladaz emailed Goldstone about setting up another meeting with T people and sent a document bearing allegations similar to those conveyed on June 9th. Kavaladaz followed up with Goldstone stating that Mr. A, which Goldstone understood to mean Aras Agalarov, called to ask about the meeting. Goldstone emailed the documents to Rona Graff saying that Aras Agalarov had asked me to pass on this document in the hope it could be passed on to the appropriate team. If needed, a lawyer representing the case is in New York currently and happy to meet with any member of his transition team. According to Goldstone, around January 2017, Kevin Laz contacted him again to set up another meeting, but Goldstone did not make the request. The investigation did not identify evidence of the transition team follow-up. Participants in the June 9, 2016 meeting began receiving inquiries from attorneys representing the Trump Organization starting in approximately June 2017. On approximately June 2nd, 2017, Goldstone spoke with Alan Garten, General Counsel of the Trump Organization, about his participation in the June 9th meeting. The same day, Goldstone emailed Veselnitskaya's name to Garten, identifying her as the woman who was the attorney who spoke at the meeting from Moscow. Later in June 2017, Goldstone participated in a lengthier call with Garten and Alan Futerfus, outside counsel for the Trump Organization, and subsequently personal counsel for Trump Jr. On June 27, 2017, Goldstone emailed Eamon Agalarov with the subject, Trump attorneys, and stated that he was interviewed by attorneys about the June 9th meeting who were concerned because it links Don Jr. to officials from Russia, which he has always denied meeting. Goldstone stressed that he did not say at the time that was an awful idea and a terrible meeting. Eamon Agalarov sent a screenshot of the message to Kevin Laz. The June 9th meeting became public in July 2017. In July 9, 2017 text message to Eamon Agalarov, Goldstone wrote, I made sure I kept you and your father out of this story. And if contacted, I can do a dance and keep you out of it. Goldstone added, FBI now investigating, and I hope this favor was worth for your dad. It could blow up. On July 12, 2017, Eamon Agalarov complained to Kevin Laz that his father, Aris, never listens to him and that the relationship with Mr. T has been thrown down the drain. The next month, Goldstone commented to Eamon Agalarov about the volume of publicity the June 9th meeting had generated, stating that his reputation was basically destroyed by this dumb meeting, which your father insisted on, even though Ike and me told him it would be bad news and not to do. Goldstone added, I am not to respond out of courtesy to you and your father, so I'm painted as some mysterious link to Putin. After public reporting on June 9th meeting began, representatives from the Trump Organization again reached out to participants. On June 10, 2017, Futerfus sent Goldstone an email with a proposed statement for Goldstone to issue, which read, as a person who arranged the meeting, I can definitely state that the statements I have read by Donald Trump Jr. are 100% accurate. The meeting was a complete waste of time, and Don was never told Ms. Veselnitskaya's name prior to the meeting. Ms. Veselnitskaya mostly talked about the Magnitsky Act and Russian adoption laws. The meeting lasted 20, 30 minutes at most. There was never any follow-up, and nothing ever came of the meeting. Redacted, the statement drafted by Trump Organization representatives was redacted. He proposed a different statement, asserting that he had been asked by his client in Moscow, Eamon Agalarov, to facilitate a meeting between a Russian attorney, Natalia Naskalov, and Donald Trump Jr. The lawyer had apparently stated that she had some information regarding funding to the DNC from Russia, which she believed Mr. Trump Jr. might find interesting. Goldstone never released either statement. Start right there.
On the Russian end, there were also communications about what participants should say about the June 9 meeting. Specifically, the organization that hired Samo Kornov, an anti-Magnitsky Act group controlled by Veselnitskaya, and the owner of Prevezon, offered to pay $90,000 of Samo Kornov's legal fees. At Veselnitskaya's request, the organization sent Samo Kornov a transcript of a Veselnitskaya press interview, and Samo Kornov understood that the organization would pay his legal fees only if he made statements consistent with Veselnitskaya's. Samo Kornov declined, telling the office that he did not want to perjure himself. The individual who conveyed Veselnitskaya's request to Samo Kornov stated that he did not expressly condition payment on following Veselnitskaya's answers, but in hindsight, recognized that by sending the transcript, Samo Kornov could have interpreted the offer of assistance to be conditioned on his not contradicting Veselnitskaya's account. Volume 2, Section 2G, discusses interactions between President Trump, Trump Jr., and others in June and July 2017 regarding the June 9 meeting. Events at the Republican National Convention. Trump campaign officials met with Russia Ambassador Sergei Kislyak during the week of the Republican National Convention. The evidence indicates that those interactions were brief and non-substantive. During platform committee meetings immediately before the convention, J.D. Gordon, a senior campaign advisor on policy and national security, diluted a proposed amendment to the Republican Party's platform expressing support for providing lethal assistance to Ukraine in response to Russian aggression. Gordon requested that platform committee personnel revise the proposed amendment to state that only appropriate assistance be provided to Ukraine. The original sponsor of the lethal assistance amendment stated that Gordon had told her, the sponsor, that he was on the phone with candidate Trump in connection with his request to dilute the language. Gordon denied making that statement to the sponsor, although he acknowledged it was possible he mentioned having previously spoken to the candidate about the subject matter. The investigation did not establish that Gordon spoke to or was directed by the candidate to make that proposal. Gordon said that he sought the change because he believed the proposed language was inconsistent with Trump's position on Ukraine. Ambassador Kislyak's encounters with Senator Sessions and J.D. Gordon the week of the RNC. In July 2016, Senator Sessions and Gordon spoke at the Global Partners in Diplomacy event, a conference co-sponsored by the State Department and the Heritage Foundation held in Cleveland, Ohio, the same week as the Republican National Convention, RNC or convention. Approximately 80 foreign ambassadors of the United States, including Kislyak, were invited to the conference. On July 20, 2016, Gordon and Sessions delivered their speeches at the conference. In his speech, Gordon stated in pertinent part that the United States should have better relations with Russia. During Sessions' speech, he took questions from the audience, one of which may have been asked by Kislyak. When the speech is concluded, several ambassadors lined up to greet the speakers. Gordon shook hands with Kislyak and reiterated that he meant what he said in the speech about improving U.S.-Russia relations. Sessions separately spoke with between 6 and 12 ambassadors, including Kislyak. Although Sessions stated during interviews with the office that he had no specific recollection of what he discussed with Kislyak, he believed that the two spoke for only a few minutes and that they would have exchanged pleasantries and said some things about U.S.-Russia relations. Later that evening, Gordon attended a reception as part of the conference. Gordon ran into Kislyak as the two prepared plates of food, and they decided to sit at the same table to eat. They were joined at the table by the ambassadors from Azerbaijan and Kazakhstan and by Trump campaign advisor Carter Page. As they ate, Gordon and Kislyak talked for what Gordon estimated to have been 3 to 5 minutes, during which Gordon again mentioned that he meant what he said in his speech about improving U.S.-Russia relations. Change to Republican Party platform. In preparation for the 2016 convention, foreign policy advisors to the Trump campaign, working with the Republican National Committee, reviewed the 2012 convention's foreign policy platform to identify divergence between the earlier platform and candidate Trump's position. The campaign team discussed toning down language from the 2012 platform that identified Russia as the country's #1 threat, given the candidates' belief that there needed to be a better U.S. relations with Russia. The RNC Platform Committee sent the 2016 draft to the National Security and Defense Platform Subcommittee on July 10, 2016, the evening before its first meeting to propose amendments. Although only delegates could participate in formal discussions and vote on the platform, the Trump campaign could request changes, and members of the Trump campaign attended committee meetings. John Masburn, the campaign's policy director, helped oversee the campaign's involvement in the platform committee meetings. He told the office that he directed campaign staff at the convention, including J.D. Gordon, to take a hands-off approach and only to challenge platform planks if they directly contradicted Trump's wishes. On July 11, 2016, Delegate Diane Denman submitted a proposed platform amendment that included provisions of armed support for Ukraine. The amendment described Russia's ongoing military aggression in Ukraine and announced support for maintaining and, if warranted, increasing sanctions against Russia until Ukraine's sovereignty and territorial integrity are fully restored, and for providing lethal defensive weapons to Ukraine's armed forces and greater coordination with NATO on defense planning. Gordon reviewed the proposed platform changes, including Denman's. Gordon stated that he flagged this amendment because of Trump's stated position on Ukraine, which Gordon personally heard the candidates say at the March 31 foreign policy meeting, namely that the Europeans should take primary responsibility for any assistance to Ukraine, that there should be improved U.S.-Russia relations, and that he did not want to start World War III over that region. Gordon told the office that Trump's statements on the campaign trail following the March meeting underscored those positions to the point where Gordon felt obliged to object to the proposed platform change and seek its dilution. On July 11, 2016, at a meeting of the National Security and Defense Platform Subcommittee, Denman offered her amendment. Gordon and another campaign staffer, Matt Miller, approached a committee co-chair and asked him to table the amendment to permit further discussion. Gordon's concern with the amendment was the language about providing lethal defensive weapons to Ukraine. Miller did not have any independent basis to believe that this language contradicted Trump's views and relied on Gordon's recollection of the candidate's views. According to Denman, she spoke with Gordon and Matt Miller, and they told her that they had to clear the language and that Gordon was talking to New York. Denman told others that she was asked by two Trump campaign staffers to strike lethal defense weapons from the proposal, but that she refused. Denman recalled Gordon saying that he was on the phone with candidate Trump, but she was skeptical whether that was true. Gordon denied having told Denman that he was on the phone with Trump, although he acknowledged it was possible that he had mentioned having previously spoken to the candidate about the subject matter. Gordon's phone records revealed a call to Sessions' office in Washington that afternoon, but do not include calls directly to a number associated with Trump. And according to the president's written answers to the office question, he does not recall being involved in the change in language of the platform amendment.
Gordon stated that he tried to reach Rick Dearborn, a senior foreign policy advisor, and Mashburn, the campaign policy director. Gordon stated that he connected with both of them. He could not recall if by phone or in person, and apprised them of the language he took issue with in the proposed amendment. Gordon recalled no objection by either Dearborn or Mashburn, and that all three campaign advisors supported the alternative formulation, quote, appropriate assistance. Dearborn recalled Gordon warning them about the amendment, but not weighing in because Gordon was more familiar with the campaign's foreign policy stance. Mashburn stated that Gordon reached him and he told Gordon that Trump had not taken a stance on the issue and that the campaign should not intervene. When the amendment came up again in the committee's proceedings, the subcommittee changed the amendment by striking the, quote, lethal defense weapons, end quote, language, and replacing it with, quote, appropriate assistance, end quote. Gordon stated that he and the subcommittee co-chair ultimately agreed to replace the language about armed assistance with appropriate assistance. The subcommittee accordingly approved Denman's amendment, but with the term appropriate assistance. Gordon stated that to his recollection, this was the only change sought by the campaign. Sam Clovis, the campaign's national co-chair and chief policy advisor, stated he was surprised by the change and did not believe it was in line with Trump's stance. Mashburn stated that when he saw the word appropriate assistance, he believed that Gordon had violated Mashburn's directive not to intervene. 7, post-convention contacts with Kislyak. Ambassador Kislyak continued his efforts to interact with campaign officials with responsibility for the foreign policy portfolio, among them Sessions and Gordon, in the weeks after the convention. The office did not identify evidence in those interactions of coordination between the campaign and the Russian government. 7A, Ambassador Kislyak invites J.D. Gordon to breakfast at the ambassador's residence. On August 3, 2016, an official from the Embassy of the Russian Federation in the United States wrote to Gordon, quote, on behalf of, end quote, Ambassador Kislyak, inviting Gordon to, quote, have breakfast tea with the ambassador at his residence, end quote, in Washington, D.C. the following week. Gordon responded 5 days later to decline the invitation. He wrote, quote, these days are not optimal for us, as we are busily knocking down a constant stream of false media stories while also preparing for the first debate with HRC. Hope to take a rain check for another time when things quiet down a bit. Please pass along my regards to the ambassador, end quote. The investigation did not identify evidence that Gordon made any other arrangements to meet or met with Kislyak after this email. 7B, Senator Sessions' September 2016 meeting with Ambassador Kislyak. Also in August 2016, a representative of the Russian embassy contacted Sessions' Senate office about setting up a meeting with Kislyak. At the time, Sessions was a member of the Senate Foreign Relations Committee and would meet with foreign officials in that capacity. But Sessions' staff reported, and Sessions himself acknowledged, that meeting requests from ambassadors increased substantially in 2016 as Sessions assumed a prominent role in the Trump campaign and his name was mentioned for potential cabinet-level positions in a future Trump administration. On September 8, 2016, Sessions met with Kislyak in his Senate office. Sessions said that he believed he was doing the campaign a service by meeting with foreign ambassadors, including Kislyak. He was accompanied in the meeting by at least 2 of his Senate staff, Sandra Luff, his legislative director, and Pete Landrum, who handled military affairs. The meeting lasted less than 30 minutes. Sessions voiced concerns about Russia's sale of a missile defense system to Iran, Russian planes buzzing U.S. military assets in the Middle East, and Russian aggression in emerging democracies such as Ukraine and Moldova. Kislyak offered explanations on these issues and complained about NATO land forces in former Soviet bloc countries that border Russia. Landrum recalled that Kislyak referred to the presidential campaign as, quote, an interesting campaign, end quote. And Sessions also recalled Kislyak saying that the Russian government was receptive to the overtures Trump had laid out during his campaign. None of the attendees, though, remembered any discussion of Russian election interference or any request that Sessions convey information from the Russian government to the Trump campaign. During the meeting, Kislyak invited Sessions to further discuss U.S.-Russia relations with him over a meal at the ambassador's residence. Sessions was non-committal when Kislyak extended the invitation. After the meeting ended, Luff advised Sessions against accepting the one-on-one meeting with Kislyak, whom she assessed to be an, quote, old-school KGB guy, end quote. Neither Luff nor Landrum recalled that Sessions followed up on the invitation or made any further effort to dine or meet with Kislyak before the November 2016 election. Sessions and Landrum recalled that after the election, some efforts were made to arrange a meeting between Sessions and Kislyak. According to Sessions, the request came through CNI and would have involved a meeting between Sessions and Kislyak, two other ambassadors, and the governor of Alabama. Sessions, however, was in New York on the day of the anticipated meeting and was unable to attend. The investigation did not identify evidence that the two men met at any point after their September 8th meeting. Section 8, Paul Manafort. Paul Manafort served on the Trump campaign, including a period as campaign chairman from March to August 2016. Manafort had connections to Russia through his prior work for Russian oligarch Oleg Deripaska, and later through his work for a pro-Russian regime in Ukraine. Manafort stayed in touch with these contacts during the campaign period through Konstantin Kilimnik, a longtime Manafort employee who previously ran Manafort's office in Kiev and who the FBI assesses to have ties to Russian intelligence. Manafort instructed Rick Gates, his deputy on the campaign and a longtime employee, to provide Kilimnik with updates on the Trump campaign, including internal polling data, although Manafort claims not to recall that specific instruction. Manafort expected Kilimnik to share that information with others in Ukraine and with Deripaska. Gates periodically sent such polling data to Kilimnik during the campaign. Manafort also twice met with Kilimnik in the United States during the campaign period and conveyed campaign information. The second meeting took place on August 2nd, 2016, in New York City. Kilimnik requested the meeting to deliver in person a message from former Ukrainian President Viktor Yanukovych, who was then living in Russia. The message was about a peace plan for Ukraine that Manafort has since acknowledged was a, quote, backdoor means for Russia to control eastern Ukraine. Several months later, after the presidential election, Kilimnik wrote an email to Manafort expressing the view, which Manafort later said he shared, that the plan's success would require U.S. support to succeed. Quote, all that is required to start the process is a very minor wink or slight push from Donald Trump, end quote. The email also stated that if Manafort were designated as the U.S. representative and started the process, Yanukovych would ensure his reception in Russia, quote, at the very top level. Manafort communicated with Kilimnik about peace plans for Ukraine on at least 4 occasions after their first discussion of the topic on August 2nd. December 2016, the Kilimnik email described above, January 2017, February 2017, and again in the spring of 2018. The office reviewed numerous Manafort email and text communications and asked President Trump about the plan in written questions. The investigation did not uncover evidence of Manafort's passing along information about Ukrainian peace plans to the candidate or anyone else in the campaign or the administration. The office was not, however, able to gain access to all of Manafort's electronic communications. In some instances, messages were sent using encryption applications. And while Manafort denied that he spoke to members of the Trump campaign or the new administration about the peace plan, he lied to the office and the grand jury about the peace plan and his meetings with Kilimnik. And his unreliability on this subject was among the reasons that the district judge found that he breached his cooperation agreement. The office could not reliably determine Manafort's purpose in sharing internal polling data with Kilimnik during the campaign period. Manafort, redacted, did not see a downside to sharing campaign information and told Gates that his role in the campaign would be, quote, good for business and potentially a way to be made whole for work he previously completed in the Ukraine. As to Deripaska, Manafort claimed that by sharing campaign information with him, Deripaska might see value in their relationship and resolve a, quote, disagreement, a reference to one or more outstanding lawsuits. Because of questions about Manafort's credibility and our limited ability to gather evidence on what happened to the polling data after it was sent to Kilimnik, the office could not assess what Kilimnik or others he may have given it to did with it. The office did not identify evidence of a connection between Manafort's sharing polling data and Russia's interference with the election, which had already been reported by US media outlets at the time of the August 2nd meeting. The investigation did not establish that Manafort otherwise coordinated with the Russian government on its election interference efforts. 8A, Paul Manafort's ties to Russia and Ukraine. Manafort's Russian contacts during the campaign and transition periods stem from his consulting work for Deripaska from approximately 2005 to 2009, and his separate political consulting work in Ukraine from 2005 to 2015, including through his company DMP International LLC, otherwise known as DMI. Kilimnik worked for Manafort in Kiev during this entire period and continued to work with Manafort through at least June 2018. Kilimnik, who speaks and writes Ukrainian and Russian, facilitated many of Manafort's communications with Deripaska and Ukrainian oligarchs. Section 8I, Oleg Deripaska consulting work. In approximately 2005, Manafort began working for Deripaska, a Russian oligarch who has a global empire involving aluminum and power companies and who is closely aligned with Vladimir Putin. A memorandum describing work that Manafort performed for Deripaska in 2005 regarding the post-Soviet republics referenced the need to brief the Kremlin and the benefits that the work could confer on, quote, the Putin government. Gates described the work Manafort did for Deripaska as, quote, political risk insurance, and explained that Deripaska used Manafort to install friendly political officials in countries where Deripaska had business interests. Manafort's company earned tens of millions of dollars from its work for Deripaska and was loaned millions of dollars by Deripaska as well. In 2007, Deripaska invested through another entity, Empirical's Emerging Market Partners LP, otherwise known as Pericles, an investment fund created by Manafort and former Manafort business partner Richard Davis. The Pericles Fund was established to pursue investments in Eastern Europe. Deripaska was the sole investor. Gates stated in interviews with the office that the venture led to a deterioration of the relationship between Manafort and Deripaska. In particular, when the fund failed, litigation between Manafort and Deripaska ensued. Gates stated that by 2009, Manafort's business relationship with Deripaska had, quote, dried up. According to Gates, Various interactions with Deripaska and his intermediaries over the past few years have involved trying to resolve the legal dispute. As described below, in 2016, Manafort, Gates, Kilimnik, and others engaged in the efforts to revive the Deripaska relationship and resolve the litigation. Section 8A2, Political Consulting Work. Through Deripaska, Manafort was introduced to Rinat Akhmedov, a Ukrainian oligarch who hired Manafort as a political consultant. In 2005, Akhmedov hired Manafort to engage in political work supporting the Party of Regions, a political party in Ukraine that was generally understood to align with Russia. Manafort assisted the Party of Regions in regaining power, and its candidate, Viktor Yanukovych, won the presidency in 2010. Manafort became a close and trusted political advisor to Yanukovych during his time as president of Ukraine. Yanukovych served in that role until 2014, when he fled to Russia amidst popular protests.
Konstantin Kilimnik. Kilimnik is a Russian national who's lived in both Russia and Ukraine and was a longtime Manafort employee. Kilimnik had direct and close access to Yanukovych and his senior entourage, and he facilitated communications between Manafort and his clients, including Yanukovych and multiple Ukrainian oligarchs. Kilimnik also maintained a relationship with Deripaska's deputy, Viktor Boyarkin, a Russian national who previously served in the defense attaché office of the Russian embassy to the United States. Manafort told the office that he didn't believe Kilimnik was working as a Russian spy. The FBI, however, assesses that Kilimnik has ties to Russian intelligence. Several pieces of the office's evidence, including witness interviews and emails obtained through court-authorized search warrants, support that assessment. Kilimnik was born on April 27, 1970, in Dnipropetrovsk Oblast, then of the Soviet Union, and attended the Military Institute of the Ministry of Defense from 1987 until 1992. Sam Patton, a business partner to Kilimnik, stated that Kilimnik told him he was a translator in the Russian army for 7 years and that he later worked in the Russian armament industry, selling arms and military equipment. U.S. government visa records revealed that Kilimnik obtained a visa to travel to the United States with a Russian diplomatic passport in 1997. Kilimnik worked for the International Republican Institute, that's the IRI Moscow office, where he did translation work and general office management from 1998 to 2005. While another official recalled the incident differently, one former associate of Kilimnik's at IRI told the FBI that Kilimnik was fired from his post because his links to Russian intelligence were too strong. The same individual stated that it was well known at IRI that Kilimnik had links to the Russian government. Jonathan Hawker, a British national who was a public relations consultant at FTI Consulting, worked with DMI on a public relations campaign for Yanukovych. After Hawker's work for DMI ended, Kilimnik contacted Hawker about working for a Russian government entity on a public relations project that would promote, in Western and Ukrainian media, Russia's position on its 2014 invasion of Crimea. Gates suspected that Kilimnik was a spy, a view that he shared with Manafort, Hawker, and Alexander van der Zwaan, an attorney who had worked with DMI on a report for the Ukrainian Ministry of Foreign Affairs. Then there's a redaction. Contacts during Paul Manafort's time with the Trump campaign. Paul Manafort joins the campaign. Manafort served on the Trump campaign from late March to August 19, 2016. On March 29, 2016, the campaign announced that Manafort would serve as the campaign's convention manager. On May 19, 2016, Manafort was promoted to campaign chairman and chief strategist, and Gates, who had been assisting Manafort on the campaign, was appointed deputy campaign chairman. Thomas Barak and Roger Stone both recommended Manafort to candidate Trump. In early 2016, at Manafort's request, Barack suggested to Trump that Manafort join the campaign to manage the Republican convention. Stone had worked with Manafort from approximately 1980 until the mid-1990s through various consulting and lobbying firms. Manafort met Trump in 1982 when Trump hired the Black Manafort, Stone and Kelly lobbying firm. Over the years, Manafort saw Trump at political and social events in New York City and at Stone's wedding, and Trump requested VIP status at the 1988 and 1996 Republican conventions worked by Manafort. According to Gates, in March 2016, Manafort traveled to Trump's Mar-a-Lago estate in Florida to meet with Trump. Trump hired him at that time. Manafort agreed to work on the campaign without pay. Manafort had no meaningful income at this point in time, but resuscitating his domestic political campaign career could be financially beneficial in the future. Gates reported that Manafort intended, if Trump won the presidency, to remain outside the administration and monetize his relationship with the administration. Paul Manafort's campaign period contacts. Immediately upon joining the campaign, Manafort directed Gates to prepare for his review separate memoranda addressed to Deripaska, Akhmatov, Sergei Lyavichkin, and Boris Kolesnikov, the last three being Ukrainian oligarchs who were senior opposition bloc officials. The memoranda described Manafort's appointment to the Trump campaign and indicated his willingness to consult on Ukrainian politics in the future. On March 30th, 2016, Gates emailed the memoranda and a press release announcing Manafort's appointment to Kalimnik for translation and dissemination. Manafort later followed up with Kalimnik to ensure his messages had been delivered, emailing on April 11th, 2016, to ask whether Kalimnik had shown our friends the media coverage of his new role. Kalimnik replied, absolutely every article. Manafort further asked, how do we use to get whole? Has OVD, that's Oleg Vladimirovich Deripaska, operation seen? Kalimnik wrote back the same day, yes, I have been sending everything to Viktor Boyarkin, Deripaska's deputy, who has been forwarding the coverage directly to OVD. Gates reported that Manafort said that being hired on the campaign would be good for business and increased the likelihood that Manafort would be paid the approximately $2 million he was owed for previous political consulting work in the Ukraine. Gates also explained to the office that Manafort thought his role on the campaign could help confirm that Deripaska had dropped the Pericles lawsuit and that Gates believed Manafort sent polling data to Deripaska, as discussed further below, so that Deripaska would not move forward with his lawsuit against Manafort. Gates further stated that Deripaska wanted a visa to the United States, that Deripaska could believe that having Manafort in a position inside the campaign or administration might be helpful to Deripaska, and that Manafort's relationship with Trump could help Deripaska in other ways as well. Gates stated, however, that Manafort never told him anything specific about what, if anything, Manafort might be offering Deripaska. Gates also reported that Manafort instructed him in April 2016 or early May 2016 to send Kalimnik campaign internal polling data and other updates so that Kalimnik in turn could share that information with Ukrainian oligarchs. Gates understood that the information would also be shared with Deripaska, and then there's a redacted portion. Gates reported to the office that he did not know why Manafort wanted him to send polling information, but Gates thought it was a way to showcase Manafort's work, and Manafort wanted to open doors to jobs after the Trump campaign ended. Gates said that Manafort's instruction included sending internal polling data prepared for the Trump campaign by pollster Tony Fabrizio. Fabrizio had worked with Manafort for years and was brought into the campaign by Manafort. Gates stated that, in accordance with Manafort's instruction, he periodically sent Kalimnik polling data via WhatsApp. Gates then deleted the communications on a daily basis. Gates further told the office that after Manafort left the campaign in mid-August, Gates sent Kalimnik polling data less frequently, and that the data he sent was more publicly available information and less internal data. Gates' account about polling data is consistent redaction, with multiple emails that Kalimnik sent to U.S. associates and press contacts between late July and mid-August of 2016. Those emails referenced internal polling, described the status of the Trump campaign and Manafort's role in it, and assessed Trump's prospects for victory. Manafort did not acknowledge instructing Gates to send Kalimnik internal data. Redaction. The office also obtained contemporaneous emails that shed light on the purpose of the communications with Deripaska and that are consistent with Gates' account. For example, in response to a July 7, 2016 email from a Ukrainian reporter about Manafort's failed Deripaska-backed investment, Manafort asked Kalimnik whether there had been any movement on this issue with our friend. Gates stated that our friend likely referred to Deripaska, and Manafort told the office that the issue, and our biggest interest, as stated below, was a solution to the Deripaska-Pericles issue. Kalimnik replied, I am carefully optimistic on the question of our biggest interest. Our friend, Boyarkin, says there's lately significantly more attention to the campaign in his boss's, that's Deripaska's, mind, and he will most likely be looking for ways to reach out to you pretty soon, understanding all the time sensitivity. I am more than sure it will be resolved and we will get back to the original relationship with V's boss, Deripaska. 8 minutes later, Manafort replied that Kalimnik should tell Boyarkin's boss, a reference to Deripaska, that if he needs private briefings, we can accommodate. Manafort has alleged to the office he was willing to brief Deripaska only on public campaign matters and gave an example, why Trump had selected Mike Pence as the vice presidential running mate. Manafort said he never gave Deripaska a briefing. Manafort noted that if Trump won, Deripaska would want to use Manafort to advance whatever interests Deripaska had in the United States and elsewhere. Paul Manafort's 2 campaign period meetings with Konstantin Kalimnik in the United States. Manafort twice met with Kalimnik in person during the campaign period, once in May and again in August 2016. The first meeting took place on May 7, 2016 in New York City. In the days leading to the meeting, Kalimnik had been working to gather information about the political situation in Ukraine. That included information gleaned from a trip that former Party of Regions official Yuri Boyko had recently taken to Moscow, a trip that likely included meetings between Boyko and high-ranking Russian officials. Kalimnik then traveled to Washington, D.C. on or about May 5, 2016. While in Washington, Kalimnik had prearranged meetings with State Department employees. Late on the evening of May 6, Gates arranged for Kalimnik to take a 3 a.m. train to meet Manafort in New York for breakfast on May 7th. According to Manafort, during the meeting, he and Kalimnik talked about events in Ukraine, and Manafort briefed Kalimnik on the Trump campaign, expecting Kalimnik to pass the information back to individuals in Ukraine and elsewhere. Manafort stated that opposition bloc members recognized Manafort's position on the campaign was an opportunity, but Kalimnik did not ask for anything. Kalimnik spoke about a plan of Boyko to boost election participation in the eastern zone of Ukraine, which was the base for the opposition bloc. Kalimnik returned to Washington, D.C. right after the meeting with Manafort. Manafort met with Kalimnik a second time at the Grand Havana Club in New York City on the evening of August 2, 2016. The events leading to the meeting are as follows. On July 28, 2016, Kalimnik flew from Kiev to Moscow. The next day, Kalimnik wrote to Manafort requesting that they meet using coded language about a conversation he had that day. In an email with a subject line, Black Caviar, Kalimnik wrote, I met today with the guy who gave you your biggest black caviar jar several years ago. We spent about 5 hours talking about his story, and I have several important messages from him to you. He asked me to go and brief you on our conversation. I said I have to run it by you first, but in principle, I'm prepared to do it. It has to do about the future of his country and is quite interesting. Manafort identified the guy who gave you your biggest black caviar jar as Yanukovych. He explained that in 2010, he and Yanukovych had lunch to celebrate the recent presidential election. Yanukovych gave Manafort a large jar of black caviar that was worth approximately $30,000 to $40,000. Manafort's identification of Yanukovych as the guy who gave you your biggest black caviar jar is consistent with Kalimnik being in Moscow, where Yanukovych resided, when Kalimnik wrote, I met today with the guy, and with a December 2016 email in which Kalimnik referred to Yanukovych as BG. Manafort replied to Kalimnik's July 29 email, Tuesday, August 2 is best, Tuesday or Wednesday in NYC. 3 days later, on July 31st, 2016, Kalimnik flew back to Kiev from Moscow and on that same day wrote to Manafort that he needed about 2 hours for their meeting because it's a long caviar story to tell. Kilimnik wrote that he would arrive at JFK on August 2 at 7:30 p.m., and he and Manafort agreed to a late-night dinner that night. Documentary evidence, including flight, phone, and hotel records and the timing of the text messages exchanged, confirms the dinner took place as planned on August 2nd. Continuing. As the contents of the meeting itself, the accounts of Manafort and Gates, who arrived late to the dinner, differ in certain respects, but the versions of events, when assessed alongside available documentary evidence and what Kilimnik told business associate Sam Patton, indicate that at least 3 principal topics were discussed.
First, Manafort and Kilimnik discussed a plan to resolve the ongoing political problems in Ukraine by creating an autonomous republic in its more industrialized eastern region of Donbass. And having Yanukovych, the Ukrainian president ousted in 2014, elected to head that republic. That plan, Manafort later acknowledged, constituted a backdoor means for Russia to control eastern Ukraine. Manafort initially said that if he had not cut off the discussion, Kilimnik would have asked Manafort in the August 2 meeting to convince Trump to come out in favor of the peace plan, and Yanukovych would have expected Manafort to use his connections in Europe and Ukraine to support the plan. Manafort also initially told the office that he had said to Kilimnik that the plan was crazy, that the discussion ended, and that he did not recall Kilimnik asking Manafort to reconsider the plan after their August 2 meeting. Manafort said, redacted, that he reacted negatively to Yanukovych, sending years later an urgent request when Yanukovych needed him. When confronted with an email written by Kilimnik on or about December 8, 2016, however, Manafort acknowledged Kilimnik raised the peace plan again in that email. Manafort ultimately acknowledged Kilimnik also raised the peace plan in January and February 2017 meetings with Manafort and redacted. Second, Manafort briefed Kilimnik on the state of the Trump campaign and Manafort's plan to win the election. That briefing encompassed the campaign's messaging and its internal polling data. According to Gates, it also included discussion of battleground states, which Manafort identified as Michigan, Wisconsin, Pennsylvania, and Minnesota. Manafort did not refer explicitly to battleground states in his telling of the August 2 discussion, redacted. Third, according to Gates, and what Kilimnik told Patton, Manafort, and Kilimnik discussed 2 sets of financial disputes related to Manafort's previous work in the region. Those consisted of the unresolved Deripaska lawsuit and the funds that the opposition bloc owed to Manafort for his political consulting work and how Manafort might be able to obtain payment. After the meeting, Gates and Manafort both stated that they left separately from Kilimnik because they knew the media was tracking Manafort and wanted to avoid media reporting on his connections to Kilimnik. C, post-resignation activities. Manafort resigned from the Trump campaign in mid-August 2016, approximately 2 weeks after his second meeting with Kilimnik, amidst negative media reporting about his political consulting work for the pro-Russian parties of regions in Ukraine. Despite his resignation, Manafort continued to offer advice to various campaign officials through the November election. Manafort told Gates that he still spoke with Kushner, Bannon, and candidate Trump, and some of those post-resignation contacts are documented in emails. For example, on October 21, 2016, Manafort sent Kushner an email and attached a strategy memorandum proposing that the campaign make the case against Clinton, quote, as the failed and corrupt champion of the establishment, unquote, and that, quote, WikiLeaks provides the Trump campaign the ability to make the case in a very credible way by using the words of Clinton, its campaign officials, and DNC members, unquote. Later, in a November 5, 2016 email to Kushner entitled Securing the Victory, Manafort stated that he was, quote, really feeling good about our prospects on Tuesday and focusing on preserving the victory, and that he was concerned the Clinton campaign would respond to a loss by, quote, moving immediately to discredit the Trump victory and claim voter fraud and cyber fraud, including the claim that the Russians have hacked into the voting machines and tampered with the results. unquote. Trump was elected president on November 8, 2016. Manafort told the office that in the wake of Trump's victory, he was not interested in an administration job. Manafort instead preferred to stay on the outside and monetize his campaign position to generate business given his familiarity and relationship with Trump in the incoming administration. Manafort appeared to follow that plan as he traveled to the Middle East, Cuba, South Korea, Japan, and China, and was paid to explain what a Trump presidency would entail. Manafort's activities in early 2017 included meetings relating to Ukraine and Russia. The first meeting, which took place in Madrid, Spain, in January 2017, was with Georgy Oganov. Oganov, who had previously worked at the Russian Embassy in the United States, was a senior executive at a Deripaska company and was believed to report directly to Deripaska. Manafort initially denied attending the meeting. When he later acknowledged it, he claimed that the meeting had been arranged by his lawyers and concerned only the Pericles lawsuit. Other evidence, however, provides reason to doubt Manafort's statement that the sole topic of the meeting was the Pericles suit. In particular, text messages to Manafort from a number associated with Kilimnik suggest that Kilimnik and Boyarkin, not Manafort's counsel, had arranged the meeting between Manafort and Oganov. Kilimnik's message states that the meeting was supposed to be not about money or Pericles, but instead about recreating the old friendship, ostensibly between Manafort and Deripaska, quote, and talking about global politics, unquote. Manafort also replied by text that he, quote, needs this finished before January the 20th, unquote, which appears to be a reference to resolving Pericles before the inauguration. On January 15th, 2017, 3 days after his return from Madrid, Manafort emailed KT McFarland, who was at the time designated to be Deputy National Security Advisor, and was formally appointed to that position on January 20th, 2017. Manafort's January 15th email to McFarland stated, quote, I have some important information I want to share that I picked up on my travels over the last month, unquote. Manafort told the office that the email referred to an issue regarding Cuba, not Russia or Ukraine, and Manafort had traveled to Cuba in the past month. Either way, McFarland, who was advised by Flynn not to respond to the Manafort inquiry, appears not to have responded to Manafort. Manafort told the office that around the time of the presidential inauguration in January, he met with Kilimnik and Ukrainian oligarch Sergei Leovochkin at the Westin Hotel in Alexandria, Virginia. During this meeting, Kilimnik again discussed the Yanukovych peace plan that he had broached at the August 2 meeting, and in a detailed December 8, 2016 message found in Kilimnik's DMP email account. In that December 8 email, which Manafort acknowledged having read, Kilimnik wrote, quote, all that is required to start the process is a very minor wink or slight push from DT, in apparent reference to President-elect Trump, and a decision to authorize you to be a special representative and manage this process, unquote. Kilimnik assured Manafort with that authority he, quote, could start the process and within 10 days visit Russia. Yanukovych guarantees your reception at the very top level and that, quote, DT could have peace in Ukraine basically within a few months after the inauguration. As noted above, redacted, in statements to the office, Manafort sought to qualify his engagement on and support for the plan, redacted, 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 redacted. On February 26, 2017, Manafort met Kilimnik in Madrid, where Kilimnik had flown from Moscow. In his first two interviews with the office, Manafort denied meeting with Kilimnik on his Madrid trip, and then, after being confronted with documentary evidence that Kilimnik was in Madrid at the same time as him, recognized that he met him in Madrid. Manafort said that Kilimnik had updated him on a criminal investigation into so-called black ledger payments to Manafort that was being conducted by Ukraine's National Anti-Corruption Bureau, redacted. Manafort remained in contact with Kilimnik throughout 2017 and into the spring of 2018. Those contacts included matters pertaining to the criminal charges brought by the office in the Ukraine peace plan. In early 2018, Manafort retained his longtime polling firm to craft a draft poll in Ukraine, sent the pollsters a 3-page primer on the plan sent by Kilimnik, and worked with Kilimnik to formulate the polling questions. The primer sent to the pollsters specifically called for the United States and President Trump to support the autonomous Republic of Donbass with Yanukovych as prime minister. In a series of questions in the draft poll asked for opinions on Yanukovych's role in resolving the conflict in Donbass. The poll was not solely about Donbass. It also sought participants' views on leaders apart from Yanukovych as they pertain to the 2019 Ukraine presidential elections. The office has not uncovered evidence that Manafort brought the Ukraine peace plan to the attention of the Trump campaign or the Trump administration. Kilimnik continued his efforts to promote the peace plan to the executive branch, e.g., U.S. Department of State, into the summer of 2018. B, post-election and transition period context. Trump was elected president on November 8, 2016. Beginning immediately after the election, individuals connected to the Russian government started contacting officials on the Trump campaign and transition team through multiple channels, sometimes through Russian Ambassador Kislyak, and other times through individuals who sought reliable contacts through U.S. persons not formally tied to the campaign or transition team. The most senior levels of the Russian government encouraged these efforts. The investigation did not establish that these efforts reflected or constituted coordination between the Trump campaign and Russia in its election interference activities. 1, immediate post-election activity. As soon as news broke that Trump had been elected president, Russian government officials and prominent Russian businessmen began trying to make inroads into the new administration. They appeared not to have pre-existing contacts and struggled to connect with senior officials around the president-elect. As explained below, those efforts entailed both official contact through the Russian embassy in the United States and outreaches sanctioned at high levels of the Russian government through business rather than political contacts. A, outreach from the Russian government. At approximately 3 a.m. on election night, Trump campaign press secretary Hope Hicks received a telephone call on her personal cell phone from a person who sounded foreign but was calling from a number with a DC area code. Although Hicks had a hard time understanding the person, she could make out the words Putin call. Hicks told the caller to send her an email. The following morning on November 9, 2016, Sergei Kuznetsov, an official at the Russian embassy in the United States, emailed Hicks from his Gmail address with the subject line, message from Putin. Attached to the email was a message from Putin in both English and Russian, with Kuznetsov, which Kuznetsov asked Hicks to convey to the president-elect. In the message, Putin offered his congratulations to Trump for his electoral victory, stating he looked forward to working with Trump on leading Russian-American relations out of crisis. Hicks forwarded the email to Kushner asking, can you look into this? Don't want to get duped, but I don't want to blow off Putin. Kushner stated in congressional testimony that he believed that it would be possible to verify the authenticity of the forwarded email through the Russian ambassador, whom Kushner had previously met in April 2016. Unable to recall the Russian ambassador's name, Kushner emailed Dmitry Simis of CNI, whom he had consulted previously about Russia, and asked, what is the name of Russian ambassador? Kushner forwarded Simis's response, which identified Kislyak by name to Hicks. After checking with Kushner to see what he had learned, Hicks conveyed Putin's letter to transition officials. 5 days later, on November 14, 2016, Trump and Putin spoke by phone in the presence of transition team members, including incoming National Security Advisor Michael Flynn. B, high-level encouragement of contacts through alternative channels. As Russian officials in the United States reached out to the president-elect and his team, a number of Russian individuals working in the private sector began their own efforts to make contact. Petra Avin, a Russian national who heads Alfa Bank, Russia's largest commercial bank, described to the office interactions with Putin during this time period that might account for the flurry of Russian activity. Avin told the police that he is one of approximately 50 wealthy Russian businessmen who regularly meet with Putin in the Kremlin. These 50 men are often referred to as oligarchs. Avin told the office that he met on a quarterly basis with Putin, including the fourth quarter of 2016, shortly after the US presidential election. Avin said that he took these meetings seriously and understood that any suggestions or critiques that Putin made during the meetings were implicit directives and that there would be consequences for Avin if he did not follow through. As was typical, the 2016 Q4 meeting with Putin was preceded by a preparatory meeting with Putin's chief of staff, Anton Vaino. According to Avin, at his Q4 2016 one-on-one meeting with Putin, Putin raised the prospect the United States would impose additional sanctions on Russian interests, including sanctions against Avon and/or Alfa Bank. Putin suggested that Avon needed to take steps to protect himself and Alfa Bank. Avon also testified that Putin spoke of the difficulty faced by the Russian government in getting in touch with the incoming Trump administration. According to Avon, Putin indicated he did not know with whom formally to speak and generally did not know the people immediately around the president-elect. Avon, redacted, told Putin he would take steps to protect himself and the Alfa Bank shareholders from potential sanctions. And one of those steps would be to try to reach out to the incoming administration to establish a line of communication. Avon described Putin responding with skepticism about Avon's prospect for success. According to Avon, although Putin did not expressly direct him to reach out to the Trump transition team, Avon understood that Putin expected him to try to respond to the concerns he had raised. Avon's efforts are described in Volume 1, Section 4b5. 2. Kirill Dmitriev's transition-era outreach to the incoming administration. Avon's description of his interactions with Putin is consistent with the behavior of Kirill Dmitriev, a Russian national who heads Russia's sovereign wealth fund and is closely connected to Putin. Dmitriev undertook efforts to meet members of the incoming Trump administration in the months after the election. Dmitriev asked a close business associate who worked for the United Arab Emirates, Royal Court, George Nader, to introduce him to Trump transition officials. And Nader eventually arranged a meeting in the Seychelles between Dmitriev and Eric Prince, a Trump campaign supporter and an associate of Steve Bannon. In addition, the UAE National Security Advisor introduced Dmitriev to a hedge fund manager and friend of Jared Kushner, Rick Gerson, in late November 2016. In December 2016 and January 2017, Dmitriev and Gerson worked on a proposal for reconciliation between the United States and Russia, which Dmitriev implied he cleared through Putin. Gerson provided that proposal to Kushner before the inauguration, and Kushner later gave copies to Bannon and Secretary of State Rex Tillerson. A background. Dmitriev is a Russian national who was appointed CEO of Russian Sovereign Wealth Fund, the Russian Direct Investment Fund, when it was founded in 2011. Dmitriev reported directly to Putin and frequently referred to Putin as his boss.
RDIF has co-invested in various projects with UAE sovereign wealth funds. Dmitriev regularly interacted with Nader, a senior advisor to the UAE Crown Prince Mohammed bin Zayed, Crown Prince Mohammed, in connection with RDIF's dealings with the UAE. Putin wanted Dmitriev to be in charge of both the financial and political relationship between Russia and the Gulf states, in part because Dmitriev had been educated in the West and spoke English fluently. Nader considered Dmitriev to be Putin's interlocutor in the Gulf region and would relay Dmitriev's views directly to Crown Prince Mohammed. Nader developed contacts with both U.S. presidential campaigns during the 2016 election and kept Dmitriev abreast of his efforts to do so. According to Nader, Dmitriev said that his and the government of Russia's preference was for candidate Trump to win, and asked Nader to assist him in meeting members of the Trump campaign. Redaction. Nader did not introduce Dmitriev to anyone associated with the Trump campaign before the election. And another redacted paragraph. Eric Prince is a businessman who had relationships with various individuals associated with the Trump campaign, including Steve Bannon, Donald Trump Jr., and Roger Stone. Prince did not have a formal role in the campaign, although he offered to host a fundraiser for Trump and sent unsolicited policy papers on issues such as foreign policy, trade, and Russian election interference to Bannon. After the election, Prince frequently visited transition offices at Trump Tower, primarily to meet with Bannon, but on occasion to meet Michael Flynn and others. Prince and Bannon would discuss, inter alia, foreign policy issues and Prince's recommendations regarding who should be appointed to fill key national security positions. Although Prince was not formally affiliated with the transition, Nader, redaction, received assurances, redaction, that the incoming administration considered Prince a trusted associate. Kirill Dmitryev's post-election contacts with the incoming administration. Soon after midnight on election night, Dmitriev messaged, redaction, who was traveling to New York to attend the 2016 World Chess Championship. Redaction, Dmitry Peskov, the Russian Federation's press secretary, who was also attending the World Chess Championship. Redaction. At approximately 2:40 a.m. on November 9th, 2016, news reports stated that candidate Clinton had called President-elect Trump to concede. At redaction, wrote to Dmitriev, Putin has won. Later that morning, Dmitriev contacted Nader, who was in New York, to request a meeting with the key people in the incoming administration as soon as possible in light of the great results. He asked Nader to convey to the incoming administration that we want to start rebuilding the relationship in whatever is a comfortable pace for them. We understand all of the sensitivities and are not in a rush. Dmitriev and Nader had previously discussed Nader introducing him to the contacts Nader had made within the Trump campaign. Dmitriev also told Nader he would ask Putin for permission to travel to the United States, where he would be able to speak to media outlets about the positive impact of Trump's election and the need for reconciliation between the United States and Russia. Later that day, Dmitriev flew to New York, where Peskov was separately traveling to attend the chess tournament. Dmitriev invited Nader to the opening of the tournament and noted that if there was a chance to see anyone key from the Trump camp, he would love to start building for the future. Dmitriev also asked Nader to invite Kushner to the event so that he, Dmitriev, could meet him. Nader did not pass along Dmitriev's invitation to anyone connected with the incoming administration. Although one World Chess Federation official recalled hearing from an attendee that President-elect Trump had stopped by the tournament, the investigation did not establish that Trump or any campaign or transition team official attended the event. And the president's written answers denied that he had. Nader stated that Dmitriev continued to press him to set up a meeting with transition officials and was particularly focused on Kushner and Trump Jr. Dmitriev told Nader that Putin would be very grateful to Nader and that a meeting would make history. Redaction. According to Nader, Dmitriev was very anxious to connect him with the incoming administration and told Nader that he would try other routes to do so besides Nader himself. Nader did not ultimately introduce Dmitriev to anyone associated with the incoming administration during Dmitriev's post-election trip to New York. In early December 2016, Dmitriev again broached the topic of meeting incoming administration officials with Nader in January or February. Dmitriev sent Nader a list of publicly available quotes of Dmitriev speaking positively about Donald Trump in case they were helpful. Eric Prince and Kirill Dmitriev meet in the Seychelles. George Nader and Eric Prince arranged Seychelles meeting with Dmitriev. Nader traveled to New York in early January 2017 and had lunchtime and dinner meetings with Eric Prince on January 3rd, 2017. Nader and Prince discussed Dmitriev. Nader informed Prince that the Russians were looking to build a link with the incoming Trump administration. Redaction. He told Prince that Dmitriev had been pushing Nader to introduce him to someone from the incoming administration. Redaction. Nader suggested, in light of Prince's relationship with transition team officials, that Prince and Dmitriev met to discuss issues of mutual concern. Redaction. Prince told Nader that he needed to think further about it and to check with transition team officials. After his dinner with Prince, Nader sent Prince a link to the Wikipedia entry about Dmitriev and sent Dmitriev a message stating that he had just met with some key people within the family and inner circle, a reference to Prince, and that he had spoken at length and positively about Dmitriev. Nader told Dmitriev that the people he met had asked for Dmitriev's bio, and that Dmitriev replied that he would update and send it. Nader later received from Dmitriev 2 files concerning Dmitriev. One was a 2-page biography, the other was a list of Dmitriev's positive quotes about Donald Trump. The next morning, Nader forwarded the message and attachments Dmitriev sent him to Prince. Nader wrote to Prince that these documents were the versions to be used with some additional details for them, with them referring to members of the incoming administration. Prince opened the attachments at Trump Tower within an hour of receiving them. Prince stated that while he was at Trump Tower that day, he spoke with Kellyanne Conway, Wilbur Ross, Steve Mnuchin, and others while waiting to see Bannon. Cell site location data for Prince's mobile phone indicates that Prince remained at Trump Tower for approximately 3 hours. Prince said he could not recall whether during those 3 hours he met with Bannon and discussed Dmitriev with him. Redaction. Prince booked a ticket to the Seychelles on January 7, 2017. The following day, Nader wrote to Dmitriev that he had a pleasant surprise for him, namely that he had arranged for Dmitriev to meet a special guest from the new team, referring to Prince. Nader asked Dmitriev if he could come to the Seychelles for the meeting on January 12, 2017, and Dmitriev agreed. The following day, Dmitriev sought assurance from Nader that the Seychelles meeting would be worthwhile. Dmitriev was not enthusiastic about the idea of meeting with Prince, and that Nader assured him that Prince wielded influence with the incoming administration. I'm sorry, I skipped a redaction. Nader wrote to Dmitriev, "This guy, Prince, is designated by Steve Bannon to meet you. I know him and he is very, very well connected and trusted by the new team. His sister is now a minister of education." According to Nader, Prince had led him to believe that Bannon was aware of Prince's upcoming meetings with Dmitriev, and Prince acknowledged that it was fair for Nader to think that Prince would pass information on to the transition team. Bannon, however, told the office that Prince did not tell him in advance about his meeting with Dmitriev. The Seychelles meeting. Dmitriev arrived with his wife in the Seychelles on January 11, 2017, and checked into the Four Seasons resort where Crown Prince Mohammed and Nader were staying. Prince arrived that same day. Prince and Dmitriev met for the first time that afternoon in Nader's villa, with Nader present. The initial meeting lasted approximately 30 to 45 minutes. Redaction. Prince described the 8 years of the Obama administration in negative terms and stated that he was looking forward to a new era of cooperation and conflict resolution. According to Prince, he told Dmitriev that Bannon was effective if not conventional, and that Prince provided policy papers to Bannon. Redaction. Redaction. The topic of Russian interference in the 2016 election did not come up. Redaction. Prince added that he would inform Bannon about his meeting with Dmitriev and that if there was interest in continuing the discussion, Bannon or someone else on the transition team would do so. Redaction. Afterwards, Prince returned to his room where he learned that a Russian aircraft carrier had sailed to Libya, which led him to call Nader and ask him to set up another meeting with Dmitriev. According to Nader, Prince called and said he had checked with his associates back home and needed to convey to Dmitriev that Libya was off the table. Nader wrote to Dmitriev that Prince had received an urgent message that he needs to convey to you immediately and arranged for himself, Dmitriev, and Prince to meet at a restaurant on the Four Seasons property. At the second meeting, Prince told Dmitriev that the United States could not accept any Russian involvement in Libya because it would make the situation there much worse. Redaction. After the second meeting concluded, Nader and Dmitriev discussed what had transpired. Dmitriev told Nader that he was disappointed in his meetings with Prince for two reasons. First, he believed the Russians needed to be communicating with someone who had more authority within the incoming administration than Prince had. Second, he had hoped to have a discussion of greater substance, such as outlining a strategic roadmap for both countries to follow. Dmitriev told Nader that, redaction, Prince's comments, redaction, were insulting, redaction. Hours after the second meeting, Prince sent two text messages to Bannon from the Seychelles. As described further below, investigators were unable to obtain the content of these or other messages between Prince and Bannon, and the investigation also did not identify evidence of any further communication between Prince and Dmitriev after their meetings in the Seychelles. Eric Prince's meeting with Steve Bannon after the Seychelles trip. After the Seychelles meetings, Prince told Nader that he would inform Bannon about his discussion with Dmitriev and would convey that someone within the Russian power structure was interested in seeking better relations with the incoming administration. On January 12, 2017, Prince contacted Bannon's personal assistant to set up a meeting for the following week. Several days later, Prince messaged her again, asking about Bannon's schedule. Prince said that he met Bannon at Bannon's home after returning to the United States in mid-January and briefed him about several topics, including his meeting with Dmitriev. Prince told the office that he explained to Bannon that Dmitriev was the head of a Russian sovereign wealth fund and was interested in improving relations between the United States and Russia. Prince had on his cell phone a screenshot of Dmitriev's Wikipedia page dated January 16, 2017, and Prince told the office that he likely showed that image to Bannon. Prince also believed he provided Bannon with Dmitriev's contact information. According to Prince, Bannon instructed Prince not to follow up with Dmitriev, and Prince had the impression that the issue was not a priority for Bannon. Prince related that Bannon did not appear angry, just relatively uninterested.
Bannon, by contrast, told the office that he never discussed with Prince anything regarding Dmitriev, RDIF, or any meetings with Russian individuals or people associated with Putin. Bannon also stated he had Prince mentioned such a meeting, Bannon would have remembered it, and Bannon would have objected to such a meeting having taken place. The conflicting accounts provided by Bannon and Prince could not be independently clarified by reviewing their communications, because neither one was able to produce any of the messages they exchanged in the time period surrounding the Seychelles meeting. Prince's phone contained no text message prior to March 2017, though provider records indicate that he and Bannon exchanged dozens of messages. Prince denied deleting any messages, but claimed he did not know why there were no messages on his device before March 2017. Bannon's devices similarly contained no messages in the relevant period of time, and Bannon also stated he did not know why messages did not appear on his device. Bannon told the office that during both the months before and after the Seychelles meeting, he regularly used his personal BlackBerry and personal email for the work-related communications, including those with Prince, and he took no steps to preserve those work communications. Kirill Dmitriev's post-election contact with Rick Gerson regarding U.S.-Russia relations, Section D. Dmitriev's contacts during the transition period were not limited to those facilitated by Nader. In approximately late November of 2016, the UAE National Security Advisor introduced Dmitriev to Rick Gerson, a friend of Jared Kushner, who runs a hedge fund in New York. Gerson stated he had no formal role in the transition and had no involvement in the Trump campaign other than occasional casual discussions about the campaign with Kushner. After the election, Gerson assisted the transition by arranging meetings for transition officials with former UK Minister Tony Blair and UAE delegation led by Crown Prince Mohammed. When Dmitriev and Gerson met, they principally discussed potential joint ventures between Gerson's hedge fund and RDIF. Dmitriev was interested in improved economic cooperation between the United States and Russia and asked Gerson who he should meet with in the incoming administration who would be helpful toward that goal. Gerson replied that he would try to figure out the best way to arrange appropriate introductions, but noted that confidentiality would be required because of the sensitivity of holding such a meeting before the new administration took power and before cabinet nominations had been confirmed by the Senate. Gerson said he would ask Kushner and Michael Flynn, who were the key person or people were on the topics of reconciliation with Russia, joint security concerns, and economic matters. Dmitriev told Gerson that he had been tasked by Putin to develop and execute a reconciliation plan between the United States and Russia. He noted in a text message to Gerson that if Russia was, quote, approached with respect and willingness to understand our position, we can have major breakthroughs quickly, end quote. Gerson and Dmitriev exchanged ideas in December of 2016 about such a reconciliation plan and what it would include. Gerson told the office that the transition team had not asked him to engage in these discussions with Dmitriev and that he did so on his own initiative as a private citizen. On January 9th, 2017, the same day he asked Nader whether meeting Prince would be worthwhile, Dmitriev sent his biography to Gerson and asked him if he could, quote, share it with Jared, parentheses, or somebody else senior in the team so that they know we are focused from our side on improving the relationship, and my boss asked me to play a key role in that, end quote. Dmitriev also asked Gerson if he knew Prince and if Prince was somebody important or worth spending time with. After his trip to the Seychelles, Dmitriev told Gerson that Bannon had asked Prince to meet with Dmitriev and that the two had a positive meeting. On January 16, 2017, Dmitriev consolidated the ideas for the US-Russia reconciliation that he and Gerson had been discussing on a two-page document that listed 5 main points. 1, jointly fighting terrorism. 2, jointly engaging in anti-weapons mass destruction efforts. 3, developing a win-win economic and investment initiatives. 4, maintaining an honest, open, and continual dialogue regarding issues of disagreement. And 5, ensuring proper communication and trust by, quote, key people, end quote, from each country. On January 18, 2017, Gerson gave a copy of that document to Kushner. Kushner had not heard of Dmitriev at that time. Gerson explained that Dmitriev was the head of RDIF and that Gerson may have alluded to Dmitriev's being well connected. Kushner placed the document in a file and said he would get it to the right people. Kushner ultimately gave one copy of the document to Bannon and another to Rex Tillerson. According to Kushner, neither of them followed up with Kushner about it. On January 19, 2017, Dmitriev sent Nader a copy of the two-page document, telling him that this was, quote, a view from our side that I had discussed in my meeting on the islands, and with you and with our friends, please share with them. We believe this is a good foundation to start from, end quote. Gerson informed Dmitriev that he had given the document to Kushner soon after delivering it. On January 26, 2017, Dmitriev wrote to Gerson that his, quote, boss, an apparent reference to Putin, was asking if there had been any feedback on the proposal. Dmitriev said, quote, we do not want to rush things and move at a comfortable speed. At the same time, my boss asked me to try to have the key U.S. meetings in the next 2 weeks if possible, end quote. He informed Gerson that Putin and President Trump would speak by phone that Saturday and noted that the information was, quote, very confidential, end quote. The same day, Dmitriev wrote to Nader and said he had seen his, quote, boss again, who had, quote, emphasized that this is a great priority for us and that we need to build this communication channel to avoid bureaucracy, end quote. On January 28, 2017, Dmitriev texted Nader that he wanted to, quote, see if I can confirm to my boss that your friends may use some of the ideas from the two-pager I sent you in a telephone call that will happen at 12 Eastern Standard Time, end quote, an apparent reference to the call scheduled between President Trump and Putin. Nader replied, quote, definitely, paper was so submitted to team by Rick and me. They took it seriously, exclamation point, end quote. After the call between President Trump and Putin occurred, Dmitriev wrote to Nader and said, quote, the call went very well. My boss wants me to continue making some public statements that US-Russia cooperation is good and important, end quote. Gerson also wrote to Dmitriev to say that the call had gone well and that Dmitriev replied that the document they had drafted together, quote, played an important role, end quote. Gerson and Dmitriev appeared to stop communicating with one another in approximately March of 2017, when the investment deal they had been working on together showed no signs of progressing. Section 3, Ambassador Kislyak's meeting with Jared Kushner and Michael Flynn in Trump Tower following the election. On November 16, 2016, Catherine Vargas, an executive assistant to Kushner, received a request for a meeting with Russian Ambassador Sergei Kislyak. That same day, Vargas sent Kushner an email with the subject, quote, missed call, in caps, Russian Ambassador to the US, Sergei Kislyak, end quote. The text of the email read, regarding setting up a time to meet with you on 12/1, LMK, how to proceed, end quote. Kushner responded in relevant part, quote, I think I do this one. confirmed that with Dmitry Sims of CNI, that this is the right guy, end quote. After reaching out to a colleague of Sims at CNI, Vargas reported back to Kushner that Kislyak was, quote, the best go-to guy for routine matters in the US, end quote, while Yuri Yukashov, a Russian foreign policy advisor, was the contact for, quote, more direct, substantial matters, end quote. Bob Forsman, the UBS investment bank executive who had previously tried to transmit to candidate Trump an invitation to speak at an economic forum in Russia, see Volume 1, Section 4, may have provided similar information to the transition team, according to Forsman, at the end of an early December 2016 meeting with incoming National Security Advisor Michael Flynn and his designated deputy, K.T. McFarland, in New York. Flynn asked Forsman for his thoughts on Kislyak. Forsman did not meet Kislyak, but told Flynn while Kislyak was an important person, Kislyak did not have a direct line to Putin. Forsman subsequently traveled to Moscow, inquired of a source he believed to be close to Putin, and heard back that the source, that Yukashov, would be the official channel for the incoming U.S. National Security Advisor. Forsman acknowledged that Flynn had not asked him to undertake that inquiry in Russia, but told the office that he nonetheless felt obligated to report the information back to Flynn, and that he worked to get a face-to-face meeting with Flynn in January 2017 so that he could do so. Email correspondence suggests that the meeting ultimately went forward, but Flynn has no recollection of it or of the earlier December meeting. Parentheses, the investigation did not identify evidence of Flynn or Kushner meeting with Yukashov after being given his name, and parentheses. In the meantime, although he had already formed the impression that Kislyak was not necessarily the right point of contact, Kushner went forward with the meeting that Kislyak had requested on November the 16th. It took place at Trump Tower on November 30th, 2016. At Kushner's invitation, Flynn also attended. Bannon was invited but did not attend. During the meeting, which lasted approximately 30 minutes, Kushner expressed a desire on the part of incoming administration to start afresh with U.S.-Russian relations. Kushner also asked Kislyak to identify the best person, parentheses, whether Kislyak or someone else, end parentheses, with whom to direct future discussions, someone who had contact with Putin and the ability to speak for him. The three men also discussed U.S. policy toward Syria, and Kislyak floated the idea of having Russian generals brief the transition team on the topic using a secure communications line. After Flynn explained that there was no secure line in the transition team offices, Kushner asked Kislyak if they could communicate using secure facilities at the Russian embassy. Kislyak quickly rejected that idea. Section 4. Jared Kushner's meeting with Sergei Gorkov. On December 6, 2016, the Russian embassy reached out to Kushner's assistant to set up a second meeting between Kislyak and Kushner. Kushner declined several proposed meeting dates, but Kushner's assistant indicated that Kislyak was very insistent about securing a second meeting. Kushner told the office that he did not want to take another meeting because he had already decided Kislyak was not the right channel for him to communicate with Russia, so he arranged to have one of his assistants, Avi Berkowitz, meet with Kislyak in his stead. Although embassy official Sergei Kuznetsov wrote to Berkowitz that Kislyak thought it, quote, important, end quote, to, quote, continue the conversation with Mr. Kushner in person, end quote, Kislyak nonetheless agreed to meet instead with Berkowitz once it became apparent that Kushner was unlikely to take a meeting. Berkowitz met with Kislyak on December 12, 2016 at Trump Tower. The meeting lasted only a few minutes, during which Kislyak indicated that he wanted Kushner to meet someone who had a direct line to Putin, Sergei Gorkov, the head of the Russian government-owned bank, Bank, VEB. Kushner agreed to meet Gorkov. The one-on-one meeting took place the next day, December 13, 2016, at the Colony Capitol Building in Manhattan, where Kushner had previously scheduled meetings. VEB was and is the subject of the Department of Treasury economic sanctions imposed in response to Russia's annexation of Crimea. Kushner did not, however, recall any discussions during his meetings with Gorkov about the sanctions against VEB or sanctions more generally. Kushner stated in an interview that he did not engage in any preparation for the meeting and that no one on the transition team even did a Google search for Gorkov's name. At the start of the meeting, Gorkov presented Kushner with two gifts, a painting and a bag of soil from the town of Belarus where Kushner's family originated. The accounts from Kushner and Gorkov differ as to whether the meeting was diplomatic or business in nature. Kushner told the office that the meeting was diplomatic, with Gorkov expressing disappointment with U.S.-Russia relations under President Obama and hopes for improved relations with the incoming administration. According to Kushner, although Gorkov told Kushner a little bit about his bank and made some statements about the Russia economy, the two did not discuss Kushner's companies or private business dealings of any kind. Parentheses, at the time of the meeting, Kushner companies had a debt obligation coming due on a building it owned at 666 Fifth Avenue, and there had been public reporting both about efforts to secure lending on the property and possible conflicts of interest for Kushner arising out of his company's borrowing from foreign leaders, end parentheses. In contrast, in a 2017 public statement, VEB suggested Gorkov met with Kushner in Kushner's capacity as CEO of Kushner Companies for the purpose of discussing business rather than as a part of a diplomatic effort. In particular, VEB characterized Gorkov's meeting with Kushner as part of a series of, quote, roadshow meetings, end quote, with, quote, representatives of major U.S. banks and business circles, end quote, which included, quote, negotiations, end quote, and discussions of the, quote, most promising business lines and sectors, end quote. Forsman, the investment bank executive mentioned in Volume 1, Sections 4A1, told the office that he met with Gorkov and VEB Deputy Chairman Nikolai Toshmensky in Moscow just before Gorkov left for New York to meet Kushner. According to Forsman, Gorkov and Toshmensky told him that they were traveling to New York to discuss post-election issues with U.S. financial institutions, that their trip was sanctioned by Putin, that they were reporting back to Putin upon their return. The investigation did not resolve the apparent conflict in the accounts of Kushner and Gorkov, or determine whether the meeting was diplomatic in nature, as Kushner stated, focused on business, as VEB public statements indicated, or whether it involved some combination of those matters or other matters. Regardless, the investigation did not identify that Kushner and Gorkov engaged in any substantive follow-up after the meeting. Rather, a few days after the meeting, Gorkov's assistant texted Kushner's assistant, quote, "Hi, please inform your side that the information about the meeting had a very positive response, exclamation point," end quote. Over the following weeks, the two assistants exchanged a handful of additional cordial texts. On February 8, 2017, Gorkov's assistant texted Kushner's assistant, Berkowitz, to try to set up another meeting, and followed up by text at least twice in the days that followed. According to Berkowitz, he did not respond to the meeting request in light of the press coverage regarding the Russia investigation, and did not tell Kushner about the meeting request. Section 5, Petr Oven outreach efforts to the transition team. In December 2016, weeks after the one-on-one meeting with Putin described in Volume 1, Section 4, Petr Oven attended what he described as a separate, quote, all-hands, end quote, oligarch meeting between Putin and Russia's most prominent businessmen. As in Oven's one-on-one meeting, a main topic of discussion at the oligarch meeting in December of 2016 was the prospect of forthcoming U.S. economic sanctions. After the December 2016 all-hands meeting, Avin tried to establish a connection to the Trump team. Avin instructed Richard Burt to make contact with the incoming Trump administration. Burt was on the board of directors of Letter One, another company headed by Avin, and had done work for Alpha Bank. Burt had previously served as U.S. Ambassador to Germany and Assistant Secretary of State for European and Canadian Affairs, and one of his primary roles with Alpha Bank and L1 was to facilitate introductions to business contacts in the United States and other Western countries. While at L1, board members held in Luxembourg in late December 2016, Avin pulled Burt aside, and he told him he had spoken to someone high in the Russian government who expressed interest in establishing a communications channel between the Kremlin and the Trump transition team. Avin asked for Burt's help in contacting members of the transition team. Although Burt had been responsible for helping Avin build connections in the past, Burt viewed Avin's request as unusual and outside the normal realm of his dealings with Avin. Burt, who is a member of the board of CNI, discussed previously, decided to approach CNI President Dimitri Sims for help facilitating Avin's request, recalling that Sims had some relationship with Kushner. At the time, Sims was lobbying the Trump transition team on Burt's behalf to appoint Burt U.S. Ambassador to Russia.
Burt contacted Symes by telephone and asked if he could arrange a meeting with Kushner to discuss setting up a high-level communications channel between Putin and the incoming administration. Symes told the office that he declined and stated to Burt that setting up such a channel was not a good idea in light of the media attention surrounding Russian influence in the U.S. presidential election. According to Symes, he understood that Burt was seeking a secret channel, and Symes did not want CNI to be seen as an intermediary between the Russian government and the incoming administration. Based on what Symes had read in the media, he stated that he already had concerns that Trump's business connections could be exploited by Russia, and Symes said that he did not want CNI to have any involvement or apparent involvement in facilitating any connection. Through a trusted third party, I have reached out to the very influential person I mentioned in Luxembourg concerning Project A. Prior to that, in an email dated December 22nd, 2016, Burt recounted for Avin his conversation with Symes. And he said, through a trusted third party, I have reached out to the very influential person I mentioned in Luxembourg concerning Project A. There is an interest and an understanding for the need to establish such a channel, but the individual emphasized at this moment with so much intense interest in the Congress and the media over the question of cyber hacking and who ordered that, Project A was too explosive to discuss. The individual agreed to discuss it again after the new year. I trust the individual's instincts on this. If this is unclear to you, or would you like to discuss, don't hesitate to call. According to Burt, the very influential person referred in this, a reference rather in this email was Symes, and the reference to a trusted third party was a fabrication, and no such third party existed. Project A was a term that Burt created for Ivan's effort to help establish a communications channel between Russia and the Trump team, which he used in light of the sensitivities surrounding what Ivan was requesting, especially in light of the recent attention to Russia's influence in the U.S. presidential election. According to Burt, his report that there was interest in a communications channel reflected Times' views, not necessarily those of the transition team, and in any event, Burt acknowledged that he added some hype so that sentence to make it sound like there was more interest from the transition team than may have actually existed. Ivan replied to Burt's email on the same day, saying, "Thank you, all clear." According to Ivan, this statement indicated that he did not want the outreach to continue. Burt spoke to Ivan sometime thereafter about his attempt to make contact with the Trump team, explaining to Ivan that the current environment made it impossible. Redacted, redacted. Burt did not recall discussing Ivan's request with Symes again, nor did he recall speaking to anyone else about the request. In the first quarter of 2017, Ivan met again with Putin and other Russian officials. At that meeting, Putin asked about Ivan's attempt to build relations with the Trump administration, and Ivan recounted his lack of success. Redaction. Putin continued to inquire about Ivan's efforts to connect to the Trump administration in several subsequent quarterly meetings. Ivan also told Putin's chief of staff that he had been subpoenaed by the FBI. As part of that conversation, he reported that he had been asked by the FBI about whether he had worked to create a back channel between the Russian government and the Trump administration. According to Ivan, the official showed no emotion in response to this report and did not appear to care. This is numbered 6 Carter Page contact with Deputy Prime Minister Arkady Dvorak. In December 2016, more than 2 months after he was removed from the Trump campaign, former campaign foreign policy advisor Carter Page again visited Moscow in an attempt to pursue business opportunities. According to Konstantin Kilimnik, Paul Manafort's associate, Page also gave some individuals in Russia the impression that he had maintained his connections to President-elect Trump. In a December 8, 2016 email intended for Manafort, Kilimnik wrote, "Carter Page is in Moscow today, sending messages he is authorized to talk to Russia on behalf of DT on a range of issues of mutual interest, including Ukraine." On December 9, 2016, Page went to dinner with NES employees Shlomo Weber and Andrei Krikovich. Weber had contacted Dvorak to let him know that Page was in town and to invite him to stop by the dinner if he wished to do so. And Dvorak came to the restaurant for a few minutes to meet with Page. Dvorak congratulated Page on Trump's election and expressed interest in starting a dialogue between the United States and Russia. Dvorak asked Page if he could facilitate connecting Dvorak with individuals involved in the transition to begin a discussion of future cooperation. Redaction, 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 redaction. Dvorak separately discussed working together in the future by forming an academic partnership. Contacts with and through Michael T. Flynn. Incoming National Security Advisor Michael Flynn was the transition team's primary conduit for communications with the Russian ambassador and dealt with Russia on 2 sensitive matters during the transition period: a United Nations Security Council vote, and Russian government's reaction to the United States imposition of sanctions for Russian interference in the 2016 election. Despite Kushner's conclusion that Kislyak did not yield influence inside the Russian government, the transition team turned to Flynn's relationship with Kislyak on both issues. As to the sanctions, Flynn spoke by phone to KT McFarland, his incoming deputy, to prepare his call to Kislyak. McFarland was with the president-elect and other senior members of the transition team at Mar-a-Lago at the time. Although transition officials at Mar-a-Lago had some concern about possible Russian reactions to the sanctions, the investigation did not identify evidence that the president-elect asked Flynn to make any request to Kislyak. Flynn asked Kislyak not to escalate the situation in response to U.S. sanctions imposed on December 29, 2016, and Kislyak later reported to Flynn that Russia acceded to that request. United Nations vote on Israel settlements. On December 21, 2016, Egypt submitted a resolution to the United Nations Security Council calling on Israel to cease settlement activities in Palestinian territory. The Security Council, which includes Russia, was scheduled to vote on the resolution the following day. There was speculation in the media that the Obama administration would not oppose the resolution. Redaction. As discussed further in Volume 1, Section 5C4, Infra, Flynn pleaded guilty to making false statements to the FBI in violation of 18 U.S.C. 1001 about these communications with Ambassador Kislyak. Plea agreement, United States versus Michael T. Flynn, number 117 CR 232 DDC, December 1, 2017. According to Flynn, the transition team regarded the vote as a significant issue and wanted to support Israel by opposing the resolution. On December 22, 2016, multiple members of the transition team, as well as the President-elect Trump, communicated with foreign government officials to determine their views on the resolution and to rally support to delay the vote to defeat the resolution. Kushner led the effort for the transition team. Flynn was responsible for the Russian government. Minutes after an early morning phone call with Kushner on December 22nd, Flynn called Kislyak. According to Flynn, he informed Kislyak about the vote and the transition team's opposition to the resolution and requested the Russian vote against or delay the resolution. Later that day, President-elect Trump spoke with Egyptian President Abdel Fattah al-Sisi about the vote. Ultimately, Egypt postponed the vote. On December 23, 2016, Malaysia, New Zealand, Senegal, and Venezuela resubmitted the resolution. Throughout the day, members of the transition team continued to talk with foreign leaders about the resolution, with Flynn continuing to lead the outreach with Russian government through Kislyak. When Flynn again spoke with Kislyak, Kislyak informed Flynn that if the resolution came to a vote, Russia would not vote against it. The resolution later passed 14-0 with the United Nations abstaining. U.S. sanctions against Russia. Flynn was also the transition team member who spoke with the Russian government when the Obama administration imposed sanctions and other measures against Russia in response to Russia's interference in the 2016 presidential election. On December 28, 2016, when President Obama signed Executive Order 13757, which took effect at 12:01 a.m. the following day, and imposed sanctions on 9 Russian individuals and entities. On December 29, 2016, the Obama administration also expelled 35 Russian government officials and closed 2 Russian government-owned compounds in the United States. During the rollout of the sanctions, President-elect Trump and multiple transition team senior officials, including McFarlane, Steve Bannon, and Priebus, were staying at the Mar-a-Lago Club in Palm Beach, Florida. Flynn was on vacation in the Dominican Republic, but was in daily contact with McFarlane. The transition team and President-elect Trump were concerned that these sanctions would harm the United States' relationship with Russia. Although the details and timing of the sanctions were unknown, on December 28, 2016, the media began reporting that retaliatory measures from the Obama administration against Russia were forthcoming. When asked about imposing sanctions on Russia for its alleged interference in the 2016 presidential election, President-elect Trump told the media, and I quote, "I think we ought to get on with our lives," quote unquote. Russia initiated the outreach to the transition team. On the evening of December 28, 2016, Kislyak texts Flynn, "Can you kindly call me back at your convenience?" Flynn did not respond to the text message that evening. Someone from the Russian embassy also called Flynn the next morning at 10:38 a.m., but they did not talk. The sanctions announced publicly on December 29, 2016 at 1:53 p.m. that day, McFarlane began exchanging emails with multiple transition team members and advisors about the impact the sanctions would have on the incoming administration. At 2:07 p.m., a transition team member texts Flynn a link to a New York Times article about the sanctions. McFarlane called Flynn, but they did not talk. Shortly thereafter, McFarlane and Bannon discussed the sanctions. According to McFarlane, Bannon remarked that the sanctions would hurt their ability to have good relations with Russia and that Russian escalation would make things more difficult. McFarlane believed she told Bannon that Flynn was scheduled to talk to Kislyak later that night. McFarlane also believed she may have discussed the sanctions with Priebus, and likewise told him that Flynn was scheduled to talk to Kislyak that night. At 3:14 p.m., Flynn texted a transition team member who was assisting McFarlane, "Time for a call." The transition team member responded that McFarlane was on the phone with Tom Bossert, a transition team senior official, to which Flynn responded, "Tit for tat with Russia not good, Russian AMBO reaching out to me today." Flynn recalled that he chose not to communicate with Kislyak about the sanctions until he had heard from the team at Mar-a-Lago. He first spoke with Michael Ledeen, the transition team member who advised on foreign policy and national security members for 20 minutes. Flynn then spoke with McFarlane for almost 20 minutes to discuss what, if anything, to communicate Kislyak about the sanctions. On that call, McFarlane and Flynn discussed the sanctions, including their potential impact on the incoming administration's foreign policy goals. McFarlane and Flynn also discussed that transition team members in Mar-a-Lago did not want Russia to escalate the situation. They both understood that Flynn would delay a message to Kislyak in hopes of making sure the situation would not get out of hand.
Immediately after speaking with McFarlane, Flynn called and spoke with Kislyak. Flynn discussed multiple topics, including the sanctions, scheduling a video teleconference between President-elect Trump and Putin, an upcoming terrorism conference, and Russia's views about the Middle East. With respect to the sanctions, Flynn requested that Russia not escalate the situation, not get into a tit-for-tat, but only respond to the sanctions in a reciprocal manner. Multiple transition team members were aware that Flynn was speaking with Kislyak that day. In addition to her conversations with Bannon and Reince Priebus at 4:43 p.m., McFarland sent an email to the transition team members about the sanctions, informing the group that, quote, General Flynn is talking to Russian ambassador this evening. Less than an hour later, McFarland briefed President-elect Trump. Bannon, Priebus, Sean Spicer, and other transition team members were present. During the briefing, President-elect Trump asked McFarland if the Russians did it, meaning the intrusions intended to influence the presidential election. McFarland said yes, and President-elect Trump expressed doubt that it was the Russians. McFarland also discussed potential Russian responses to the sanctions and said Russia's response would be an indicator of what the Russians wanted going forward. President-elect Trump opined that the sanctions provided him with the leverage to use with the Russians. McFarland recalled that at the end of the meeting, someone may have mentioned to President-elect Trump that Flynn was speaking to the Russian ambassador that evening. After the briefing, Flynn and McFarland spoke over the phone. Flynn reported on the substance of his call, including the discussion of sanctions. According to McFarland, Flynn mentioned that the Russian response to the sanctions was not going to be escalatory because they wanted a good relationship with the incoming administration. McFarland also gave Flynn a summary of her recent briefings with President-elect Trump. The next day, December 30th, 2016, Russian Foreign Minister Sergei Lavrov remarked that Russia would respond in kind to the sanctions. Putin superseded that comment 2 hours later, releasing a statement that Russia would not take retaliatory measures in response to the sanctions at that time. Hours later, President-elect Trump tweeted, "Great move on delay." Shortly thereafter, Flynn sent a text message to McFarland summarizing his call with Kislyak from the day before, which she emailed to Kushner, Bannon, Priebus, and other transition team members. The text message and email did not include sanctions as one of the topics. Flynn told the office that he did not document his discussion of sanctions because it could be perceived as getting in the way of the Obama administration's foreign policy. On December 31st, 2016, Kislyak called Flynn and told him the request had been received at the highest levels and that Russia had chosen not to retaliate to the sanctions in response to the request. 2 hours later, Flynn spoke with McFarland and relayed his conversation. According to McFarland, Flynn remarked that the Russians wanted a better relationship and that the relationship was back on track. Flynn also told McFarland that he believed his phone call had made a difference. McFarland called congratulating Flynn in response. Flynn spoke with other transition team members that day, but does not recall whether they discussed the sanctions. Flynn recalled discussing the sanctions with Bannon the next day, and Bannon appeared to know about Flynn's conversation. Bannon, for his part, recalled meeting with Flynn that day, but said he did not remember discussing sanctions with him. Additional information about Flynn's sanctions-related discussions and the handling of those discussions by the transition team and the Trump administration is provided in Volume 2 of this report. In sum, the investigations establish multiple links between the Trump campaign officials and individuals tied to the Russian government. Those links included Russian offers of assistance to the campaign. In some instances, the campaign was receptive to the offer, while in other instances, the campaign officials shied away. Ultimately, the investigation did not establish that the campaign coordinated or conspired with the Russian government in its election interference activities. The appointment order authorized the special counsel's office to prosecute federal crimes arising from its investigation of matters assigned to it. In deciding whether to exercise this prosecutorial authority, the office has been guided by the principles of federal prosecution set forth in the Justice Manual. In particular, the office has evaluated whether the conduct of individuals considered for prosecution constituted a federal offense, and whether admissible evidence would probably be sufficient to obtain and sustain a conviction for such an offense. Justice Manuel, where the answer to those questions was yes, the office further considered whether the prosecution would serve a substantial federal interest. The individuals were subject to effective prosecution in another jurisdiction, and there existed an adequate, non-criminal alternative to prosecution. As explained below, those considerations led the office to seek charges against 2 sets of Russian nationals for their roles in perpetuating the Active Measures social media campaign and computer intrusion operations. There is redacted material. The office, similar to the contacts between the campaign officials and Russian-linked individuals, either did not involve the commission of a federal crime, or in the case of campaign finance offenses, that our evidence was not sufficient to obtain and sustain a criminal conviction. At the same time, the office concluded that the principles of federal prosecution supported charging certain individuals connected to the campaign with making false statements or otherwise obstructing this investigation or parallel congressional investigations. On February 16, 2018, a federal grand jury in the District of Columbia returned an indictment charging 13 Russian nationals and 3 Russian entities, including the Internet Research Agency and Concord Management and Consulting, with violating U.S. criminal laws in order to interfere with the U.S. elections and political processes. The indictment charges all of the defendants with conspiracy to defraud the United States, 3 defendants with conspiracy to commit wire fraud and bank fraud, and 5 defendants with aggravated identity theft. Concord, which is one of the entities charged in Count 1, conspiracy, entered an appearance through U.S. counsel and moved to dismiss the charge on multiple grounds. In orders and memorandums, opinions issued on August 13th and November 15th, 2018, the district court denied Concord's motions to dismiss. As of this writing, the prosecution of Concord remains ongoing before the U.S. District Court of the District of Columbia. The other defendants remain at large. Although members of the IRA had contact with individuals affiliated with the Trump campaign, the indictment does not charge any Trump campaign official or any other U.S. person with participating in the conspiracy. That is because the investigation did not identify evidence that any U.S. person who coordinated or communicated with the IRA knew that he or she was speaking with Russian nationals engaged in a criminal conspiracy. The office therefore determined that such persons did not have the knowledge or criminal purpose required to charge them in the conspiracy to defraud the United States or in the separate count alleging a wire and bank fraud conspiracy involving the IRA and 2 individual Russian nationals. The office did, however, charge 1 U.S. national for his role in supplying false or stolen bank account numbers that allowed the IRA conspirators to access U.S. online payment systems by circumventing those systems' security features. On February 12, 2018, Richard Pinedo pleaded guilty pursuant to a single count information to identity fraud. The investigation did not establish that Pinedo was aware of the identity of the IRA members who purchased bank account numbers from him. Pinedo's sale of account numbers enabled the IRA members to anonymously access a financial network through which they transacted with U.S. persons and companies. Pinedo was sentenced to 6 months imprisonment to be followed by 6 months of home confinement and was ordered to complete 100 hours of community service. On July 13, 2018, a federal grand jury in the District of Columbia returned an indictment charging Russian military intelligence officers from the GRU with conspiring to hack into various U.S. computers used by the Clinton campaign, the DNC, DCCC, and other U.S. persons in violation of 18 U.S.C., committing identity theft and conspiring to commit money laundering in furtherance of that hacking conspiracy, and a separate conspiracy to hack into the computers of U.S. persons and entities responsible for the administration of the 2016 U.S. elections. As of this writing, all 12 defendants remain at large. The indictment alleges that the defendants conspired with one another and with others to hack into the computers of U.S. persons and entities involved in the 2016 U.S. presidential election, steal documents from those computers, and stage releases of the stolen documents to interfere in the election. The indictment also described how, in staging the releases, the defendants used the Guccifer 2.0 persona to disseminate documents through WikiLeaks. On July 22, 2016, WikiLeaks released over 20,000 emails and other documents that the hacking conspirators had stolen from the DNC. In addition, on October 7, 2016, WikiLeaks began releasing emails that some conspirators had stolen from Clinton campaign chairman John Podesta after a successful spear-phishing operation. Redacted material. Another page of redacted material. A third page of redacted material. Another half page of redacted material. Applying the principles of federal prosecution, however, the office determined that prosecution of this potential violation was not warranted. Those principles instruct prosecutors to consider, among other things, the nature and seriousness of the offense, the person's culpability in connection with the offense, and the probable sentence to be imposed if the prosecution is successful. Redacted material. As explained in Section 4 above, the office's investigation uncovered evidence of numerous links between the Trump campaign officials and individuals having or claiming to have ties to the Russian government. The office evaluated the context under several sets of federal laws, including conspiracy laws, governing foreign agents who operate in the United States. After considering the available evidence, the office did not pursue charges under these statutes against any of the individuals discussed in Section 4 above, with the exception of the FARA charges against Paul Manafort and Richard Gates, based on their activities on the behalf of Ukraine. One of the interactions between the Trump campaign and Russian-affiliated individuals, the June 9, 2016 meeting between high-ranking campaign officials and Russians promising derogatory information on Hillary Clinton, implicates an additional body of law, campaign finance statutes. Schemes involving the solicitation or receipt of assistance from foreign sources raise different statutory and constitutional questions. As explained below, the office evaluated those questions in connection with the June 9th meeting, redacted material. The office ultimately concluded that even if the principal legal questions were resolved favorably to the government, a prosecution would encounter difficulties proving that campaign officials or individuals connected to the campaign willfully violated the law. Finally, although the evidence of contacts between campaign officials and Russian-affiliated individuals may not have been sufficient to establish or sustain criminal charges, several U.S. persons connected to the campaign made false statements about those contacts and took other steps to obstruct the office's investigation and those of Congress. This office has therefore charged some of those individuals with making false statements and obstructing justice. As an initial matter, this office evaluated potentially criminal conduct that involved the collective action of multiple individuals, not under the rubric of collusion, but through the lens of conspiracy law. In doing so, the office recognized that the word collude appears in the Acting Attorney General's August 2nd, 2017 memorandum. It has frequently been invoked in public reporting, and it is sometimes referenced in antitrust law. But collusion is not a specific offense or theory of liability found in the U.S. Code, nor is it a term of art in the federal criminal law. To the contrary, even as defined in legal dictionaries, collusion is largely synonymous with conspiracy, as that crime is set forth in the General Federal Conspiracy Statute. For that reason, this office's focus in resolving the question of joint criminal liability was on conspiracy, not the common discussed term collusion. The office considered in particular whether contacts between Trump campaign officials and Russia-linked individuals could trigger liability for the crime of conspiracy, either under statutes that have their own conspiracy language or under general conspiracy statute. The investigation did not establish that the contacts described in Volume 1 amounted to an agreement to commit any substantive violation of federal criminal law, including foreign influence and campaign finance laws. The office therefore did not charge any individual associated with the Trump campaign with conspiracy to commit a federal offense arising from Russia contacts, either under a specific statute or under Section 371's Offenses Clause. The office also did not charge any campaign official or associate with a conspiracy under Section 371's Defraud Clause. That clause criminalizes participating in an agreement to obstruct a lawful function of the U.S. government or its agencies through deceitful or dishonest means. The investigation did not establish any agreement among campaign officials or between such officials and Russia-linked officials to interfere with or obstruct a lawful function of a government agency during the campaign or transition period. And as discussed in Volume 1, the investigation did not identify that any campaign official or associate knowingly and intentionally participated in the conspiracy to defraud that office charged, namely the active measures conspiracy described in Volume 1. Accordingly, the office did not charge any campaign associate or other U.S. person with conspiracy to defraud the United States based on the Russian-related contacts described in Section 4 above. The office next assessed the potential liability of a campaign-affiliated individuals under federal statutes regulating actions on behalf of or work done for a foreign government.
Governing law. Under 18 U.S.C. 951, it's generally illegal to act in the United States as an agent of a foreign government without providing notice to the Attorney General. Although the defendant must act on behalf of a foreign government, as opposed to any other kinds of foreign entities, the acts need not involve espionage. Rather, acts of any type suffice for liability. An agent of a foreign government is an individual who agrees to operate in the United States subject to the direction or control of a foreign government or official. The crime defined by Section 951 is complete upon knowingly acting in the United States as an unregistered foreign government agent. The statute does not require willfulness, and knowledge of the notification requirement is not an element of the offense. The Foreign Agents Registration Act, FARA, generally makes it illegal to act as an agent of a foreign principal by engaging in certain largely political activities in the United States without registering with the Attorney General. The triggering agency relationship must be with a foreign principal or a person any of whose activities are directly or indirectly supervised, directed, controlled, financed, or subsidized in whole or in major part by a foreign principal. That includes a foreign government or political party and various foreign individuals and entities. A covered relationship exists if a person acts as an agent, representative, employee, or servant, or in any other capacity at the order, request, or under the foreign principal's direction or control. It is sufficient if the person agrees, consents, assumes, or purports to act as, or who is or holds himself out to be, whether or not pursuant to contractual relationship, the agent of a foreign principal. The triggering activity is that the agent directly or through any other person in the United States, number one, engages in political activities for or in the interests of the foreign principal, which includes attempts to influence federal officials or the public. Number two, acts as a public relations counsel, publicity agent, information service employee, or political consultant for or in the interests of such foreign principal. Three, solicits, collects, disperses, or dispenses contributions, loans, money, or other things of value for or in the interest of such foreign principal, or four, represents the interests of such foreign principal before any federal agency or official. It is a crime to engage in a willful violation of any provision of the Act or any regulation thereunder. It is also a crime willfully to make false statements or omissions of material facts in FARA registration statements or supplements. Most violations have a maximum penalty of 5 years of imprisonment and a $10,000 fine.
Application. The investigation uncovered extensive evidence that Paul Manafort's and Richard Gates's pre-campaign work for the government of Ukraine violated FARA. Manafort and Gates were charged for that conduct and admitted to it when they pleaded guilty to superseding criminal informations in the District of Columbia prosecution. The evidence underlying those charges is not addressed in this report because it was discussed in public court documents and in a separate prosecution memorandum submitted to the acting attorney general before the original indictment in that case. In addition, the investigation produced evidence of FARA violations involving Michael Flynn. Those potential violations, however, concerned a country other than Russia, i.e. Turkey, and were resolved when Flynn admitted to the underlying facts in the statement of offense that accompanied his guilty plea to a false statements charge, statement of offense. The investigation did not, however, yield evidence sufficient to sustain any charge that any individual affiliated with the Trump campaign acted as an agent of a foreign principal within the meaning of FARA, or in terms of Section 951, subject to the direction or control of the government of Russia or any official thereof. In particular, the office did not find evidence likely to prove beyond a reasonable doubt that campaign officials such as Paul Manafort, George Papadopoulos, and Carter Page acted as agents of the Russian government or at its direction, control, or request during the relevant time period. As a result, the office did not charge, redacted, any other Trump campaign official with violating FARA or Section 951 or attempting or conspiring to do so based on contacts with the Russian government or a Russian principal. Finally, the office investigated whether one of the above campaign advisors, George Papadopoulos, acted as an agent of or at the direction and control of the government of Israel. While the investigation revealed significant ties between Papadopoulos and Israel, and search warrants were obtained in part on that basis, the office ultimately determined that the evidence was not sufficient to obtain and sustain a conviction under FARA or Section 951. 3, campaign finance. Several areas of the office's investigation involved efforts or offers by foreign nationals to provide negative information about candidate Clinton or to the Trump campaign, or to distribute that information to the public to the anticipated benefit of the campaign. As explained below, the office considered whether two of those efforts in particular, the June 9th, 2016 meeting at Trump Tower, redacted, constituted prosecutable violations of the campaign finance laws. The office determined that the evidence was not sufficient to charge either incident as a criminal violation. A, overview of governing law. The United States has a compelling interest in limiting the participation of foreign citizens in activities of democratic self-government and in thereby preventing foreign influence over the U.S. political process, Blumen versus FEC. To that end, federal campaign finance law broadly prohibits foreign nationals from making contributions, donations, expenditures, or other disbursements in connection with federal, state, or local elections, and prohibits anyone from soliciting, accepting, or receiving such contributions or donations. As relevant here, foreign nationals may not make, and no one may solicit, accept, or receive from them a contribution or donation of money or other thing of value, or an express or implied promise to make a contribution or donation in connection with a federal, state, or local election. The term contribution, which is used throughout the campaign finance law, includes any gift, subscription, loan, advance, or deposit of money or anything of value made by any person for the purpose of influencing any election for federal office. It excludes, among other things, the value of volunteer services. Foreign nationals are also barred from making an expenditure, independent expenditure, or disbursement for an electioneering communication. The term expenditure includes any purchase, payment, distribution, loan, advance deposit, or gift of money or anything of value made by any person for the purpose of influencing any election for federal office. It excludes, among other things, news stories and nonpartisan get-out-the-vote activities. An independent expenditure is an expenditure expressly advocating the election or defeat of a clearly identified candidate and made independently of the campaign. An electioneering communication is a broadcast communication that refers to a clearly identified candidate for federal office and is made within specified time periods and targeted at the relevant electorate. The statute defines foreign national by reference to FARA and the Immigration and Nationality Act with minor modification. That definition yields 5 sometimes overlapping categories of foreign nationals, which include all of the individuals and entities relevant for present purposes, namely foreign governments and political parties, individuals outside of the U.S. who are not legal permanent residents, and certain non-U.S. entities located outside of the U.S. A knowing and willful violation involving an aggregate of $25,000 or more in a calendar year is a felony. Citations, a knowing and willful violation involving an aggregate of $2,000 or more in a calendar year, but less than $25,000, is a misdemeanor. B, application to June 9 Trump Tower meeting. The office considered whether to charge Trump campaign officials with crimes in connection with the June 9 meeting described in Volume 1, Section 4A5 Supra. The office concluded that, in light of the government's substantial burden of proof on issues of intent, knowing and willful, and the difficulty of establishing the value of the offered information, criminal charges would not meet the Justice Manual standard that the admissible evidence will probably be sufficient to obtain and sustain a conviction. In brief, the key facts are that on June 3, 2016, Robert Goldstone emailed Donald Trump Jr. to pass along from Emin and Aras Agalarov an offer from Russia's Crown Prosecutor to the Trump campaign of official documents and information that would incriminate Hillary and her dealings with Russia and would be very useful to Trump Jr.'s father. The email described this as very high-level and sensitive information that is part of Russia and its government's support to Mr. Trump, helped along by Aras and Emin. Donald Trump Jr. responded, "If it's what you say, I love it, especially later in the summer." Trump Jr. and Emin Agalarov had follow-up conversations and within days scheduled a meeting with Russian representatives that was attended by Trump Jr., Manafort, and Kushner. The communications setting up the meeting and the attendance by high-level campaign representatives support an inference that the campaign anticipated receiving derogatory documents and information from official Russian sources that could assist candidate Trump's electoral prospects. The series of events could implicate the federal election law ban on contributions and donations by foreign nationals. Specifically, Goldstone passed along an offer, purportedly from a Russian government official, to provide official documents and information to the Trump campaign for purposes of influencing the presidential election. Trump Jr. appears to have accepted that offer and to have arranged a meeting to receive those materials. Documentary evidence in the form of email chains supports the inference that Kushner and Manafort were aware of that purpose and attended the June 9 meeting anticipating the receipt of helpful information to the campaign from Russian sources. Are you taking over? Okay. The office considered whether this evidence would establish a conspiracy to violate the foreign contributions ban in violation of 18 U.S.C. 371, the solicitation of an illegal foreign source contribution, or the acceptance or receipt of an express or implied promise to make a foreign source contribution, both in violation of 52 U.S.C. 30121. There are reasonable arguments that the offered information would constitute a thing of value within the meaning of these provisions, but the office determined that the government would not be likely to obtain and sustain a conviction for two other reasons. First, the office did not obtain admissible evidence likely to meet the government's burden to prove beyond a reasonable doubt that these individuals acted willfully, i.e. with general knowledge of the illegality of their conduct. And second, the government would likely encounter difficulty in proving beyond a reasonable doubt that the value of the promised information exceeded the threshold for a criminal violation. One, thing of value element. A threshold legal question is whether providing to a campaign documents and information of the type involved here would constitute a prohibited campaign contribution. The foreign contribution ban is not limited to contributions of money. It expressly prohibits a contribution or donation of money or other thing of value. And the term contribution is defined throughout the campaign finance laws to include any gift, subscription, loan, advance, or deposit of money or anything of value. Okay, I left off there.
This is the introduction to Volume 2. This report is submitted to the Attorney General pursuant to 28 CFR Section 608C, which states that at the conclusion of the special counsel's work, he shall provide the Attorney General a confidential report explaining the prosecution or declination decisions reached. Beginning in 2017, the President of the United States took a variety of actions towards the ongoing FBI investigations into Russia's interference in the 2016 presidential election and related matters that raised questions about whether he had obstructed justice. The order appointing the special counsel gave this office jurisdiction to investigate matters that arose directly from the FBI's Russia investigation, including whether the president had obstructed justice in connection with Russia-related investigations. The special counsel's jurisdiction also covered potentially obstructive acts related to the special counsel's investigation itself. This volume of our report summarizes our obstruction of justice investigation of the president. We first describe the considerations that guided our obstruction of justice investigation and then provide an overview of this volume. First, a traditional prosecution or declination decision entails a binary determination to initiate or decline a prosecution. But we determined not to make a traditional prosecutorial judgment. The Office of Legal Counsel has issued an opinion finding that the indictment or criminal prosecution of a sitting president would impermissibly undermine the capacity of the executive branch to perform its constitutionally assigned functions in violation of the constitutional separation of powers. Given the role of special counsel as attorney in the Department of Justice and framework of the special counsel regulations, this office accepted OLC's legal conclusion for the purpose of executing prosecutorial jurisdiction. And apart from OLC's constitutional view, we recognize that a federal criminal accusation against a sitting president would place burdens on the president's capacity to govern and potentially preempt constitutional processes for addressing presidential misconduct. Second, while the OLC opinion concludes that a sitting president may not be prosecuted, it recognizes that a criminal investigation during the president's term is permissible. The OLC opinion also recognizes that a president does not have immunity after he leaves office. And if individuals other than the president committed an obstruction offense, they may be prosecuted at this time. Given these considerations, the facts known to us, and the strong public interest in safeguarding the integrity of the criminal justice system, we conducted a thorough factual investigation in order to preserve the evidence when memories were fresh and documentary materials were available. Third, we considered whether to evaluate the conduct we investigated under the Justice Manual standards governing prosecution and declination decisions, but we determined not to apply an approach that could potentially result in a judgment that the president committed crimes. The threshold step under the Justice Manual standards is to assess whether a person's conduct constitutes a federal offense. Fairness concerns counsel against potentially reaching that judgment when no charges can be brought. The ordinary means for an individual to respond to an accusation is through a speedy and public trial, with all the procedural protections that surround a criminal case. An individual who believes he was wrongly accused can use that process to seek to clear his name. In contrast, a prosecutor's judgment that crimes were committed but that no charges will be brought affords to such adversarial opportunity for public name clearing before an impartial adjudicator. The concerns about the fairness of such a determination would be heightened in the case of a sitting president, where a federal prosecutor's accusation of a crime, even in an internal report, could carry consequences that extend beyond the realm of criminal justice. OLC noted similar concerns about sealed indictments. Even if an indictment were sealed during the president's term, OLC reasoned it would be very difficult to preserve an indictment's secrecy. And if an indictment became public, the stigma and opprobrium could imperil the president's ability to govern. Although the prosecutor's internal report could not represent a formal public accusation akin to an indictment, the possibility of the report's public disclosure and the absence of a neutral adjudicatory forum to review its findings counseled against potentially determining that the person's conduct constitutes a federal offense. Fourth, If we had confidence that a thorough investigation of the facts that the president clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, however, we were unable to reach that judgment. The evidence we obtained about the president's actions and intent present difficult issues that prevent us from conclusively determining that no criminal conduct occurred. Accordingly, while this report does not conclude that the president committed a crime, it also does not exonerate him. This report of our investigation consists of 4 parts. Section 1 provides an overview of obstruction of justice principles and summarizes certain investigatory and evidentiary considerations. Section 2 sets forth the factual results of our obstruction investigation and analyzes the evidence. Section 3 addresses statutory and constitutional defenses. Section 4 states our conclusion. This is the executive summary to Volume 2. Our obstruction of justice inquiry focused on a series of actions by the president that related to the Russian interference investigations, including the president's conduct towards the law enforcement officials overseeing the investigation and the witnesses to relevant events. Factual results of the obstruction investigation. The key issues and events we examined include the following: the campaign's response to reports about Russian support for Trump. During the 2016 presidential campaign, questions arose about the Russian government's apparent support for candidate Trump. After WikiLeaks released politically damaging Democratic Party emails that were reported to have been hacked by Russia, Trump publicly expressed skepticism that Russia was responsible for the hacks, at the same time that he and other campaign officials privately sought information. Redacted portion. About any further planned WikiLeaks releases. Trump also denied having any business in or connections to Russia, even though, as late as June 2016, the Trump Organization had been pursuing a licensing deal for a skyscraper to be built in Russia called Trump Tower Moscow. After the election, the president expressed concerns to advisors that reports of Russia's election interference might lead the public to question the legitimacy of his election. Conduct involving FBI Director Comey and Michael Flynn. In mid-January 2017, incoming National Security Advisor Michael Flynn falsely denied to the Vice President, other administration officials, and FBI agents that he had talked to Russian Ambassador Sergei Kislyak about Russia's response to U.S. sanctions on Russia for its election interference. On January 27th, a day after the president was told that Flynn had lied to the vice president and had made similar statements to the FBI, the president invited FBI Director Comey to a private dinner at the White House and told Comey that he needed loyalty. On February 14th, the day after the president requested Flynn's resignation, the president told an outside advisor, "Now that we fired Flynn, the Russia thing is over." The advisor disagreed and said the investigations would continue. Late that afternoon, the president cleared the Oval Office to have a one-on-one meeting with Comey. Referring to the FBI's investigation of Flynn, the president said, "I hope you can see your way clear to letting Flynn go. He is a good guy. I hope you can let this go." Shortly after requesting Flynn's resignation and speaking privately to Comey, the president sought to have Deputy National Security Advisor K.T. McFarland draft an internal letter stating that the president had not directed Flynn to discuss sanctions with Kislyak. McFarland declined because she did not know whether that was true, and a White House counsel's office attorney thought that the request would look like quid pro quo for an ambassadorship she had been offered. The president's reaction to the continuing Russia investigation. In February 2017, Attorney General Jeff Sessions began to assess whether he had to recuse himself from campaign-related investigations because of his role in the Trump campaign. In early March, the president told White House counsel Donald McGahn to stop Sessions from recusing. And after Sessions announced his recusal on March 2nd, the president expressed anger at the decision and told advisors that he should have an attorney general who would protect him. That weekend, the president took Sessions aside at an event and urged him to unrecuse. Later in March, Comey publicly disclosed at a congressional hearing that the FBI was investigating the Russian government's efforts to interfere in the 2016 presidential election, including any links or coordination between the Russian government and the Trump campaign.
As the members finish voting, I'll continue reading. In the following days, the President reached out to the Director of National Intelligence and the leaders of the Central Intelligence Agency and the National Security Agency to ask them what they could do to publicly dispel the suggestion that the President had any connection to the Russian election interference effort. The President also twice called Comey directly, notwithstanding guidance from McGahn to avoid direct contacts with the Department of Justice. Comey had previously assured the president that the FBI was not investigating him personally, and the president asked Comey to lift the cloud, quote, of the Russian investigation by saying that publicly. The president's termination of Comey. On May 3rd, 2017, Comey testified at a congressional hearing but declined to answer questions about whether the president was personally under investigation. Within days, the president decided to terminate Comey. The president insisted that the termination letter, which was written for public release, state that Comey had informed the president that he was not under investigation. The day of the firing, the White House maintained that Comey's termination resulted from independent recommendations from the Attorney General and Deputy Attorney General that Comey should be discharged for mishandling the Hillary Clinton email investigation. But the president had decided to fire Comey before hearing from Department of Justice. The day after firing Comey, the president told Russian officials that he had faced great pressure because of Russia, which had been taken off by Comey's firing. The next day, the president acknowledged in a television interview that he was going to fire Comey regardless of the Department of Justice's recommendation that when he decided to just do it, he was thinking that this thing with Trump and Russia is a made-up story. In response to a question about whether he was angry with Comey and about the Russia investigation, the president said, "As far as I'm concerned, I want that thing to be done absolutely properly," adding that firing Comey might even lengthen out the investigation. The appointment of a special counsel and the efforts to remove him. On May 17, 2017, the acting Attorney General for Russia investigation appointed a special counsel to conduct the investigation and related matters. The president reacted to news that a special counsel had been appointed by telling advisors that it was the end of his presidency and demanding that Sessions resign. Sessions submitted his resignation, but the president ultimately did not accept it. The president told aides that the special counsel had conflicts of interest and suggested that the special counsel therefore should not serve. The president's advisors told him the asserted conflicts were meritless and that it had already been considered by the Department of Justice. On June 14, 2017, the media reported that the special counsel's office was investigating whether the president had obstructed justice. Press reports called this a major turning point in the investigation. While Comey had told the president he was not under investigation, following Comey's firing, the president now was under investigation. The president reacted to this news with a series of tweets, criticizing the Department of Justice and the special counsel's investigation. On June 17, 2017, the president called McGahn at home and directed him to call the acting attorney general and say that the special counsel had conflicts of interest and must be removed. McGahn did not carry out the direction, however, deciding that he would resign rather than trigger what he regarded as a potential Saturday night massacre. Efforts to curtail the special counsel's investigation. 2 days after directing McGahn to have the special counsel removed, the president made another attempt to affect the course of the Russia investigation. On June 19, 2017, the president met one-on-one in the Oval Office with his former campaign manager, Corey Lewandowski, a trusted advisor outside the government, and dictated a message for Lewandowski to deliver to Sessions. The message said that Sessions should publicly announce that, notwithstanding his recusal from the Russia investigation, the investigation was, quote, very unfair to the president. The president had done nothing wrong, and Sessions planned to meet with the special counsel and, quote, let him move forward with investigating election meddling for future elections. Lewandowski said he understood what the president wanted Sessions to do. 1 month later, in another private meeting with Lewandowski on July 19, 2017, the president asked about the status of his message for Sessions to limit the special counsel investigation to future election interference. Lewandowski told the president that the message would be delivered soon. Hours after that meeting, the president publicly criticized Sessions in an interview with the New York Times, and then issued a series of tweets making it clear that Sessions' job was in jeopardy. Lewandowski did not want to deliver the president's message personally, so he asked senior White House official Rick Dearborn to deliver it to Sessions. Dearborn was uncomfortable with this task and did not follow through. Efforts to prevent public disclosure of evidence. In the summer of 2017, the president learned that media outlets were asking questions about the June 9, 2016 meeting at Trump Tower between senior campaign officials, including Donald Trump Jr., and a Russian lawyer who was said to be offering damaging information about Hillary Clinton as, quote, part of Russia and its government support for Mr. Trump. On several occasions, the president directed aides not to publicly disclose the emails setting up the July 9th meeting, suggesting that the emails would not leak and that the number of lawyers with access to them should be limited. Before the emails became public, the president edited a press statement for Trump Jr. by deleting a line that acknowledged that the meeting was with an individual, quote, an individual who Trump Jr. was told might have information helpful to the campaign, and instead said only that the meeting was about adoptions of Russian children. When the press asked questions about the president's involvement in Trump Jr.'s statement, the president's personal lawyer repeatedly denied the president had played any role. Further efforts to have the Attorney General take control of the investigation.
Further efforts to have the Attorney General take control of the investigation. In early summer 2017, the president called Sessions at home and again asked him to reverse his recusal from the Russia investigation. Sessions did not reverse his recusal. In October 2017, the president met privately with Sessions in the Oval Office and asked him to take a look at investigating Clinton. In December 2017, shortly after Flynn pled guilty pursuant to a cooperation agreement, the president met with Sessions in the Oval Office and suggested, according to notes taken by a senior advisor, that if Sessions unrecused and took back supervision of the Russia investigation, he would be a hero. The president told Sessions, I'm not going to do anything or direct you to do anything. I just want to be treated fairly. In response, Sessions volunteered that he'd never seen anything improper on the campaign and told the president there was a whole new leadership team in place. He did not unrecuse. Efforts to have McGahn deny that the president had ordered him to have the special counsel removed. In early 2018, the press reported that the president had directed McGahn to have the special counsel removed in June 2017, and that McGahn had threatened to resign rather than carry out the order. The president reacted to the news story by directing White House officials to tell McGahn to dispute the story and create a record stating he had not been ordered to have the special counsel removed. McGahn told those officials that the media reports were accurate in stating that the president had directed McGahn to have the special counsel removed. The president then met with McGahn in the Oval Office and again pressured him to deny the reports. In the same meeting, The president also asked McGahn why he had told the special counsel about the president's effort to remove the special counsel and why McGahn took notes of his conversations with the president. McGahn refused to back away from what he remembered happening and perceived the president to be testing his mettle. Conduct towards Flynn Manafort. After Flynn withdrew from a joint defense agreement with the president and began cooperating with the president's personal counsel left a message for Flynn's attorneys reminding them of the president's warm feelings towards Flynn, which he said still remains, and asking for a heads up if Flynn knew information that implicates the president. When Flynn's counsel reiterated that Flynn could no longer share information pursuant to a joint defense agreement, the president's personal counsel said he would make sure that the president knew that Flynn's actions reflected hostility towards the president. During Manafort's prosecution and when the jury in his criminal trial was deliberating, the president praised Manafort in public and said that Manafort was being treated unfairly and declined to rule out a pardon. After Manafort was convicted, the president called Manafort a brave man for refusing to break and said that flipping almost ought to be outlawed. Portion redacted. Conduct involving Michael Cohen. The president's conduct towards Michael Cohen, a former Trump Organization executive, changed from praise for Cohen when he falsely minimized the president's involvement in the Trump Tower Moscow project to castigation of Cohen when he became a cooperating witness. From September 2015 to June 2016, Cohen had pursued the Trump Tower Moscow project on behalf of the Trump Organization and had briefed candidate Trump on the project numerous times, including discussing whether Trump should travel to Russia to advance the deal. In 2017, Cohen provided false testimony to Congress about the project, including stating that he had only briefed Trump on the project 3 times and never discussed travel to Russia with him in an effort to adhere to a party line that Cohen said was developed to minimize the president's connection to Russia. While preparing for his congressional testimony, Cohen had extensive discussions with the president's personal counsel, who, according to Cohen, said that Cohen should stay on message and not contradict the president. After the FBI searched Cohen's home and office in April 2018, the president publicly asserted that Cohen would not flip, contacting him directly to tell him to stay strong, and privately passed messages of support to him. Cohen also discussed pardons with the president's personal counsel and believed that if he stayed on message, he would be taken care of. But after Cohen began cooperating with the government in the summer of 2018, the president publicly criticized him, called him a rat, and suggested that his family members had committed crimes. Overarching factual issues. We did not make a traditional prosecution decision about these facts, but the evidence we obtained supports several general statements about the president's conduct. Several features of the conduct we investigated distinguish it from typical obstruction of justice cases. First, the investigation concerned the president, and some of his actions, such as firing the FBI director, involved facially lawful acts within his Article II authority, which raises constitutional issues discussed below. At the same time, the president's position as the head of the executive branch provided him with a unique and powerful means of influencing official proceedings, subordinate officers, and potential witnesses, all of which is relevant to a potential obstruction of justice analysis. Second, unlike cases in which a subject engages in obstruction of justice to cover up a crime, the evidence we obtained did not establish that the president was involved in an underlying crime related to Russian election interference. Although the obstruction statutes do not require proof of such a crime, the absence of that evidence affects the analysis of the president's intent and requires consideration of other possible motives for his conduct. Third, many of the president's acts directed at witnesses, including discouragement of cooperation with the government and suggestions of possible future pardons, took place in public view. That circumstance is unusual, but no principle of law excludes public acts from the reach of the obstruction laws. If the likely effect of public acts is to influence witnesses or alter their testimony, the harm to the justice system's integrity is the same. Although the series of events we investigated involved discrete acts, the overall pattern of the president's conduct towards the investigation can shed light on the nature of the president's acts and the inferences that can be drawn about his intent. In particular, the actions we investigated can be divided into two phases, reflecting a possible shift in the president's motives. The first phase covered the period from the president's first interactions with Comey through the president's firing of Comey. During that time, the president had been repeatedly told he was not personally under investigation. Soon after the firing of Comey and the appointment of the special counsel, however, the president became aware that his own conduct was being investigated in an obstruction of justice inquiry. At that time, the president engaged in a second phase of conduct involving public attacks on the investigation, non-public efforts to control it, and efforts in both public and private to encourage witnesses not to cooperate with the investigation. Judgments about the nature of the president's motives during each phase would be informed by the totality of the evidence. Statutory and constitutional defenses. The president's counsel raised statutory and constitutional defenses to a possible obstruction of justice analysis of the conduct we investigated. We concluded that none of those legal defenses provided a basis for declining to investigate the facts. Statutory defenses. Consistent with precedent and the Department of Justice's general approach to interpreting obstruction statutes, we concluded that several statutes could apply here. Section 1512C2 is an omnibus obstruction of justice provision that covers a range of obstructive acts directed at pending or contemplated official proceedings. No principle of statutory construction justifies narrowing the provision to cover only conduct that impairs the integrity or availability of evidence. Sections 1503 and 1505 also offer broad protection against obstructive acts directed at pending grand jury, judicial, administrative, and congressional proceedings. And they are supplemented by a provision in Section 1512B aimed specifically at conduct intended to prevent or hinder the communication to law enforcement or of information related to a federal crime. Constitutional defenses. As for constitutional defenses arising from the president's status as the head of the executive branch, we recognize that the Department of Justice and the courts have not definitively resolved these issues. We therefore examined those issues through the framework established by Supreme Court precedent governing separation of power issues. The Department of Justice and the president's personal counsel have recognized that the president is subject to statutes that prohibit obstruction of justice by bribing a witness or suborning perjury because that conduct does not implicate his constitutional authority. With respect to whether the president can be found to have obstructed justice by exercising his powers under Article 2 of the Constitution, we concluded that Congress has authority to prohibit a president's corrupt use of his authority in order to protect the integrity of the administration of justice. Under applicable Supreme Court precedent, the Constitution does not categorically and permanently immunize a president for obstructing justice through the use of his Article II powers. The separation of powers doctrine authorizes Congress to protect official proceedings, including those of courts and grand juries, from corrupt, obstructive acts regardless of their source. We also concluded that any inroad on presidential authority that would occur from prohibiting corrupt acts does not undermine the president's ability to fulfill his constitutional mission. The term corruptly sets a demanding standard. It requires a concrete showing that a person acted with the intent to obtain an improper advantage for himself or someone else, inconsistent with official duty and the rights of others. A preclusion of corrupt official action does not diminish the president's ability to exercise Article II powers. For example, the proper supervision of criminal law does not demand freedom for the president to act with a corrupt intention to shield himself from criminal punishment, avoiding financial liability, or preventing personal embarrassment. To the contrary, a statute that prohibits official action undertaken for such corrupt purposes furthers rather than hinders the impartial and even-handed administration of the law. It also aligns with the president's constitutional duty to faithfully execute the laws. Finally, we concluded that in the rare case in which a criminal investigation of the president's conduct is justified, inquiries to determine whether the president acted for a corrupt motive should not impermissibly chill his performance of his constitutionally assigned duties. The conclusion that Congress may apply the obstruction laws to the president's corrupt exercise of the powers of office accords with our constitutional system of checks and balances and the principle that no person is above the law. Conclusion. Because we determined not to make a traditional prosecutorial judgment, we did not draw ultimate conclusions about the president's conduct. The evidence we obtained about the president's actions and intent presents difficult issues that would need to be resolved if we were to make a traditional prosecutorial judgment. At the same time, if we had confidence after a thorough investigation of the facts that the president clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, we are unable to reach that judgment. Accordingly, while this report does not conclude that the president committed a crime, it also does not exonerate him. Background, legal, and evidentiary principles. A, legal framework of obstruction of justice. The May 17, 2017 appointment order and the special counsel regulations provide this office with jurisdiction to investigate federal crimes committed in the course of it and with intent to interfere with the special counsel's investigation, such as perjury, obstruction of justice, destruction of evidence, and intimidation of witnesses. Because of that description of our jurisdiction, we sought evidence for our obstruction of justice investigation with the elements of obstruction offenses in mind. Our evidentiary analysis is similarly focused on the elements of such offenses, although we do not draw conclusions on the ultimate questions that govern a prosecutorial decision under the principles of federal prosecution. Here, we summarize the law interpreting the elements of potentially relevant obstruction statutes in an ordinary case. This discussion does not address the unique constitutional issues that arise in an inquiry into official acts by the president. Those issues are discussed in a later section of this report, addressing constitutional defenses that the President's counsel have raised. Three basic elements are common to most of the relevant obstruction statutes. 1, an obstructive act. 2, a nexus between the obstructive act and an official proceeding. And 3, a corrupt intent. We describe those elements as they have been interpreted by the courts. We then discuss a more specific statute aimed at witness tampering and describe the requirements for attempted offenses and endeavors to obstruct justice. Obstructive act. Obstruction of justice law reaches all corrupt conduct capable of producing an effect that prevents justice from being duly administered, regardless of the means employed. An effort to influence a proceeding can qualify as an endeavor to obstruct justice, even if the effort was subtle or circuitous, or however cleverly or with whatever cloaking of purpose it was made. The verbs obstruct or impede are broad and can refer to anything that blocks, makes difficult, or hinders. An improper motive can render an actor's conduct criminal even when the conduct would otherwise be lawful and within the actor's authority. Nexus to a pending or contemplated official proceeding. Obstruction of justice law generally requires a nexus or connection to an official proceeding.
In Section 1503, the nexus must be pending judicial or grand jury proceedings. In Section 1505, the nexus can include a connection to a pending federal agency proceeding or a congressional inquiry or investigation. Under both statutes, the government must demonstrate a relationship in time, causation, or logic between the obstructive act and the proceeding or inquiry to be obstructed. Section 1512C prohibits obstructive efforts aimed at official proceedings, including judicial or grand jury proceedings. For purposes of Section 1512, an official proceeding need not be pending or about to be instituted at the time of the offense. Although a proceeding need not already be in progress to trigger liability under Section 1512C, a nexus to a contemplated proceeding still must be shown. The nexus requirement narrows the scope of obstruction statutes to ensure that individuals have fair warning of what the law prescribes. The nexus showing has subjective and objective components. As an objective matter, a defendant must act in a manner that is likely to obstruct justice, such that the statute excludes defendants who have an evil purpose but use means that would only unnaturally and improbably be successful. The endeavor must have the natural and probable effect of interfering with the due administration of justice. As a subjective matter, the actor must have contemplated a particular foreseeable proceeding. A defendant need not directly impede the proceeding. Rather, a nexus exists if discretionary actions of a third person would be required to obstruct the judicial proceeding if it was foreseeable to the defendant that the third party would act on the defendant's communication in such a way as to obstruct the judicial proceeding. Corruptly. The word corruptly provides the intent element for obstruction of justice and means acting knowingly and dishonestly, or with an improper motive. Sorry, lots of citations. The requisite showing is made when a person acted with an intent to obtain an improper advantage for himself or someone else, inconsistent with official duty and the right of others. Witness tampering. A more specific provision in Section 1512 prohibits tampering with a witness. To establish corrupt persuasion, it is sufficient that the defendant asked a potential witness to lie to investigators in contemplation of a likely federal investigation into his conduct. The persuasion need not be coercive, intimidating, or explicit. It is sufficient to urge, induce, ask, argue, give reasons, coach, remind witnesses by planting misleading facts. Corrupt persuasion is shown where a defendant tells a potential witness a false story, as if the story were true, intending that the witness believe the story and testify to it. It also covers urging a witness to recall a fact that the witness did not know, even if the fact was actually true. Corrupt persuasion also can be shown in certain circumstances when a person with an improper motive urges a witness not to cooperate with law enforcement.
When the charge is acting with the intent to hinder, delay, or prevent the communication of information to law enforcement under Section 1512b3, the nexus to a preceding inquiry articulated in Aguilar, that an individual have knowledge that his actions are likely to affect the judicial proceeding, does not apply because the obstructive act is aimed at the communication of information to investigators, not at impeding an official proceeding. Acting knowingly, corruptly, requires proof that the individual was conscious of wrongdoing. It is an affirmative defense that the conduct consisted solely of lawful conduct and that the defendant's sole intention was to encourage, induce, or cause the other person to testify truthfully, attempts and endeavors. Section 1512c2 covers both substantive obstruction offenses and attempts to obstruct justice. Under general principles of attempt law, a person is guilty of an attempt when he has the intent to commit a substantive offense and takes an overt act that constitutes a substantial step towards that goal. The act must be substantial in that it was strongly corroborative of the defendant's criminal purpose. While mere abstract talk does not suffice, any concrete and specific acts that corroborate the defendant's intent can constitute a substantial step. Thus, soliciting an innocent agent to engage in conduct constituting an element of the crime may qualify as a substantial step. The Omnibus Clause of 18 U.S.C. 1503 prohibits an endeavor to obstruct justice which sweeps more broadly than Section 1512's attempt provision. It is well established that an obstruction of justice offense is complete when one corruptly endeavors to obstruct or impede the due administration of justice. The prosecution need not prove that the due administration of justice was actually obstructed or impeded. Investigative and evidentiary considerations. After the appointment of the special counsel, the office obtained evidence about the following events relating to potential issues of obstruction of justice involving the president. A, the president's January 27, 2017 dinner with former FBI Director James Comey, in which the president reportedly asked for James Comey's loyalty one day after the White House had been briefed by the Department of Justice on contacts between former National Security Advisor Michael Flynn and the Russian ambassador. B, the president's February 14, 2017 meeting with Comey, in which the president reportedly asked Comey not to pursue an investigation of Michael Flynn. C, the president's private request to Comey to make public the fact that the president was not the subject of an FBI investigation and to lift what the president regarded as a cloud. D, the president's outreach to the director of national intelligence and the directors of the National Security Agency and the Central Intelligence Agency about the FBI's Russia investigation. E, the president's stated rationales for terminating Comey on May 9, 2017, including statements that could reasonably be understood as acknowledging that the FBI's Russia investigation was a factor in Comey's termination. And F, the president's reported involvement in issuing a statement about the June 9, 2016 Trump Tower meeting between Russians and senior Trump campaign officials that said the meeting was about adoption and omitted that the Russians had offered to provide the Trump campaign with derogatory information about Hillary Clinton. Taking into account that information in our analysis of applicable statutory and constitutional principles, we determined that there was a sufficient factual and legal basis to further investigate potential obstruction of justice issues involving the president. Many of the core issues in an obstruction of justice investigation turn on an individual's actions and intent. We therefore requested that the White House provide us with documentary evidence in its possession on the relevant events. We also sought and obtained the White House's concurrence in our conducting interviews of White House personnel who had relevant information, and we interviewed other witnesses who had pertinent knowledge, obtained documents on a voluntary basis when possible, and used legal process where appropriate. These investigative steps allowed us to gather a substantial amount of evidence. We also sought a voluntary interview with the president. After more than a year of discussion, the president declined to be interviewed. Redacted. During the course of our discussions, the president did agree to answer written questions on certain Russia-related topics, and he provided us with answers. He did not similarly agree to provide written answers to questions on obstruction topics or questions on events during the transition. Ultimately, while we believed that obstruction topics or questions, while we believed that we had the authority and legal justification to issue a grand jury subpoena to obtain the president's testimony, we chose not to do so. We made the decision in view of the substantial delay that such an investigative step would likely produce at a late stage in our investigation. We also assessed that based on the significant body of evidence we'd already obtained of the president's actions and his public and private statements describing or explaining those actions, we had sufficient evidence to understand relevant events and to make certain assessments without the president's testimony. The office's decision-making process on this issue is described in more detail in Appendix C in a note that precedes the president's written responses.
In assessing the evidence we obtained, we relied on common principles that apply in any investigation. The issue of criminal intent is often inferred from circumstantial evidence. The principle that intent can be inferred from circumstantial evidence is a necessity in criminal cases, given the right of a subject to assert his privilege against compelled self-incrimination under the Fifth Amendment and therefore to decline to testify. Accordingly, determinations on intent are frequently reached without opportunity to interview an investigatory subject. Obstruction of justice cases are consistent with this rule. So, credibility judgments may also be based on objective facts and circumstantial evidence. Standard jury instructions highlight a variety of factors that are often relevant in assessing credibility. These include whether a witness had opportunity to tell the truth, whether the witness had good memory, whether the witness had opportunity to observe the events about which he testified, whether the witness's testimony was corroborated by other witnesses, and whether anything the witness said or wrote previously contradicts his testimony. In addition to these general factors, we took into account more specific factors in assessing the credibility of conflicting accounts of facts. For example, contemporaneous written notes can provide strong corroborating evidence. Similarly, a witness's resuscitation of the account before he had any motive to fabricate also supports a witness's credibility.
Factual results of the obstruction investigation. This section of the report details the evidence we obtained. We first provide an overview of how Russia became an issue in the 2016 presidential campaign and how candidate Trump responded. We then turn to the key events that we investigated: the president's conduct concerning the FBI investigation of Michael Flynn, the president's reaction to public confirmation of the FBI's Russia investigation, events leading up to and surrounding the termination of FBI Director Comey, efforts to terminate the special counsel, efforts to curtail the scope of the special counsel's investigation, efforts to prevent disclosure of information about the June 9, 2016 Trump Tower meeting between Russians and senior campaign officials, efforts to have the Attorney General unrecuse, and conduct towards McGahn, Cohen, and other witnesses. We summarize the evidence we found and then analyze it by reference to the three statutory obstruction of justice elements: obstructive act, nexus to a proceeding, and intent. We focus on elements because, by regulation, the special counsel has jurisdiction to investigate federal crimes committed in the course of and with the intent to interfere with the special counsel's investigation, such as perjury, obstruction of justice, destruction of evidence, and intimidation of witnesses. Consistent with our jurisdiction to investigate federal obstruction crimes, we gathered evidence that is relevant to the elements of those crimes and analyzed them within an elements framework, while refraining from reaching ultimate conclusions about whether crimes were committed for the reasons explained above. This section also does not analyze legal and constitutional defenses raised by counsel for the president. Those defenses are analyzed in Volume 2, Section 3.
the campaign's response to reports about Russian support for Trump. During the 2016 campaign, the media raised questions about a possible connection between the Trump campaign and Russia. The questions intensified after WikiLeaks released politically damaging Democratic Party emails that were reported to have been hacked by Russia. Trump responded to questions about possible connections to Russia by denying any business involvement in Russia, even though the Trump Organization had pursued a business project in Russia as late as June 2016. Trump also expressed skepticism that Russia had hacked the emails at the same time as he and other campaign advisors privately sought information, redaction, about any further planned WikiLeaks releases. After the election, when questions persisted about possible links between Russia and the Trump campaign, the president-elect continued to deny any connections to Russia and privately expressed concerns that reports of Russian election interference might lead the public to question the legitimacy of his election. Press reports alleged links between Trump campaign and Russia. On June 16, 2015, Donald J. Trump declared his intent to seek nomination as the Republican candidate for president. By early 2016, he distinguished himself among Republican candidates by speaking of closer ties with Russia, saying he would get along well with Russian President Vladimir Putin, questioning whether the NATO alliance was obsolete, and praising Putin as a strong leader. The press reported that Russian political analysts and commentators perceived Trump as favorable to Russia.
Beginning in February 2016 and continuing through the summer, the media reported that several Trump campaign advisors appeared to have ties to Russia. For example, the press reported that campaign advisor Michael Flynn was seated next to Vladimir Putin at an RT gala in Moscow in December 2015, and that Flynn appeared regularly on RT as an analyst. The press also reported that foreign policy advisor Carter Page had ties to a Russian state-run gas company, and that campaign chairman Paul Manafort had done work for the Russian-backed former Ukrainian President Viktor Yanukovych. In addition, the press raised questions during the Republican National Convention about the Trump campaign's involvement in changing the Republican platform's stance on giving weapons to Ukraine to fight Russian and rebel forces. The Trump campaign reacts to WikiLeaks' release of hacked emails. On June the 14th, 2016, a cybersecurity firm that had conducted in-house analysis for the Democratic National Convention, or Committee, Democratic National Committee, DNC, posted an announcement that Russian government hackers had infiltrated the DNC's computer and obtained access to documents. On July 22nd of 2016, the day before the Democratic National Convention, WikiLeaks posted thousands of hacked DNC documents revealing sensitive internal deliberations. Soon thereafter, Hillary Clinton's campaign manager publicly contended that Russia had hacked the DNC emails and arranged their release in order to help candidate Trump. On July 26, 2016, the New York Times reported that U.S. intelligence agencies had told the White House they now have high confidence that the Russian government was behind the theft of emails and documents from the Democratic National Committee. Within the Trump campaign, aides reacted with enthusiasm to reports of the hacks. Then there's a redaction. Discussed with campaign officials that WikiLeaks would release the hacked material. Some witnesses said that Trump himself discussed the possibility of upcoming releases. Then there's a redaction. Michael Cohen, then Executive Vice President of the Trump Organization and Special Counsel to Trump, recalled hearing, then there's another deletion, another redaction. Cohen recalled that Trump responded, "Oh, good, all right," and then redaction. Manafort said that shortly after WikiLeaks' July 22nd, 2016 release of hacked documents, he spoke to Trump, redaction. Manafort recalled that Trump responded that Manafort should, redacted, keep Trump updated. Deputy campaign manager Rick Gates said that Manafort was getting pressure about redacted information and that at the same time Gates was with Trump on a trip to an airport, redaction, and shortly after the call ended, Trump told Gates that more releases of damaging information would be coming. Redaction were discussed within the campaign, and in the summer of 2016, the campaign was planning a communication strategy based on the possible release of Clinton's emails by WikiLeaks. In the days that followed WikiLeaks' July 22nd, 2016 release of hacked DNC emails, the Trump campaign publicly rejected suggestions that Russia was seeking to aid candidate Trump. On July 26, 2016, Trump tweeted that it was crazy to suggest that Russia was dealing with Trump and that, for the record, he had zero investment in Russia. In a press release the next day, July 27, 2016, Trump characterized, quote, this whole thing with Russia, end quote, as a, quote, total deflection, end quote, and stated that it was far-fetched and ridiculous. Trump said that the assertion that Russia had hacked the emails was unproven, but stated that it would give him no pause if Russia had Clinton's emails. Trump added, Russia, if you're listening, I hope you're able to find the 30,000 emails that are missing. I think you will probably be rewarded mightily by our press, end quote. Trump also said that, quote, there's nothing that I can think of that I'd rather do than have Russia friendly as opposed to the way they are now, end quote. And in response to a question about whether he would recognize Crimea as a Russian territory and consider lifting sanctions, Trump replied, quote, we'll be looking at that. Yeah, we'll be looking at that, end quote. During the press conference, Trump repeated, quote, I have nothing to do with Russia, end quote, 5 times. He stated that the closest he came to Russia was that Russia may have purchased a home or condos from him. He said that after he held the Miss Universe pageant in Moscow in 2013, he had been interested in working with Russian companies that, quote, wanted to put a lot of money into developments in Russia, end quote, but, quote, it never worked out, end quote. He explained, quote, frankly, I didn't want to do it for a couple of different reasons, but we had a major developer that wanted to develop property in Moscow and other places, but we decided not to do it, end quote. The Trump organization, however, had been pursuing a building project in Moscow, the Trump Tower Moscow project, from approximately September 2015 through June 2016, and the candidate was regularly updated on developments, including possible trips by Michael Cohen to Moscow to promote the deal and by Trump himself to finalize it. Cohen recalled speaking with Trump after the press conference about Trump's denial of any business dealings in Russia, which Cohen regarded as untrue. Trump told Cohen that Trump Tower Moscow was not a deal yet and said, quote, why mention it if it's not a deal, end quote. According to Cohen, at around this time, in response to Trump's disavowal of connections to Russia, campaign advisors had developed a party line that Trump had no business with Russia and no connections to Russia. In addition to denying any connections with Russia, the Trump campaign reacted to reports of Russian election interference in aid of the campaign by seeking to distance itself from the Russian contacts. For example, in August 2016, Foreign Policy Advisor J.D. Gordon declined an invitation to Russian Ambassador Sergei Kislyak's residence because the timing was, quote, not optimal, end quote, in view of media reports about Russian interference. On August 19, 2016, Manafort was asked to resign amid media coverage scrutinizing his ties to a Russian political party in Ukraine and links to Russian business. And when the media published stories about Page's connections to Russia in September 2016, Trump campaign officials terminated Page's association with the campaign and told the press that he had played no role in the campaign. On October 7, 2016, WikiLeaks released the first set of emails stolen by a Russian intelligence agency from Clinton campaign chairman John Podesta. The same day, the federal government announced that the Russian government directed the recent compromises of emails from U.S. persons and institutions, including from U.S. political organizations. The government statement directly linked Russian hacking to the release of WikiLeaks with the goal of interfering with the presidential election and concluded that only Russia's senior-most officials could have authorized these activities based on their scope and sensitivity.
On October 11, 2016, Podesta stated publicly that the FBI was investigating Russia's hacking and said that candidate Trump might have known in advance that the hacked emails were going to be released. Vice presidential candidate Mike Pence was asked whether the Trump campaign was, quote, in cahoots, end quote, with WikiLeaks in releasing damaging Clinton-related information and responded, quote, nothing could be further from the truth, end quote. 4. After the election, Trump continues to deny any contacts or connections with Russia or that Russia aided his election. On November 8, 2016, Trump was elected president. 2 days later, Russian officials told the press that the Russian government had maintained contacts with Trump's immediate entourage during the campaign. In response, Hope Hicks, who had been the Trump campaign spokesperson, said, quote, we are not aware of any campaign representatives that were in touch with any foreign entities before yesterday when Mr. Trump spoke with many world leaders, end quote. Hicks gave an additional statement denying any contacts between the campaign and Russia. Quote, it never happened. There was no communication between the campaign and any foreign entity during the campaign, end quote. On December 10, 2016, the press reported that U.S. intelligence agencies had, quote, concluded that Russia interfered in last month's presidential election to boost Donald Trump's bid for the White House, end quote. Reacting to the story the next day, President-elect Trump stated, I think it's ridiculous. I think it's just another excuse. He continued that no one really knew who was responsible for the hacking, suggesting that the intelligence community had, in his words, quote, no idea if it's Russia or China or somebody. It could be somebody sitting in a bed someplace, end quote. The president-elect also said that Democrats were, quote, putting out, end quote, the story of Russian interference because, quote, they suffered one of the greatest defeats in the history of politics, end quote. On December 18, 2016, Podesta told the press that the election was distorted by Russian intervention and questioned whether Trump campaign officials had been in touch with the Russians. The same day, incoming Chief of Staff Reince Priebus appeared on Fox News Sunday and declined to say whether the president-elect accepted the intelligence community's determination that Russia intervened in the election. When asked about any contact or coordination between the campaign and Russia, Priebus said, even this question is insane. Of course we didn't interface with the Russians. He added that this whole thing is a spin job and said, the real question is, why are the Democrats doing everything they can to delegitimize the outcome of the election? On December 29, 2016, the Obama administration announced that in response to Russian cyber operations aimed at the U.S. US election, it was imposing sanctions and other measures on several Russian individuals and entities. When first asked about the sanctions, President-elect Trump said, "I think we ought to get on with our lives." He then put out a statement that said, "It's time for our country to move on to bigger and better things," but indicated that he would meet with intelligence community leaders the following week for a briefing on Russian interference. The briefing occurred on January 6, 2017. Following the briefing, the intelligence community released the public version of its assessment, which concluded with high confidence that Russia had intervened in the election through a variety of means with the goal of harming Clinton's electability. The assessment further concluded with high confidence that Putin and the Russian government had developed a clear preference for Trump. Several days later, BuzzFeed published unverified allegations compiled by former British intelligence officer Christopher Steele during the campaign about candidate Trump's Russia connections under the headline, "These reports allege Trump has deep ties to Russia." In a press conference the next day, the president-elect called the release, quote, "an absolute disgrace," end quote, and said, "I have no dealings with Russia. I have no deals that could happen in Russia because we've stayed away. So I have no deals, I have no loans, and I have no dealings. We could make deals in Russia very easily if we wanted to. I just don't want to because I think that would be a conflict." Several advisors recalled that the president-elect viewed stories about his Russian connections, the Russia investigations, and the intelligence community assessment of Russian interference as a threat to the legitimacy of his electoral victory. Hicks, for example, said that the president-elect viewed the intelligence community assessment as his, quote, "Achilles heel," end quote, because even if Russia had no impact on the election, people would think Russia helped him win, taking away what he had accomplished. Sean Spicer, the first White House communications director, recalled that the president thought that the Russia story was developed to undermine the legitimacy of his election. Gates said that the president viewed the Russia investigation as an attack on the legitimacy of his win, and Priebus recalled that when the intelligence assessment came out, the president-elect was concerned that people would question the legitimacy of his win. B, the president's conduct concerning the investigation of Michael Flynn. Overview. During the presidential transition, incoming National Security Advisor Michael Flynn had 2 phone calls with the Russian ambassador to the United States about the Russian response to U.S. sanctions imposed because of Russia's election interference. After the press reported on Flynn's contacts with the Russian ambassador, Flynn lied to incoming administration officials by saying he had not discussed sanctions on the calls. The officials publicly repeated those lies in press interviews. The FBI, which previously was investigating Flynn for other matters, interviewed him about the calls in the first week after the inauguration, and Flynn told similar lies to the FBI. On January 26, 2017, Department of Justice officials notified the White House that Flynn and the Russian ambassador had discussed sanctions and that Flynn had been interviewed by the FBI. The next night, the president had a private dinner with FBI Director James Comey in which he asked for Comey's loyalty. On February 13, 2017, the president asked Flynn to resign. And the following day, the president had a one-on-one conversation with Comey in which he said, quote, "I hope you can see your way clear to letting this go, to letting Flynn go," end quote. Evidence. 1. Incoming National Security Advisor Flynn discusses sanctions on Russia with Russian Ambassador Sergei Kislyak. Shortly after the election, President-elect Trump announced he would appoint Michael Flynn as his National Security Advisor. For the next 2 months, Flynn played an active role on the presidential transition team, coordinating policy positions and communicating with the foreign government officials, including Russian Ambassador to the United States, Sergei Kislyak. On December 29, 2016, as noted in Volume 2, Section 2.A.4 Supra, the Obama administration announced that it was imposing sanctions and other measures on several Russian individuals and entities. That day, multiple members of the presidential transition team exchanged emails about the sanctions and the impact that they would have on the incoming administration, and Flynn informed members of the transition team that he would be speaking to the Russian ambassador later in the day. Flynn, who was in the Dominican Republic at the time, and K.T. McFarland, who was slated to become the Deputy National Security Advisor and was at the Mar-a-Lago Resort in Florida with the president-elect and other senior staff, talked by phone about what, if anything, Flynn should communicate to Kislyak about the sanctions. McFarland had spoken with incoming administration officials about the sanctions and Russia's possible responses, and thought that she had mentioned in those conversations that Flynn was scheduled to speak with Kislyak. Based on those conversations, McFarland informed Flynn that incoming administration officials at Mar-a-Lago did not want Russia to escalate the situation. At 4:43 p.m. that afternoon, McFarland sent an email to several officials about the sanctions and informed the group that, quote, General Flynn is talking to Russian ambassador this evening, end quote. Approximately 1 hour later, McFarland met with the president-elect and senior officials and briefed them on the sanctions and Russia's possible responses. Incoming Chief of Staff Reince Priebus recalled that McFarland may have mentioned at the meeting that the sanctions situation could be, quote, cooled down, end quote, and not escalated. McFarland recalled that at the end of the meeting, someone may have mentioned to the president-elect that Flynn was speaking to the Russian ambassador that evening. McFarland did not recall any response by the president-elect. Priebus recalled that the president-elect viewed the sanctions as an attempt by the Obama administration to embarrass him by delegitimizing his election. Immediately after discussing the sanctions with McFarland on December 29, 2016, Flynn called Kislyak and requested that Russia respond to the sanctions only in a reciprocal manner without escalating the situation. After the call, Flynn briefed McFarland on its substance. Flynn told McFarland that the Russian response to the sanctions was not going to be escalatory because Russia wanted a good relationship with the Trump administration. On December 30th, 2016, Russian President Vladimir Putin announced that Russia would not take retaliatory measures in response to the sanctions at that time and would instead, quote, plan further steps to restore Russian-U.S. relations based on the policies of the Trump administration. Following that announcement, the president-elect tweeted, "Great move on delay by V. Putin. I always knew he was very smart!" exclamation point. On December 31st, 2016, Kislyak called Flynn and told him that Flynn's request had been received at the highest levels and Russia had chosen not to retaliate in response to the request. Later that day, Flynn told McFarland about this follow-up conversation with Kislyak and Russia's decision not to escalate the sanctions situation based on Flynn's request. McFarland recalled that Flynn thought his phone call had made a difference. Flynn spoke with the other incoming administration officials that day, but does not recall whether they discussed the sanctions. Flynn recalled discussing the sanctions issue with incoming administration official Steve Bannon the next day.
Flynn said that Bannon appeared to know about Flynn's conversation with Kislyak, and he and Bannon agreed that they had stopped the train on Russia's response to the sanctions. On January 3, 2017, Flynn saw the president-elect in person and thought they discussed the Russian reaction to the sanctions, but Flynn did not have a specific recollection of telling the president-elect about the substance of his calls with Kislyak. Members of the intelligence community were surprised by Russia's decision to retaliate in response to the sanctions. While analyzing Russia's response, they became aware of Flynn's discussion of sanctions with Kislyak. Previously, the FBI had opened an investigation of Flynn based on his relationship with the Russian government. Flynn's contacts with Kislyak became a key component of the investigation. On January 6th, as noted in Volume 2, intelligence officials briefed President-elect Trump and the incoming administration on the intelligence community's assessment that Russia had interfered in the 2016 presidential election. When the briefing concluded, Comey spoke with the president-elect privately to brief him on unverified, personally sensitive allegations compiled by Steele. According to a memorandum Comey drafted immediately after their private discussion, the president-elect began the meeting by telling Comey he had conducted himself honorably over the prior year and had a great reputation. The president-elect stated that he thought highly of Comey, looking forward to working with him, and hoped he had planned to stay on as FBI director. Comey responded that he intended to continue serving in that role. Comey then briefed the president-elect on the sensitive material in the Steele reporting. Comey recalled that the president-elect seemed defensive, so Comey decided to assure him that the FBI was not investigating him personally. Comey recalled he did not want the president-elect to think of the conversation as a J. Edgar Hoover move. On January 10, 2017, the media reported that Comey had briefed the president-elect on the Steele reporting, and BuzzFeed News published information compiled by Steele online stating that the information included specific, unverified, and potentially unverifiable allegations of contact between Trump aides and Russia operatives. The next day, the president-elect expressed concern to the intelligence community leaders about the fact that the information had leaked and asked whether they could make public statements refuting the allegations in the Steele reports. In the following weeks, 3 congressional committees opened investigations to examine Russia's interference in the election and whether the Trump campaign had colluded with Russia. On January 13, 2017, the Senate Select Committee on Intelligence announced that it would conduct a bipartisan inquiry into Russian interference in the election, including any links between Russia and individuals associated with political campaigns. On January 25, 2017, the House Permanent Select Committee on Intelligence announced that it had conducted an investigation. It had been conducting an investigation into Russian election interference and possible coordination with the political campaigns. And on February 2nd, 2017, the Senate Judiciary Committee announced that it too would investigate Russia efforts to intervene in the election. On January 12, 2017, a Washington Post columnist reported that Flynn and Kislyak communicated on the day the Obama administration announced the Russia sanctions. The column questioned whether Flynn had said something to undercut the U.S. sanctions and whether Flynn's communication had violated the letter or spirit of the Logan Act. President-elect Trump called Priebus after the story was published and expressed anger about it. Priebus recalled that the president-elect asked, "What the hell is this all about?" Priebus called Flynn and told him that President-elect was angry about the reporting on Flynn's conversation with Kislyak. Flynn recalled that he felt a lot of pressure because Priebus had called the Washington Post columnist and informed him that no discussion of sanctions had occurred. McFarland recalled that Flynn said words of the effect, "I want to kill the story." McFarland made the call as Flynn had requested, although she knew she was providing false information, and the Washington Post updated the column to reflect that a Trump official had denied that Flynn and Kislyak discussed sanctions. When Priebus and other incoming administration officials questioned Flynn's internally about the Washington Post column, Flynn maintained that he had not discussed sanctions with Kislyak. Flynn repeated the claim to Vice President-elect Michael Pence and to incoming press secretary Sean Spicer. In subsequent media interviews in mid-January, Pence, Priebus, and Spicer denied that Flynn and Kislyak had discussed sanctions, basing those denials on their conversations with Flynn. The public statements of incoming administration officials denying that Flynn and Kislyak had discussed sanctions alarmed senior DOJ officials who were aware that the statements were not true. Those officials were concerned that Flynn had lied to his colleagues, who in turn had unwittingly misled the American public, creating a compromised situation for Flynn because the Department of Justice assessed that the Russian government could prove Flynn lied. The FBI investigative team also believed that Flynn's calls with Kislyak were subsequent denials about discussing sanctions, raised potential Logan Act issues, and were relevant to the FBI's broader Russia investigation. On January 30, 2017, President Trump was inaugurated and Flynn was sworn in as National Security Advisor. On January 23, 2017, Spicer delivered his first press briefing and stated that he had spoken with Flynn the night before, who confirmed that the calls with Kislyak were about topics unrelated to sanctions. Spicer's statements added to the Department of Justice concerns that Russia had leverage over Flynn based on his lies and could use the derogatory information to compromise him. On January 24, 2017, Flynn agreed to be interviewed by agents of the FBI. During the interview, which took place at the White House, Flynn falsely stated that he did not ask Kislyak to refrain from escalating the situation in response to the sanctions on Russia imposed by the Obama administration. Flynn also falsely stated that he did not remember a follow-up conversation in which Kislyak stated that Russia had chosen to moderate its response to those sanctions as a result of Flynn's request. On January 26, 2017, Acting Attorney General Sally Yates contacted White House counsel Don McGahn and informed him that she needed to discuss a sensitive matter with him in person. Later that day, Yates and Mary McCord, a senior national security advisor at the Department of Justice, met at the White House with McGahn and White House counsel Office Attorney James Burnham. Yates said that the public statements made by the Vice President denying that Flynn and Kislyak discussed sanctions were not true and put Flynn in a potentially compromised position because the Russians would know he had lied. Yates disclosed that Flynn had been interviewed by the FBI. She declined to answer a specific question about how Flynn had performed during the interview, but she indicated that Flynn's statements to the FBI were similar to the statements he had made to Pence and Spicer, denying that he had discussed sanctions. McGahn came away from the meeting with the impression that the FBI did not pin Flynn down in lies, but he asked John Esselberg, who served as legal counsel to the National Security Council, to examine potential legal issues raised by Flynn's FBI interview and his contacts with Kislyak. That afternoon, McGahn notified the president that Yates had come to the White House to discuss concerns about Flynn. McGahn describes what Yates had told him, and the president asked him to repeat it, so he did. McGahn recalled that when he described the FBI's interview of Flynn, he said that Flynn did not disclose having discussed sanctions with Kislyak, but that there may not have been a clear violation. The president asked about sanctions 1001, and McGahn explained the law to him and also explained the Logan Act. The president instructed McGahn to work with Priebus and Bannon to look into the matter further and directed that they not discuss it with any other officials. Priebus recalled that the president was angry with Flynn in light of what Yates had told the White House and said, "Not again, this guy, this stuff." The evening, the president dined with several senior advisors and asked the group what they thought about FBI Director Comey. According to the Director of National Intelligence, Dan Coates, who was at the dinner, no one openly advocated terminating Comey, but the consensus was he was not positive. Coates told the group that he thought Comey was a good director. Coates encouraged the president to meet Comey face-to-face and spend time with him before making a decision about whether to retain him. The next day, January 27, 2017, McGahn and Eiselberg discussed the results of Eiselberg's initial legal research into Flynn's conduct, and specifically whether Flynn had violated the Espionage Act, the Logan Act. Based on his preliminary research, Eiselberg informed McGahn that there was a possibility that Flynn had violated the code and the Logan Act. Eiselberg noted that the United States had never successfully prosecuted an individual under the Logan Act, and that Flynn could have defenses, and told McGahn that he believed it was unlikely that a prosecutor would pursue a Logan Act charge under the circumstances. That same morning, McGahn asked Yates to return to the White House to discuss Flynn again. On that second meeting, McGahn expressed doubts that the Department of Justice would bring a Logan Act prosecution against Flynn, but stated that the White House did not want to take action that would interfere with an ongoing FBI investigation of Flynn. Yates responded that the Department of Justice had notified the White House so that it could take action in response to the information provided. McGahn ended the meeting by asking Yates to assess to the underlying information the Department of Justice possessed pertaining to Flynn's discussion with Kislyak. Also, on January 27, the president called FBI Director Comey and invited him to dinner that evening. Previously recalled, before the dinner, he told the president something like, "Don't talk about Russia, whatever you do," and the president promised that he would not talk about Russia at the dinner. McGahn had previously advised the president that he should not communicate directly with the Department of Justice to avoid the perception or reality of political interference in law enforcement. When Bannon learned about the president's plans for dinner with Comey, he suggested that he and Priebus also attend, but the president stated that he wanted to dine with Comey alone. Comey said that when he arrived for the dinner that evening, he was surprised and concerned to see that no one else had been invited. Comey provided an account of the dinner in a contemporaneous memo, an interview with this office, and congressional testimony. According to Comey's account of the dinner, the president repeatedly brought up Comey's future, asking whether he wanted to stay as the FBI director. Because the president had previously said he wanted Comey to stay on as FBI director, Comey interpreted the president's comments as an effort to create a patronage relationship by having Comey ask for his job. The president also brought up the Steele report that Comey had raised in the January 6, 2017 briefing, and stated that he was thinking about ordering the FBI to investigate the allegations to prove they were false. Comey responded that the president should think carefully about issuing such an order because it could create a narrative that the FBI was investigating him personally, which was incorrect. Later at the dinner, the president brought up Flynn and said, "The guy has serious judgment issues." Comey did not comment on Flynn, and the president did not acknowledge any FBI interest in or contact with Flynn. According to Comey's account, at one point during the dinner, the president stated, "I need loyalty. I expect loyalty." Comey did not respond, and the conversation moved on to other topics, but the president returned to the subject of Comey's job at the end of the dinner and repeated, "I need loyalty." Comey responded, "You will always get honesty from me." The president said, "That's what I meant, honest loyalty." Comey said, "You will get that from me." After Comey's account of the dinner became public, the president and his advisors disputed that he had asked for Comey's loyalty. The president also indicated that he had not invited Comey to dinner, telling a reporter that he thought Comey had asked for the dinner because he wanted to stay on. But subsequent evidence corroborates Comey's account of the dinner invitation and the request for loyalty. The president's daily diary confirms that the president extended a dinner invitation to Comey on January 27. With respect to the substance of the dinner conversation, Comey documented the president's request for loyalty in a memorandum he began drafting the night of the dinner. Senior FBI officials recall that Comey told them about the loyalty request shortly after the dinner occurred, and Comey described the request while under oath in congressional proceedings and in a subsequent interview with investigators subject to penalties for lying under 18 U.S.C. Code 1001. Comey's memory of the details of the dinner, including the president's requested loyalty, has remained consistent throughout. On January 2nd, 2017, Eisenberg reviewed the underlying information related to Flynn's calls with Kislyak. Eisenberg recalled that he prepared a memorandum about criminal statutes that could apply to Flynn's conduct, but he did not believe the White House had enough information to make a definitive recommendation to the president. Eisenberg and McCann discussed that Eisenberg's review of the underlying information confirms his preliminary conclusions that Flynn was unlikely to be prosecuted for violating the Logan Act. Because White House officials were uncertain what Flynn had told the FBI, however, they could not assess his exposure to prosecution. The week of January 6, Flynn had a one-on-one conversation with the president in the Oval Office about the negative media coverage of his contacts with Kislyak. Flynn recalled that the president was upset and asked him for information on the conversations. Flynn listed the specific dates on which he remembered speaking with Kislyak, but the president corrected one of the dates he listed. The president asked Flynn what he and Kislyak discussed, and Flynn responded that he might have talked about sanctions. There was also evidence that corroborates other aspects of the memorandum Comey wrote, documenting his interactions with the president. For example, Comey recalled that his memorandums reflect that he said the president in his January 6, 2017 meeting and on phone calls on March 30th and April 11, 2017, that the FBI was not investigating the president personally. On May 8, 2017, in the White House discussions about firing Comey, the president told Rosenstein and others that Comey had told him 3 times that he was not under investigation, including once in person and twice on the phone. On February 9, 2017, the Washington Post reported that Flynn discussed sanctions with Kislyak the month before the president took office. After the publication of the story, Vice President Pence learned of the Department of Justice notification to the White House about the content of Flynn's calls. He and other advisors had sought access to and reviewed the underlying information about Flynn's contacts with Kislyak. FBI Deputy Director Andrew McCabe, who provided the White House officials access to the information, was present when they reviewed it. Recall the officials asking him about Flynn's conduct, asking him whether Flynn's conduct violated the Logan Act. McCabe responded that he did not know, but the FBI was investigating the matter because it was a possibility. Based on the evidence of Flynn's contacts with Kislyak, McGahn and Previs concluded that Flynn could not have forgotten the details of discussions of sanctions and had instead been lying about what he discussed with Kislyak. Flynn had also told White House officials that the FBI had told him that the FBI was closing out its investigation of him, but Eiselberg did not believe him. After reviewing the materials and speaking with Flynn, McGahn and Previs concluded that Flynn should be terminated and recommended that course of action to the president. That weekend, Flynn accompanied the president to Mar-a-Lago. Flynn recalled that on February 12, 2017, on the return flight to D.C. on Air Force One, the president asked him whether he had lied to the vice president. Flynn responded that he may have forgotten details of his calls, but he did not think he lied. The president responded, "Okay, that's fine. I got it." On February 13, 2017, Previs told Flynn he had to resign. Flynn said he wanted to say goodbye to the president, so Previs brought him to the Oval Office. Previs recalled that the president hugged Flynn, shook his hand, and said, "We'll give you a good recommendation. You're a good guy. We'll take care of you." Talking points on the resignation prepared by the White House counsel's office and distributed to the White House communications team stated that McGahn had advised the president that Flynn was unlikely to be prosecuted, and the president had determined that the issue with Flynn was one of trust. Spicer told the press the next day that Flynn was forced to resign, not based on a legal issue, but based on a trust issue. A level of trust between the president and General Flynn has eroded to the point where the president felt he had to make a change. On February 14, 2017, the day that after Flynn's resignation, the president had lunch at the White House with New Jersey Governor Chris Christie. According to Christie, at one point during the lunch, the president said, "Now that we fired Flynn, the Russia thing is over." Christie laughed and responded, "No way," he said, "this Russia thing is far from over, and we will be here on Valentine's Day 2018 talking about this." The president said, "What do you mean?" Flynn met with the Russians. That was the problem. I fired Flynn. It's over. Christie recalled responding that based on his experience, both as a prosecutor and as someone who had been investigated, firing Flynn would not end the investigation. Christie said that there was no way to make an investigation shorter, but a lot of ways to make it longer. The president asked Christie what he meant, and Christie told the president not to talk about the investigation, even if he was frustrated at times. Christie also told the president that he would never be able to get rid of Flynn like gum on the bottom of your shoe. Towards the end of the lunch, the president brought up Comey and asked if Christie was still friendly with him. Christie said he was. The president told Christie to call Comey and tell him that the president really liked him. Tell him he's part of the team. At the end of the lunch, the president repeated his request that Christie reach out to Comey. Christie had no intention of complying with the president's request that he contact Comey. He thought the president's request was nonsensical, and Christie did not want to put Comey in the position of having to receive such a phone call. Christie thought it would have been uncomfortable to pass on that message. At 4 p.m. that afternoon, the president met with Comey, Sessions, and other officials for a Homeland Security briefing. At the end of the briefing, the president dismissed the other attendees and stated that he wanted to speak with Comey alone. Sessions and senior advisor to the president, Jared Kushner, remained in the Oval Office as other participants left. But the president excused them, repeated that he wanted to speak only with Comey. At some point, after others had left the Oval Office, Previs opened the door, but the president sent him away. According to Comey's account of the meeting, once they were alone, the president began the conversation by saying, "I want to talk about Mike Flynn." The president stated that Flynn had not done anything wrong in speaking with the Russians, but had to be terminated because he had misled the vice president. The conversation turned to the topic of leaks of classified information, but the president returned to Flynn, saying he was a good guy and has been through a lot. The president stated, "I hope you can see your way to clear to letting this go, to letting Flynn go. He is a good guy. I hope you can let this go." Comey agreed that Flynn was a good guy, but did not commit to ending the investigation of Flynn. Comey testified under oath that he took the president's statement as a direction because of the president's position and the circumstances of the one-on-one meeting. Shortly after meeting with the president, Comey began drafting a memorandum documenting their conversation. Comey also met with his senior leadership team to discuss the president's request, and they agreed not to inform FBI officials working on the Flynn case of the president's statement, so the officials would not be influenced by the request. Comey also asked for a meeting with Sessions and requested that Sessions not leave Comey alone with the president again. The media raises questions about the president's delay in terminating Flynn. After Flynn was forced to resign, the media raised questions about why the president waited more than 2 weeks after the DOJ's notification to remove Flynn, and whether the president had known about Flynn's contact with Kislyak before the DOJ notification. The press also continued to raise questions about connections between Russia and the president's campaign. On February 15, 2017, the president told reporters, "General Flynn is a wonderful man. I think he's been treated very, very unfairly by the media." On February 16, 2017, the president held a press conference and said that he removed Flynn because Flynn didn't tell the vice president of the United States the facts, and then he didn't remember. And that just wasn't acceptable to me. The president said he did not direct Flynn to discuss sanctions with Kislyak, but it certainly would have been okay for me if he did. I would not have directed him to do it if I thought he wasn't doing it. I didn't direct him, but I would have directed him because that's his job. In listing the reasons for terminating Flynn, the president did not say that Flynn had lied to him. The president also denied having any connection to Russia, stating, "I have nothing to do with Russia. I told you, I have no deals there. I have no anything." The president also said that he had nothing to do with WikiLeaks' publication of information hacked from the Clintons' campaign. On February 22nd, 2017, Priebus and Bannon told McFarland and that the president wanted her to resign as Deputy National Security Advisor, but they suggested to her that the administration could make her ambassador to Singapore. The next day, the president asked Priebus to have McFarland draft an internal email that would confirm that the president did not direct Flynn to call the Russian ambassador about sanctions. Priebus said he told the president he could only direct McFarland to write such a letter if she was comfortable with it. Priebus called McFarland into his office to convey the president's request that she memorialize in writing that the president did not direct Flynn to talk to Kislyak. McFarland told Priebus she did not know whether the president had directed Flynn to talk to Kislyak about sanctions, and she declined to say yes or no to the request. Priebus understood that McFarland was not comfortable with the president's request, and he recommended that she talk to attorneys in the White House counsel's office. McFarland had reached out to Eiselberg. McFarland told him that she had been fired from her job as Deputy National Security Advisor and offered their ambassadorship in Singapore, but that the president and Priebus wanted a letter from her denying that the president directed Flynn to discuss sanctions with Kislyak. Eisenberg advised McFarland not to write the requested letter, as documented by McFarland in a contemporaneous memorandum for the record that she wrote because she was concerned by the president's request. Eiselberg thought the requested email in the letter would be a bad idea from my side because the email would be awkward. Why would I be emailing Priebus to make a statement for the record? But it would also be a bad idea for the president because it looked as if my ambassadorial appointment was in some way a quid pro quo. Later that evening, Priebus stopped by McFarland's office and told her not to write the email and to forget he even mentioned it. Around the same time, the president asked Priebus to reach out to Flynn and let him know that the president still cared about him. Priebus called Flynn and said that he was checking in and that Flynn was an American hero. Priebus thought the president did not want Flynn saying bad things about him. On March 31st, 2017, following news that Flynn had offered to testify before the FBI congressional investigators in exchange for immunity, the president tweeted, "Mike Flynn should ask for immunity in that this is a witch hunt, excuse for a big election loss by media and Dems of historic proportion." In late March or early April, the president asked McFarland to pass a message to Flynn telling him the president felt bad for him and that he should stay strong. Analyzing the president's conduct related to the Flynn investigation, the following evidence is relevant to the elements of obstruction of justice. Obstruction Act. According to Comey's account of his February 14, 2017 meeting with the Oval Office, the president told him, "I hope you can see your way clear to letting this go, to letting Flynn go. I hope you can let this go." And analyzing whether these statements constitute an obstructive act, a threshold question is whether Comey's account of the interaction is accurate, and if so, whether the president's statements had the tendency to impede the administration of justice by shutting down an inquiry that could result in a grand jury investigation and a criminal charge. After Comey's account of the president's request to let Flynn go became public, the president publicly disputed several aspects of the story. The president told the New York Times that he did not shoo other people out of the room when he talked to Comey, and that he did not remember having a one-on-one conversation with Comey. The president also publicly denied that he had asked Comey to let Flynn go or otherwise communicated that Comey should drop the investigation of Flynn. In private, the president denied aspects of Comey's account to White House advisors, but acknowledged the previous that he brought Flynn up in the meeting with Comey and stated that Flynn was a good guy. Despite those denials, substantial evidence corroborates Comey's account. First, Comey wrote a detailed memorandum of his encounter with the president on the same day it occurred. Comey also told senior FBI officials about the meeting with the president that day. After their recollections of what Comey told him at the time are consistent with Comey's account. Second, Comey provided testimony about the president's request that he let Flynn go under oath in congressional proceedings and in interviews when federal investigators subject to penalties for lying under 18 U.S.C. Code 1001. Comey's recollections of the encounter have remained consistent over time.
Third, the objective corroborated circumstances of how the one-on-one meeting came to occur support Comey's description of the event. Comey recalled that the president cleared the room to speak with Comey alone after a Homeland Security briefing in the Oval Office, that Kushner and Sessions lingered and had to be shooed out by the president, and that Priebus briefly opened the door during the meeting, prompting the president to wave him away. While the president has publicly denied those details, other administration officials who were present have confirmed Comey's account of how he ended up in a one-on-one meeting with the president. And the president acknowledged to Priebus and McGahn that he in fact spoke to Comey about Flynn in their one-on-one meeting. Fourth, the president's decision to clear the room and in particular to exclude the Attorney General from the meeting signals that the president wanted to be alone with Comey, which is consistent with the delivery of a message of the type that Comey recalls, rather than a more innocuous conversation that could have occurred in the presence of the Attorney General. Finally, Comey's reaction to the president's statements is consistent with the president having asked him to let Flynn go. Comey met with the FBI leadership team, which agreed to keep the president's statements closely held and not to inform the team working on the Flynn investigation so they would not be influenced by the president's request. Comey also promptly met with the Attorney General to ask him not to be left alone with the president again, an account verified by Sessions, FBI Chief of Staff James Rubicki, and Jody Hunt, who was then the Attorney General's Chief of Staff. A second question is whether the president's statements, which were not phrased as a direct order to Comey, could impede or interfere with the FBI's investigations of Flynn. While the president said he hoped Comey could let Flynn go, rather than affirmatively directing him to do so, the circumstances of the conversation show that the president was asking Comey to close the FBI's investigation into Flynn. First, the president arranged the meeting with Comey so that they would be alone and purposely excluded the Attorney General, which suggests that the president meant to make a request to Comey that he did not want anyone else to hear. Second, because the president is the head of the executive branch, when he says that he hopes, because the president is the head, that he hopes a subordinate will do something, it is reasonable to expect that the subordinate will do what the president wants. Indeed, the president repeated a version of the "let this go" 3 times, and Comey testified that he understood the president's statements as a directive, which is corroborated by the way Comey reacted at the time. Nexus to a proceeding. To establish a nexus to a proceeding, it would be necessary to show that the president could reasonably foresee and actually contemplated that the investigation of Flynn was likely to lead to a grand jury investigation or prosecution. At the time of the president's one-on-one meeting with Comey, no grand jury subpoenas had been issued as part of the FBI's investigation into Flynn. But Flynn's lies to the FBI violated federal criminal law, redaction, and resulted in Flynn's prosecution for violating 18 U.S.C. 1001. By the time the president spoke to Comey about Flynn, DOJ officials had informed McGahn, who informed the president, that Flynn's statements to senior White House officials about his contacts with Kislyak were not true, and that Flynn had told the same version of events to the FBI. McGahn also informed the president that Flynn's conduct could violate 18 U.S.C. 1001. After the vice president and senior White House officials reviewed the underlying information about Flynn's calls on February 10, 2017, they believed that Flynn could not have forgotten his conversations with Kislyak and concluded that he'd been lying. In addition, the president's instruction to the FBI director to let Flynn go suggests his awareness that Flynn could face criminal exposure for his conduct and was at risk of prosecution. Intent. As part of our investigation, we examined whether the president had a personal stake in the outcome of an investigation into Flynn. For example, whether the president was aware of Flynn's communications with Kislyak close in time to when they occurred, such that the president knew that Flynn had lied to senior White House officials and that those lies had been passed on to the public. Some evidence suggests that the president knew about the existence and content of Flynn's calls when they occurred, but the evidence is inconclusive and could not be relied upon to establish the president's knowledge. In advance of Flynn's initial call with Kislyak, the president attended a meeting where the sanctions were discussed, and an advisor may have mentioned that Flynn was scheduled to talk to Kislyak. Flynn told McFarland about the substance of his calls with Kislyak and said they may have made a difference in Russia's response. And Flynn recalled talking to Bannon in early January 2017 about how they had successfully stopped the train on Russia's response to sanctions. It would have been reasonable for Flynn to have wanted the president to know of his communications with Kislyak because Kislyak told Flynn that his request had been received at the highest levels in Russia and that Russia had chosen not to retaliate in response to the request. And the president was pleased by the Russian response, calling it a great move. And the president never said publicly or internally that Flynn had lied to him about the calls with Kislyak. But McFarland did not recall providing the president-elect with Flynn's readout of his calls with Kislyak, and Flynn does not have a specific recollection of telling the president-elect directly about the calls. Bannon also said that he did not recall hearing about the calls from Flynn. And in February 2017, the president asked Flynn what was discussed on the calls and whether he had lied to the vice president, suggesting that he did not already know. Our investigation accordingly did not produce evidence that established that the president knew about Flynn's discussion of sanctions before the Department of Justice notified the White House of those discussions in late January 2017. The evidence also does not establish that Flynn otherwise possessed information damaging to the president that would give the president a personal incentive to end the FBI's inquiry into Flynn's conduct. Evidence does establish that the president connected the Flynn investigation to the FBI's broader Russia investigation and that he believed, as he told Christie, that terminating Flynn would end the whole Russia thing. Flynn's firing occurred at a time when the media and Congress were raising questions about Russia's interference in the election and whether members of the president's campaign had colluded with Russia. Multiple witnesses recalled that the president viewed the Russia investigation as a challenge to the legitimacy of his election. The president paid careful attention to negative coverage of Flynn and reacted with annoyance and anger when the story broke, disclosing that Flynn had discussed sanctions with Kislyak. Just hours before meeting one-on-one with Comey, the president told Christie that firing Flynn would put an end to the Russia inquiries. And after Christie pushed back, telling the president that firing Flynn would not end the Russia investigation, the president asked Christie to reach out to Comey and convey that the president liked him and he was part of the team. That afternoon, the president cleared the room and asked Comey to let Flynn go. We also sought evidence relevant to assessing whether the president's direction to Comey was motivated by sympathy towards Flynn. In public statements, the president repeatedly described Flynn as a good person who'd been harmed by the Russia investigation, and the president directed advisors to reach out to Flynn to tell him the president cared about him and felt bad for him. At the same time, multiple senior advisors, including Bannon, Priebus, and Hicks, said that the president had become unhappy with Flynn well before Flynn was forced to resign, and that the president was frequently irritated with Flynn. Priebus said he believed the president's initial reluctance to fire Flynn
stemmed not from personal regard, but from concern about the negative press that would be generated by firing the National Security Advisor so early in the administration. And Priebus indicated that the president's post-firing expressions of support for Flynn were motivated by the president's desire to keep Flynn from saying negative things about him. The way in which the president communicated the request to Comey also is relevant to understanding the president's intent. When the president first learned about the FBI investigation into Flynn, he told McGahn, Bannon, and Priebus not to discuss the matter with anyone else in the White House. The next day, the president invited Comey for a one-on-one dinner against the advice of an aide who recommended that other White House officials also attend. At the dinner, the president asked Comey for loyalty, and at a different point in the conversation mentioned that Flynn had judgment issues. When the president met with Comey the day after Flynn's termination, shortly after being told by Christie that firing Flynn would not end the Russia investigation, the president cleared the room, even excluding the Attorney General, so that he could again speak to Comey alone. The president's decision to meet one-on-one with Comey contravened the advice of the White House counsel that the president should not communicate directly with the Department of Justice to avoid any appearance of interfering in law enforcement. And the president later denied that he cleared the room and asked Comey to let Flynn go, a denial that would have been unnecessary if he believed his request was a proper exercise of prosecutorial discretion. Finally, the president's effort to have McFarland write an internal email denying that the president had directed Flynn to discuss sanctions with Kislyak highlights the president's concern about being associated with Flynn's conduct. The evidence does not establish that the president was trying to have McFarland lie. The president's request, however, was sufficiently irregular that McFarland, who did not know the full extent of Flynn's communications with the president and thus could not make the representation that the president wanted, felt the need to draft an internal memorandum documenting the president's request, and Eisenberg was concerned that the request would look like a quid pro quo in exchange for an ambassadorship. The president's reaction to public confirmation of the FBI's Russia investigation. Overview. In early March 2017, the president learned that Sessions was considering recusing from the Russia investigation and tried to prevent the recusal. After Sessions announced his recusal on March 2nd, the president expressed anger at Sessions for the decision and then privately asked Sessions to unrecuse. On March 20th, 2017, Comey publicly disclosed the existence of the FBI's Russia investigation. In the days that followed, the president contacted Comey and other intelligence agency leaders and asked them to push back publicly on the suggestion that the president had any connection to the Russian election interference effort in order to lift the cloud of the ongoing investigation. Evidence. Number one, Attorney General Sessions recuses from the Russia investigation. In late February 2017, the Department of Justice began an internal analysis of whether Sessions should recuse from the Russia investigation based on his role in the 2016 Trump campaign. On March 1st, 2017, the press reported that, in his January confirmation hearing to become Attorney General, Senator Sessions had not disclosed 2 meetings he had with Russian Ambassador Kislyak before the presidential election, leading to congressional calls for Sessions to recuse or for a special counsel to investigate Russia's interference in the presidential election. Also on March 1, the president called Comey and said he wanted to check in and see how Comey was doing. According to an email Comey sent to his chief of staff after the call, the president talked about Sessions a bit, said that he heard Comey was doing great, and said that he hoped Comey would come by and say hello when he was at the White House. Comey interpreted the call as an effort by the president to pull him in, but he did not perceive the call as an attempt by the president to find out what Comey was doing with the Flynn investigation. The next morning, the president called McGahn and urged him to contact Sessions to tell him not to recuse himself from the Russia investigation. McGahn understood the president to be concerned that a recusal would make Sessions look guilty for omitting details in his confirmation hearing, leave the president unprotected from an investigation that could hobble the presidency and derail his policy objectives, and detract from favorable press coverage of a presidential address to Congress the president had delivered earlier in the week. McGahn reached out to Sessions and reported that the president was not happy about the possibility of a recusal. Sessions replied that he intended to follow the rules on recusal. McGahn reported back to the president about the call with Sessions, and the president reiterated that he did not want Sessions to recuse. Throughout the day, McGahn continued trying on behalf of the president to avert Sessions' recusal by speaking to Sessions' personal counsel, Sessions' chief of staff, and Senate Majority Leader Mitch McConnell, and by contacting Sessions himself 2 more times. Sessions recalled that other White House advisors also called him that day to argue against his recusal. That afternoon, Sessions announced his desire to recuse from any existing or future investigations of any matters related in any way to the campaign for President of the United States. Sessions believed the decision to recuse was not a close call, given the applicable language in the Code of Federal Regulations, which Sessions considered to be clear and decisive. Sessions thought that any argument that the CFR did not apply to him was very thin. Sessions got the impression, based on calls he received from White House officials, that the president was very upset with him and did not think he had done his duty as Attorney General. Shortly after Sessions announced his recusal, the White House counsel's office directed that Sessions should not be contacted about the matter. Internal White House counsel's office notes from March 2, 2017 state, no contact with Sessions and no comms, serious concerns about obstruction. On March 3rd, the day after Sessions' recusal, McGahn was called into the Oval Office. Other advisors were there, including Priebus and Bannon. The president opened the conversation by saying, "I don't have a lawyer." The president expressed anger at McGahn about the recusal and brought up Roy Cohn, stating that he wished Cohn was his attorney. McGahn interpreted this comment as directed at him, suggesting that Cohn would fight for the president, whereas McGahn would not. The president wanted McGahn to talk to Sessions about the recusal, but McGahn told the president that DOJ ethics officials had weighed in on Sessions' decision to recuse. The president then brought up former Attorneys General Robert Kennedy and Eric Holder and said that they had protected their presidents. The president also pushed back on the DOJ contacts policy and said words to the effect of, "You're telling me that Bobby and Jack didn't talk about investigations, or Obama didn't tell Eric Holder who to investigate?" Bannon recalled that the president was as mad as Bannon had ever seen him, and that he screamed at McGahn about how weak Sessions was. Bannon recalled telling the president that Sessions' recusal was not a surprise, and that before the inauguration they had discussed that Sessions would have to recuse from campaign-related investigations because of his work on the Trump campaign. That weekend, Sessions and McGahn flew to Mar-a-Lago to meet with the president. Sessions recalled that the president pulled him aside to speak to him alone and suggested that Sessions should unrecuse from the Russian investigation. The president contrasted Sessions with Attorneys General Holder and Kennedy, who had developed a strategy to help their presidents where Sessions had not. Sessions said he had the impression that the president feared that the investigation could spin out of control and disrupt his ability to govern, which Sessions could have helped avert if he were still overseeing it. On March 5, 2017, the White House counsel's office was informed that the FBI was asking for transition period records relating to Flynn, indicating that the FBI was still actively investigating him. On March 6, the president told advisors he wanted to call the acting attorney general to find out whether the White House or the president was being investigated, although it's not clear whether the president knew at the time of the FBI's recent request concerning Flynn. 2. FBI Director Comey publicly confirms the existence of the Russian investigation in testimony before HPSI. On March 9, 2017, Comey briefed the Gang of 8 congressional leaders about the FBI's investigation of Russian interference, including an identification of the principal U.S. subjects of the investigation. Although it's unclear whether the president knew of that briefing at the time, notes taken by Annie Donaldson, then McGahn's chief of staff, on March 12, 2017 state, "POTUS in panic, chaos, need binders to put in front of POTUS. Number 1, all things related to Russia." The week after Comey's briefing, the White House counsel's office was in contact with SSCI Chairman Senator Richard Burr about the Russia investigations and appears to have received information about the status of the FBI investigation. On March 20, 2017, Comey was scheduled to testify before HPSI. In advance of Comey's testimony, congressional officials made clear that they wanted Comey to provide information about the ongoing FBI investigation. Dana Boente, who at the time was the acting attorney general for the Russia investigation, authorized Comey to confirm the existence of the Russia investigation and agreed that Comey should decline to comment on whether any particular individuals, including the president, were being investigated. In his opening remarks at the HPSI hearing, which were drafted in consultation with the Department of Justice, Comey stated that he'd been authorized by the Department of Justice to confirm that the FBI, as part of its counterintelligence mission,
is investigating the Russian government's efforts to interfere in the 2016 presidential election, and that includes investigating the nature of any leaks between individuals associated with the Trump campaign and the Russian government, and whether there was any coordination between the campaign and Russia's efforts. As with any counterintelligence investigation, this will also include an assessment of whether any crimes were committed. Comey added that he wouldn't comment further on what the FBI was doing and whose conduct it was examining, because the investigation was ongoing and classified, but he observed that he had taken the extraordinary step in consultation with the Department of Justice of briefing this Congress's leaders in a classified setting in detail about the investigation. Comey was specifically asked about whether President Trump was under investigation during the campaign or under investigation now. Comey declined to answer, stating, "Please don't overinterpret what I've said. As the chair and ranking know, we have briefed him in great detail on the subjects of the investigation and what we're doing, but I'm not going to answer about anybody in this forum." Comey was also asked about whether the FBI was investigating the information contained in the Steele reporting, and he declined to answer.
According to McCann and Donaldson, the president had expressed frustration with Comey before his March 20th testimony, and the testimony made matters worse. The president had previously criticized Comey for too frequently making headlines and for not attending intelligence briefings at the White House, and the president suspected Comey of leaking certain information to the media. McCann said the president thought Comey was acting like, quote, his own branch of government. Press reports following Comey's March 20th testimony suggested that the FBI was investigating the president, contrary to what Comey had told the president at the end of January 6, 2017 intelligence assessment briefing. McCann, Donaldson, and senior advisor Stephen Miller recalled that the president was upset with Comey's testimony and the press coverage that followed because of the suggestion that the president was under investigation. Notes from the White House counsel's office dated March 21st, 2017, indicated that the president was beside himself over Comey's testimony. The president called McCann repeatedly that day to ask him to intervene with the Department of Justice, and, according to the notes, the president was getting hotter and hotter. Get rid. Officials in the White House counsel's office became so concerned that the president would fire Comey that they began drafting a memorandum that examined whether the president needed cause to terminate the FBI director. At the president's urging, McCann contacted Bonte several times on March 21st, 2017, to seek Bonte's assistance in having Comey or the Department of Justice correct the misperception that the president was under investigation. Bonte did not specifically recall the conversation, although he did remember one conversation with McCann that around this time where McCann asked if there was a way to speed up or end the Russian investigation as quickly as possible. Bonte said McCann told him the president was under a cloud, and it made it hard for him to govern. Bonte recalled telling McCann that there's no good way to shorten the investigation, and attempting to do so could erode confidence in the investigation's conclusion. Bonte said that McCann agreed and dropped the issue. The president also sought to speak directly with Bonte, but McCann told the president that Bonte did not want to talk to the president about the request with Comey. McCann recalled Bonte telling him in calls that day that he did not think it was sustainable for Comey to stay on as FBI director for the next 4 years, which McCann said he conveyed to the president. Bonte did not recall discussing with McCann or anyone else the idea that Comey should not continue as FBI director. Number 3, the president asks intelligence community leaders to make public statements that he had no connection to Russia. In the weeks following Comey's March 21st, 2017 testimony, the president repeatedly asked intelligence community officials to push back publicly on any suggestion that the president had a connection to the Russian election interference efforts. On March 22nd, 2017, the president asked Director of National Intelligence Daniel Coats and CIA Director Michael Pompeo to stay behind in the Oval Office after a presidential daily briefing. According to Coats, the president asked them whether they would say publicly that no link existed between him and Russia. Coats responded that the Office of the Director of National Intelligence has nothing to do with the investigations, and it was not his role to make a public statement on the Russia investigation. Pompeo had no recollection of being asked to stay behind after the March 22nd briefing, but he recalled that the president regularly urged officials to get the word out that he had done nothing wrong related to Russia. Coats told this office that the president never asked him to speak to Comey about the FBI investigation. Some ODNI staffers, however, had a different recollection of how Coats described the meeting immediately after it occurred. According to senior ODNI official Michael Dempsey, Coats said after the meeting that the president had brought up the Russia investigation and asked him to contact Comey to see if there was a way to get past the investigation, get it over with, end it, or words to that effect. Dempsey said that Coats described the president's comments as falling somewhere between musing about hating the investigation and wanting Coats to, quote, do something to stop it. Dempsey said that Coats had made it clear that he would not get involved with an ongoing FBI investigation. Edward J. Arstow, another ODNI official, recalled that right after Coats' meeting with the president, on the walk from the Oval Office back to Eisenhower Executive Office Building, Coats said that the president had kept him behind to ask him what he could do to help with the investigation. Another ODNI staffer who had been waiting for Coats outside the Oval Office talked to Gestero a few moments later and recalled Gestero reporting that Coats was upset because the president had asked him to contact Comey to convince him there was nothing to the Russian investigation. On Saturday, March 25th, 2017, 3 days after the meeting in the Oval Office, the president called Coats and again complained about the Russian investigation, saying words to the effect of, I can't do anything with Russia. There's nothing I'd like to do with Russia, with trade or ISIS. They're all over me on this. Coats told the president that the investigations were going to go on and the best thing to do was let them run their course. Coats testified later in a congressional hearing that he had, quote, never felt pressure to intervene or interfere in any way and with shaping intelligence in a political way or in a relationship to an ongoing investigation. On March 26, 2017, the day after the president called Coats, the president called NSA Director Admiral Michael Rogers. The president expressed frustration with the Russian investigation, saying it made relations with the Russians difficult. The president told Rogers the thing with the Russians messing up, his ability to get things done with Russia. The president also said that the news story linking him with Russia were not true and asked Rogers if he could do anything to refute the stories. Deputy Director of NSA Richard Leggett, who was present for the call, said it was the most unusual thing he'd experienced in 40 years of government service. After the call concluded, Leggett prepared a memorandum that he and Rogers both signed, documenting the content of the conversation and the president's request, and they placed the memorandum in a safe. But Rogers did not perceive the president's request to be an order, and the president did not ask Rogers to push back on the Russia investigation itself. Rogers later testified in a congressional hearing that as NSA director, he had, quote, never been directed to do anything he believed to be illegal, immoral, unethical, or inappropriate, and did not, quote, recall ever feeling pressured to do so. In addition to the specific comments made to Coates, Pompeo, and Rogers, the president spoke on other occasions in the presence of intelligence community officials about the Russian investigation and stated that it interfered with his ability to conduct foreign relations. On at least 2 occasions, the president began presidential daily briefings by stating that there was no collusion with Russia, and he hoped a press statement to that effect could be issued. Pompeo recalled that the president vented about the investigation on multiple occasions, complaining that there was no evidence against him and that nobody would publicly defend him. Rogers recalled a private conversation with the president in which he vented about the investigation, and he said he had done nothing wrong, and said something like, quote, Russia thing has got to go away. Coates recalled the president bringing up the Russia investigation several times, and Coates said he finally told the president that Coates' job was to provide intelligence and not get involved with investigations. 4, the president asked Comey to lift the cloud created by the Russia investigation. On the morning of March 30th, 2017, the president reached out to Comey directly about the Russia investigation. According to Comey's contemporaneous record of the conversation, the president said he was trying to run the country, and the cloud of this Russia business was making that difficult. The president asked Comey what could be done to lift the cloud. Comey explained that we're running it down as quickly as possible and that there would be great benefits if we didn't find anything to our good housekeeping seal of approval, but that we had to do our work. Comey also told the president that congressional leaders were aware that the FBI was not investigating the president personally. The president said several times, we need to get the facts out. The president commented that if there was some satellite, which Comey took to mean an associate of the president or of the campaign, that did something, it would be good to find out, but that he himself had not done anything wrong, and he hoped Comey would find a way to get out that we weren't investigating him. After the call ended, Comey called Bonte and told him about the conversation and asked for guidance about how to respond, and said he was uncomfortable with direct contact with the president about the investigation.
On the morning of April 11th, 2017, the president called Comey again. According to Comey's contemporaneous record of the conversation, the president said he was following up to see if Comey did what the president had asked last time, getting out that he personally is not under investigation. Comey responded that he had passed the request to Bonte, but had not heard back, and he informed the president that the traditional channel for such a request would be to have the White House counsel contact DOJ leadership. The president said that he would take that step. The president then added, because I have been very loyal to you, very loyal. We had that thing, you know. In a televised interview that was taped early that afternoon, the president was asked if it was too late for him to ask Comey to step down. The president responded, no, it's not too late, but you know, I have confidence in him. We'll see what happens. You know, it's going to be interesting. After the interview, Hicks told the president she thought the president's comment about Comey should be removed from the broadcast of the interview, but the president wanted to keep it in, which Hicks thought was unusual. Later that day, the president told senior advisors, including McGahn and Priebus, that he had reached out to Comey twice in recent weeks. The president acknowledged that McGahn would not approve of the outreach to Comey because McGahn had previously cautioned the president that he should not talk to Comey directly to prevent any perception that the White House was interfering with the investigations. The president told McGahn that Comey had indicated that the FBI could make a public statement that the president was not under investigation if the Department of Justice approved the action. After speaking with the president, McGahn followed up with Bonte to relay the president's understanding that the FBI could make a public announcement if the Department of Justice cleared it. McGahn recalled that Bonte said Comey had told him there was nothing obstructive about the calls from the president, but they made Comey uncomfortable. According to McGahn, Bonte responded that he did not want to issue a statement about the president not being under investigation because of the potential political ramifications, and did not want to order Comey to do it because that action could prompt the appointment of a special counsel. Bonte did not recall that aspect of his conversation with McGahn, but did recall telling McGahn that the direct outreaches from the president to Comey were a problem. Bonte recalled that McGahn agreed and said he would do what he could to address that issue. Analysis. In analyzing the president's reaction to Sessions' recusal and the requests he made to Coates, Pompeo, Rogers, and Comey, the following evidence is relevant to the elements of obstruction of justice. A, an obstructive act. The evidence shows that after Comey's March 20th, 2017 testimony, the president repeatedly reached out to intelligence agency leaders to discuss the FBI's investigation. But witnesses had different recollections of the precise content of those outreaches. Some ODNI officials recalled that Coates told them immediately after the March 22 Oval Office meeting that the president asked Coates to intervene with Comey and stop the investigation. But the first-hand witnesses to the encounter remember the conversation differently. Pompeo had no memory of the specific meeting, but generally recalled the president urging officials to get the word out that the president hadn't done anything wrong related to Russia. Coates recalled that the president asked that Coates state publicly that no link existed between the president and Russia, but did not ask him to speak with Comey or to help end the investigation. The other outreaches by the president during this period were similar in nature. The president asked Rogers if he could do anything to refute the stories linking the president to Russia, and the president asked Comey to make a public statement that would lift the cloud of the ongoing investigation by making clear that the president was not personally under investigation. These requests, while significant enough that Rogers thought it important to document the encounter in a written memorandum, were not interpreted by the officials who received them as directives to improperly interfere with the investigation. B, nexus to a proceeding. At the time of the president's outreaches to leaders of the intelligence agencies in late March and early April 2017, the FBI's Russia investigation did not yet involve grand jury proceedings. The outreaches, however, came after and were in response to Comey's March 20th, 2017 announcement that the FBI, as part of its counterintelligence mission, was conducting an investigation into Russian interference in the 2016 presidential election. Comey testified that the investigation included any links or coordination with the Trump campaign officials and would include an assessment of whether any crimes were committed. C, intent. As described above, the evidence does not establish that the president asked or directed intelligence agency leaders to stop or interfere with the FBI's Russia investigation. And the president affirmatively told Comey that if some satellite was involved in Russia election interference, it would be good to find that out. But the president's intent in trying to prevent Sessions' recusal and in reaching out to Coates, Pompeo, Rogers, and Comey following Comey's public announcement of the FBI's Russia investigation is nevertheless relevant to understanding what motivated the president's other actions towards the investigation. The evidence shows that the president was focused on the Russia investigation's implications for his presidency, and specifically on dispelling any suggestion that he was under investigation or had links to Russia. In early March, the president attempted to prevent Sessions' recusal, even after being told that Sessions was following DOJ conflict of interest rules. After Sessions recused, the White House counsel's office tried to cut off further contact with Sessions about the matter, although it's not clear whether the direction was conveyed to the president. The president continued to raise the issue of Sessions' recusal, and when he had the opportunity, he pulled Sessions aside and urged him to unrecuse. The president also told advisors he wanted an attorney general who would protect him, the way he perceived Robert Kennedy and Eric Holder to have protected their presidents. The president made statements about being able to direct the course of criminal investigations, saying words to the effect of, "You're telling me that Bobby and Jack didn't talk about investigations, or Obama didn't tell Eric Holder who to investigate?" After Comey publicly confirmed the existence of the FBI's Russia investigation on March 20th, 2017, the president was beside himself and expressed anger that Comey didn't issue a statement correcting any misperception that the president himself was under investigation. The president sought to speak with Acting Attorney General Bonte directly and told McGahn to contact him to request that Comey make a clarifying statement. The president then asked other intelligence community leaders to make public statements to refute the suggestion that the president had links to Russia, but the leaders told him that they could not publicly comment on the investigation. On March 30th and April 11th, against the advice of White House advisors who informed him that any direct contact with the FBI could be perceived as an improper interference in an ongoing investigation, the president made personal outreaches to Comey, asking him to lift the cloud of the Russia investigation by making public the fact that the president was not personally under investigation. Evidence indicates that the president was angered by both the existence of the Russia investigation and the public reporting that he was under investigation, which he knew was not true based on Comey's representations. The president complained to advisors that if people thought Russia helped him with the election, it would detract from what he had accomplished. Other evidence indicates that the president was concerned about the impact of the Russia investigation on his ability to govern. The president complained that the perception that he was under investigation was hurting his ability to conduct foreign relations, particularly with Russia. The president told Coates he can't do anything with Russia. He told Rogers that the thing with the Russians was interfering with his ability to conduct foreign affairs. And he told Comey that he was trying to run the country and the cloud of this Russia business was making that difficult. Events leading up to and surrounding the termination of FBI Director Comey. Overview. Comey was scheduled to testify before Congress on May 3rd, 2017. Leading up to that testimony, the president continued to tell advisors that he wanted Comey to make public that the president was not under investigation. At the hearing, Comey declined to answer questions about the scope or subjects of the Russia investigation and did not state publicly that the president was not under investigation. 2 days later, on May 5th, 2017, the president told close aides he was going to fire Comey. And on May 9th, he did so, using his official termination letter to make public that Comey had on 3 occasions informed the president that he was not under investigation. The president decided to fire Comey before receiving advice or a recommendation from the Department of Justice, but he approved an initial public account of the termination that attributed it to a recommendation from the Department of Justice based on Comey's handling of the Clinton email investigation. After Deputy Attorney General Rod Rosenstein resisted attributing the firing to his recommendation, the president acknowledged that he intended to fire Comey regardless of the DOJ recommendation and was thinking of the Russia investigation when he made the decision. The president also told the Russian foreign minister, "I just fired the head of the FBI. He was crazy, a real nut job. I faced great pressure because of Russia. That's taken off. I'm not under investigation." Evidence. Number 1, Comey testifies before the Senate Judiciary Committee and declines to answer questions about whether the president is under investigation. On May 3rd, 2017, Comey was scheduled to testify at an FBI oversight hearing before the Senate Judiciary Committee. McGahn recalled that in the week leading up to the hearing, the president said that it would be the last straw if Comey did not take the opportunity to set the record straight by publicly announcing that the president wasn't under investigation. The president had previously told McGahn that the perception that the president was under investigation was hurting his ability to carry out his presidential duties and deal with foreign leaders. At the hearing, Comey declined to answer questions about the status of the Russia investigation, stating the Department of Justice had authorized him to confirm that the Russia investigation exists, but that he was not going to say another word about it until the investigation was completed. Comey also declined to answer questions about whether investigators had ruled out anyone in the Trump campaign as potentially a target of the criminal investigation, including whether the FBI had ruled out the President of the United States. Comey was also asked at the hearing about his decision to announce 11 days before the presidential election that the FBI was reopening the Clinton email investigation. Comey stated that it made him mildly nauseous to think that we might have had some impact on the election, but added that even in hindsight, he would make the same decision. He later repeated that he had no regrets
about how he had handled the email investigation and believed that he had done the right thing at each turn. In the afternoon following Comey's testimony, the president met with McGahn, Sessions, and Sessions Chief of Staff Jody Hunt. At that meeting, the president asked McGahn how Comey had done in his testimony, and McGahn relayed that Comey had declined to answer questions about whether the president was under investigation. The president became very upset and directed his anger at Sessions. According to notes written by Hunt, the president said, "This is terrible, Jeff. It's all because you recused. AG is supposed to be most important appointment. Kennedy appointed his brother, Obama appointed Holder, I appointed you, and you recused yourself. You left me on an island. I can't do anything." The president said that the recusal was unfair and that it was interfering with his ability to govern and undermining his authority with foreign leaders. Sessions responded that he had no choice but to recuse, and it was a mandatory rather than a discretionary decision. Hunt recalled that Sessions also stated at some point during the conversation that a new start at the FBI would be appropriate and the president should consider replacing Comey as FBI director. According to Sessions, when the meeting concluded, it was clear that the president was unhappy with Comey, but Sessions didn't think the president had made the decision to terminate Comey. Bannon recalled that the president brought Comey up with him at least 8 times on May 3rd and May 4th, 2017. According to Bannon, the president said the same thing each time. "He told me 3 times I'm not under investigation. He's a showboater. He's a grandstander. I don't know any Russians. There was no collusion." Bannon told the president that he could not fire Comey because that ship had sailed. Bannon also told the president that firing Comey was not going to stop the investigation, cautioning him that he could fire the FBI director but could not fire the FBI. Number 2, the president makes the decision to terminate Comey. The weekend following Comey's May 3rd, 2017 testimony, the president traveled to his resort in Bedminster, New Jersey. At a dinner on Friday, May 5th, attended by the president and various advisors and family members, including Jared Kushner and senior advisor Stephen Miller, the president said that he wanted to remove Comey and had ideas for a letter that would be used to make the announcement. The president dictated arguments in specific language for the letter, and Miller took notes. As reflected in the notes, the president told Miller that the letter should start, "While I greatly appreciate you informing me that I'm not under investigation concerning what I have often stated as a fabricated story on the Trump-Russia relationship pertaining to the 2016 presidential election, please be informed that I believe the American public, including D's and R's, have lost faith in you as director of the FBI." Following the dinner, Miller prepared a termination letter based on these notes and research he conducted to support the president's arguments. Over the weekend, the president provided several rounds of edits on the draft letter. Miller said the president was adamant that he not tell anyone at the White House what they were preparing because the president was worried about leaks. In his discussions with Miller, the president made clear that he wanted the letter to open with a reference to him not being under investigation. Miller said he believed that fact was important to the president to show that Comey was not being terminated based on any such investigation. According to Miller, the president wanted to establish as a factual matter that Comey had been under a review period and did not have assurances from the president that he would be permitted to keep his job. The final version of the termination letter prepared by Miller and the president began in a way that closely tracked what the president had dictated to Miller at the May 5th dinner. "Dear Director Comey, while I greatly appreciate your informing me on 3 separate occasions that I am not under investigation concerning the fabricated and politically motivated allegations of a Trump-Russia relationship with respect to the 2016 presidential election, please be informed that I, along with members of both political parties and most importantly the American people, have lost faith in you as the director of the FBI and you are hereby terminated." The 4-page letter went on to critique Comey's judgment and conduct, including his May 3rd testimony before the Senate Judiciary Committee, his handling of the Clinton email investigation, and his failure to hold leakers accountable. The letter stated that Comey had asked the president at a dinner shortly after inauguration to let Comey stay on in the director's role, and the president said that he would consider it, but the president had concluded that he had no alternative but to find new leadership for the Bureau, a leader that restores confidence and trust. In the morning of Monday, May 8th, 2017, the president met in the Oval Office with senior advisors, including McGahn, Priebus, and Miller, and informed them that he had decided to terminate Comey. The president read aloud the first paragraphs of the termination letter he wrote with Miller and conveyed that the decision had been made and was not up for discussion.
The president told the group that Miller had researched the issue and determined the president had the authority to terminate Comey without cause. In an effort to slow down the decision-making process, McGahn told the president that DOJ leadership was currently discussing Comey's status and suggested that White House counsel's office attorneys should talk with Sessions and Rod Rosenstein, who had recently been confirmed as the Deputy Attorney General. McGahn said that previously scheduled meetings with Sessions and Rosenstein that day would be an opportunity to find out what they thought about firing Comey. At noon, Sessions, Rosenstein, and Hunt met with McGahn and White House counsel's office attorney, Uttam Dhillon, at the White House. McGahn said that the president had decided to fire Comey and asked for Sessions and Rosenstein's views. Sessions and Rosenstein criticized Comey and did not raise concerns about replacing him. McGahn and Dhillon said that the president's decision to fire Comey was not McGahn and Dhillon said that the fact that neither Sessions nor Rosenstein objected to replacing Comey gave them peace of mind that the president's decision to fire Comey was not an attempt to obstruct justice. An Oval Office meeting was scheduled later that day so that Sessions and Rosenstein could discuss the issue with the president. At around 5 p.m., the president and several White House officials met with Sessions and Rosenstein to discuss Comey. The president told the group that he had watched Comey's May 3 testimony over the weekend and thought that something was not right with Comey. The president said that Comey should be removed and asked Sessions and Rosenstein for their views. Hunt, who was in the room, recalled that Sessions responded that he had previously recommended that Comey be replaced. McGahn and Dhillon said Rosenstein described his concerns about Comey's handling of the Clinton email investigation. The president then distributed copies of the termination letter he had drafted with Miller, and the discussion turned to the mechanics of how to fire Comey and whether the president's letter should be used. McGahn and Dhillon urged the president to permit Comey to resign, but the president was adamant that he be fired. The group discussed the possibility that Rosenstein and Sessions could provide a recommendation in writing that Comey should be removed. The president agreed and told Rosenstein to draft a memorandum, but said he wanted to receive it first thing the next morning. Hunt's notes reflect that the president told Rosenstein to include in his recommendation the fact that Comey had refused to confirm that the president was not personally under investigation. According to notes taken by a senior DOJ official of Rosenstein's description of his meeting with the president said, "Put the Russia stuff in the memo." Rosenstein responded that the Russia investigation was not the basis of his recommendation, so he did not think Russia should be mentioned. The president told Rosenstein he would appreciate it if Rosenstein put it in his letter anyway. When Rosenstein left the meeting, he knew that Comey would be terminated, and he told DOJ colleagues that his own reasons for replacing Comey were not the president's reasons. On May 9th, Hunt delivered to the White House a letter from Sessions recommending Comey's removal and a memorandum from Rosenstein addressed to the Attorney General titled Restoring Public Confidence in the FBI. McGahn recalled that the president liked the DOJ letters and agreed that they should provide the foundation for a new cover letter from the president accepting the recommendation to terminate Comey. Notes taken by Donaldson on May 9th reflected the view of the White House counsel's office that the president's original termination letter should not see the light of day, and that would be better to offer no other rationales for the finding than what was in Rosenstein's and Sessions' memoranda. The president asked Miller to draft a new termination letter and directed Miller to say in the letter that Comey had informed the president 3 times that he was not under investigation. McGahn, Priebus, and Dhillon objected to including that language, but the president insisted that it be included. McGahn, Priebus, and others perceived that language to be the most important part of the letter to the president. Dhillon made a final pitch to the president that Comey should be permitted to resign, but the president refused. Around the time the president's letter was finalized, Priebus summoned Spicer and the press team to the Oval Office, where they were told that Comey had been terminated for the reasons stated in the letters by Rosenstein and Sessions. To announce Comey's termination, the White House released a statement which Priebus thought had been dictated by the president. In full, the statement read, "Today, President Donald J. Trump informed FBI Director James Comey that he'd been terminated and removed from office. President Trump acted based on the clear recommendations of both Deputy Attorney General Rod Rosenstein and Attorney General Jeff Sessions." That evening, the FBI Deputy Director Andrew McCabe was summoned to meet with the president at the White House. The president told McCabe that he had fired Comey because of the decisions Comey had made in the Clinton email investigation and for many other reasons. The president asked McCabe if he was aware that Comey had told the president 3 times that he was not under investigation. The president also asked McCabe whether many people in the FBI disliked Comey and whether McCabe was part of the resistance that had disagreed with Comey's decisions in the Clinton investigation. McCabe told the president that he knew Comey had told the president he was not under investigation, that most people in the FBI felt positively about Comey, and that McCabe worked very closely with Comey and was part of all the decisions that had been made in the Clinton investigation. Later that evening, the president told his communications team he was unhappy with the press coverage of Comey's termination and ordered them to go out and defend him. The president also called Chris Christie, and according to Christie, said he was getting killed in the press over Comey's termination. The president asked what he should do. Christie asked, "Did you fire Comey because of what Rod wrote in the memo?" And the president responded, "Yes." Christie said that the president should get Rod out there and have him defend the decision. The president told Christie this was a good idea and he was going to call Rosenstein right away. That night, the White House press office called the Department of Justice and said that the White House wanted to put out a statement saying that it was Rosenstein's idea to fire Comey. Rosenstein told other DOJ officials that he would not participate in putting out a false story. The president then called Rosenstein directly and said he was watching Fox News, that the coverage had been great, and that he wanted Rosenstein to do a press conference. Rosenstein responded this was not a good idea because if the press asked him, he would tell the truth that Comey's firing was not his idea. Sessions also informed the White House counsel's office that evening that Rosenstein was upset that his memorandum was being portrayed as the reason for Comey's termination. In an unplanned press conference late in the evening of May 9, 2017, Spicer told reporters it was all Rosenstein, no one from the White House. It was a DOJ decision. That evening and the next morning, White House officials and spokespeople continued to maintain that the president's decision to terminate Comey was driven by the recommendations the president received from Rosenstein and Sessions. In the morning of May 10, 2017, President Trump met with the Russian Foreign Minister Sergei Lavrov and Russian Ambassador Sergei Kislyak in the Oval Office. The media subsequently reported that during the May 10 meeting, the president brought up his decision the prior day to terminate Comey, telling Lavrov and Kislyak, "I just fired the head of the FBI. He was crazy, a real nut job. I faced great pressure because of Russia. That's taken off. I'm not under investigation." The president never denied making those statements, and the White House did not dispute the account, instead issuing a statement that said, "By grandstanding and politicizing the investigation into Russia's actions, James Comey created unnecessary pressure on our ability to engage and negotiate with Russia. The investigation would have always continued, and obviously the termination of Comey would not have ended it. Once again, the real story is that our national security has been undermined by the leaking of private and highly classified information." Hicks said that when she told the president about the reports on his meeting with Lavrov, he didn't look concerned and said of Comey, "He is crazy." When McGahn asked the president about his comments to Lavrov, the president said it was good that Comey was fired because that took the pressure off by making it clear that he was not under investigation so he could get more work done. That same morning, on May 10, 2017, the president called McCabe. According to a memorandum McCabe wrote following the call, the president asked McCabe to come over to the White House to discuss whether the president should visit FBI headquarters and make a speech to employees. The president said he had received hundreds of messages from FBI employees indicating their support for terminating Comey. The president also told McCabe that Comey should not have been permitted to travel back to Washington, D.C. on the FBI's airplane after he'd been terminated, and he didn't want Comey in the building again, even to collect his belongings. When McCabe met with the president that afternoon, the president, without prompting, told McCabe that people in the FBI loved the president, estimated that at least 80% of the FBI had voted for him, and asked McCabe who he had voted for in the 2016 presidential election. In the afternoon of May 10, 2017, Deputy Press Secretary Sarah Sanders spoke to the president about his decision to fire Comey and then spoke to reporters in a televised press conference. Sanders told reporters that the president, the Department of Justice, and bipartisan members of Congress had lost confidence in Comey, and most importantly, the rank and file of the FBI had lost confidence in their director. Accordingly, the president accepted the recommendation of his Deputy Attorney General to remove James Comey from his position. In response to questions from reporters, Sanders said that Rosenstein decided on his own to review Comey's performance and that Rosenstein decided on his own to come to the president on Monday, May 8th to express his concerns about Comey. When a reporter indicated that the vast majority of FBI agents supported Comey, Sanders said, "Look, we've heard from countless members of the FBI that say very different things." Following the press conference, Sanders spoke to the president
who told her she did a good job and did not point out any inaccuracies in her comments. Sanders told this office that her reference to the hearing from countless members of the FBI was a slip of the tongue. She also recalled that her statement in a separate press interview that rank-and-file FBI agents had lost confidence in Comey was a comment she made in the heat of the moment that was not founded on anything. Also on May 10, 2017, Sessions and Rosenstein each spoke to McGahn and expressed concern that the White House was creating a narrative that Rosenstein had initiated the decision to fire Comey. The White House counsel's office agreed that it was factually wrong to say that the Department of Justice had initiated Comey's termination, and McGahn asked attorneys in the White House counsel's office to work with the press office to correct the narrative. The next day, on May 11, 2017, the president participated in an interview with Lester Holt. The president told White House counsel's office attorneys in advance of the interview that the communications team could not get the story right, so he was going on Lester Holt to say what really happened. During the interview, the president stated that he'd made the decision to fire Comey before the president met with Rosenstein and Sessions. The president told Holt, "I was going to fire regardless of recommendation. Rosenstein made a recommendation, but regardless of recommendation, I was going to fire Comey knowing there was no good time to do it." The president continued, "And in fact, when I decided to just do it, I said to myself, you know, this Russia thing with Trump and Russia is a made-up story. It's an excuse by the Democrats for having lost an election that they should have won." In response to a question about whether he was angry with Comey about the Russia investigation, the president said, "As far as I'm concerned, I want that thing to be absolutely done properly." The president added that he realized his termination of Comey probably maybe will confuse people, with the result that it might even lengthen out the investigation. But he had to do the right thing for the American people, and Comey was the wrong man for the position. The president described Comey as a showboat and a grandstander and said that the FBI has been in turmoil, and said he wanted to have a really competent, capable director. The president affirmed that he expected the new FBI director to continue the Russia investigation. On the evening of May 11, 2017, following the Lester Holt interview, the president tweeted, "Russia must be laughing up their sleeves watching as the U.S. tears itself apart over a Democrat excuse for losing the election." The same day, the media reported that the president had demanded that Comey pledge his loyalty to the president in a private dinner shortly after being sworn in. Late in the morning of May 12, 2017, the president tweeted, "Again, the story that there was collusion between the Russians and Trump campaign was fabricated by Dems as an excuse for losing the election." The president also tweeted, "James Comey better hope there are no tapes of our conversations before he starts leaking to the press," and "Where James Clapper himself and virtually everyone else with knowledge of the witch hunt says there is no collusion, when does it end?" Analysis. In analyzing the president's decision to fire Comey, the following evidence is relevant to the elements of obstruction of justice. Obstructive act. The act of firing Comey removed the individual overseeing the FBI's Russia investigation. The president knew that Comey was personally involved in the investigation based on Comey's briefing of the Gang of Eight, Comey's March 20th, 2017 public testimony about the investigation, and the president's one-on-one conversations with Comey. Firing Comey would qualify as an obstructive act if it had the natural and probable effect of interfering with or impeding the investigation. For example, if the termination would have the effect of delaying or disrupting the investigation, or providing the president with the opportunity to appoint a director who would take a different approach to the investigation that the president perceived as more protective of his personal interests. Relevant circumstances bearing on that issue include whether the president's actions had the potential to discourage a successor director or other law enforcement officials in their conduct of the Russian investigation. The president fired Comey abruptly without offering him an opportunity to resign, banned him from the FBI building, and criticized him publicly, calling him a showboat and claiming that the FBI was in turmoil under his leadership. And the president followed the termination with public statements that were highly critical of the investigation. For example, 3 days after firing Comey, the president referred to the investigation as a witch hunt and asked, "Where does it end?" Those actions had the potential to affect a successor director's conduct of the investigation. The anticipated effect of removing the FBI director, however, would not necessarily be to prevent or impede the FBI from continuing its investigation. As a general matter, FBI investigations run under the operational direction of FBI personnel levels below the FBI director. Bannon made a similar point when he told the president that he could fire the FBI director, but he couldn't fire the FBI. The White House issued a press statement the day after Comey was fired that said the investigation would have always continued, and obviously the termination of Comey would not have ended it. In addition, in his May 11 interview with Lester Holt, the president stated that he understood when he made the decision to fire Comey that the action might prolong the investigation. And the president chose McCabe to serve as interim director, even though McCabe told the president he had worked very closely with Comey and was part of all the decisions made in the Clinton investigation. Nexus to a proceeding. The nexus element of obstruction would be satisfied by evidence showing that a grand jury proceeding or criminal prosecution arising from an FBI investigation was objectively foreseeable and actually contemplated by the president when he terminated Comey. Several facts would be relevant to such a showing. At the time the president fired Comey, a grand jury had not begun to hear evidence related to the Russia investigation, and no grand jury subpoenas had been issued. On March 20th, 2017, however, Comey had announced that the FBI was investigating Russia's interference in the election, including an assessment of whether any crimes were committed. It was widely known that the FBI, as part of its Russia investigation, was investigating the hacking of the DNC's computers, a clear criminal offense. In addition, at the time the president fired Comey, evidence indicates that the president knew that Flynn was still under criminal investigation and could potentially be prosecuted, despite the president's February 14, 2017 request that Comey let Flynn go. On May 5, 2017, the White House counsel's office was informed that the FBI was asking for transition period records relating to Flynn, indicating that the FBI was still actively investigating him. The same day, the president told advisors he wanted to call Dana Bonte, then the acting attorney general for the Russia investigation, to find out whether the White House or president was being investigated. On March 31, 2017, the president signaled his awareness that Flynn remained in legal jeopardy by tweeting, "Mike Flynn should ask for immunity," before he agreed to provide testimony to the FBI or Congress. And in late March or early April, the president asked McFarland to pass a message to Flynn, telling him that the president felt bad for him and that he should stay strong, further demonstrating the president's awareness of Flynn's criminal exposure. Intent. Substantial evidence indicates that the catalyst for the president's decision to fire Comey was Comey's unwillingness to publicly state that the president was not personally under investigation, despite the president's repeated requests that Comey make such an announcement. In the week leading up to Comey's May 3, 2017 Senate Judiciary Committee testimony, the president told McGahn it would be the last straw if Comey didn't set the record straight and publicly announced that the president wasn't under investigation. But during his May 3 testimony, Comey refused to answer questions about whether the president was being investigated. Comey's refusal angered the president, who criticized Sessions for leaving him isolated and exposed, saying, "You left me on an island." 2 days later, the president told advisors he'd decided to fire Comey and dictated a letter to Stephen Miller that began with a reference to the fact that the president was not being investigated. "While I greatly appreciate you informing me that I'm not under investigation concerning what I have often stated is a fabricated story on a Trump-Russia relationship." The president later asked Rosenstein to include Russia in his memorandum and to say that Comey had told the president he was not under investigation. And the president's final termination letter included a sentence at the president's insistence and against McGahn's advice, stating that Comey had told the president on 3 separate occasions he was not under investigation. The president's other stated rationales for why he fired Comey are not similarly supported by the evidence. The termination letter the president and Stephen Miller prepared in Bedminster cited Comey's handling of the Clinton email investigation. And the president told McCabe he fired Comey for that reason. But the facts surrounding Comey's handling of the Clinton email investigation were well known to the president at the time he assumed office. And the president had made it clear to both Comey and the president's senior staff in early 2017 that he wanted Comey to stay on as director. And Rosenstein articulated his criticism of Comey's handling of the Clinton investigation after the president had already decided to fire Comey. The president's draft termination letter also stated that morale in the FBI was at an all-time low, and Sanders told the press after Comey's termination that the White House had heard from countless FBI agents who'd lost confidence in Comey. But the evidence does not support those claims. The president told Comey at their January 27 dinner
that the people of the FBI really like him. No evidence suggests that the president heard otherwise before deciding to terminate Comey, and Sanders acknowledged to investigators that her comments were not founded on anything. We also considered why it was important to the president that Comey announced publicly that he wasn't under investigation. Some evidence indicates that the president believed that the erroneous perception that he was under investigation harmed his ability to manage domestic and foreign affairs, particularly in dealings with Russia. The president told Comey that the cloud of this Russia business was making it difficult to run the country. The president told Sessions and McGahn that foreign leaders had expressed sympathy to him for being under investigation, and that the perception that he was under investigation was hurting his ability to address foreign relations issues. The president complained to Rogers that the thing with the Russians was messing up his ability to get things done with Russia, and told Coates, "I can't do anything with Russia. There's things I'd like to do with Russia, with trade, with ISIS. They're all over me with this." The president also may have viewed Comey as insubordinate for his failure to make clear in the May 3rd testimony that the president was not under investigation. Other evidence, however, indicates that the president wanted to protect himself from an investigation into the campaign. The day after learning about the FBI's interview of Flynn, the president had a one-on-one dinner with Comey against the advice of senior aides and told Comey he needed Comey's loyalty. When the president later asked Comey for a second time to make public that he was not under investigation, he brought up loyalty again, saying, "Because I have been very loyal to you, very loyal. We had that thing, you know." After the president learned of Sessions' recusal from the Russia investigation, the president was furious and said that he wanted an attorney general who would protect him the way he perceived Robert Kennedy and Eric Holder to have protected their presidents. The president also said he wanted to be able to tell his attorney general who to investigate. In addition, the president had a motive to put the FBI's Russia investigation behind him. The evidence did not establish that the termination of Comey was designed to cover up a conspiracy between the Trump campaign and Russia. As described in Volume 1, the evidence uncovered in the investigation did not establish that the president or those close to him were involved in the charged Russian computer hacking or active measure conspiracies, or that the president otherwise had an unlawful relationship with any Russian official. But the evidence does indicate that a thorough FBI investigation would uncover facts about the campaign and the president personally that the president could have understood to be crimes or that would give rise to personal and political concerns. Although the president publicly stated during and after the election that he had no connection to Russia, the Trump Organization, through Michael Cohen, was pursuing the proposed Trump Tower Moscow project through June 2016, and candidate Trump was repeatedly briefed on the progress of those efforts. In addition, some witnesses said that Trump was aware that, read action, at a time when public reports stated that the Russian intelligence officials were behind the hacks and that Trump privately sought information about future WikiLeaks releases. More broadly, multiple witnesses described the president's preoccupation with press coverage of the Russia investigation and his persistent concern that it raised questions about the legitimacy of his election. Finally, the president and White House aides initially advanced a pretextual reason to the press and the public for Comey's termination. In the immediate aftermath of the firing, the president dictated a press statement suggesting he had acted based on the DOJ recommendations, and White House press officials repeated that story. But the president had decided to fire Comey before the White House solicited those recommendations. Although the president ultimately acknowledged that he was going to fire Comey regardless of the Department of Justice's recommendations, he did so only after DOJ officials made clear to him that they would resist the White House suggestion that they had prompted the process that led to Comey's termination. The initial reliance on a pretextual justification could support an inference that the president had concerns about providing the real reason for the firing, although the evidence does not resolve whether those concerns were personal, political, or both. E, the president's efforts to remove the special counsel. The acting attorney general appointed a special counsel on May 17, 2017, prompting the president to state that it was the end of his presidency and that Attorney General Sessions had failed to protect him and should resign. Sessions submitted his resignation, which the president ultimately did not accept. The president told senior advisors that the special counsel had conflicts of interest,
but they responded that those claims were ridiculous and posed no obstacle to the special counsel's service. Department of Justice ethics officials similarly cleared the special counsel's service. On June 14, 2017, the press reported that the president was being personally investigated for obstruction of justice, and the president responded with a series of tweets criticizing the special counsel's investigation. That weekend, the president called McGahn and directed him to have the special counsel removed because of asserted conflicts of interest. McGahn did not carry out the instruction for fear of being seen as triggering another Saturday night massacre and instead prepared to resign. McGahn ultimately did not quit, and the president did not follow up with McGahn on his request to have the special counsel removed. Evidence. Number 1, the appointment of the special counsel and the president's reaction. On May 17, 2017, Acting Attorney General appointed Robert S. Mueller III as special counsel and authorized him to conduct the Russia investigation and matters that arose from the investigation. The president learned of the special counsel's appointment from Sessions, who was with the president, Hunt, and McGahn, conducting interviews for a new FBI director. Sessions stepped out of the Oval Office to take a call from Rosenstein, who told him about the special counsel appointment, and Sessions then returned to inform the president of the news. According to notes written by Hunt, when Sessions told the president that a special counsel had been appointed, the president slumped back in his chair and said, and I quote, "Oh my God, this is terrible. This is the end of my presidency. I'm fucked." End quote. The president became angry and lambasted the attorney general for his decision to recuse from the investigation, stating, "How could you let this happen, Jeff?" The president said the position of attorney general was his most important appointment and that Sessions had let him down, contrasting him to Eric Holder and Robert Kennedy. Sessions recalled that the president said to him, "You were supposed to protect me," or words to that effect. The president returned to the consequences of the appointment and said, quote, "Everyone tells me if you get one of those independent counsels, it ruins your presidency. It takes years and years and I won't be able to do anything. This is the worst thing that ever happened to me." End quote. The president then told Sessions he should resign as attorney general. Sessions agreed to submit his resignation and left the Oval Office. Hicks saw the president shortly after Sessions departed and described the president as being extremely upset by the special counsel's appointment. Hicks said that she had only seen the president like that one other time when the Access Hollywood tape came out during the campaign. The next day, May 18, 2017, FBI agents delivered to McGahn a preservation notice that discussed an investigation related to Comey's termination and directed the White House to preserve all relevant documents. When he received the letter, McGahn issued a document hold to White House staff and instructed them not to send out any burn bags over the weekend while he sorted things out. Also on May 18, Sessions finalized a resignation letter that stated, "Pursuant to our conversation of yesterday and at your request, I hereby offer my resignation." Sessions, accompanied by Hunt, brought the letter to the White House and handed it to the president. The president put the resignation letter in his pocket and asked Sessions several times whether he wanted to continue serving as Attorney General. Sessions ultimately told the president he wanted to stay, but it was up to the president. The president said he wanted Sessions to stay. At the conclusion of the meeting, the president shook Sessions' hand, but did not return the resignation letter. When Priebus and Bannon learned that the president was holding on to Sessions' resignation letter, they became concerned that it could be used to influence the Department of Justice. Priebus told Sessions it was not good for the president to have the letter because it would function as kind of a shock collar that the president could use anytime he wanted. Priebus said the president had DOJ by the throat. Priebus and Bannon told Sessions they would attempt to get the letter back from the president with a notation that he was not accepting Sessions' resignation. On May 19, 2017, the president left for a trip to the Middle East. Hicks recalled that on the president's flight from Saudi Arabia to Tel Aviv, the president pulled Sessions' resignation letter from his pocket, showed it to a group of senior advisors, and asked them what he should do about it. During the trip, Priebus asked about the resignation letter so he could return it to Sessions, but the president told him the letter was back at the White House, somewhere in the residence. It was not until May 30th, 3 days after the president returned from the trip, that the president returned the letter to Sessions with a notation saying, "Not accepted." 2. The president asserts that the special counsel has conflicts of interest. In the days following the special counsel's appointment, the president repeatedly told advisors, including Priebus, Bannon, and McGahn, that special counsel Mueller had conflicts of interest. The president cited as conflicts that Mueller had interviewed for the FBI director positions shortly before being appointed as special counsel, that he had worked for a law firm that represented people affiliated with the president, and that Mueller had disputed certain fees relating to his membership in a Trump golf course in Northern Virginia. The president's advisors pushed back on his assertion of conflicts, telling the president that they did not count as true conflicts. Bannon recalled telling the president that the purported conflicts were ridiculous and that none of them was real or could come close to justifying precluding Mueller from serving as special counsel. As for Mueller's interview for FBI director, Bannon recalled that the White House had invited Mueller to speak to the president to offer a perspective on the institution of the FBI. Bannon said that, although the White House thought about beseeching Mueller to become director again, he did not come in looking for the job. Bannon also told the president that the law firm position did not amount to a conflict in the legal community. And Bannon told the president that the golf club dispute did not rise to the level of a conflict, and claiming one was ridiculous and petty. The president did not respond when Bannon pushed back on the stated conflicts of interest. On May 23, 2017, the Department of Justice announced that ethics officials had determined that the special counsel's prior law firm position did not bar his service, generating media reports that Mueller had been cleared to serve. McGahn recalled that around the same time, the president complained about the asserted conflicts and prodded McGahn to reach out to Rosenstein about the issue. McGahn said he responded that he could not make such a call and that the president should instead consult his personal lawyer because it was not a White House issue. Contemporaneous notes of a May 23, 2017 conversation between McGahn and the president reflect that McGahn told the president that he would not call Rosenstein and that he would suggest that the president not make such a call either. McGahn advised the president that he could discuss the issue with his personal attorney, but it would look like still trying to meddle in the investigation, and knocking out Mueller would be another fact used to claim obstruction of justice. McGahn told the president that his biggest exposure was not his act of firing Comey, but his other contacts and calls and his ask regarding Flynn. By the time McGahn provided this advice to the president, there had been widespread reporting on the president's request for Comey's loyalty, which the president publicly denied, his request that Comey let Flynn go, which the president also denied, and the president's statement to the Russian foreign minister that the termination of Comey had relieved great pressure related to Russia, which the president did not deny. On June 8, 2017, Comey testified before Congress about his interactions with the president before his termination, including the request for loyalty, the request that Comey let Flynn go, and the request that Comey lift the cloud over the presidency caused by the ongoing investigation. Comey's testimony led to a series of news reports about whether the president had obstructed justice. On June 9, 2017, the special counsel's office informed the White House counsel's office that investigators intended to interview intelligence community officials who had allegedly been asked by the president to push back against the Russian investigation. On Monday, June 12, 2017, Christopher Ruddy, the chief executive of Newsmax Media and a longtime friend of the president's, met at the White House with Priebus and Bannon. Ruddy recalled that they told him the president was strongly considering firing the special counsel, and that he would do so precipitously without vetting the decision through administration officials. Ruddy asked Priebus if Ruddy could talk publicly about the discussion they had about the special counsel, and Priebus said he could. Priebus told Ruddy he hoped another blow-up like the one that followed the termination of Comey didn't happen. Later that day, Ruddy stated in a televised interview that the president was considering perhaps terminating the special counsel based on purported conflicts of interest. Ruddy later told another news outlet that Trump is definitely considering terminating the special counsel, and it's not something that's being dismissed. Ruddy's comments led to extensive coverage in the media that the president was considering firing the special counsel. White House officials were unhappy with that press coverage, and Ruddy heard from friends that the president was upset with him. On June 13, 2017, Sanders asked the president for guidance on how to respond to press inquiries about the possible firing of the special counsel. The president dictated an answer, which Sanders delivered, saying that while the president has every right to fire the special counsel, he has no intention to do so. Also on June 13, 2017, the president's personal counsel contacted the special counsel's office,
and raised concerns about possible conflicts. The President's counsel cited Mueller's previous partnership in his law firm, his interview for the FBI director position, and an asserted personal relationship he had with Comey. The same day, Rosenstein had testified publicly before Congress and said he saw no evidence of good cause to terminate the special counsel, including for conflicts of interest. 2 days later, on June 15, 2017, the special counsel's office informed the acting attorney general's office about the areas of concern raised by the President's counsel and told the President's counsel that their concerns had been communicated to Rosenstein so that the Department of Justice could take any appropriate action. Number 3, the press reports that the President is being investigated for obstruction of justice, and the President directs the White House counsel to have the special counsel removed. On the evening of June 14, 2017, the Washington Post published an article stating that the special counsel was investigating whether the President had attempted to obstruct justice. This was the first public report that the President himself was under investigation by the special counsel's office, and cable news networks quickly picked up the report. The Post story stated that the special counsel was interviewing intelligence community leaders, including Coates and Rogers, about what the President had asked them to do in response to Comey's March 20, 2017 testimony, that the inquiry into obstruction marked a major turning point in the investigation, and that while Trump had received private assurances from then FBI Director James B. Comey starting in January that he was not personally under investigation, officials say that changed shortly after Comey's firing. That evening at approximately 10:31 p.m., the President called McGahn on McGahn's personal cell phone, and they spoke for about 15 minutes. McGahn did not have a clear memory of the call, but thought they might have discussed the stories reporting that the President was under investigation. Beginning early the next day, June 15, 2017, the President issued a series of tweets acknowledging the existence of the obstruction investigation and criticizing it. He wrote, "They made up a phony collusion with the Russian story, found zero proof, so now they go for obstruction of justice on the phony story. Nice. You are witnessing the single greatest witch hunt in American political history, led by some very bad and conflicted people. And Crooked H destroyed phones with hammer, bleached emails, and had husband meet with AG days before she was cleared, and they talk about obstruction?" The next day, June 16, 2017, the President wrote additional tweets criticizing the investigation. "After 7 months of investigations and committee hearings about my collusion with the Russians, nobody has been able to show any proof. Sad. And I'm being investigated for firing the FBI director by the man who told me to fire the FBI director. Witch hunt." On Saturday, June 17, 2017, the President called McGahn and directed him to have the special counsel removed. McGahn was at home and the President was at Camp David. In interviews with this office, McGahn recalled that the President called him at home twice, and on both occasions directed him to call Rosenstein and say that Mueller had conflicts that precluded him from serving as special counsel. On the first call, McGahn recalled that the President said something like, "You gotta do this, you gotta call Rod." McGahn said he told the President that he would see what he could do. McGahn was perturbed by the call and did not intend to act on the request. He and other advisors believed that the asserted conflicts were silly and not real, and they had previously communicated that view to the President. McGahn also had made clear to the President that the White House counsel's office should not be involved in any effort to press the issue of conflicts. McGahn was concerned about having any role in asking the acting attorney general to fire the special counsel because he'd grown up in the Reagan era and wanted to be more like Judge Robert Bork and not Saturday Night Massacre Bork. McGahn considered the President's request to be an inflection point, and he wanted to hit the brakes. When the President called McGahn a second time to follow up on the order to call the Department of Justice, McGahn recalled that the President was more direct, saying something like, "Call Rod. Tell Rod that Mueller has conflicts and can't be special counsel." McGahn recalled the President telling him, "Mueller has to go," and "Call me back when you do it." McGahn understood the President to be saying that the special counsel had to be removed by Rosenstein. To end the conversation with the President, McGahn left the President with the impression that McGahn would call Rosenstein. McGahn recalled that he had already said no to the President's request and he was worn down, so he just wanted to get off the phone. McGahn recalled feeling trapped because he didn't plan to follow the President's directive, but did not know what he would say the next time the President called.
McGahn decided he had to resign. He called his personal lawyer and then called his chief of staff, Annie Donaldson, to inform her of his decision. He then drove to the office to pack his belongings and submit his resignation letter. Donaldson recalled that McGahn told her the president had called and demanded that he contact the Department of Justice and that the president wanted him to do something that McGahn did not want to do. McGahn told Donaldson that the president had called at least twice, and in one of the calls asked, "Have you done it?" McGahn did not tell Donaldson the specifics of the president's request because he was consciously trying not to involve her in the investigation, but Donaldson inferred that the president's directive was related to the Russia investigation. Donaldson prepared to resign along with McGahn. That evening, McGahn called both Priebus and Bannon and told them that he intended to resign. McGahn recalled that after speaking with his attorney and given the nature of the president's request, he decided not to share details of the president's request with other White House staff. Priebus recalled that McGahn said the president had asked him to do crazy shit, but he thought McGahn did not tell him the specifics of the president's request because McGahn was trying to protect Priebus from what he did not need to know. Priebus and Bannon both urged McGahn not to quit, and McGahn ultimately returned to work that Monday and remained in his position. He had not told the president directly that he planned to resign, and when they next saw each other, the president did not ask McGahn whether he had followed through with calling Rosenstein. Around the same time, Chris Christie recalled a telephone call with the president in which the president asked what Christie thought about the president firing the special counsel. Christie advised against doing so because there was no substantive basis for the president to fire the special counsel, and because the president would lose support from Republicans in Congress if he did so. Analysis. In analyzing the president's directive to McGahn to have the special counsel removed, the following evidence is relevant to the elements of obstruction of justice. An obstructive act. As with the president's firing of Comey, the attempt to remove the special counsel would qualify as an obstructive act if it would naturally obstruct the investigation and any grand jury proceedings that might flow from the inquiry. Even if the removal of the lead prosecutor would not prevent the investigation from continuing under a new appointee, a fact finder would need to consider whether the act had the potential to delay further action in the investigation, chill the actions of any replacement special counsel, or otherwise impede the investigation. A threshold question is whether the president in fact directed McGahn to have the special counsel removed. After news organizations reported that in June 2017 the president had ordered McGahn to have the special counsel removed, the president publicly disputed those accounts and privately told McGahn he'd simply wanted McGahn to bring conflicts of interest to the Department of Justice's attention. Some of the president's specific language that McGahn recalled from the calls is consistent with the explanation. Substantial evidence, however, supports the conclusion that the president went further and, in fact, directed McGahn to call Rosenstein to have the special counsel removed.
Representative Mary Gay Scallon is awesome. Sorry, that's not in the report. I just did an ad lib. I'm going to read the report now. First, McGahn's clear recollection was that the president directed him to tell Rosenstein not only that conflicts existed, but also that Mueller has to go. McGahn is a credible witness with no motive to lie or exaggerate given the position he held in the White House. McGahn spoke with the president twice and understood the directive the same way both times, making it unlikely that he misheard or misinterpreted the president's request. In response to that request, McGahn decided to quit because he did not want to participate in events that he described as akin to the Saturday Night Massacre. I'm just going to read that again. In response to that request, McGahn decided to quit because he did not want to participate in events that he described as akin to the Saturday Night Massacre. He called his lawyer, drove to the White House, packed up his office, prepared to submit a resignation letter with his chief of staff, told Priebus that the president had asked him to do crazy shit, and informed Priebus and Bannon that he was leaving. I'm going to read that phrase again. Told Priebus that the president had asked him to do crazy shit, and informed Priebus and Bannon that he was leaving. Those acts would be a highly unusual reaction to a request to convey information to the Department of Justice. Second, in the days before the calls began, the president, through his counsel, had already brought the asserted conflicts to the attention of the Department of Justice. Accordingly, the president had no reason to have McGahn call Rosenstein that weekend to raise conflicts issues that already had been raised. Third, the president's sense of urgency and repeated requests from McGahn to take immediate action on the weekend. You gotta do this. You gotta call Rod. Supported McCann's recollection that the president wanted the Department of Justice to take action to remove the special counsel. Had the president instead sought only to have the Department of Justice re-examine asserted conflicts to evaluate whether they pose an ethical bar, it would have been unnecessary to set the process in motion on Saturday and to make repeated calls to McGahn. Finally, the president had discussed knocking out Mueller and raised conflicts of interest in a May 23, 2017 call with McGahn, reflecting that the president connected the conflicts to a plan to remove the special counsel. And in the days leading up to June 17, 2017, the president made clear to Priebus and Bannon, who then told Ruddy that the president was considering terminating the special counsel. Also during this time period, the president reached out to Christie to get his thoughts on firing the special counsel. This evidence shows that the president was not just seeking the examination of whether conflicts existed, but instead was looking to use asserted conflicts as a way to terminate the special counsel. Nexus to an official proceeding. To satisfy the proceeding requirement, it would be necessary to establish a nexus between the president's act of seeking to terminate the special counsel and a pending or foreseeable grand jury proceeding. Substantial evidence indicates that by June 17, 2017, the president knew his conduct was under investigation by a federal prosecutor who could present any evidence of federal crimes to a grand jury. On May 23, 2017, McGahn explicitly warned the president that his biggest exposure was not his act of firing Comey, but his other contacts and calls and his ask regarding Flynn. By early June, it was widely reported in the media that federal prosecutors had issued grand jury subpoenas in the Flynn inquiry and that the special counsel had taken over the Flynn investigation. On June 9, 2017, the special counsel's office informed the White House that investigators would be interviewing intelligence agency officials who allegedly had been asked by the president to push back against the Russia investigation. On June 14, 2017, news outlets began reporting that the president himself was being investigated for obstruction of justice. Based on widespread reporting, the president knew that such an investigation could include his request for Comey's loyalty, his request that Comey let Flynn go, his outreach to Coates and Rogers, and his termination of Comey, and statement to the Russian foreign minister that the termination had relieved great pressure related to Russia. And on June 17, the day before he directed McGahn to leave have the special counsel removed, the president publicly acknowledged that his conduct was under investigation by a federal prosecutor, tweeting, "I am being investigated for firing the FBI director by the man who told me to fire the FBI director." Intent. Substantial evidence, let me repeat that, substantial evidence indicates that the president's attempts to remove the special counsel were linked to the special counsel's oversight of investigations that involved the president's conduct, and most immediately to reports that the president was being investigated for potential obstruction of justice. Before the president terminated Comey, the president considered it critically important that he was not under investigation and that the public not erroneously think that he was being investigated. As described in Volume 2, Section 2D, advisors perceived the president, while he was drafting Comey termination letter, to be concerned more than anything else about getting out that he was not personally under investigation. When the president learned of the appointment of the special counsel on May 17, 2017, he expressed further concern about the investigation, saying, quote, "This is the end of my presidency," unquote. The president also faulted Sessions for recusing, saying, quote, "You were supposed to protect me," unquote. On June 14, 2017, when the Washington Post reported that the special counsel was investigating the president for obstruction of justice, the president was facing what he had wanted to avoid, a criminal investigation into his own conduct that was the subject of widespread media attention. The evidence indicates that news of the obstruction investigation prompted the president to call McGahn and seek to have the special counsel removed. By mid-June, the Department of Justice had already cleared the special counsel's service, and the president's advisors had told him that the claimed conflict of interest was silly and did not provide a basis to remove the special counsel. On June 13, 2017, the acting attorney general testified before Congress that no good case no good cause for removing the special counsel existed, and the president dictated a press statement to Sanders saying he had no intention of firing the special counsel. But the next day, the media reported the president was under investigation for obstruction of justice, and the special counsel was interviewing witnesses about events related to possible obstruction, spurring the president to write critical tweets about the special counsel's investigation. The president called McGahn at home that night and then called him on Saturday from Camp David. The evidence accordingly indicates that news that an obstruction investigation had been opened is what led the president to call McGahn to have the special counsel terminated. There is also evidence that the president knew that he should not have made those calls to McGahn. The president made the calls to McGahn after McGahn has specifically told the president that the White House counsel's office and McGahn himself could not be involved in pressing conflicts claims, and the president should consult with his personal counsel if he wished to raise conflicts. Instead of relying on his personal counsel to submit the conflicts claims, the president sought to use his official powers to remove the special counsel. I'm going to read that sentence again. Instead of relying on his personal counsel to submit the conflicts claims, the president sought to use his official powers to remove the special counsel. And after the media reported on the president's actions, he denied that he ever ordered McGahn to have the special counsel terminated and made repeated efforts to have McGahn deny this story, as discussed in Volume 2, Section 2.I. Those denials are contrary to the evidence and suggest the president's awareness that the direction to McGahn could be seen as improper. The president's efforts to curtail the special counsel investigation. 2 days after the president directed McGahn to have the special counsel removed, the president made another attempt to affect the course of the Russia investigation. On June 19, 2017, the president met one-on-one with Corey Lewandowski in the Oval Office and dictated a message to be delivered to Attorney General Sessions that would have had the effect of limiting the Russia investigation to future election interference only. 1 month later, the president met again with Lewandowski and followed up on the request to have Sessions limit the scope of the Russia investigation. Lewandowski told the president the message would be delivered soon. Hours later, the president publicly criticized Sessions in an unplanned press interview, raising questions about Sessions' job security. The president asked Corey Lewandowski to deliver a message to Sessions to curtail the special counsel investigation. On June 19, 2017, 2 days after the president directed McGahn to have the special counsel removed, the president met one-on-one in the Oval Office with his former campaign manager, Corey Lewandowski. Senior White House advisors described Lewandowski as a devotee of the president and said the relationship between the president and Lewandowski was close. During the June 19th meeting, Lewandowski recalled that after some small talk, the president brought up Sessions and criticized his recusal from the Russia investigation. The president told Lewandowski that Sessions was weak and that if the president had known about the likelihood of recusal in advance, he would not have appointed Sessions. The president then asked Lewandowski to deliver a message to Sessions and said, "Write this down." This was the first time the president had asked Lewandowski to take dictation, and Lewandowski wrote as fast as possible to make sure he captured the content correctly. The president directed that Sessions should give a speech publicly announcing, "I know that I recused myself from certain things having to do with specific areas, but our POTUS is being treated very unfairly. He shouldn't have a special prosecutor counsel, but because he hasn't done anything wrong. I was on the campaign with him for 9 months. There were no Russians involved with him. I know it for a fact because I was there. He didn't do anything wrong except he ran the greatest campaign in American history." The dictated message went on to state that Sessions would meet with the special counsel to limit his jurisdiction to future election interference. Now a group of people want to subvert the Constitution of the United States. I'm going to meet with a special prosecutor to explain this is very unfair and let the special prosecutor move forward with investigating election immediately for future elections so that nothing can happen in future elections. The president said that if Sessions delivered that statement, he would be the most popular guy in the country. Lewandowski told the president he understood what the president wanted Sessions to do. Lewandowski wanted to pass the message to Sessions in person rather than over the phone. He did not want to meet at the Department of Justice because he did not want a public log of his visit and did not want Sessions to have an advantage over him by meeting on what Lewandowski described as Sessions' turf. Lewandowski called Sessions and arranged a meeting for the following evening at Lewandowski's office, but Sessions had to cancel due to a last-minute conflict. Shortly thereafter, Lewandowski left Washington, D.C. without having had an opportunity to meet with Sessions to convey the president's message. Lewandowski stored the notes in a safe at his home, which he stated was the standard procedure with sensitive items. The president follows up with Lewandowski. Following his June meeting with the president, Lewandowski contacted Rick Dearborn, then a senior White House official, and asked if Dearborn could pass a message to Sessions. Dearborn agreed without knowing what the message was, and Lewandowski later confirmed that Dearborn would meet with Sessions for dinner in late July and could deliver the message then. Lewandowski recalled thinking that the president had asked him to pass a message because the president knew Lewandowski could be trusted, but Lewandowski believed Dearborn would be a better messenger because he had a long-standing relationship with Sessions and because Dearborn was in the government while Lewandowski was not. On July 19, 2017, the president again met with Lewandowski alone in the Oval Office. In the preceding days, as described in Volume 2, Section 2.g, emails and other information about the June 19, 2016 meeting between several Russians and Donald Trump Jr., Jared Kushner, and Paul Manafort have been publicly disclosed. In July 19th meeting with Lewandowski, the president raised his previous request and asked Lewandowski to talk to Sessions. Lewandowski told the president that the message would be delivered soon. Lewandowski recalled that the president told him that if Sessions did not meet with him, Lewandowski should tell Sessions he was fired. Immediately following the meeting with the president, Lewandowski saw Dearborn in the anteroom outside the Oval Office and gave him a typewritten version of the message the president had dictated to be delivered to Sessions. Lewandowski told Dearborn that notes were the message they had discussed, but Dearborn did not recall whether Lewandowski said the message was from the president. The message definitely raised an eyebrow for Dearborn, and he recalled not wanting to ask where it came from or think further about doing anything with it. Dearborn also said that being asked to serve as a messenger to Sessions made him uncomfortable. He recalled later telling Lewandowski that he had handled the situation, but he did not actually follow through with delivering the message to Sessions, and he did not keep a copy of the typewritten notes Lewandowski had given him. The president publicly criticizes Sessions in a New York Times interview. Within hours of the president's meeting with Lewandowski on July 19, 2017, the president gave an unplanned interview to the New York Times in which he criticized Sessions' decision to recuse from the Russian investigation. The president said that Sessions should have never recused himself, and he was going to recuse himself. He should have told me before he took the job, and I would have picked somebody else. Sessions' recusal, the president said, was very unfair to the president. How do you take a job and then recuse yourself? If he would have recused himself before the job, I would have said, thanks, Jeff, but I can't, I'm not going to take you. It's extremely unfair, and that's a mild word to the president. Hicks, who was present for the interview, recalled trying to throw herself between the reporters and the president to stop parts of the interview, but the president loved the interview. Later that day, Lewandowski met with Hicks, and they discussed the president's New York Times interview. Lewandowski recalled telling Hicks about the president's request that he meet with Sessions and joking with her about the idea of firing Sessions as a private citizen if Sessions would not meet with him. As Hicks remembered the conversation, Lewandowski told her the president had recently asked him to meet with Sessions and deliver a message that he needed to do the right thing and resign. While Hicks and Lewandowski were together, the president called Hicks and told her he was happy with how coverage of his New York Times interview criticizing Sessions was playing out. The president orders Priebus to demand Sessions' resignation. 3 days later, on July 21, 2017, the Washington Post reported that U.S. intelligence intercepts showed that Sessions had discussed campaign-related matters with the Russian ambassador, contrary to what Sessions had said publicly. That evening, Priebus called Hunt to talk about whether Sessions might be fired or might resign. Priebus had previously talked to Hunt when the media had reported on tensions between Sessions and the president, and after speaking to Sessions, Hunt had told Priebus that the president would have to fire Sessions if he wanted to remove Sessions because Sessions was not going to quit. According to Hunt, who took contemporaneous notes of the July 21st call, Hunt told Priebus that, as they had previously discussed, Sessions had no intention of resigning. Hunt asked Priebus what the president would accomplish by firing Sessions, pointing out there was an investigation before and there would be an investigation after. Early the following morning, July 22, 2017, the president tweeted, "A new intelligence link from the Amazon Washington Post, this time against AG Jeff Sessions. These illegal leaks like Comey's must stop." Approximately 1 hour later, the president tweeted, "So many people are asking why isn't the AG special counsel looking at the many Hillary Clinton and Comey crimes, 33,000 emails deleted." Later that evening, while aboard Marine One on the way to Norfolk, Virginia, the president told Priebus that he had to get Sessions to resign immediately. The president said that the country had lost confidence in Sessions and the negative publicity was not tolerable. According to contemporaneous notes taken by Priebus, the president told Priebus to say that he needed a letter of resignation on his desk immediately and that Sessions had no choice but must immediately resign. Priebus replied that if they fired Sessions, they would never get a new attorney general confirmed, and that the Department of Justice and Congress would turn their backs on the president, but the president suggested he could make a recess appointment to replace Sessions. Priebus believed that the president's request was a problem, so he called McGahn and asked for advice, explaining that he did not want to pull the trigger on something that was all wrong. Although the president tied his desire for Sessions to resign to Sessions' negative press and poor performance in congressional testimony, Priebus believed that the president's desire to replace Sessions was driven by the president's hatred of Sessions' recusal from the Russia investigation. McGahn told Priebus not to follow the president's order and said they should consult their personal counsel with whom they had attorney-client privilege. McGahn and Priebus discussed the possibility that they would both have to resign rather than carry out the president's order to fire Sessions. That afternoon, the president followed up with Priebus about demanding Sessions' resignation using words to the effect of, "Did you get it? Are you working on it?" Priebus said that he believed that his job depended on whether he followed the order to remove Sessions, although the president did not directly say so. Even though Priebus did not intend to carry out the president's directive, he told the president he would get Sessions to resign. Later in the day, Priebus called the president and explained that it would be a calamity if Sessions resigned because Priebus expected that Rosenstein and Associate Attorney General Rachel Brand would also resign and the president would be unable to get anyone else confirmed. The president agreed to hold off on demanding Sessions' resignation until after the Sunday shows the next day to prevent the shows from focusing on the firing. By the end of that weekend, Priebus recalled that the president relented and agreed not to ask Sessions to resign. Over the next several days, the president tweeted about Sessions. On the morning of Monday, July 24, 2017, the president criticized Sessions for neglecting to investigate Clinton and called him beleaguered. On July 25th, the president tweeted, "Attorney General Jeff Sessions has taken a very weak position on Hillary Clinton crimes. Where emailed DNC server and Intel leakers." The following day, July 26th, the president tweeted, "Why didn't AG Sessions replace acting FBI Director Andrew McCabe, a Comey friend who wasn't charged of Clinton investigation?" According to Hunt, in light of the president's frequent public attacks, Sessions prepared another resignation letter, and the rest of the year carried it with him in his pocket every time he went to the White House. All right, analysis. In analyzing the president's efforts to have Lewandowski deliver a message directing Sessions to publicly announce that the special counsel investigation will be confirmed to future election interference, the following evidence is relevant to the elements of obstruction of justice. Obstructive act. The president's effort to send Sessions a message through Lewandowski would qualify as an obstructive act if it would naturally obstruct the investigation and any grand jury proceedings that might flow from the inquiry. The president sought to have Sessions announce that the president shouldn't have a special prosecutor counsel and that Sessions was going to meet with the special prosecutor to explain this is very unfair and let the special prosecutor move forward with investigating election and meddling for future elections so that nothing can happen in future elections. The president wanted Sessions to disregard his recusal from the investigation, which had followed from a formal DOJ ethics interview, and have Sessions declare that he knew for a fact that there were no Russians involved with the campaign because he was there. The president further directed that Sessions to explain that the president should not be subject to investigation because he hasn't done anything wrong. Taken together, the president's directives indicate that Sessions was being instructed to tell the special counsel to end the existing investigation into the president and his campaign, with the special counsel being permitted to move forward with investigating election meddling for future elections. Nexus to an official proceeding. As described above, by the time of the president's initial one-on-one meeting with Lewandowski on June 19, 2017, the existence of grand jury investigations supervised by the special counsel was public knowledge. By the time of the president's follow-up meeting with Lewandowski, this part's redacted. See Volume 2, Section 2.g. To satisfy the nexus requirement, it would be necessary to show that limiting the special counsel's investigation would have the natural and probable effect of impeding that grand jury investigation proceeding. Intent. Substantial evidence indicates that the president's effort to have Sessions limit the scope of the special counsel's investigation to future election interference was intended to prevent further investigative scrutiny of the president's and his campaign's conduct. As previously described, see Volume 2, Section 2.b, the president knew that the Russia investigation was focused in part on his campaign, and he perceived allegations of Russian interference to cast doubt on the legitimacy of his election. The president further knew that the investigation had broadened to include his own conduct and whether he had obstructed justice. Those investigations would not perceive that special counsel's jurisdiction were limited to future election interference only. The timing and circumstance of the president's actions support the conclusion that he sought that result. The president's initial direction that Sessions should limit the special counsel's investigation came just 2 days after the president had ordered McGahn to have the special counsel removed, which itself followed public reports that the president was personally under investigation for obstruction of justice. The sequence of those events raises an inference that after seeking to terminate special counsel, the president sought to exclude his and his campaign's conduct from the investigation scope. The president raised the matter with Lewandowski again on July 19, 2017, just days after emails and information about the June 19, 2016 meeting between Russians and senior campaign officials had been publicly disclosed, generating substantial media coverage and investigative interest. The manner in which the president acted provides additional evidence of his intent. Rather than rely on official channels, the president met with Lewandowski alone in the Oval Office. The president selected a loyal devotee outside the White House to deliver the message, supporting an inference that he was working outside White House channels, including McGahn, who had previously resisted contacting the Department of Justice about the special counsel. The president also did not contact the acting attorney general, who had just testified publicly that there was no cause to remove the special counsel. Instead, the president tried to use Sessions to restrict and redirect the special counsel's investigation when Sessions was recused and could not properly take any action on it. The July 19, 2070 events provide further evidence of the president's intent. The president followed up with Lewandowski in a separate one-on-one meeting 1 month after he first dictated the message for Sessions, demonstrating he still sought to pursue the request. And just hours after Lewandowski assured the president that the message would soon be delivered to Sessions, the president gave an unplanned interview to the New York Times in which he publicly attacked Sessions and raised questions about his job security. 4 days later, on July 22, 2017, the president directed Priebus to obtain Sessions' resignation. That evidence could raise an inference that the president wanted Sessions to realize that his job might be on the line as he evaluated whether to comply with the president's direction that Sessions publicly announced that, notwithstanding his recusal, he was going to confine the special counsel's investigation to future election interference. The president's efforts to prevent disclosure of emails about the June 9, 2016 meeting between Russians and senior campaign officials. Overview. By June 2017, the president became aware of emails setting up the June 9, 2016 meeting between senior campaign officials and Russians who offered derogatory information on Hillary Clinton as part of Russia and its government's support for Mr. Trump. On multiple occasions in late June and early June 2017, the president directed aides not to publicly disclose emails, and he then dictated a statement about the meeting to be issued by Donald Trump Jr., describing the meeting as about adoption. Evidence. The president learns about the existence of emails concerning the June 9, 2016 Trump Tower meeting. In mid-June 2017, the same week that the president first asked Lewandowski to pass the message Sessions, senior administration officials became aware of emails exchanged during the campaign, arranging a meeting between Donald Trump Jr., Paul Manafort, Jared Kushner, and a Russian attorney. As described in Volume 1, Section 4.8.5, the email stated that the Crown Prosecutor of Russia had offered, quote, to provide the Trump campaign with some official documents and information that would incriminate Hillary in her dealings with Russia, unquote, as part of Russia and its government support Mr. Trump. Trump Jr. responded, quote, if it's what you say, I love it. And he, Kushner, and Manafort met with Russian attorney and several other Russian individuals at Trump Tower on June 9, 2016. I'm going to read that sentence again. Trump Jr. responded, if it's what you say, I love it. And he, Kushner, and Manafort met with the Russian attorney and several other Russian individuals at Trump Tower on June 9, 2016. At the meeting, the Russian attorney claimed that funds derived from illegal activities in Russia were provided to Hillary Clinton and other Democrats, and the Russian attorney then spoke about the Magnitsky Act, a 2012 U.S. statute that imposed financial and travel sanctions on Russian officials and that had resulted in a retaliatory ban in Russia on U.S. adoptions of Russian children. According to written answers submitted by the president in response to questions from this office, the president had no recollection of learning of the meeting or the email sending up at the time the meeting occurred or at any other time before the election. The Trump campaign had previously received a document request from SSCI that called for the production of various information, including a list and a description of all meetings between any individual affiliated with the Trump campaign and any individual formally or informally affiliated with the Russian government or Russian business interests, which took place between June 16, 2015 and 12 p.m. on January 20, 2017, and associated records. Trump Organization attorneys became aware of the June 9th meeting no later than the first week of June 2017 when they began interviewing the meeting participants, and the Trump Organization attorneys provided the email setting up meeting to the president's personal counsel. Mark Corrello, who had been hired as spokesman for the president's personal legal team, recalled that he learned about the June 9th meeting about June 21st or June 22nd, 2017. Previous recalled learning about the June 9th meeting from Fox News host Sean Hannity in late June 17. Priebus notified one of the president's personal attorneys who told Priebus he was already working on it. By late June, several advisors recalled receiving media inquiries that could relate to June 9th meeting. The president directs communication staff not to publicly disclose information about the June 9th meeting. Communication advisors Hope Hicks and Josh Rafael recalled discussions with Jared Kushner and Ivanka Trump that emails were damaging and would inevitably be leaked. Hicks and Rafael advised that the best strategy was to proactively release the emails to the press. On or about June 22, 2017, Hicks attended a meeting in the White House residence with the President, Kushner, and Ivanka Trump. According to Hicks, Kushner said that he wanted to fill the president on something that had been discovered in the documents he was to provide to the congressional committees involving a meeting with him, Manafort, and Trump Jr. Kushner brought a photo documents to the meeting and tried to show them to the president, but the president stopped Kushner and said he did not want to know about it, shutting the conversation down. On June 28, 2017, Hicks viewed the emails at Kushner's attorney's office. She recalled being shocked by the emails because they looked, quote, really bad, unquote. The next day, Hicks spoke privately with the president and mentioned her concern about the emails, which she understood were soon going to be shared with Congress. The president seemed upset because too many people knew about the emails, and he told Hicks that just one lawyer should deal with the matter. The president indicated that he did not think the emails would leak, but said they would leak if everyone had access to them. Later that day, Hicks, Kushner, and Ivanka Trump went together to talk to the president. Hicks recalled that Kushner told the president the June 9th meeting was not a big deal, it was about Russian adoption, but that emails existed sitting at the meeting. Hicks said she wanted to get in front of the story and have Trump Jr. release the emails as part of an interview with softball questions. The president said he did not want to know about it and they should not go to the press. Hicks warned the president that the emails were, quote, really bad, unquote, and and that the story would be massive when it broke, but the president was insistent that he did not want to talk about it and said he did not want details. Hicks recalled that the president asked Kushner when his document production was due. Kushner responded that it would be a couple weeks, and the president said, then leave it alone. Hicks also recalled that the president said Kushner's attorney should give the emails to whomever he needed to give them to, but the president did not think they would be leaked to the press. Rafael later heard from Hicks that the president had directed the group not to be proactive in disclosing emails because the president believed they would not leak. The president directs Trump Jr.'s response to press inquiries about the June 9th meeting. The following week, the president departed on an overseas trip to the G20 summit in Hamburg, Germany, accompanied by Hicks, Rafael, Kushner, and Ivanka Trump, among others. On July 7, 2017, while the president was overseas, Hicks and Rafael learned that the New York Times was working on a story about the June 9th meeting. The next day, Hicks told the president about the story and he directed her not to comment. Hicks thought the president's reaction was odd because he usually considered not responding to the press to be the ultimate sin. Later that day, Hicks and the president again spoke about the story. Hicks recalled that the president asked her what the meeting had been about, and she said that she had been told the meeting was about Russia adoption. The president responded, then just say that. On a flight home from the G20 in July 8, 2017, Hicks obtained a draft statement about the meeting to be released by Trump Jr. and brought it to the president. The draft statement began with a reference to information that was offered by the Russians in setting up the meeting. I was asked to have a meeting by an acquaintance I knew from the 2013 Miss Universe pageant with an individual who I thought might have information helpful to the campaign. Hicks again wanted to disclose the entire story, but the president directed that the statement not be issued because he said too much. The president told Hicks to say only that Trump Jr. took a brief meeting and it was about Russian adoption. After speaking with the president, Hicks texted Trump Jr. a revised statement on the June 9th meeting that read, it was a short meeting. I asked Jared and Paul to stop by. We discussed a program about the adoption of Russian children that was active and popular with American families years ago and was since ended by the Russian government, but it was not a campaign issue. At that time, there was no follow-up. Hicks' text concluded, are you okay with this? Attributed to you. Trump Jr. responded by text message that he wanted to add the word primarily before discussed so that the statement would read, we primarily discussed a program about the adoption of Russian children. Trump Jr. texted that he wanted to change because they started with some Hillary thing, which was BS, and some other nonsense, which we shut down first. Hicks texted back, I think that's right too, but boss man worries and invites a lot of questions. Ultimately defer to you and your attorney on that word because I know it's important. I think the mention of a campaign issue adds something to it in case we have to go further. Trump Jr. responded, if I don't have it in there, it appears as though I'm lying later when they inevitably leak something. Trump Jr.'s statement, adding the word primarily and making other minor additions, was then provided in the New York Times. The full statement provided Times stated,
it was a short introductory meeting. I asked Jared and Paul to stop by. We primarily discussed a program about the adoption of Russian children that was active and popular with American families years ago and was since ended by the Russian government, but it was not a campaign issue at the time, and there was no follow-up. I was asked to attend the meeting by an acquaintance, but was not told the name of the person I would be meeting with beforehand. The statement did not mention the offer of derogatory information about Clinton or any discussion of the Magnitsky Act or U.S. sanctions, which were the principal subjects of the meeting, as described in Volume 1, Section 4, A5 Supra. A short while later, while still on Air Force One, Hicks learned that Priebus knew about the emails, which further convinced her that additional information about the June 9 meeting would leak, and the White House should be proactive and get in front of the story. Hicks recalled again going to the president to urge him that they should be fully transparent about the June 9 meeting, but he again said no, telling Hicks, quote, "You've given a statement, we're done," quote. Later on the flight home, Hicks went to the president's cabin where the president was on the phone with one of his personal attorneys. At one point, the president handed the phone to Hicks, and the attorney told Hicks that he had been working with Circa News on a separate story and that she should not talk to the New York Times. 4. The media reports on the June 9, 2016 meeting. Before the president's flight home from G20 landed, the New York Times published its story about the June 9, 2016 meeting. In addition to the statement from Trump Jr., the Times story also quoted a statement from Corallo on behalf of the president's legal team, suggesting that the meeting might have been a setup by individuals working with the firm that produced the Steele reporting. Corallo also worked with Circa News on a story published an hour later that questioned whether Democratic operatives had arranged the June 9 meeting to create the appearance of improper connections between Russia and Trump family members. Hicks was upset about Corallo's public statement and called him that evening to say that the president had not approved the statement. The next day, July 9, 2017, Hicks and the president called Corallo together, and the president criticized Corallo for the statement he had released. Corallo told the president that the statement had been authorized and further observed that Trump Jr.'s statement was inaccurate and that a document existed that would contradict it. Corallo said that he purposely used the term, quote, document, end quote, to refer to the emails setting up the June 9 meeting because he did not know what the president knew about the emails. Corallo recalled that when he referred to the document on the call with the president, Hicks responded that only a few people had access to it and said, quote, "It will never get out," end quote. Corallo took contemporaneous notes of the call that say, quote, also mentioned existence of also mentioned the existence of Doc. Hope says, quote, "Only a few people have it, it will never get out," end quote. Hicks later told investigators that she had no memory of making that comment and had always believed the emails would eventually be leaked. But she might have been channeling the president on the phone call because it was clear to her throughout her conversation with the president that he did not think the emails would leak. On July 11, 2017, Trump Jr. posted redacted images of the emails setting up the June 9 meeting on Twitter. The New York Times reported that he did so, after being told that the Times was about to publish the content of the emails. Later that day, the media reported that the president had been personally involved in preparing Trump Jr.'s initial statement to the New York Times that had claimed the meeting was primarily concerned with a program about the adoption of Russian children. Over the next several days, the president's personal counsel repeatedly and inaccurately denied that the president played any role in drafting Trump Jr.'s statement. After consulting with the president on the issue, White House Press Secretary Sarah Stevens told the media that the president, quote, certainly didn't dictate, end quote, the statement, but that, quote, he weighed in, offered suggestions like any father would do, end quote. Several months later, the president's personal counsel stated in a private communication to the special counsel's office that, quote, the president dictated a short but accurate response to the New York Times article on behalf of his son, Donald Trump Jr., end quote. The president later told the press that it was irrelevant whether he dictated the statement and said, it's a statement to the New York Times. This is not a statement to a high tribunal of judges. On July 12, 2017, the special counsel's office, there's a redaction, Trump Jr., another redaction, related to the June 9 meeting and those who attended the June 9 meeting. On July 19, 2017, the president had his follow-up meeting with Lewandowski and then met with reporters for the New York Times. In addition to criticizing Sessions in his Times interview, the president addressed the June 9, 2016 meeting and said that he didn't know anything about the meeting at the time. The president added, quote, "As I've said, most other people, when they call up and say, by the way, we have information on your opponent, I think most politicians, I was just with a lot of people, they said, who wouldn't have taken a meeting like that?" In analysis, in analyzing the president's actions regarding the disclosure of information about the June 9 meeting, the following evidence is relevant to the elements of obstruction of justice. A, obstructive act. On at least 3 occasions between June 29, 2017 and July 9, 2017, the president directed Hicks and others not to publicly disclose information about the June 9, 2016 meeting between senior campaign officials and a Russian attorney. On June 29, Hicks warned the president that the emails setting up the June 9 meeting were really bad, and the story would be massive when it broke. But the president told her and Kushner to leave it alone. Early on July 8th, after Hicks told the president the New York Times was working on a story about the June 9 meeting, the president directed her not to comment, even though Hicks said that the president usually considered not responding to the press to be the ultimate sin. Later that day, the president rejected Trump Jr.'s draft statement that would have acknowledged that the meeting was with an individual who I was told might have information helpful to the campaign. The president then dictated a statement to Hicks that said that the meeting was about Russian adoption, which the president had twice been told was discussed at the meeting. The statement dictated by the president did not mention the offer of derogatory information about Clinton. Each of these efforts by the president involved his communications team and was directed at the press. They would amount to obstructive acts only if the president, by taking these actions, sought to withhold information from or mislead congressional investigators or the special counsel. On May 17, 2017, the president's campaign received a document request from SSCI that clearly covered the June 9 meeting and underlying emails, and those documents also plainly would have been relevant to the special counsel's investigation. But the evidence does not establish that the president took steps to prevent the emails or other information about the June 9 meeting from being provided to Congress or the special counsel. The series of discussions in which the president sought to limit access to the emails and prevent their public release occurred in the context of a developing press strategy. The only evidence we have of the president discussing the production of documents to Congress or the special counsel is the conversation on June 29, 2017, when Hicks recalled the president acknowledging that Kushner's attorney should provide emails related to the June 9 meeting to whomever he needed and to give them to. We do not have evidence of what the president discussed with his own lawyers at the time. B, nexus to an official proceeding. As described above, by the time of the president's attempts to prevent the public release of the emails regarding the June 9 meeting, the existence of a grand jury investigation supervised by the special counsel was public knowledge, and the president had been told that the emails were responsive to congressional inquiries. To satisfy nexus requirements, however, it would be necessary to show that preventing the release of the emails to the public would have the natural and probable effect of impeding the grand jury proceeding or congressional inquiries. As noted above, the evidence does not establish that the president sought to prevent disclosure of the emails in those official proceedings. C, intent. The evidence establishes that the president's substantial involvement in the communication strategy related to information about his campaign's connections to Russia and his desire to minimize public disclosures about their connections. The president became aware of the emails no later than June 29, 2017, when he discussed them with Hicks and Kushner, and he could have been aware of them as early as June 2, 2017, when lawyers for the Trump Organization began interviewing witnesses who participated in the June 9 meeting. The president thereafter repeatedly rejected the advice of Hicks and other staffers to publicly release information about the June 9 meeting. The president expressed concern that multiple people had access to the emails and instructed Hicks that only one lawyer should deal with the matter. And the president dictated a statement to be released by Trump Jr. in response to the first press accounts of the June 9 meeting that said the meeting was about adoption. But as described above, the evidence does not establish that the president intended to prevent the special counsel's office or Congress from obtaining the emails setting up the June 9 meeting or other information about that meeting. The statement recorded by Corallo that the emails, quote, will never get out, end quote, can be explained as reflecting a belief that the emails would not be made public if the president's press strategy were followed, even if the emails were provided to Congress and the special counsel. H, the president's further efforts to have the Attorney General take over the investigation. From summer of 2017 through 2018, the president attempted to have Attorney General Sessions reverse his recusal, take control of the special counsel's investigation, and order an investigation of Hillary Clinton. Evidence. President again seeks to have Sessions reverse his recusal. After returning Sessions' resignation letter at the end of May 2017, but before the president's July 19, 2017 New York Times interview in which he publicly criticized Sessions for recusing from the Russia investigation, the president took additional steps to have Sessions reverse his recusal. In particular, at some point after the May 17, 2017 appointment of the special counsel himself, according to Sessions, the president asked him to reverse his recusal so that Sessions could direct the Department of Justice to investigate and prosecute Hillary Clinton. And the gist of the conversation was that the president wanted Sessions to unrecuse from all of it, including the special counsel's Russia investigation. Sessions listened but did not respond, and he did not reverse his recusal or order the investigation of Clinton. In early July 2017, the president asked Staff Secretary Rob Porter what he thought of the Associate Attorney General Rachel Brand. Porter recalled that the president asked him if Brand was good, tough, and, quote, on the team, end quote. The president also asked if Porter thought Brand was interested in being responsible for the special counsel's investigation and whether she would want to be the Attorney General one day. Because Porter knew Brand, the president asked him to sound her out about taking responsibility for the investigation and being Attorney General. Contemporaneous notes taken by Porter show that the president told Porter to, quote, keep in touch with your friend, end quote, in reference to Brand. Later, the president asked Porter a few times in passing whether he had spoken to Brand, but Porter did not reach out to her because he was uncomfortable with the task. In asking him to reach out to Brand, Porter understood the president to want to find someone to end the Russia investigation or fire the special counsel, although the president never said so explicitly. Porter did not contact Brand because he was sensitive to the implications of that action, and he did not want to be involved in the chain of events associated with an effort to end the investigation or fire the special counsel. McGahn recalled that during the summer of 2017, he and the president discussed the fact that if Sessions were no longer in his position, the special counsel would report directly to a non-recused attorney general. McGahn told the president that things might not change much under a new attorney general. McGahn also recalled that in or around July 2017, the president frequently brought up his displeasure with Sessions. Hicks recalled that the president viewed Sessions' recusal from the Russia investigation as an act of disloyalty. In addition to criticizing Sessions' recusal, the president raised other concerns about Sessions and his job performance with McGahn and with Hicks. 2, additional efforts to have Sessions unrecused or direct investigations covered by his recusal. Later in 2017, the president continued to urge Sessions to reverse his recusal from campaign-related investigations and considered replacing Sessions with an attorney general who would not be recused. On October 16, 2017, the president met privately with Sessions and said that the Department of Justice was not investigating individuals and events that the president thought the department should be investigating. According to contemporaneous notes taken by Porter, who was at the meeting, the president mentioned Clinton's emails and said, quote, "Don't have to tell us, just take a look," end quote. Sessions did not offer any assurances or promises to the president that the Department of Justice would comply with that request. 2 days later, on October 18, 2017, the president tweeted, quote, "Wow, FBI confirms report that James Comey drafted letter exonerating crooked Hillary Clinton long before investigation was complete. Many people not interviewed, including Clinton herself. Comey stated under oath that he didn't do this. Obviously a fix. Where is the Justice Department?" End quote. On October 29, 2017, the president tweeted that there was, quote, "anger and unity," end quote, over a, quote, "lack of investigation," end quote, of Clinton and the Comey fix, and concluded, quote, "do something," exclamation mark, end quote. On December 6, 2017, 5 days after Flynn pleaded guilty to lying about his contacts with the Russian government, the president asked to speak with Sessions in the Oval Office at the end of a cabinet meeting. During the Oval Office meeting, which Porter attended, the president again suggested that Sessions could unrecuse, which Porter linked to taking back supervision of the Russia investigation and directing an investigation of Hillary Clinton. According to contemporaneous notes taken by Porter, the president said, quote, "I don't know if you can unrecuse yourself. You'd be a hero. Not telling you to do anything. Dershowitz says POTUS can get involved, can order AG to investigate. I don't want to get involved. I'm not going to get involved. I'm not going to do anything or direct you to do anything. I just want to be treated fairly," end quote. According to Porter's notes, Sessions responded, quote, "We are taking steps. Whole new leadership team. Professionals will operate according to the law," end quote. Sessions also said, quote, "I never saw anything that was improper," which Porter thought was noteworthy because it did not fit with the previous discussion about Clinton. Porter understood Sessions to be reassuring the president that he was on the president's team, end quote. At the end of December, the president told the New York Times it was too bad that Sessions had recused himself from the Russia investigation. When asked whether Holder had been a more loyal attorney general to President Obama than Sessions to him, the president said, quote, "I don't want to get into loyalty, but I will tell you that I will say this: Holder protected President Obama, totally protected him. When you look at the things that they did, and Holder protected the president, and I have great respect for that, I'll be honest," end quote. Later in January, the president brought up the idea of replacing Sessions and told Porter that he wanted to, quote, "clean house," end quote, at the Department of Justice. In a meeting at the White House residence, that Porter attended on January 27, 2018, Porter recalled that the president talked about the great attorneys he had in the past with successful win records, such as Roy Cohn and Jay Goldberg, and said that one of his biggest failings as president was that he had not surrounded himself with good attorneys, citing Sessions as an example. The president raised Sessions' recusal and brought up and criticized the special counsel's investigation. Over the next several months, the president continued to criticize Sessions in tweets and media interviews, and on several occasions appeared to publicly encourage him to take action in the Russia investigation despite his recusal. On June 5th, 2018, for example, the president tweeted, quote, "The Russian witch hunt hoax continues, all because Jeff Sessions didn't tell me he was going to recuse himself. I would have quickly picked someone else. So much time and money wasted, so many lives ruined, and Sessions knew better than most that there was no collusion," exclamation point, end quote. On August 1, 2018, the president tweeted that, quote, "The Attorney General Jeff Sessions should stop this rigged witch hunt right now," end quote. On August 23, 2018, the president publicly criticized Sessions in a press interview and suggested that prosecutions at the Department of Justice were politically motivated because Paul Manafort had been prosecuted but Democrats had not. The president said, and I quote, "I put in an attorney general that never took control of the Justice Department, Jeff Sessions." That day, Sessions issued a press statement that said, quote, "I took control of the Justice Department the day I was sworn in. While I'm Attorney General, the actions of the Department of Justice will not be improperly influenced by political considerations," end quote. The next day, the president tweeted a response, quote, "Department of Justice will not be improperly influenced by political considerations," end quote. Jeff, this is great, what everyone wants, so look into all of the corruption on the other side, including deleted emails, Comey lies and leaks, Mueller conflicts, McCabe's, Strzok, Page, OHR, Pfizer abuse, Christopher Steele and his phony corrupt dossier, and the Clinton Foundation, illegal surveillance of Trump campaign, Russian collusion by Dems, and so much more. Open up the papers and documents without redaction. Come on, Jeff, you can do it. The country is waiting, exclamation point, end quote. On November 7, 2018, the day after the midterm elections, the president replaced Sessions with Sessions' chief of staff as acting attorney general. Analysis. In analyzing the president's efforts to have Sessions unrecuse himself and regain control of the Russia investigation, the following considerations and evidence are relevant to the elements of obstruction of justice. A, obtrusive act. To determine if the president's effort to have Attorney General recuse himself could qualify as an obstructive act, it would be necessary to assess evidence on whether those actions would naturally impede the Russia investigation. That inquiry would take into account the supervisory role that the Attorney General, if unrecused, would play in the Russia investigation. It would also have to take into account that the Attorney General's recusal covered other campaign-related matters. The inquiry would not turn on what Attorney General Sessions would actually do if unrecused, but on whether the efforts to reverse his recusal would naturally have had the effect of impeding the Russia investigation. On multiple occasions in 2017, the president spoke with Sessions about reversing his recusal so that he could take over the Russia investigation and begin an investigation and prosecution of Hillary Clinton. For example, in early summer 2017, Sessions recalled the president asking him to unrecuse, but Sessions did not take it as a directive. When the president raised the issue again in December 2017,